ಮಾತ್ರ ಬನ್ನಿ. ಹಾ, ವೈ ಯು ಪೀಪಲ್ ವೇಸ್ಟ್ ದಿ ಟೈಮ್. ಬೆಳಗ್ಗೆ ನೋಡಿ 10 ನಿಮಿಷ ಹೋಯ್ತು. ತೇಜೇಶ್ ಸುಂಕಾಪುರ್, ಹಾ ಹೇಳಿ, ಎಷ್ಟು ದಿವಸ ಬೇಕು? 2 days. Council seeks 2 days. If complied, post the matter as per roster. Nisar Saab, absent 2 weeks time granted. N Suresha, absent 2 weeks time granted. 4 Raju CN, absent 2 weeks time granted. GV Manjunatha, absent 2 days. Council seeks 2 days time granted. Joseph Joji, absent 2 weeks. Javed S, ಹೇಳಿ, ಎಷ್ಟು ಸಭೆ ಬೇಕು ಹೇಳಿ? Council seeks 2 days post the matter after compliance. Second time non-compliance. Dayamani, yes madam. How much time you require? Only 1 week. Council seeks 1 week granted. Next, serial number 9 and 10 first time matters. ಏನಾರು ನೋಟಿಸ್ ಹೋಗೋದಿದೆಯೇನ್ರಿ? ಯಾವ್ದು? ಅದ್ ಬೇಡ್ರಿ, ಫಸ್ಟ್ ಇನ್ ಮಾತ್ರ, ಫಸ್ಟ್ ಪೇಜ್ ಹೇಳಿ. 9 and 10 ಅಲ್ಲಿ ಯಾವ್ದಿಲ್ಲ. HCGP is directed to take notice and file objections if any. List this matters on 28th. Serial number 11 to 25.
Serial number 11. I am for the petition, my lord. Serial number 11.
1 ನಿಮಿಷ ವೇಟ್ ಮಾಡಿ, ಹೇಳ್ರಿ ಯಾವ್ದಾರು ನೋಟಿಸ್ ಹೋಗೋದಿದೆಯಾ? 12, 14, 23, 25. 12 ಯಾರು? ಶ್ರೀನಿವಾಸ್ ಇದ್ದೀರಾ? ಎಷ್ಟು ಏಜ್ ಎಷ್ಟು ವಿಕ್ಟಿಮ್ದು ನೋಡಿದಿರಾ? ವಿಕ್ಟಿಮ್ ಏಜ್ ಎಷ್ಟು ನೋಡಿದಿರಾ? ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾ ಬೇರೆಯವ್ರಿಗೆ? ವಿಕ್ಟಿಮ್ಗೆ ಏನಾರು 16 ವರ್ಷದ ಕಡಿಮೆ ಇದಾರಾ? 12 ಅಲ್ಲಿ ನೀವಿಲ್ವಾ? ಮತ್ತೆ ಯಾಕೆ? 12 ಯಾರು ಇದ್ದೀರಾ? ಇಲ್ಲ. 14 ಯಾರು ಇದ್ದೀರಾ? ಬಿ ರಮೇಶ್, ಏನ್ರಿ ಇದ್ರಲ್ಲಿ ಯಾರು ಇದಾರಾ? ಎಷ್ಟು ವಿಕ್ಟಿಮ್ಗೆ ಯಾರಿಗಾರು ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾ? ಇಲ್ಲ. ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ 23 ಸುರೇಶ್ ಎಂ ಚರ್ಮಗಲ್, ಏನು? ಸೇಮ್ ಪಿಟಿಷನರ್ ಆದ್ರೆ 2 ಹ್ಯಾಂಗ್ ಬರ್ತದೆ? ಟ್ರೈನ್ ಬೇರೆ ಬೇರೆ ಆದ್ರೆ ಒಟ್ಟಿಗೆ ತಗೊಳಕ್ ಬರೋದಿಲ್ಲ. ಆಯ್ತು. ನೆಕ್ಸ್ಟ್ ಪೋಕ್ಸೋ ಏನಾರು ಇದೆಯಾ? ಇಲ್ಲ. ನೆಕ್ಸ್ಟ್ 25 HV ಮಂಜುನಾಥ, ಏನಾದ್ರು ಪೋಕ್ಸೋ ಇದೆಯಾ? ಅಫೆನ್ಸ್ ಇಲ್ಲಲ್ಲ, ತೊಳಿ. ಎಲ್ಲಾ ಮ್ಯಾಟ್ರು ಸೀರಿಯಲ್ ನಂಬರ್ 11 to 25. HCGP is directed to take notice and file objections if any. List this matters on 25th. ಏನಾದ್ರು ಸಬ್ಮಿಷನ್ಸ್, ಏನಾದ್ರು ಅಡ್ವೊಕೇಟ್ಸ್ ಏನಾರು ಇದೆಯಾ?
No, my lord.
Serial number 17.
No, my lord.
ಆಯ್ತು. ಆಲ್ ಮ್ಯಾಟ್
Serial number 17, Your Honor.
ಆಯ್ತು. ಆಲ್ ಮ್ಯಾಟ್
Serial number 17, Your Honor.
all right.
Serial number 17, Your Honor.
Lords, court mic is muted.
Please.
When the property of 75 acres is grabbed by a person, that is also by a former chief secretary in the name of mother, you people are not taking any decision. Why? Why you are not taking decision? But 230. ಎಷ್ಟ್ ಸರಿ ಟೈಮ್ ಕೇಳಿದ್ರಿ ನೀವು? ಒಂದ್ಸರಿ 17 ಅಲ್ಲಿ ಪರ್ಮಿಷನ್, ಒಂದ್ಸರಿ 19 ಅಲ್ಲಿ ಪರ್ಮಿಷನ್ ಹೇಳ್ಬಿಡಿ, ಬರ್ಕೊಟ್ಬಿಡಿ. ಇಲ್ಲ 66 ಎಕರೆನು ಅವನಿಗೇನೆ ಬರ್ಕೊಟ್ಬಿಡ್ರಿ ಅತ್ಲಾಗಿ. ಮತ್ತೆ ಈ ತರ ಮಾಡ್ತೀರಾ? 6 ವರ್ಷ ಆಯ್ತು. ಐ ಥಿಂಕ್ 2016 ಕಂಪ್ಲೇಂಟ್. ಯು ಆರ್ ನಾಟ್ ಟೇಕನ್ ಎನಿ ಆಕ್ಷನ್. ಅವ್ನು ಯಾವನ ತಹಸೀಲ್ದಾರ್ ಆಫೀಸ್ ಅಲ್ಲಿ ಪಾಪ ಯಾವನು ಗುಮಾಸ್ತಾ ಇರ್ತಾನ, ಅವನಿಗೆ ಪರ್ಮಿಷನ್ ಕೊಡ್ತೀರಿ ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಕ್ ಅವನ ಮೇಲೆ. ಎಲ್ಲ DC, ಎಲ್ಲ ಚೀಫ್ ಸೆಕ್ರೆಟರಿ ಎಲ್ಲರನ್ನು ಬಿಟ್ಬಿಟ್ಟು, whether this court has to monitor, is it not the duty of the state to monitor all these things? It appears that state is in also hand in glove with those people. Otherwise, I will pass orders at 2:30. I will pass strictures against government if that is the case. ಫಾರ್ಮರ್ ಚೀಫ್ ಸೆಕ್ರೆಟರಿ ಅವ್ರ ಅಮ್ಮನ ಹೆಸರಲ್ಲಿ ಆಸ್ತಿ ಹೊಡಿತಾನೆ 66 ಎಕರೆ, ನೀವು ಕಣ್ಣು ಮುಚ್ಕೋ ಕೂತ್ಕೋತೀರಿ. ನೋ ಆಕ್ಷನ್ ಇಸ್ ಟೇಕನ್. ಅವರು 3 ವರ್ಷದ ಮೇಲೆ 4 ವರ್ಷದ ಮೇಲೆ ಅದು ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ತಾರೆ. ಬಾಕಿಗೆಲ್ಲ ಮೊದ್ಲೇ ನಿಂತಿರ್ತಾರೆ ACB ಅವರು, ಲೋಕಾಯುಕ್ತದವರು. ಅದಕ್ಕೆ ನೀವು ಪರ್ಮಿಷನ್ ಕೊಡಕ್ಕೆ 6 ವರ್ಷ ಬೇಕು ಅವನ್ ಪ್ರಾಸಿಕ್ಯೂಟ್ ಮಾಡಕ್ಕೆ. State is also a culprit. 2:30, no, we'll see. Is it a duty of the court to monitor all this? Is it not the duty of the state when the state property is not by a former chief secretary? And he only influenced all subordinates, district DC, AC, ತಹಸೀಲ್ದಾರ್ ಆಫೀಸ್ ಅಲ್ಲಿ ಇರೋರು, ಅವ್ರೆಲ್ಲರನ್ನು ಇನ್ಫ್ಲೂಯೆನ್ಸ್ ಮಾಡಿ ಕೆಲಸ ಮಾಡ್ಕೊಳ್ಳೋದು ಅವನು. ನೀವು ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡೋದು ಅವ್ನು ಯಾರೋ ತಹಸೀಲ್ದಾರ್ ಆಫೀಸಲ್ಲಿ ಅವನ ಒಬ್ಬ ಇರ್ತಾನೆ, ಅವನಿಗೆ ಮಾತ್ರ. By monitoring this court only you gave sanction for DC, AC and all. Now ಈಗ 19 ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಸ್ಯಾಂಕ್ಷನ್ಗೆ ಮತ್ತೆ ಇನ್ನೆಷ್ಟು ವರ್ಷ ಇಟ್ಕೋಬೇಕು ಅಂತಿದ್ದೀರಿ? Just at 2:30 if no positive report. 2:30. Parted in orders 27 SVP ಏನ್ರಿ ಇದು? A4 to 7. Why it was parted? Order sheet ಕೊಡಿ ಮೇಡಮ್. Other side are Kemparaj for R1.
Yes, madam. I am for the respondent, madam.
ಹೇಳಿ ಏನು?
Kumar.
ಆಯ್ತು ಹೇಳ್ರಿ.
My friend argued this matter.
ಬರ್ತಾರಾ ಪಾಸ್ ಅವರಾ? 2:30 ಆಯ್ತು. 2:30 ಸಬ್ಜೆಕ್ಟ್ ಮಧ್ಯಾಹ್ನ ಒಂದು ಬೆಂಚ್ ಇದೆ, ಆ ಟೈಮ್ ನೋಡಿ.
Your Lordships, appearing for the petitioner. On the last hearing, the Honorable Court had directed if there is a possibility of marriage, consider.
ಏನಾಯ್ತು ಮದುವೆ ಮಾಡಿದ್ರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು ಏನಾಗಿದೆ, I'll just brief the background.
ಹೇಳಿ.
The petitioner and the respondents were known to each other since 2012.
ಆಯ್ತ್ರಿ. ಅದೆಲ್ಲ ಆದ್ಮೇಲೆ ಮದುವೆ ಮಾಡ್ಕೋತೀನಿ ಅಂತೆಲ್ಲ ಮಾಡಿ
ಅದು ಎಂಗೇಜ್ಮೆಂಟ್ ಕೂಡ ವಿತ್ ಫ್ಯಾಮಿಲಿ
ಅಡ್ಡ ಬಂದಿದೆ. ಹೇಳಿ ಆಮೇಲೆ ಹೇಳಿ.
ವಿತ್ ಬೋತ್ ದ ಫ್ಯಾಮಿಲಿ ಕನ್ಸೆಂಟ್.
ಅವಾಗ ಒಟ್ಟಿಗೆ ಸೇರಕ್ ಜಾತಿ ಇರ್ಲಿಲ್ಲ.
ಈಗ ಜಾತಿ ಇಲ್ಲ ಸ್ವಾಮಿ, ಜಾತಿ ಪ್ರಶ್ನೆ ಇಲ್ಲ ಇದ್ರಲ್ಲಿ. ಏನಾಯ್ತು,
ಮದುವೆ ಮಾಡ್ಕೊಳಕ್ ರೆಡಿ ಇಲ್ಲ.
ಇಲ್ಲ ಈಗ ಅದಲ್ಲ ಸ್ವಾಮಿ. I mean, my humble submission is,
counsel last time I adjourned only on the ground that you say that you are going to marry her, then I will consider it in a lenient way.
Because now, yes. Now the thing is that there is no proper forum or conciliation. There is no proper forum to even consider.
ಬಿಡಿ ಸ್ವಲ್ಪ ದಿವಸ ಒಳಗಿರಿ, ಆಮೇಲೆ ಪ್ರಾಪರ್ ಫಾರಂ.
ಅಲ್ಲ ಸ್ವಾಮಿ, I mean, please, my humble submission with regard to facts of the case.
Counsel, it is a heinous offense of 376. So you have approached this court by invoking section 438. What are the grounds you make out?
Yes, I'll just highlight a few facts here.
ಹೇಳಿ 2012 ಅವಾಗಿಲ್ಲ. ಆಮೇಲೆ ವಿತ್ ಕನ್ಸೆಂಟ್ ಸೆಕ್ಸ್ ನಿಮ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಇಟ್ ಈಸ್ ಮೇಜರ್. ಹೌದಾ?
Both are 33 years as of now. 33 years.
ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್
Your Lordships, we are not disputing any electronic evidence in this case. There are a lot of electronic evidence, conversation, and also photos, and we are ready to submit those conversations also, which will contradict the case of the complainant victim.
ಅದಲ್ಲ ಈಗ ನೋಡ್ಲಿಕ್ಕೆ ಆಗೋದಿಲ್ಲ.
ಅಲ್ಲ, ಅದಕ್ಕೆ ಸ್ವಾಮಿ, I mean, my humble submission is we are ready to go and
subject to the admissibility of the judgment of the apex court in Court Karnataka case.
Yes.
That is
So-
also confirmed the earlier judgment of PV Basir's case.
Yes.
That will be considered only at the time of
Trial.
electronic evidence, at the time of leading evidence. not
Of
at
course,
the
Your
time.
Lordship. My humble
Even
submission
at
is,
the time of filing charge sheet also, no need to place any electronic evidence certificate also.
Of
This is the present situation
yes,
regarding
Your Lord.
electronic evidence. ಹೇಳಿ.
My humble submission is,
438 ಅಲ್ಲಿ consider ಮಾಡ್ಲಿಕ್ಕೆ ಆಗುತ್ತಾ ಹೇಳಿ ಅಷ್ಟೇ ಹೇಳಿ.
because this is a more like a matrimonial dispute, because
ಆಯ್ತು.
because the after engagement they were also ready for the marriage. In the meanwhile, what happened? The mother of
ಆಯ್ತು,
the
ಎಂಗೇಜ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ ಮದುವೆ ಮಾಡ್ಕೊಳಕ್ಕೇನ್ರಿ?
ಅಲ್ಲಿ ಅದೇನಾಯ್ತು ಸ್ವಾಮಿ, mother of the
ಮದುವೆಗಿಂತ ಎಲ್ಲ ಮಾಡಿಬಿಟ್ಟು ಈಗ ಆಗಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗೆ?
ಇಲ್ಲ ಸ್ವಾಮಿ, I mean mother of the petitioner fell ill and it got postponed, and during that period the victim,
ಎಂಗೇಜ್ಮೆಂಟ್ ಆಗಿದ್ದೆ ಯಾವಾಗ? ಎಂಗೇಜ್ಮೆಂಟ್ ಆಗಿದ್ದೆ ಯಾವಾಗ?
2019 November, Your Lordship.
19. Now we are in 2022.
Yes, Your Lordship.
For a
But
period
in the
of
meanwhile, there were like the victim showed suicidal tendencies, and then because of that there were a lot of disagreements between the petitioner and the victim. It's a very the intimate disputes arose during that period. Hangagi, I mean, I am ready to cooperate and furnish all the details. I am not disputing the relationship, Your Lordship. No, I am not disputing.
Yes,
Only my humble submission. The victim has falsely implicated the relatives. 12 accused na implicate ಮಾಡಿದ್ರು sir. 12 accused. The family who had attended the engagement, they had no way connected to this.
See, now only petitioner only is before the court. Why you argue all these arguments?
My humble submission.
When they are not the parties in the petition, why you make all this submission?
No, the background of the.
Restrict your argument only for the 438 in respect of the petitioner.
Pardon me.
That's all.
Yes.
Honorable court. The father of the victim, mother of the victim, neighbor of the victim family. Police have taken the statement pertaining to the performance of the engagement.
Engagement ಎಲ್ಲ ಆಯ್ತು, ಆಯ್ತು.
The examination was being made. Subsequently, citing the reason of the caste, the petitioner and their family retracted to perform the marriage of the victim. So now this the petitioner has approached under 438. So considering the gravity of the offense and the facts, it is honorable court to dismiss the petition.
Heard the petitioner, counsel, and also the counsel appearing for the state. The factual matters of the case of the prosecution is that the complainant victim in the complaint has stated that this petitioner and the victim, both of them fell in love. And this petitioner subjected her for sexual act. And thereafter also he married her. And when the same comes to know about the family members of the petitioner, they have approached that they are going to perform the marriage as per the customs. And in this regard, engagement was also made. And now they are refusing to take her back and to perform the marriage as he belongs to the SC community. ಏನ್ರಿ ಇದು ಬೋವಿ ಅಂತಿದೆ
ST ಬರುತ್ತೆ.
ST ಬರುತ್ತಾ?
Petitioner is ST song.
ST community, and also subjected for humiliation. And now they refuse to perform the marriage. Hence, the action is sought against the petitioner. Counsel appearing for the petitioner would submit that then petitioner is not disputing the fact that already engagement was taken place between the victim and also the petitioner. And also counsel would submit that there are electronic evidence regarding the subsequent development. And counsel also would submit that the mother of the petitioner is suffering from ill health, and hence marriage could not take place. And hence this court has to invoke section 438 of CRPC. For count of the counsel appearing for the state would submit that he was subjected to sexual act against her wish, and also promised to marry her, but now he turns hostile and telling the caste of the victim. And though the engagement was done in 2019, till date marriage is not performed as per the customs, but already there was a marriage as stated in the complaint itself, and hence there are prima facie material against the petitioner. Having heard the respective counsel and also perusal of when the petitioner is court invoking under section 438 of CRPC, court has to take note of the gravity of the offense and seriousness of allegation made in the complaint. Complaint specific allegation is made that she was subjected to rape as against her wish. Also subsequently promised to marry her, and also engagement was done in 2019, and subsequently not performed the marriage, and they subjected her for
Your Lordship,
humiliation, taking her caste name, and also demanded an amount of rupees 10 lakhs as well as gold, and also demanded for car to perform the marriage. When specific allegations are made against the petitioner, subjecting her for heinous offense of rape,
Your Lordship,
and with a promise to marry her. When specifying the factual aspects, it is not a fit case to exercise the power.
Your Lordship, one submission.
Considering the gravity of the offense and also the seriousness of allegation made in the complaint.
Your Lordship, one submission, Your Lordship.
If you have the discussions made up, I pass the following order. Bail petition is rejected. Really.
Your Lordship, the delay in engagement and the marriage was in the meanwhile, the
Delay
mother-
376 LL delay is not the matter. Right. Next. I heard a lot of you. 29. ಏನಾಯ್ತ್ರಿ ಅವರು ಅಡ್ವೊಕೇಟ್ 29 serial number 29. ಈಗೇನ ಹೇಳಿದ್ರಲ್ಲ ಕರೆಕ್ಷನ್ ಮಾಡ್ತೀನಿ ಅಂತೇನು.
Yeah, for second respondent it connected, madam lordship.
Petitioner counsel ಇದೇನ್ ಮೇಡಮ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಮೇಲೆ ಬಂದಿದೆಯಲ್ಲ. The petitioner counsel seeks amount is ಮಾಡಿರೋದ. ಆಯ್ತು. Counsel seeks time to comply with office objections. ಅಷ್ಟೇ ಆಗ್ಬೋದು. This matter ಇದೇ ನಮ್ಮ ಮುಂದೆನೆ ಬರಬೇಕು, ಬೇರೆ ಮುಂದೆ ಹೋಗೋದಿಲ್ಲ. This matter on 28.
There is no substance in the application, my lordship. Is simply
ನೋಡೋಣ ಆಮೇಲೆ ಫಸ್ಟ್ ಲೆಟ್ ಹಿಮ್ ಕಂಪ್ಲೈ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್.
Please, my lordship.
ಮೆರಿಟ್ ಇದೆಯೋ ಇಲ್ಲ ಆಮೇಲೆ ನೋಡೋಣ. That advocate came to my chamber. I am going to file the application ಅಂತ.
He made so many, my lordship. He filed several.
ಪಾರ್ಟಿನೂ ಕರ್ಕೊಂಡ್ ಬಂದು ಹೊರಗಡೆ ನಿಲ್ಸ್ಕೊಂಡಿದ್ರ ಗೊತ್ತಿಲ್ಲ, ಊದ್ ಕಳ್ಸಿದೀನಿ. Don't comes to my chamber.
ಫೋನ್ ಮಾಡಿದಾರಂತೆ.
ಹೌದಾ? ಅಲ್ಲ ಯಾರು ನಾನು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತೀನಿ ಅಂತ ಯಾರ ಚೇಂಬರ್ಗೆ ಹೇಳಕ್ ಬರ್ತಾರಲ್ರಿ?
ಅಲ್ಲ ಅಲ್ಲಿಗೆ ಮಿನಿಸ್ಟರ್ನೆಲ್ಲ ಪಾರ್ಟಿ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ದಂಡ ಹಾಕಿ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದೀನಿ ಅಪ್ಲಿಕೇಶನ್ಸ್.
He said he has to make parties minister also in the state.
ಇಲ್ಲ ಯಾರನ್ನಾರು ಮಾಡ್ಕೊಳ್ಳಿ ಅದನ್ನ ಹೇಳಿದ್ದು. That should not the practice of an advocate. ನನಗೆ ಗೊತ್ತಿಲ್ಲ, ನಾನು ಯಾವಾಗ ಅಲ್ಲಿ ಇಲ್ಲ ಅಲ್ಲಿ ಚೇಂಬರ್ ಫಸ್ಟ್ ಒಂದ್ ದಿವಸ ಬಂದು ಹೋಗಿದ್ರೆ ನನ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಯಾರು. ನೆಕ್ಸ್ಟ್ ನೋಡ್ರಿ ನಾನು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತಾ ಇದ್ದೀನಿ ಸಾಹೇಬ್ರೆ ಅಂತ ಬಂದ್ರು. ಜಗದೀಶ್ ಹೇಳ್ರಿ. 15 years. 18 years. ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ಏನಿದೆ? ಆಯ್ತು ಅದೆಲ್ಲ ಇರುತ್ತೆ. ಇದೆ ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ಏನು ಹೇಳಿ? ಆಮೇಲೆ ಒಪಿನಿಯನ್ ಏನು, ವೆದರ್ ಸಿ ಸಬ್ಜೆಕ್ಟೆಡ್ ಟು ಸೆಕ್ಷುವಲ್ ಆಕ್ಟ್ ಆರ್ ನಾಟ್? 45. Opinion. ಡಾಕ್ಟರ್ ಫೈನಲ್ ಒಪಿನಿಯನ್ ಏನ್ರಿ? ಕೊಟ್ಟಿಲ್ವಾ? ಓನ್ಲಿ ಹೈಮನ್ ಇಸ್ ನಾಟ್ ಇಂಟ್ಯಾಕ್ಟ್. 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆಯಾ? ವಾಟ್ ಶಿ ಸೇಸ್? ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ ಅಲ್ಲ ಲಾಸ್ಟ್ 1 year 3 months.
In 164 statement she has not stated. But in the 161 statement before the police.
161 ಬೇಡ, 164 ಲಿ ಏನ್ ಹೇಳಿದಾಳೆ ಹೇಳಿ?
Court, there is no allegation of
ಡಾಕ್ಟರ್ ಫೈನಲ್ ಒಪಿನಿಯನ್ ಏನ್ ಕೊಟ್ಟವ್ರ ಆಫ್ಟರ್ ದಿ ಫಿಸಿಕಲ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಜೆನೈಟಲ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡಿ ಆದ್ಮೇಲೆ
ಕೆಪ್ಟ್ ಪೆಂಡಿಂಗ್ FSL ರಿಪೋರ್ಟ್ ಅಂತ.
ರೀ FSL ಏನಕ್ ಬೇಕ್ರಿ ಡಾಕ್ಟರ್ಗೆ? ಯಾರು ನಿಮ್ ಡಾಕ್ಟರ್? FSL ಓನ್ಲಿ ಸ್ವಾಬ್ ಸೈನ್ಸ್ ಇವೆಲ್ಲ ಕಲೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ಮಾತ್ರ ಆ ರಿಪೋರ್ಟಿಗೆ ಇರಬೇಕು. ವೆದರ್ ಶಿ ವಾಸ್ ಸಬ್ಜೆಕ್ಟೆಡ್ ಟು ಸೆಕ್ಷುವಲ್ ಆಕ್ಟ್ ಆರ್ ನಾಟ್. ಆಫ್ಟರ್ ದಿ ಜೆನೈಟಲ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಹಿ ಹ್ಯಾಸ್ ಟು ಗಿವ್ ಎ ಒಪಿನಿಯನ್. ಅದರ್ವೈಸ್ ಐ ವಿಲ್ ಸಮನ್ ಹಿಮ್. 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಡಿ. ಏನ್ ಹೇಳಿದಳ? ಅವಳಿಗೆ ಬಿಡದವ್ರು ನಮ್ಗೇನು ಕೊಡಿ. ವೆಜನಲ್ ಸ್ವಾಬ್ ಇವೆಲ್ಲ ತಗೊಂಡು ಕಳ್ಸಿರ್ತಾರೆ. ಅದು ಓನ್ಲಿ ಅವಾಗಿದ್ರೆ ಯಾವಾಗ ಆಗಿರೋದು ಆಕ್ಚುಲಿ ಸೆಕ್ಷುವಲ್ ಆಕ್ಟ್ ಯಾವಾಗ, ಎಕ್ಸಾಮಿನೇಷನ್ ಯಾವಾಗ, ಗ್ಯಾಪ್ ಎಷ್ಟು? ಅಲೇಜ್ ರೇಪ್ ಯಾವಾಗ್ರಿ? ಡೇಟ್ 9/12. ಅವಳ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿರೋದು ಯಾವಾಗ? 24/10. ಅದ್ ಹೆಂಗ್ರಿ ಆಗುತ್ತೆ? ಅಲೇಜ್ ಇನ್ಸಿಡೆಂಟ್ ರೇಪ್ 9/12, 24/10 ಎಕ್ಸಾಮಿನೇಷನ್ ಹೆಂಗಾಗುತ್ತೆ? ಅಲೇಜ್ ರೇಪ್ ಯಾವತ್ತು? ಯಾವಾಗ ಡೇಟ್? 26/11 ಅಲ್ಲಿ ಒಟ್ಟಿಗೆ ಹೋದ್ರು.
7/12/2020.
ಎಕ್ಸಾಮಿನೇಷನ್ ಯಾವಾಗ? 7/12. 7/12 ಬಂದಿದ್ದು. ಮೆಡಿಕಲ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಯಾವಾಗ? 9/12. ಹೌದಾ? 9/12 7/12. 7/12 ಅಲ್ಲೇ ಮಾಡಿದಾರ. ಇವನ್ ಅರೆಸ್ಟೆಡ್ ಆನ್ 9/12. ಹೌದಾ? ಹೆಂಗ್ ಬಾಯ್? ಅವಳು 15 ವರ್ಷ ಅಲ್ಲ, ಏನ್ ಮಾಡ್ತೀರ? ನೋಡಿ, heard the petitioner counsel and also the council appeal to the state. ಯಾರೀ ಡಾಕ್ಟರ್? ಅದು ಯಾವ ಊರು? ಡಾಕ್ಟರ್ ಮಾಡಿರೋದು? will issue showcase notice to the doctor. Why they have not given the report? ಡಾಕ್ಟರ್ ಹತ್ರಕ್ಕೆ ಎಕ್ಸಾಮಿನೇಷನ್ ಕರ್ಕೊಂಡು ಹೋಗಿ ವೆದರ್ ಶಿ ವಾಸ್ ಸಬ್ಜೆಕ್ಟೆಡ್ ಟು ಸೆಕ್ಷುವಲ್ ಆಕ್ಟ್ ಆರ್ ನಾಟ್ ಕೊಡಿ, ರಿಪೋರ್ಟ್ ಕೊಡಿ, ಜೆನೈಟಲ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಂತ ಹೇಳಿ ಮಾಡಿ ಕೊಟ್ರೆ ಯಾಕೆ ರಿಪೋರ್ಟ್ ಕೊಟ್ಟಿಲ್ಲ ಡಾಕ್ಟರ್? ಅವರು ಯಾರು ಡಾಕ್ಟರ್? ಯಾರು ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಟಿರೋದು? AC ಜನರಲ್ ಬೆಂಗಳೂರಲ್ಲ. ಸಮನಿಮ್ ಇಲ್ಲಿ ಸಮನಿಮ್ ಎಲ್ಲಾ ಕೇಸ್ಗಳಲ್ಲಿ ಹಿಂಗೆ ಮಾಡ್ತಾರೆ ಕೆಲವು ಡಾಕ್ಟರ್ಗಳು. ಕಸ ತಿಂದ್ ಬಿಡ್ತಾರೆ. ಇನ್ನೇನ್ ಮಾಡ್ತೀರಿ? ರಿಪೋರ್ಟ್ ಕೊಡೋದಿಲ್ಲ. You keep the doctor before the court, then I will take a decision. He has not given any opinion. ಯಾವಾಗ ಕರೆಸ್ತೀರಿ? Thursday. Told heard the matter. HCGP is directed to keep the doctor who conducted genital examination of the victim has not given the report whether the victim is subjected to sexual act or not. On ಯಾವಾಗ ಡೇಟ್? Thursday. ಆಯ್ತು, ಅವತ್ತು ಫುಲ್ ಡೇ ಇರ್ತದೆ. Thursday. 24th.
The copy of the order.
ಆಯ್ತು. Copy of the order. Office is directed to furnish the copy of this order to the HCGP office. 31. ತಿಗಡಿ ವೀರಣ್ಣ ಬೆಳಿಗ್ಗೆಪ್ಪ. ಹೇಳಿ. ಮ್ಯಾಟರ್ ಜಾಸ್ತಿ ಇದೆ ಅಂತ, that is not a ground. You argue. Otherwise, I have read the papers. I will dictate the order. I will give you an opportunity. If you fail to assist the court, then I will take a decision. Matter ಜಾಸ್ತಿ ಇದೆ ಅಂತ is not a ground. ಏನ್ರಿ ಕೌನ್ಸಿಲ್ ಹೇಳ್ರಿ, ನೀವೇನ್ರಿ? ಮತ್ತೆ ಏನ್ರಿ ನೀವು? ಇಲ್ಲ, ನೀವೇ ಓದ್ಕೊಂಡ್ ಹೇಳಿ. ಸೆಕ್ಷನ್ 21C, 27A, 27B, 29. ಪಾಸ್ ಓವರ್. 32 BV Pinto. 498A, 304B ಮಾತ್ರ ಹೇಳಿ. ಏನ್ 3 ತಿಂಗಳಲ್ಲೇ ಸತ್ತಿದಳ? She committed suicide in the house of Husband, in the house of the husband. ಅದೇನೋ ಕಾಲ್ ಡೀಟೇಲ್ಸ್ ಏನೋ ಹೇಳಿದ್ನಂತ. Before committing the suicide, I think she called her parents. Where is the call details?
I'm going to.
ಅದಾದ್ಮೇಲೆ ಅದೆಲ್ಲ ಮ್ಯಾಟರ್ ಆಫ್ ಇದು. ಬಟ್ ಏನ್ಲಿ ಪ್ರೈಮ್ ಆಫೀಸ್ ಇದೆಯಲ್ಲ ನೋಡ್ಬೇಕು ಅಷ್ಟೇ. ಅಲ್ಲ ಬಿಫೋರ್ ಕಮಿಟಿಂಗ್ ದಿ suicide, if she calls and makes the about the harassment meted out to her, if suddenly she takes the
On 6/6/2021 at 1 p.m. ಅಂದ್ರೆ ಮಧ್ಯಾಹ್ನ 1 ಗಂಟೆ 6 ನಿಮಿಷಕ್ಕೆ daughter has called the
mother or father?
Father. In the complaint also there is a recital about the father.
ಅದಿದೆ ಅದು ಕಾಲ್ ಮಾಡಿದ್ರು ಅಂತ.
ಸೊ ಅದು ಕೂಡ ಇದೆ. ಕಾವ್ಯ ಅವರಿಗೆ ಕಾಲ್ ಮಾಡಿ ಅವರಿಂದ ತಿಳ್ಕೊಂಡೆ ಅಂತ ಹೇಳ್ತಾರೆ. ದಟ್ ಎಕ್ಸ್ಟೆಂಟ್ ಆಲ್ಸೋ ದೇರ್ ಇಸ್ ಎ.
What time she committed suicide? 3 o'clock. Between 3 to 4 p.m. Between 3 to 4 p.m. ಈಗ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆಯಾ? ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾರಾ? ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾರಾ? ಮೆಟೀರಿಯಲ್ ನೀವು ಕೋರ್ಟ್ ಹಾಕಿದೀರಾ? ಚಾರ್ಜ್ ಶೀಟ್ ಮೆಟೀರಿಯಲ್ ಕೊಡೋದಾದ್ರೆ ನೋಡ್ತೀನಿ, ಅದನ್ನು ನೋಡ್ತೀನಿ. ನೀವು ಕೊಡೋದಾದ್ರೆ, ಇಲ್ಲ ಅಂದ್ರೆ ಈಗ ಹಾಗೆ ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ರೆ ಮಾಡ್ತೀನಿ. ಏನ್ ಮಾಡ್ತೀರಿ ಹೇಳಿ? ನೀವು ಕೊಟ್ಟರೆ ಮೆಟೀರಿಯಲ್ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಐ ವಿಲ್ ಪಾಸ್ ಆರ್ಡರ್ಸ್. ಅದರ್ವೈಸ್ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? ನನ್ಗೆ ಗೊತ್ತಾಯ್ತು. ಈಗ ಚಾರ್ಜ್ ಶೀಟ್ ಮೆಟೀರಿಯಲ್ ಇದೆ. ಚಾರ್ಜ್ ಶೀಟ್ ಮೆಟೀರಿಯಲ್ ಮದುವೆ ಎಲ್ಲಾರಾಗ್ಲಿ ಪಿಂಟೋರೆ, ನೀವು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿ. ಕ್ರೈಮ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ, ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ. If you want to place the charge sheet material, I will give you an opportunity, or otherwise I will dictate as of now as per the records. Submit ಮಾಡ್ತೀರಾ? ಆಯ್ತು. Petitioner counsel submits that the police have already completed the investigation and filed the charge sheet and seeks time to place the ಕೊಟ್ಟಿಲ್ರಿ. ಚಾರ್ಜ್ ಶೀಟ್ ಮೆಟೀರಿಯಲ್ ಏನು ಇಲ್ವಲ್ಲ, ಏನೋ ಹಾಕಿಲ್ಲ ರೀ. And hence permitted to place the charge sheet material. ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಹರ್ಡ್ ಇನ್ ಪಾರ್ಟ್ ಅಂತ ಹಾಕೊಳ್ಳಿ. this matter on Saturday ಹಾಕೊಳ್ಳಿ, ಫ್ರೈಡೆ ಹಾಕೊಳ್ಳಿ. ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ 25th. ಪಾರ್ಟ್ ಎಲ್ಲ ಮುಗಿಸ್ಕೊಳ್ಳೋಣ. ಅವತ್ತು ಯಾವ ಇರ್ತಾವ ನೋಡ್ಕೊಂಡು ಆಮೇಲೆ ಮತ್ತೆ ಬೇರೆ ರೋಸ್ಟರ್ ಕೊಟ್ಟಾಗ ಇದಕ್ಕೆ ಟೈಮ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗೋರು ಕಷ್ಟ ಆಗ್ತದೆ. 33 ನಾಮತ್ ಪಾಸ್ ಓವರ್. 34 ಗೋಪಾಲ್ 8. ಹೇಳ್ರಿ ಗೋಪಾಲ್, ಏನು ಇದ್ಯಾಕೆ 2 ಪಿಟಿಷನ್ A8 ಇದೆಯಲ್ಲ ಟೈಪಿಂಗ್, ಬಟ್ ಒಂದೇ ಕ್ರೈಮಾ? ಈ A8 ಅಂತಿದೆ. ಯಾವ್ದ್ರಲ್ಲಿ ನನ್ಗೆ ಹೆಸರು ಬೇಡ. ನಿಮ್ ಫಸ್ಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಯಾರು? A8. ಈ ಸೆಕೆಂಡ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಯಾರು? A11. ಆಯ್ತು ಹೇಳಿ. both are in respect of the same crime. ಹೇಳಿ. ಓಕೆ, 230 ಒಂದು ಬೆಂಚ್ ಬೇರೆ ಇದೆ ರೀ. ಮತ್ತೆ ಬೆಂಚ್ ಆಯ್ತು, ಬನ್ನಿ. 230 35 ಸೇಮ್ ಕನೆಕ್ಟೆಡ್ ಎರಡು. 36 ಚಂದ್ರಕುಮಾರೇಗೌಡ ಬರೋದೇ ಇಲ್ಲ. ಡಿಸ್ಮಿಸಲ್ಗೆ ಅಂತ ಇಟ್ಟಿದ್ದೀನಿ, ನೋಡೋಣ. ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಸಂಜೆ ಒಳಗೆ ಡಿಸ್ಮಿಸ್ ಮಾಡೋಣ. 37 ರಕ್ಷಿತ್ ಬೆಳಗ್ಗೆ ಏನೋ ಮೆನ್ಷನ್ ಮಾಡಿದ್ರಲ್ಲ ಇದರಲ್ಲಿ. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಟೆಸ್ಟೆಡ್ ಪಾಸಿಟಿವ್, ಇವತ್ತೇನು A10 ನೀವು ರಿಸೀವ್ ಮಾಡಿದೀರಾ? ಹೇಳಿ, ನಿಮ್ ಹೆಸರು ಹೇಳಿ. ಹಾಕಿದ್ರ NOC ವಕಾಲತ್ತು? ಆಯ್ತು, ನಿಮ್ ಹೆಸರು ಹೇಳಿ. Praveen Kumar NK submits that he has received the NOC wakalat from the earlier advocate and going to file the same in the office today itself. Show the name of the counsel and list this matter on 28. Post the matter next week. 38 ಹನುಮಂತರಾಯಪ್ಪ ಪಾಸ್ ಓವರ್ ಎಲ್ಲ ಮಾಡಿ ಯಾವಾಗ ಮೇಡಮ್ ಮಾಡೋದು? ಎಲ್ಲ ಪಾಸ್ ಓವರ್ ಆದ್ರೆ ಆಯ್ತು, ಪಾಸ್ ಓವರ್. ನೆಕ್ಸ್ಟ್ ಅಗೇನ್ ಜಗದೀಶ ಹೆಚ್. ಇದೇನ್ರಿ 439(2) ಅಲ್ವಾ? ಕ್ಯಾನ್ಸಲೇಷನ್ ಆಫ್ ಆಂಟಿಸಿಪೇಟರಿ ಬೇಲ್. ಕೊಡಿ ಏನ್ ನೋಡಿ. ಪಾಸ್ ಓವರಾ? ನಿಮ್ಗೂ ಪಾಸ್ ಓವರ್ ಆಯ್ತು. 40 ಮೋಹನ್ ಕುಮಾರ್ ಡಿ. ಎಸ್ ಕೌನ್ಸಿಲ್ ಹೇಳಿ. 302, 201, 342, 364, 120B. ಹೇಳಿ. ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ. ದಿಸ್ ಇಸ್ ದಿ ಪಿಟಿಷನ್ ಬೈ A1 ಅಲ್ಲ, A7. A7 ಅಲಿಗೇಷನ್ ಏನು A7 ಮೇಲೆ? A7 ಸೈಯದ್ ಆಟೋ ಡ್ರೈವರ್. ಹೇಳಿ ಏನ್ ಮಾಡಿದ್ವಿ? ವಿಟ್ನೆಸ್ ಇದ್ದಾರಾ? ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ? CW 4 ಓನ್ಲಿನಾ? ಎಷ್ಟು ಐ ವಿಟ್ನೆಸ್ ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ? 7, 8, 11, 5 ಜನ. ಡೈರೆಕ್ಟ್ ಏನ್ ಹೇಳಿ? ಡೈರೆಕ್ಟ್ ಎವಿಡೆನ್ಸ್ ಇದ್ದಾಗ ಏನ್ ನಿಮ್ ಗ್ರೌಂಡ್ ಏನು? ಆಯ್ತು. ಶೇರಿಂಗ್ ಆಫ್ ಕಾಮನ್ ಆಬ್ಜೆಕ್ಟ್. ಇಂಜುರೀಸ್ ಏನ್ ಹೇಳಿ? ಇಂಜುರೀಸ್ ಎಷ್ಟ್ರಿ? ಜಾಸ್ತಿ ಜನ ಹೊಡೆದಾಗ ಜಾಸ್ತಿ ಏಟ್ ಬಿದ್ದಿರ್ಬೇಕಲ್ಲ. ಮಲ್ಟಿಪಲ್ ಇಂಜುರೀಸಾ? ಕಾಸ್ ಆಫ್ ಡೆತ್ ಏನು ಪೋಸ್ಟ್ ಮಾರ್ಟಮ್ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ? ಹೇಳಿ, ನೀವೇ ಹೇಳ್ರಿ. ಕಾಸ್ ಆಫ್ ಡೆತ್. ಯಾಕಂದ್ರೆ ಇಲ್ಲಿ ಎಲ್ಲ ಏನ್ ಮಾಡ್ತಾರೆ, ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕ್ತಾರೆ, ಹೆಡ್ ಆಫ್ ದಿ ಚಾರ್ಜ್ ಶೀಟ್ ಮಾತ್ರ, PM ರಿಪೋರ್ಟ್ ಹಾಕೋದಿಲ್ಲ. ಮಲ್ಟಿಪಲ್ ಇಂಜುರೀಸ್ ಎಷ್ಟು? ಎಕ್ಸ್ಟರ್ನಲ್ ಇಂಜುರೀಸ್ ಇದೆ 37 ಇಂಜುರೀಸ್. ಅಕ್ಯೂಸ್ ಟೋಟಲ್ ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ? 11 ಜನ. ತಗೊಂಡು A8 ಗ್ರಾಂಟೆಡ್ ಬೇಲ್. ಎಲ್ಲಿದೆ ಆರ್ಡರ್? A8 to 10, A11 ಗ್ರಾಂಟೆಡ್ ಬೇಲ್. ಆರ್ಡರ್ ಕಾಪಿ ಹಾಕಿದ್ದೀರಾ? ಕೊಡಿ. ಏನ್ ರೀಸನಿಂಗ್ ಏನು ಬೇಲ್ ಕೊಡುವಾಗ? ಜಾಯಿಂಟ್ ರಿಕವರಿ. ಅದು ಏನ್ ರೀಸನಿಂಗ್ ಏನು? ಬೇಲ್ ಗ್ರಾಂಟ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಕೋರ್ಟ್ ರೀಸನಿಂಗ್ ಕೊಡಬೇಕು. ಆ ರೀಸನಿಂಗ್ ಏನು?
ನನ್ನ ಬಳಿ ಇದ್ದ ಚಾಕುವಿನಿಂದ ನನ್ನ ತಮ್ಮ ಮೊಹಮ್ಮದ್ ತನ್ವೀರ್ ಅಲಿಯಾಸ್ ಸಾಯಿಸುವ ಉದ್ದೇಶದಿಂದ ಎದೆಯ ಮೇಲೆ ಹೊಡೆಯಲು ಹೋದಾಗ ತಪ್ಪಿಸಿಕೊಂಡಿದ್ದು. ಆದ ಕೈಯನ್ನು ಅದನ್ನು ಅಡ್ಡಾತದಿಂದ ಎಡಮುಕೈ ಬಳಿ ಗಾಯವಾಗಿರುತ್ತದೆ ಮತ್ತು ಮತ್ತೊಮ್ಮೆ ಎದೆಯ ಮೇಲೆ ಚುಚ್ಚಲು ಹೋದಾಗ ತಪ್ಪಿಸಿಕೊಂಡು ಆಯಟ್ಟು ಬಲಭಾಗದ ಎದೆಯ ಮೇಲೆ.
ಆಯ್ತು. ಏನ್ ರೀಸನಿಂಗ್ ಏನು? ಕೋರ್ಟ್ನವ್ರು ಬೇಲ್ ಕೊಟ್ಟವ್ರೆ ಅಂದ್ರೆ ನೀವೀಗ A8, 10, 11ಗೆ ರೀಸನಿಂಗ್ ಏನು? ಯಾವ ಗ್ರೌಂಡ್ ಮೇಲೆ ಕೊಟ್ರು? ಯಾಕೆಂದ್ರೆ ಐ ವಿಟ್ನೆಸಸ್ ಎವಿಡೆನ್ಸ್ ಇದೆ. ಮಲ್ಟಿಪಲ್ ಇಂಜುರೀಸ್ 37 ಇದೆ. ಎಲ್ಲ ಅಟ್ಯಾಕ್ ವಿತ್ ಕಾಮನ್ ಆಬ್ಜೆಕ್ಟ್. ಐ ವಾಂಟೆಡ್ ಟು ನೋ ದಿ ರೀಸನ್ ಫಾರ್ ಗ್ರಾಂಟಿಂಗ್ ಬೇಲ್. ನಾವು ಸ್ವಲ್ಪ ಎಕ್ಯೂಪ್ ಆಗೋಣ ಅಂತ. ಆಯ್ತು, ಜಾಯಿಂಟ್ ರಿಕವರಿ. ನಾವು ಸ್ವಲ್ಪ ಎಕ್ಯೂಪ್ ಆಗೋಣ ಅಂತ ಬೇಲ್ ಕೊಡೋದ್ರಲ್ಲಿ. ಹಾಕಿದಿರಾ? ಹೋಗ್ಲಿ, ನಾನೇ ಓದ್ಕೋತೀನಿ. ಎಲ್ಲಿದೆ ಕಾಪಿ? ಹಾಕಿದಿರಾ? ಕೊಡಿ ಹೋಗ್ಲಿ. ಈ ಕೋಟ ಟ್ರಯಲ್ ಕೋಟ ಕೊಟ್ಟಿರೋದು. Admittedly, investigation is completed and charge sheet is filed. Therefore, detention of the petitioner in custody amounts to pre-trial punishment. Aita, this is the reason. Accused number 11 are similar to those already ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ ಬೇಗ, ಅದರಿಂದ ನಾನು ಬೇಲ್ ಕೊಡ್ತೀನಿ ಅಂತ ಇನ್ನೊಂದ್ರಲ್ಲಿ. This is the reason. Eyewitness evidence ಇದ್ದಾಗ brutal attack ಇದ್ದಾಗ 37 ಇಂಜುರಿ ಮಾಡಿದಾಗ ಕಣ್ಣು ಮುಚ್ಕೊಂಡು ಬೇಲ್ ಕೊಡೋದು. However, there is no recovery at the instance of the present petitioner. Investigation is completed and charge sheet is filed. ಇವನಿಂದ ಏನ್ ರಿಕವರಿ ಇದೆ ರೀ? 2 ಮಚ್ಚು. ಆಟೋ ಇವಂದೇನಾ? ಬಟ್ ಆಟೋ ಇವನ್ ಕಡೆಯಿಂದ ಹೆಂಗ್ ರಿಕವರಿ ಆಗುತ್ತೆ? If auto belongs to someone else, he was the driver. He only drove the vehicle at the time of committing the murder. Auto rickshaw na, ಹೌದಾ? ಆಟೋ ರಿಕ್ಷಾದಲ್ಲಿ ಹೋಗಿರೋದು. ನೋಡಿ.
All the witnesses specific allegation.
ಏನು ನೀವೇನ 4 ಅಂತ ಓದಿದ್ರಿ?
Other witnesses
ಆಯ್ತು. ವೋಟ್ ಆಕ್ಟ್ ಬಗ್ಗೆ. For the petitioner, counsel and also the counsel appearing for the state. The factual matrix of the case of the prosecution is that 11/12/2020, the complainant made an allegation that on the same day at 6 p.m. when the deceased was changing the auto tire at Bharat Nagar. At that time, the accused persons came in an auto rickshaw by forming an unlawful assembly with deadly weapons and committed the murder of the deceased. Hence, police have registered the case and investigated the matter and filed the charge sheet. CW 7, 8, 9, 10, 11. Akin Bunche, 4 also. 4, 7, 8, 9, 10, and 11 also the eyewitnesses to the incident. Recovery is also made. And after the completion of the investigation, the police have filed the charge sheet. The counsel appearing for the petitioner would submit that this court already granted bail in favor of accused number 8, 10, and 11. And this petitioner also placed similarly. And also there are 11 accused persons. An investigation has been completed and charge sheet is filed. There is no need of custodial trial. Any other ground ಅಷ್ಟೇನಾ? ಬೇರೆ ಏನಾರು ಇದೆಯಾ ನಿಮ್ದು? And this petitioner is falsely implicated in the case and he has been in custody from 18/12/2020. Hence, he may be enlarged on bail, ready to obey the conditions that may be imposed by this court. According to the counsel appearing for the state would submit that CW 4, 7, 8, 9, 10 have categorically stated the overt act of this petitioner that he had inflicted. He had tried to inflict the injury on the chest. And when the victim tried to ward off the said blow, at that time he had sustained injury to his head and hand. And then once again he tried to inflict the injury on the chest. And he tried to escape from the blow. As a result, he had sustained injury to right side of the chest. Right side of the chest. And the statement of these eyewitnesses is consistent against this petitioner. The counsel also submits that this petitioner only drove the vehicle to spot along with other members of unlawful assembly, and all of them came with deadly weapons and mercilessly inflicted injury. As a result, the victim has sustained 37 injuries. The cause of death is also on account of multiple injuries sustained by the victim. Then there is a prima facie case. The counsel also would submit that the very same auto rickshaw which this petitioner drove the vehicle to the spot also recovered at the instance of this petitioner, and also the weapon which was used for committing the murder also recovered at the instance of the petitioner. Hence, there is a prima facie material against the petitioner. Having heard the respective counsel and also on perusal of material, And the prosecution case is that when the deceased trying to change the tire, all of the assailants came with an auto rickshaw with the deadly weapons and mercilessly inflicted the injury and committed the murder. This incident is witnessed by CW 4, 7, 8, 9, 10, and 11. And apart from that, recovery is also made at the instance of this petitioner. The very allegation against this petitioner, only he brought the assailants in the auto rickshaw, driving the same. And also he inflicted injury with a knife. And also specific statement of eyewitnesses that with an intention to take away the blow, he tried to give blow on his chest. And in this regard, when the victim tried to ward off that blow, he had sustained injury to hand as well as his right chest. The cause of death is also on account of multiple injuries sustained by the victim, that is 37 injuries. The act of the assailants is nothing but bloodthirsty. When such being the case, it is not a fit case to exercise the powers under section 439 of CRPC only on the ground that he has been in custody from last 1.5 years. When the offense of committing the murder, that too by causing multiple injuries, 37 in number. And when this incident is witnessed by CW 4, 7, 8, 9, and 10, not a case for granting bail. The counsel appearing for the petitioner also brought to notice of this court that the accused number 8, 10, and 11 have been granted bail, who are similarly placed. By order dated 22nd day of December 2021 in criminal petition number 9200 of 2021 in respect of accused number 11, wherein an observation is made that no recovery. CW 4 vote act against the petitioner is that he took the knife belongs to the deceased and stabbed him on the chest and fled away. And when there is no any recovery, and also observed that the accused number 8 and 10 have already been enlarged on bail by coordinate bench and hence exercise the discretion. But the factual aspect and allegation against this petitioner, that is vote act. And also there is a recovery at the instance of this petitioner. And hence the same cannot be a precedent to enlarge this petitioner on bail. And court has to take note of the gravity of the offense and the seriousness of allegation made in the complaint and also in the charge sheet. In other two petitions, in criminal miscellaneous numbers 4173 of 21 and criminal petition number 5689 of 2021, granting bail in favor of accused number 8 or 10. 8. The court has observed that admittedly the investigation is completed and charge sheet is also filed, and therefore detention of the petitioner in custody would amount to pre-trial punishment. And in other case also, is made. That is accused number 10. And vote act allegation against accused number 8, 10, 11 is different from the present petitioner. And apart from that, when heinous offense of committing the murder with the common object, in furtherance of the said common object, mercilessly inflicted the injury. As a result, 37 injuries are occurred. Court has to take note of the gravity and also the seriousness of the offense. The apex court in the judgment reported in criminal appeal number 571 of 2021, Kumar Singh versus State of Rajasthan and another, reported in 2021-6, SCJ 227. In a case of committing the murder with unlawful assembly with the common object and in furtherance of common object. While cancelling the bail granted by the High Court, the Apex Court in paragraph number 14 held that it is required to be noted that all the accused are charged for the offences punishable under section 302 and 307, read with section 149 of IPC. While cancelling held that at this stage, the individual role of the accused is not required to be considered when they are alleged to have been the part of the unlawful assembly. The Apex Court also observed that there were 26 injuries found on the dead body of the deceased, and 11 injuries on the injured Vikram Singh by blunt and sharp weapons. That is, who had sustained the injuries. Further observed that merely because they were armed with lathis cannot be a ground to release them on bail. Further observed that in the circumstances of the case, considering the facts, more particularly when they are charged for the offences punishable section 302 and 307, read with section 149 of IPC, as well as section 147 and 148 of IPC, the court has to take note of gravity of the offence and seriousness of allegation made in the charge sheet. When they are the part of unlawful assembly, the court ought not to have exercised the discretion granting bail. Having considered the principles laid down in the judgment referred supra, even though the Court Act is different in respect of each of the accused persons, and the same cannot be a ground to enlarge the petitioner, and hence the orders passed by this court in exercising the discretion in favor of accused number 8, 10, and 11 not comes to the aid of this petitioner when the specific Court Act allegation is made against this petitioner with deadly weapon knife. And hence, no grounds are made out to enlarge the petitioner on bail. In view of the discussion made above, I pass the following order: bail petition is rejected. ನೋಡಿ ಕೊಟ್ಬಿಡಿ ಇವೆಲ್ಲ ಆರ್ಡರ್ ಕಾಪೀಸ್ ಕೊಟ್ಬಿಡಿ ಯಾರು ಅಡ್ವೊಕೇಟ್ ಹೋದ್ರಾ ಇಲ್ಲ ರೆಕಾರ್ಡ್ ಎಲ್ಲ ಇಟ್ಕೊಬಿಡಿ. ಹಾಕಿದಾರ ಯಾರು ಹಾಕಿರೋದು? ರಕ್ಷಿತ್ ಇದೀರಾ? ರಕ್ಷಿತ್ ಅವರು
appear for the petition in night number 41.
ಆಯ್ತು, ಎಸ್ ಕೌನ್ಸಿಲ್ ಹೇಳಿ ರೆಡಿ ಅಲ್ಲ? ನಿಮ್ಮ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ? ಅಬ್ಜೆಕ್ಷನ್ ಕಾಪಿ ಸರ್ವ್ಡ್.
Yes, yes.
ರೆಡಿ ಅಲ್ಲ ಕೌನ್ಸಿಲ್?
Yes, my lord, I received. My lord, I am challenging the
ಏನು ಸಬ್ಮಿಷನ್ ಹೇಳಿ. ದಟ್ ಈಸ್ ಆಲ್ಸೋ ಫಾರ್ ಕ್ಯಾನ್ಸಲೇಷನ್ ಆಫ್ ಬೇಲ್. ಯಾವಾಗಿದೆ ಅದು? ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಅಂತಂದ್ರೆ ಏನಾಗಿದೆ? ಯಾವ ಸ್ಟೇಜ್ ನಂಬರ್ ಇದೆಯಾ? ನಂಬರ್ ಕೊಡಿ, ಒಟ್ಟಿಗೆ ತಗೊಳ್ಳೋಣ, ಒಟ್ಟಿಗೆ ಮಾಡೋಣ. ಎರಡು ಸಪರೇಟ್
No, my lord, we are not pressing that case, my lord.
ನೀವು ಯು ಆರ್ ನಾಟ್ ಪ್ರೆಸಿಂಗ್. ಆಯ್ತು, ಅದನ್ನ ನಾವು ಪ್ರೆಸ್ ಮಾಡಲ್ಲ. ಆಯ್ತು ಹೇಳಿ. ಎಸ್ ಕೌನ್ಸಿಲ್ ಹೇಳಿ. ವಾಟ್ ಆರ್ ದಿ ಗ್ರೌಂಡ್ಸ್ ಆಫ್ ಬೇಲ್?
My lord, your lordship may kindly see page number 27, my lord, the order of the London magistrate, my lord. From para number 3, my lord.
439(2). Bail granted under section 438 or 439?
437, my lord.
439. 437 or 439?
437, my lord. Yes, my lord.
By the magistrate himself.
Magistrate himself are granted, my lord. Your lordship may kindly see page number 27, my lord.
First, what are the offences? What are the offences, counsel?
Offences are under 419, 420, and section 66C and section 66D of IT Act, my lord. But the Butts Act is also attracting in the present case, my lord. It is not invoked.
Yes, counsel.
Your lordship may kindly the order passed by the land magistrate. My lord, from para number 3, your lordship may kindly see, my lord, the learned APP filed objection that the accused has cheated more than 2,500 members, about 1,500 crores, and given assurance that 45% amount will be given as an additional and cheated without giving any amount to the complainant. The said offense is non-bailable in nature and is punishable up to 7 years. If the accused number 1 is released on bail, he may possible to continue the alleged offense and also absconding the fear of the punishment and might have tampered the prosecution witness. Hence, the prayers to reject the bail, my lord. Then your lordship may kindly see the reasons, my lord. Para number 7. On perusal of the record, it is clear that the complainant police has registered the case against the accused number 1 to 12 for the offence punishable and so and so. Though the offence alleged against the accused number 1 is non-bailable and not punishable with death or life imprisonment and trialable by this court, the investigation officer has taken custody of the accused number 1. It shows that he has completed almost his investigation. My lord, that's the first reason. And in this case, the Honorable High Court of Karnataka has granted anticipatory bail to the accused number 2 to 6. That is second reason, my lord. And in this case, the accused number 1 is suffering from COVID-19 disease and provided clause 37 CRPs. Even if the accused is committed the offences punishable with death and imprisonment of life, or previously convicted on 2 or more occasions and punishable for imprisonment of 3 years or more, but not less than 7 years, be released on bail if such person is under the age of 16 years or a woman or sick, my lord. My lord, these are all the 3 reasons granted given by the learned magistrate, my lord. Your lordship may kindly see page number 53, my lord. That is the order passed by this honorable court which the learned magistrate was referring, my lord. Page number 53.
53.
My lord, the reason, my lord, the reason is in page number 57.
Reasoning. Go to reasoning.
PT 57, my lord.
57.
Para number 7. A reading of the FIR and allegation leveled in the complaint indicate that the material allegation constituting the above offence are directed only against Avon. But learned magistrate found that they are already granted bail, and this is the reason, one of the reason for releasing the accused on bail, my lord. And for the other 2 reasons, my lord, your lordship may kindly see there are certain admitted facts in this case, my lord. In 2018, the Reserve Bank had my lords.
Yes, I am hearing.
2018, the Reserve Bank had quashed the banned all the virtual currency transactions. But later on in 2020, the Honorable Supreme Court has quashed that circular, and 2021 now it is legal, completely legal. Based on that 2018 RBI circular, the accused one had filed a title suit before Calcutta Civil Court, my lord. I had produced in page number 60, my lord. Your lordship may kindly see, my lord. The operative portion from page number 69. May I read, my lord, para number 2? That during the period of 2016-17, the investing in cryptocurrency was in trend, and the plaintiff, with his specialized knowledge, mastered with the art of mining as well as investing in the cryptocurrency market, and use of forward investment tips to his clients over Facebook account, namely Angita Singh, my lord. Your lordship may kindly note. He was a male person, you may name of Shantanu Singha, and he had used the male-female name, and SIPO investment, which though the plaintiff floated different scheme and defended accordingly, traded in coins. Then your lordship may kindly see, my lord, page number 72, my lord, para 16, my lord. That on date of such notification, he had referring to the Reserve Bank notification, my lord, just banned all the transaction in 2018, my lord. The unit of cryptocurrencies of the defendants laying with the plaintiff as per the available data is as follows. My lord, serial number 6 and 7, serial number 6 is the complainant and serial number 7 is Leelavati Anjanappa. He had stated in the title suit that almost 7 units of bitcoins are lying with him. He had admitted the fact. Then your lordship may kindly see page number 74, my lord. Second last paragraph. That defendant number 6
what happened in this suit, counsel? What happened in this suit?
My lord, is still pending because in 2018 the Reserve Bank had banned all the cryptocurrencies. But later on 2020, the Honorable Supreme Court got quashed that circular. The ground was that
now they made it as legal, and
now
in
it is
this budget
completely
also
legal.
made taxable, 30% of tax.
Yes, my lord, is correct, my lord. Second last paragraph in page number 74, my lord. Your lordship may kindly see. That defendant number 6 had filed a criminal case against the plaintiff and his family members and other relatives, and he has also threatened the plaintiff and a small implicate and plaintiff and his relative in false criminal case, and accordingly filed a criminal case before the cyber police station, case number 5615 of 2019, dated 11/7/2019, my lord. Prior to filing
Counsel, now you sum up the argument.
Yes, my lord.
Invoking of section 439(2).
Yes, my lord.
Matter is pending.
Yes, my lord. And this same the petition has been the petitioner, the respondent had also on this, my lord. And the my grounds are 8 grounds are made, my lord. First one is that there are certain admissions in the case, my lord, by the title suit.
What are
Second
those
one,
admissions?
My lord, he had
What are
already
those admissions,
admitted.
counsel?
My lord, he had already admitted in the title suit that he had taken the bitcoins from the plaintiff, from the complainants. He had created a fake name of Agita Singh, and he had accepted that. All these things we accepted admitted in the title suit, my lord, which had filed in the Honorable City Civil Court, Calcutta, my lord. Second, my lord,
Yes.
one more document, my lord, that is in page number 107, my lord. That is the order of the City Civil Court, Ahmedabad, my lord. The page number 109, kindly. My lord, this is a bail application filed by the same accused, my lord. It was rejected by the City Civil Court, Ahmedabad, my lord. Your lordship, kindly have a look at para number 5, my lord, in 109, page number 109.
He is making submission. I will give you an opportunity to you also. Bail application was rejected. Yes.
My lord, para number, your lordship, kindly have a look at the observation made, my lord. Looking to the role of the present application, present applicant accused has committed a fraud of 47 lakhs toward the complainant by tempting him to invest in the cryptocurrency. Hence, there is an active role of the present applicant accused in the alleged offense for cheating and criminal Punjab trust. It is further trespass that the present application accused belongs to the state of Kolkata. Hence, there is every possibility that he may abscond from the procedural law and he will not present the time of trial. Moreover, the present applicant accused is a habitual offender, and several cases are registered against him regarding the cheating, my lord. The same was challenged before the Honorable High Court of Ahmedabad, my lord, by page number 11, my lord, 111, my lord.
111, Annex M.
And after hearing the matter, they had withdrawn the petition with liberty to approach the appropriate forum after filing the charge sheet, my lord. My lord, in this case, the complaint was filed in 11/7/2019, my lord. And for the till 2021, he was absconding. He was arrested from a hotel in Delhi. He was arrested in a hotel in Delhi, my lord. And if your lordship may see the bail conditions, not even a condition to surrender the passport is there. He's a man sitting with 1,500 crore rupees, my lord. And there is not even a condition to surrender the passport. My lord, the and another important aspect is that not even a recovery is made. No recoveries are made in this case till date, my lord. That means he is not cooperating with the investigation. My lord, several cases has been registered against him. In fact, he himself in the title suit has admitted that there are several victims are there. My lord, my grounds are there. There are 8 points I have made out, my lord. First one is that there are specific admissions are made in the title suit, which at the time of 2018, no, he himself have made that. That is an admissible evidence, my lord, even if it is go to the trial, my lord. And he said habitual offender. That is second point, my lord. Third one is that he was an absconder and he was not even cooperating with the investigation agency. And from 2021, he was arrested from a 5-star hotel in Delhi after 2 years. And fourth point is, my lord, not even the passport is been surrendered, my lord, and the learned magistrate in the condition he are not incorporated that ground also, my lord. Third, the fifth point is that, my lord, he himself is admitting that he's having all these bitcoins, everything of the innocent people, my lord, but no recoveries. He are not cooperated with the investigation team for recovering all these things, my lord. Next point is that, my lord, even as per the prosecution case itself, there are 2,500 people are there, victims are there. The total value comes with 1,500 crore rupees, my lord. And with a man sitting with 1,500 crore rupees can easily tamper any witness and evidence, my lord. And another important aspect, my lord, out of 12 accused, my lord, only 6 accused has appeared before this honorable court. 6 accused in the same case are still absconding. That is A7 to A12 in the case, my lord. My lord, and the final point is that, my lord, that is very important, my lord. Your lordship may kindly see the address that has been given in the before the Ahmedabad Sessions Court and also in the
Make it short, counsel. Make it short.
that address itself is wrong, my lord. He is not even
Ala-
providing a correct address of it.
Allahabad court, what address he has given?
My lord, Allahabad High Court in page number 107, my lord, that is address is 4/1 Durga Charan Doctor Road, Indilia, Kolkata. That is his address.
But the petitioner before the Allahabad court is different. Shantanu Ravi Rajiv
Same.
Ranjan Sinha. Huh?
Same only, my lord. One and same.
But here Venkatesh Murthy. Before this court is Venkatesh Murthy.
No, my lord. In the Allahabad High Court, Allahabad Court is the accused as the petitioner. Here the de facto complainant is the petitioner, my lord. And also, my lord.
Here is accused. Shantanu Sinha.
My lord, in the title suit which he had filed in Kolkata, he had stated the address as some other address, my lord.
Different address. That's all. Next 439. Yes, comes.
My lord, your lordship may kindly direct my learned friend to use the mic, my lord. I cannot hear him.
Mic use ಮಾಡ್ಬೇಕಂತ ಅವ್ರು ಕೇಳ್ತಾ ಇಲ್ಲ ಅಂತ.
Two questions before this. Order passed with the magistrate.
Only 439(2) will be invoked. One is if the trial court has not considered the gravity and seriousness of the offense. If an other court is violation, but here not the violation. Only you restrict your argument regarding whether the order is perverse or capricious or not. So,
The fact, the order was passed after hearing both the sides. Here in the complaint was filed for offense section 420, 419, 66C and 66D of the IT Act. Admittedly, section 419, 66C and 66D, they are available in this.
right.
Coming to section 420, my lord, court has observed he was taken to police custody. My lord, the question of arresting him in Delhi does not arise. But because he was arrested by another police station, Bangalore jurisdiction.
Well, I3 ground head consider ಮಾಡಿದಾರಾ ಇಲ್ಲ ಅಂತ in case. His case is the court failed to consider the gravity of the offense and perverse order is passed ಅಂತ. Whether it is perverse or not. You substantiate the order passed by the trial court. That's all. Reasoning, first of all, one reason is given that A2 to 6 are already granted bail. But this court, while granting the bail, made an observation that main allegation is against accused number 1. That is contrary to the order passed by this court. Howda? That is one ground.
Yes, however, accused number 2 to 6 have been granted bail by the Honorable High Court.
That is the reasoning given by the trial court.
And he also states he was returned to police custody for a period of 14 days. But on that ground, he says the investigation should have been almost completed. Those are the two grounds which have been observed in the learned magistrate.
Whether the court, while granting the bail, considered the allegation made in the complaint?
Yes, the allegation which was made in the complaint.
You read the order of the impugned. Trial court. Is there anything is considered regarding gravity of the offense and allegations made in the complaint?
First, I would first read the reasons, then
only even if the accused is committed to the offences punishable with death or imprisonment for life or previously convicted on 2 or more occasions and punishable with imprisonment 3 years or more, but not less than 7 years, be released on bail if such person is under the age of so and so. And also the COVID reasons. These are the reasons given by the trial court. Maybe tested positive. Almost in the country, almost 75% of people have knowingly tested positive. Unknowingly, almost 90%. Is it a reason for granting bail? ಜಾಸ್ತಿ ಬೇಡ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನ ಇನ್ನೊಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಹೇಳಿದ್ದಾರೆ 2022 ನಲ್ಲಿ ಆಯ್ತಾ ಇನ್ ಎ ಕೇಸ್ ಆಫ್ ಫ್ರಾಡ್ ಇದ್ದಾಗ 2021 8 Supreme Court cases same in a case of fraud. Supreme Court says anticipatory bail relevant considerations. Court has to consider the nature of offense, role of the person, likelihood of his influencing the course of investigation and tampering with evidence, likelihood, and also further says in a case of fraud and also in a case of misappropriation of huge amount when it affects the society at large, court should be ವೆರಿ ಸ್ಲೋ ಅಂತ ಹೇಳ್ತಾರೆ.
The matter of,
Here is a matter of no reasons has been assigned.
Lord, it is a matter of 75 lakhs, my lord, it's been alleged in the complaint.
ಆಯ್ತು. 75 lakhs according to is
Lord,
a
it was
small amount.
My lord, it was invested in the form of bitcoins, not in the form of rupees. My lord, the bona fide of the respondent number 2. my
ಆಯ್ತು, ಬಿಟ್ ಕಾಯಿನ್ಸ್ ಅದು ಚಾಲೆಂಜ್ ಆಗಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನವರು ಸರ್ಕ್ಯುಲರ್ ನೇ ಸ್ಕ್ವಾಶ್ ಮಾಡಿದ್ರಲ್ಲ.
lord, my lord, that is
ಈಗ ನಾವು ಆಲ್ಸೋ ರೆಗ್ಯುಲರೈಸ್ಡ್
not that for the recovery of the said amount, they can file a recovery suit. my lord.
ರಿಕವರಿ ಸೂಟ್,
Cheated.
ನಾಟ್ ಚೀಟೆಡ್.
Not extortionate.
ಆಯ್ತು, ದೊಡ್ಸಾಲಿ ಅವರ ಆರ್ಗ್ಯುಮೆಂಟ್.
Lord, there is one more judgment, my lord.
ಆಯ್ತು, ಹೇಳಿ.
Lord, I would like to bring a lot of-
ಹ್ಮ್ ಹ್ಮ್ ಈಗೇನ್ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ?
Yes, sir.
My lord, a copy of the judgment is not produced. Handed over to me also.
ದೌಲತ್ ರಾಮ್, ಇವೆಲ್ಲ ಸೆಟ್ಲ್ಡ್ ಲಾಗಳು ಯಾವಾಗ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಬಹುದು ಬೇಲ್ ಅಂತ. ಆಯ್ತು, ಹೇಳಿ. ಹಾ,
But same-
ಪ್ರಿನ್ಸಿಪಲ್ ಹೇಳ್ಬಿಡಿ, ಯಾವ್ದು ಪ್ಯಾರಾಗ್ರಾಫ್ ಹೇಳ್ಬಿಡಿ, ನಾ ಬರ್ಕೊಬಿಡ್ತೀನಿ.
Para number
ದೌಲತ್ ರಾಮ್ ಪ್ಯಾರಾಗ್ರಾಫ್
para number 4.
4. ನೆಕ್ಸ್ಟ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಯಾವ್ದು? ದೌಲತ್ ರಾಮ್ ಕೇಸ್. ನೆಕ್ಸ್ಟ್ ಭಗೀರಥಿನ್ ಸಿನ್ಹಾ, ಅದು ಎಷ್ಟು ಪ್ಯಾರಾ ಎಷ್ಟು?
Para number 7.
ಪ್ಯಾರಾ ನಂಬರ್ 7. These early I will read and pass orders. ಯಾಕೆಂದ್ರೆ you are not allowing me to dictate right now. ನೆಕ್ಸ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ದೇವೇಂದರ್ ಕುಮಾರ್, ಪ್ಯಾರಾ
14, my lord.
14. ನೆಕ್ಸ್ಟ್
And by a lordship, my lord.
ಹಾ
Last criminal petition number 4598 of 2020.
ಹಾ ಅದ್ರಲ್ಲಿ ಪ್ಯಾರಾ ಯಾವ್ದು?
Para number 25, my lord.
25. Then
My lord, the judgment, my lord. Para number page number 15.
ಸಾವಿತ್ರಿ ಅಗರ್ವಾಲ್ ಕೇಸ
ಇಲ್ಲ, ಇಲ್ಲ. Page number 59.
59. ಹಾ,
Para number 15 and 17.
59 and ಪ್ಯಾರಾ ನಂಬರ್
15 and 17.
15 and 17. Then
Sorry.
what is the sum and substance of this principles laid down in the judgment?
Same principles, my lord.
That is once bail is granted, the court should be slow in cancellation of bail. And Daulat Ram case, what?
Granting of bail.
Ah.
Cancellation of bail, my lord.
Hmm.
Lord, your lordships have held in your judgment itself.
ಆಯ್ತು ರೀ, ಗೊತ್ತಿರುತ್ತೆ, ಹೇಳಿದೀನಿ, ಮಾಡಿದ್ವಿ, ಹೇಳಿ. ಹಾ, ಅಷ್ಟೇ ಅಲ್ಲ? ಏನ್ರಿ ನಿಮ್ದು ಸ್ಟೇಟ್ ಹೇಳ್ರಿ.
Serious allegation.
Ah.
3,000 people not treated to the 3,000 people.
Ah.
But and also not approximately 1,500 crores not
Hmm.
scam.
Ah.
There are serious allegation in the complaint. The High Court is not considering these aspects, but it was also objection made to the statement of objection, the application of the that has not been considered.
Court reserved. ತೊಗೊಳ್ಳಿ, ಈ ಸೈಟೇಷನ್ಸ್ ಎಲ್ಲ ತಗೊಂಡಿಡಿ. ಏನ್ ಹೇಳಿ? ಹಾ, ಹೇಳಿ.
He says,
ಮುಂದೆ ಹೇಳಿ.
inspectors are there.
ಹಾ,
Filed complaint.
ಹಾ,
My lord, it's an exaggerated complaint. Based upon exaggerated complaint, my lord, the bail has been granted, my lord, by hearing both the sides.
only this court will see whether the trial court has passed perverse order without considering the allegations made in the complaint. That's all.
Looking at the entirety of the case. Not a case for cancellation of bail. My lord, it's a citizen's investigation.
ಅದು ಆಲ್ರೆಡಿ ಹೇಳಿದ್ರಿ, ನಾಟ್ ಎ ಕೇಸ್ ಫಾರ್ ಕ್ಯಾನ್ಸಲೇಷನ್ ಆಫ್ ಬೇಲ್ ಅಂತ. ಆಮೇಲೆ ದೆನ್ ಅದರ್ ದೆನ್ ಏನಾರು ಹೇಳಿದ್ರೆ ಹೇಳಿ, ಬರ್ಕೊಳ್ತೀವಿ. ಅಷ್ಟೇ ಅಲ್ಲ? ನಾಟ್ ರಿಸರ್ವ್.
My lord, I am also producing one judgment, my lord, that is in page number 125, 126 and 127, my lord. I will give you the paragraph numbers.
You have already placed?
Yes, my lord.
Along with petition?
Page number
Along
1.
with petition?
Yes, my lord. Yes. Page number 125, 126 and 128, my lord. Param number 7. Param number 7.4 and param number 7.5, my lord. 7.4 and 7.5. Yes, ma'am.
Yes, counsel. I noted.
But he also submit that will not be within criminal petition number 8768 of 2021. Not that may be taken on.
You have also approached the Allahabad court and Allahabad.
That bail now is challenging the same issued order which was filed with the Honorable High Court. Same claim number. Commencing of argument.
Another.
But same
Huh?
accused number 226 tax paid to bail as High Court.
But the Allahabad High Court order as well as the order of the Allahabad City Court in respect of this crime or different crime?
Different crime.
Different crime.
Same
But
nature,
nature of
different.
similar nature of allegation.
Same cause of action.
Same set of cause of action. Yes.
But he said he will not be pressing criminal petition.
Other petition.
Other petition.
Other petition number. You are not going to press the petition.
8768, my lord. As of now,
8768
of 2021.
2021. You file memo before the registry.
Yes, my lord. Yes, my lord.
File memo before the registry.
Yes, my lord.
Next. 42 Nanjunda Goda.
Acceptable, my lord.
43 Harish Kumar. Pass out.
My lord, appearing for Harish Kumar, my lord.
ಹೇಳಿ
Lord, ಇದರಲ್ಲಿ ಒಂದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ my lord. ಮೆಮೊ ಹಾಕಿರೋದನ್ನ ಇವರು HCGP ಗೆ ಕಾಪಿ
ಮೆಮೊ ಫಾರ್
ಕೊಡ್ಬೇಕು.
ಸೈಟೇಷನ್ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ HCGP ಗೆ ಅಂತ ಅಷ್ಟೇನೆ. ಹೇಳಿ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ರ ಕಾಪಿ ಸ್ವಾಮಿ ಇಲ್ಲ ಪಾಸ್ ಓವರ್ ಮಾಡಿ ಸ್ವಾಮಿ, ಸೀನಿಯರ್ ಬರ್ತಾರೆ
ಪಾಸ್ ಓವರ್ ಆಯ್ತು. ಪಾಸ್ ಓವರ್. 44 ಸುಹಾಸ್ ಬಿ ಸಪ್ಪಣ್ಣನವರ್.
I have already argued the matter. Only 2 points I will.
As well as the copy of the charge sheet in the last station.
ಏನೋ ಚಾರ್ಜ್ ಶೀಟ್
ಪೂರ್ತಿ ಹಾಕಿರಲಿಲ್ಲ.
ಹಾಕಿದಿರಿ ಈಗ ನೀವು ಎರಡು ವಾಲ್ಯೂಮ್ ಹಾಕಿದಿರಿ ಸಪರೇಟ್ ಆಗಿ. ಹೇಳಿ.
My lord, 2 points I will bring to your lordship. Only 2 points, my lord. My lord, I will take your lordship to voluntary statement of.
Last time I think you argued.
I have argued, my lord.
Argument when he produced 2 volumes, then I adjourned it. ಕೊಡಿ ಮೇಡಮ್, ಹಳೆ ನೋಟ್ಸ್ ಇದೆ.
Regarding 120B, I intend to put forth my arguments. Only 1 point.
ಆಯ್ತು ಹೇಳಿ, ಏನು ಹೇಳಿ.
Yes, my lord. My lord, I will take your lordship kind attention to voluntary statement of A3, page 218, my lord. May kindly, your lordship, may kindly.
218,
page 218, my lord. I may permit to read, my lord. A second paragraph.
218.
218, my lord.
218.
The voluntary statement of A3, we said to have paid, given supari. I will.
A2 voluntary statement. What is it?
A3, my lord. We said to have paid supari. I will read para number 2, my lord. ದಿನಾಂಕ 15/12/2020 ಶ್ಯಾಮ್ ಆತನ ಸ್ನೇಹಿತ ಈಗ ಠಾಣೆಯಲ್ಲಿ, ಶ್ಯಾಮ್ ಅಂದ್ರೆ ದಟ್ ಇಸ್ A1, my lord. ಶ್ಯಾಮ್ ಆತನ ಸ್ನೇಹಿತ ಈಗ ಠಾಣೆಯಲ್ಲಿರುವ ವಾಸಂ ವಿನೋದ್ ದಟ್ ಇಸ್ A2 ಎಂಬುವನೊಂದಿಗೆ ಶ್ಯಾಮ್ ಚೆನ್ನೈನ ವಿಜಯಶಾಂತಿ ಅಪಾರ್ಟ್ಮೆಂಟ್ ನ ಆತನ ಫ್ಲಾಟ್ ಗೆ ಬಂದನು. ಸಂಜೆ 6 ಗಂಟೆಯಲ್ಲಿ ನಾನು ಶ್ಯಾಮ್ ಫ್ಲಾಟ್ ಗೆ ಹೋದೆನು. ಶಿ ವೆಂಟ್ ಟು ದಿ ಫ್ಲಾಟ್ ಆಫ್ A1. ಹೋದೆನು. ನಾವು 3 ಜನರು A1, A2, A3, my lord. ನಾವು 3 ಜನರು ಫ್ಲಾಟ್ ನಲ್ಲಿ ಡ್ರಿಂಕ್ಸ್ ಮಾಡಿಕೊಂಡು, ನನ್ನ ಗಂಡನ ಮೊದಲ ಹೆಂಡತಿ ಮಗ ಸಿದ್ಧಾರ್ಥನನ್ನು ನೀನು ನೋಡಿದ್ದೀಯಾ, ಆತನನ್ನು ನೀನು ನಿನ್ನ ಸಹಚರರೊಂದಿಗೆ ಸೇರಿ ಯಾರಿಗೂ ಗೊತ್ತಾಗದ ರೀತಿಯಲ್ಲಿ ಕೊಲೆ ಮಾಡಬೇಕು. ಸಿದ್ಧಾರ್ಥ್ ಸಿಂಗ್ ಬಂದ ನಂತರ ನನ್ನ ಗಂಡ ಹಣಕಾಸಿನ ವಿಚಾರಗಳಲ್ಲಿ ನನಗೆ ಸರಿಯಾದ ರೀತಿಯಲ್ಲಿ ಸ್ಪಂದಿಸುತ್ತಿರಲಿಲ್ಲ. ನಂತರ ಸಿದ್ಧಾರ್ಥ್ ಸಿಂಗ್ ನನ್ನ ಗಂಡ ಇಬ್ಬರು ಬೆಂಗಳೂರಿಗೆ ಬಂದಿದ್ದು, ನಾನು ನನ್ನ ಮಕ್ಕಳೊಂದಿಗೆ ಚೆನ್ನೈಗೆ ವಾಪಸ್ ಬಂದು ನನ್ನ ತಂಗಿ ಫ್ಲಾಟ್ ನಲ್ಲಿ ನೆಲೆಸಿದೆವು. ನನ್ನ ಗಂಡ ಬೆಂಗಳೂರಿನಲ್ಲಿ ಅವರ ಅಕ್ಕ ಶ್ರೀಮತಿ ಅಂಜಲಿ ಗೀತಾ ಅವರ ತೋಟದ ಮನೆ ಹಾಗೂ ಕೋಟ್ಯಾಂತರ ರೂಪಾಯಿ ಬೆಲೆ ಬಾಳುವ ಜಮೀನುಗಳಿದ್ದು, ಆಕೆಯು ಸಹ ಈಗಾಗಲೇ ಮೃತಪಟ್ಟಿದ್ದು. ಆಕೆ ಗಂಡನಾದ ವಿಷ್ಣು ಶಂಕರ್ ಶುಕ್ಲಾ ಅವರ ಹೆಸರಿನಲ್ಲಿ ಇದ್ದು, ಅವರಿಗೂ ಸಹ ವಯಸ್ಸಾಗಿರುತ್ತದೆ. ಅಲ್ಲದೆ ಅವರಿಗೆ ಮಕ್ಕಳ್ಯಾರು ಇರುವುದಿಲ್ಲ. ನನ್ನ ಗಂಡನೇ ಸಹ ಅವುಗಳನ್ನು ತನ್ನ ಹೆಸರಿಗೆ ಮಾಡಿಸಿಕೊಂಡು ಅವುಗಳನ್ನು ಮಾರಾಟ ಮಾಡಲು ಪ್ರಯತ್ನಿಸುತ್ತಿರುವ ವಿಚಾರ ನನಗೆ ನನ್ನ ಗಂಡನಿಂದ ತಿಳಿತು. ಸದರಿ ಜಮೀನುಗಳು ನನ್ನ ಗಂಡನ ಹೆಸರಿಗೆ ಬಂದ ನಂತರ ಸಿದ್ಧಾರ್ಥ್ ಸಿಂಗ್ ಮತ್ತು ಮಗಳಾದ ಋಷಿನಿಗೆ ಬಹುಪಾಲು ಹೋಗಬಹುದೆಂದು, ನನ್ನ ಮಕ್ಕಳಿಗೆ ಇದರಿಂದ ಅನ್ಯಾಯವಾಗಬಹುದೆಂದು ಹೇಗಾದರೂ ಮಾಡಿ ಸಿದ್ಧಾರ್ಥ್ ಸಿಂಗನನ್ನೇ ಕೊಲೆ ಮಾಡಿಸಿದರೆ ನನ್ನ ಮಗ ವಾರಸುದಾರನಾಗುತ್ತಾನೆಂದು, ಹೇಗಾದರೂ ಮಾಡಿ ಸಿದ್ಧಾರ್ಥ್ ಸಿಂಗನನ್ನು ಕೊಲೆ ಮಾಡಿಸಿದರೆ ಆಸ್ತಿಗಳೆಲ್ಲ ನನ್ನ ಮಕ್ಕಳಿಗೆ ಸಿಗುತ್ತವೆ. ಆದ್ದರಿಂದ ನನ್ನ ಹತ್ತಿರವಿರುವ 4 ಲಕ್ಷ ಹಣವನ್ನು ನಿಮಗೆ ಕೊಡುತ್ತೇನೆ. ಜೊತೆಗೆ ನಿಮ್ಮಗಳ ಲೈಫ್ಗಳನ್ನು ನಾನು ಸೆಟಲ್ ಮಾಡುತ್ತೇನೆ. ಸಿದ್ಧಾರ್ಥ್ ಸಿಂಗ್ ಈಗ ಬೆಂಗಳೂರಿನಲ್ಲಿ ವಾಸವಿರುತ್ತಾನೆ. ಎಲ್ಲಿ ವಾಸವಿರುತ್ತಾನೆ ಗೊತ್ತಿರುವುದಲ್ಲ, ಆದರೆ ಆತನ ಕಾರ್ ನಂಬರ್ ಕೆಂಪು ಬಣ್ಣದ್ದಾಗಿದ್ದು, ಅವನು ಭವಿಷ್ಯ ಬೆಂಗಳೂರು ಜಯಶ್ರೀನಗರ ಜಯಮಹಲ್ ಕಡೆಗಳಲ್ಲಿ ಹೆಚ್ಚಾಗಿ ಓಡಾಡಿಕೊಂಡಿರುತ್ತಾನೆ. ಆತನು ಪತ್ತೆ ಹಚ್ಚಿ ಕೊಲೆ ಮಾಡಿ ಎಂದು 25,000 ಕ್ಯಾಶ್ ಅನ್ನು ಶ್ಯಾಮ್ ಅಂದ್ರೆ ಏಮನಿಗೆ ಕೊಟ್ಟು ಬಂದೆ. ಸೊ ದಿ ಕಾನ್ಸ್ಪಿರಸಿ ವಾಸ್ ಹೆಲ್ಡ್ on 15/12/2020.
And also paid the amount of rupees 25,000 through bank.
To A1, my lord. Cash. On that she paid cash. Regarding payment amount, I will put forth only my one submission, my lord. It is the case of the prosecution that A2 paid rupees 2,000 to me. When A2 has paid rupees 2,000, my lord, when on 19/1, when A1, A2, deceased and myself were proceeding on the car en route to Mulbagal, they stopped the car at Vascote and they paid rupees 2,000 to me and asked me and got me down from the car and made me to get down from the car, and they got me boarded to the bus and they sent me to Bangalore with rupees 2,000. That is not called as supari. Next payment 5,000, my lord. 5,000 who has paid? A3. When my lord she has paid, I will just it has come in the voluntary statement of A3 on page number 220. The that is wallet and mobile phone of the deceased were given to me on the at Vascote, and they asked me to hand over the same to A3, and they sent me to Bangalore in the bus. So when I I gave the mobile phone and wallet of the deceased to A3, she paid me ₹5,000. That can't be called as supari, my lord. Next payment is 23,000. When it has been paid, my lord, on 25/1/2021, A1 paid me ₹23,000. By that time, already Siddhartha was murdered. And on that day, I came to know that through A1, I came to know that Siddhartha was murdered. Till then, I was oblivious regarding.
Why you have received an amount of ₹23,000?
Yes, I come to that point. He paid me 23,000, asking me to hush up the belongings of deceased. I will also come to that point. Only for that purpose, he gave me 23,000. Then he informed me, after having paid me 23,000, he informed me that himself and A2 lynched Siddhartha. Then only I came to know. Next, my lord, 20,000 was transferred to my account from the account of Venkata Madhavi on 29/1. My lord, for this payment, I will make my submission is that first of all, Venkata Madhavi is not an accused. Had she been implicated as one of the accused, then it would have been said that it is supari. She is not an accused. 20,000 was paid to me on 19/1. For two things, my lord, it can't be called as supari for two things. That is one, I have already submitted, I came to know about the murder of Siddhartha only on 25/1. So it can't be called as a supari. The second point is that, and it is the case of the prosecution, I was not present there. There's no vote act against me. And whatever the recovery, my lord, that has been done, just I will draw your lordship kind attention to merger dated 25/2/2021. Merger, my lord. On 25/2, I was taken by the police, as per the case of the prosecution. On 25/2/2021, I led the police to the spot. Just I will draw your lordship's kind attention to page number 178. I will, regarding boundaries, my lord, boundaries of this place, that is where I was said to have destroyed the materials. 178, my lord. The merger, one second, my lord, during the course of
178. ಸಿದ್ಧಾರ್ಥಿಗೆ ಸೇರಿದ ವಸ್ತುಗಳನ್ನು ಬಿಸಾಡಿದ ಸ್ಥಳದ ಪಂಚನಾಮೆ.
My lord, that is I come to that. Yes, my lord. Page number 1, relevant page number 181, my lord. Relevant page number 1. Just I will take your lordships to the boundaries of the Panchanama, my lord. 181, my lord. Boundaries: ಪೂರ್ವಕ್ಕೆ ರೆಡ್ಡಮ್ಮ ಫುಡ್ಸ್ ಎಂಬ ಅಂಗಡಿ, ಪಶ್ಚಿಮಕ್ಕೆ ಮಾಧವನಗರ ರಸ್ತೆ, ಉತ್ತರಕ್ಕೆ ಶ್ರೀಮತಿ ರತ್ನಮ್ಮ ಇವರಿಗೆ ಸೇರಿದ ಖಾಲಿ ಜಾಗ, ದಕ್ಷಿಣಕ್ಕೆ ಕಾರ್ಕಳ ರಸ್ತೆ. My lord, the site where I was said to have thrown the belongings of the deceased is a open site. That was two main road. On one side there is a shop. My lord, on 20, it is the case of the prosecution that on 25/1/2021, I threw those belongings of the deceased on the site. Exactly after 1 month, I was said to have led the police to the spot where the police found them intact. My lord, it is an open area between two main roads. It is in the heart of the city of Tirupati.
Yes, counsel, make it short.
It is accessible.
Arguing bail, not the matter on merits.
It is accessible to public, my lord. Anyhow, it is a question of trial, my lord. So the prima facie, I was not present when he was murdered, and I came to know after a week of his murder, I came to know that he has been lynched by A1 and A2. So there is no vote act against me, and my case doesn't stand on the same footing on which the case of A1 and A2 and A3 stands, my lord. And he is in justice since 23/2/2021, and he doesn't have any bad incidents, and it is the only one case in which he has been involved. It was sufficient.
Yes, counsel.
Sir, what is the motive behind
the killing of the deceased Siddharth Singh, where the stepmother, who is accused number 3, hatches an conspiracy along with accused number 1, 2, and 4. She was having an illicit affair with accused number 1, where she accused in her voluntary statement. On 15th of December, they meet up together. They hatch the conspiracy, subsequent to which an amount of 4 lakhs is promised. The first, second, and fourth accused, they come to Bangalore. They meet up in a bar called Bhavani Bar. The CC camera are evident to show that they are together with Chashi notes. Photographs indicate that three of them have sat together, consumed alcohol, subsequently come to the place where the deceased is residing. The third accused is the stepmother.
That is A1, A2, and A4.
A4. A3, who is the stepmother, is also residing in the same apartment. A1 and A4 go up to the apartment when A2 is waiting in the car. They consume alcohol in the house of the deceased, bring him down when he is in intoxicated state. The photographs indicate that A1, A4 bring down the deceased. Subsequently, A2 is sitting in the car, take him, drive away. The toll gates, wherever they have passed from all the way from Bangalore till the Andhra Pradesh border, all the toll plazas have given the photographic evidence to say that the car has traveled. Subsequently, this petitioner, who is accused number 4, is given the mobile phone and the wallet and asked to return back to A3, who is residing at the house. For the reason that they wanted to show that A3, after receiving the phone, makes WhatsApp message to the mother of the deceased, indicating that everything is all right. But the mother suspects because the manner in which the message is sent are not in the manner in which the son would send. Subsequently, goes and asks her in the house of the deceased. She says, accused number 3 says he is not there. He's taken the entire thing and gone. When accused number 4 comes with the wallet and the mobile, the photograph of the CC camera shows that she's taking the wallet and the mobile, in turn giving back the luggage as well as the laptop. The indication was that A4 takes the luggage and laptop and goes away and destroys it. A3, who receives the wallet and the mobile phone, goes to Chennai subsequently, gives it to A1. A1 takes a travel to Hyderabad and makes a call from or sends a message and uses the card in Hyderabad near the Hyderabad airport to suggest that the deceased has taken a flight and gone off to America. There would not be any chances of finding it out. Only the incident happened because the watchman suspected that on that night, 3 of them, 1, 2, and 4, came and took away the deceased. Based on his statement as well as the photograph in the CC camera, investigation started. By the time we came to know that the accused are in Chennai, on 29th, when the investigation team reaches Chennai, accused number 1 commits suicide. Accused number 2 also tries to commit suicide by jumping in front of a train, but then he sustains injury because of others, they stop it. The photographic evidence as well as the medical report shows that he sustained injury. A4 not only conspires with the accused number 1, 2, and 3 to kill the deceased, also meets up prior. He is in the place where the disease is taken away. He is in the car when the disease is being taken away. He helps them by taking away the evidence such as mobile phone and the wallet, comes and gives it to A3, subsequently goes away, destroys the same. He is arrested after 1 month. Subsequently, the call records are indicative of the fact that A4 calls up the A3, who is the person who gave the supari, prior to coming to our house in the early mornings of 19th of January 2021. All records indicate that they have met together, they have exchanged the articles as per phone and wallet, as well as taken the luggage as well as the laptop. His involvement in the crime is from the inception when the conspiracy was hatched till the.
According to you, he was there all along, except at the time of committing the murder. That's your sum and substance of your argument. That's all. Yes.
My 2 points. I am not a party to conspiracy. I was not present at the time when the murder was taken place. And only on the next day on 7:45, it is A1.
CCTV footage alla hakidira?
A1 who called the A3 and informed A3. It has come in the statement. I think that page number 220 that A1 called A3 and informed her that himself and A2 murdered the deceased. And I was not a party to the conspiracy.
How did the petitioner come? The factual matters of the case of the prosecution is that A3 gave supari to accused number 1, 2, 4 and eliminate the victim. and to kill him an amount of rupees 4 lakh and out of rupees 2,25,000 transferred through bank account. And in consequence of that supari, on 19/1/2021 at around 3:30 a.m., A1, A2, and A4 came in the vehicle bearing number AP03CB4034 in a Swift Desire car to Bangalore. Went to the apartment in the victim is staying and made him to consume alcohol. And thereafter he was taken in the very particular car. And they took out the mobile phone and also person. And the same is given to the accused number 4 to hand over the same to A3. And thereafter accused number 1 and 2, the victim murder by using the seat belt. And thereafter body was destroyed. Cremated, and thereafter it was exhumed. It was cremated with an intention to screen the evidence. And the accused number 4, that is petitioner herein, went and met accused number 3 and took the belongings of the deceased and destroyed and thrown the same. And the same is also recovered at the instance of accused number 4 after his apprehension. And the police investigated the matter and filed the charge sheet against the accused persons under section 302, 201, 120B, 364, read with section 34 of IPC. The counsel appearing for the petitioner would vehemently contend that the main contention of the prosecution is that all of them fired each other and also made the payment of rupees 2,000, 5,000 and 23,000 in favor of this petitioner. And the said payment is not in respect of the supari as contended by the prosecution. Also, allegation against this petitioner is that A1 and A2 gave the mobile and wallet belonging to hand over the same to accused number 3. And consequent upon the instructions, this petitioner also hushed up the belongings of the deceased. And recovery is also in a open place. That after the long period, almost more than 1 month. When such being the material, when the petitioner is not present at the spot while taking away the life of the victim, and conspiracy has to be proved only by examining the circumstantial witnesses before the trial court. And there is no any prima facie case against the petitioner herein. The case of the prosecution cannot be believed, and no overt act allegation against this petitioner in taking away the life of the victim. Per contra, the counsel appearing for the state would submit that the motive for eliminating the deceased is that A3 and A1, both of them were having illicit relationship. And amount of rupees 4 lakhs was paid through bank account and also the cash. And also a assurance was given to the accused person to their family. And A1 and A4 only brought the victim from his place, and he was taken in a car. And at that time also A4 was present, and only during the midst of proceeding, he was sent to hand over the wallet and also the mobile belongs to the deceased to accused number 3. And all this material is recorded in CCTV. Footage on the same is also collected. And material on CCTV footage also discloses that A4 has given the mobile as well as wallet to accused number 3. And also took the luggage belongs to the deceased. And the said crime is unearthed only based on the statement of the security guard, watchman. And called details of accused number 4, 3 and other accused also collected during the course of investigation. And hence, even though this petitioner not present at this spot while eliminating the deceased, the other material available before the court that this petitioner is a part of the conspiracy, and also he is the part of taking the victim from the house apartment in which the deceased was staying, and he also the part of in going taking the victim in a car, though he is not present present at the time of eliminating him. All other materials collected by the prosecution substantially shows prima facie case against the petitioner hearing. Having heard the petitioner, counsel and also the counsel appearing for the state, and also considering the factual aspects of the case is concerned, the prosecution mainly relying upon the CCTV footage with regard to taking the victim in a car in which this petitioner and accused number 1 and accused number 2 took the victim. And thereafter, it is also the case of the prosecution that in order to screen the evidence, the wallet belongs to the victim as well as the purse was given to this petitioner, and in turn, he went and gave the same to the accused number 3. The accused number 3 is the architect of committing the murder and who gave the sufari to these accused persons. And the same is also recorded in the CCTV footage, and the same is also collected. And apart from that, the call details of particularly accused number 3 who gave the sufari discloses that call was made in favor of accused number 4 also. No doubt the petitioner was not present at the time of committing the murder, but in all the way from taking him to commit the murder, he was very much present. And thereafter also belongings of the deceased also thrown by this petitioner, and recovery is also made at the instance. He only pointed out the place where he had thrown the belongings of the deceased. When such all materials are available before the court and CCTV footage as well as the call details and other material disclosures, it is not a fit case to exercise the discretion in favor of the petitioner. No doubt the conspiracy has to be proved by examining the circumstantial witnesses, and court also cannot expect the direct evidence with regard to the conspiracy is concerned. It has to be proved only by proving the circumstances. That is, all the accused persons going to the place of the victim and taking him to the taking him in a car and thereafter committing the murder, all is a chain of circumstances, and the same has to be proved. And then there are sound circumstances against the petitioner herein regarding involvement of committing the murder, that too for taking money for committing the murder, that is sufari. And the petitioner is also the part of sufari killer as material collected by the IO, and hence it is not a fit case to exercise the discretion in favor of the petitioner. In view of the discussions, I pass the following order. The petition is rejected. Dhananjay Kumar.
Please, my lord. I appear for the petitioner, my lord.
354, 305, 8 POCSO.
My lord. The petitioner is the sole accused, my lord. The complainant is the father of the deceased. The complaint averment is that, my lord, at page number 9, my lord. I request your lordship to read, my lord, the entire complaint, my lord, one paragraph.
Page number 9.
9 ಅಲ್ಲಿ ತಮ್ಮಲ್ಲಿ ಅರಿಕೆ ಮಾಡಿಕೊಳ್ಳುವುದೇನೆಂದರೆ, ತಾರೀಕು 3/8/2021 ಬೆಳಿಗ್ಗೆ ಸುಮಾರು 10 ಗಂಟೆಯಲ್ಲಿ ನನ್ನ ಮಗಳು ಸುಮಾರು 16 ವರ್ಷದ ತೇಜಸ್ವಿನಿ ಎಂಬುವಳು ನಮ್ಮ ಮನೆಯಲ್ಲಿ ಒಬ್ಬಳೇ ಇರುವಾಗ ನಾನು ಮತ್ತು ನನ್ನ ಹೆಂಡತಿ ಸುಮಾರು 2 ದಿನಗಳ ಹಿಂದೆ ತಮಿಳುನಾಡಿನ ಅಂಚಟ್ಟಿ ಗ್ರಾಮಕ್ಕೆ ಹೋಗಿರುವ ಸಮಯ ನೋಡಿ, ಇದೇ ಗ್ರಾಮದ ಮುನಿವೆಂಕಟಪ್ಪನವರ ಮಗ ಸುಮಾರು 27 ವರ್ಷದ ಮಂಜುನಾಥ ಎಂಬ ವಿವಾಹಿತರು ಏಕಾಏಕಿ ನಮ್ಮ ಮನೆಗೆ ನುಗ್ಗಿ ನನ್ನ ಮಗಳ ಅಪ್ರಾಪ್ತ ವಯಸ್ಸಿನವಳನ್ನು ಬಲವಂತವಾಗಿ ಅತ್ಯಾಚಾರ ಮಾಡಿ ಅವಳು ಕೂಗಾಡಲು ಯತ್ನಿಸಿದಾಗ ಅವಳನ್ನು ಸೀರೆಯೊಂದರಲ್ಲಿ ನಮ್ಮ ಮನೆಯಲ್ಲಿಯೇ ನೇಣು ಹಾಕಿ ಕೊಲೆ ಮಾಡಿರುವುದನ್ನು ನನ್ನ ತಮ್ಮ ಮಹದೇವನ ಹೆಂಡತಿ ಮಂಜುಳಾ ಮತ್ತು ಸದರಿ ನನ್ನ ಚಿಕ್ಕ ಮಗಳು ಸುಮಾರು 12 ವರ್ಷದ ಸತ್ಯಪ್ರಿಯ ಎಂಬುವರು ನೋಡಿ ನಮಗೆ ಫೋನ್ ಮಾಡಿ ವಿಷಯ ತಿಳಿಸಿದರು. ನಾವು ಗ್ರಾಮಕ್ಕೆ ಬರುವಷ್ಟರಲ್ಲಿ ಸದರಿ ನಮ್ಮ ಮಗಳು ಕೊಲೆಯಾಗಿದ್ದು ಮೇಲ್ಕಂಡ ಮಂಜುನಾಥರವರು ಪರಾರಿಯಾಗಿರುವುದನ್ನು ಮನೆಯಲ್ಲಿ ಯಾರು ಇಲ್ಲದ ಸಮಯದಲ್ಲಿ ಸದರಿ ಮಂಜುನಾಥನು ನನ್ನ ಅಪ್ರಾಪ್ತಿಯ ಚಿಕ್ಕ ಮಗಳ ಮೇಲೆ ಬಲವಂತವಾಗಿ ಇದೆ ಐ ವಿಟ್ನೆಸಸ್ ಸಾರ್ ಮಂಜುಳಾ ನಮ್ಮ ಮನೆಯಲ್ಲಿ ಹಾಕಿ ಕೊಲೆ ಮಾಡಿರುವುದನ್ನು ನನ್ನ ತಮ್ಮ ಮಹದೇವನ ಹೆಂಡತಿ ಮಂಜುಳಾ ಮತ್ತು ನನ್ನ ಚಿಕ್ಕ ಮಗಳು ಸುಮಾರು 12 ವರ್ಷದ ಸತ್ಯಪ್ರಿಯ ಮೆಲೋಡ್ he has filed complaint on the basis of the statement of Manjula. I request your lordship to the statement of Manjula at page number 42 ಅವ್ರು ನೇಣು ಹಾಕಿದ್ದನ್ನು ನೋಡಿದ್ದೇನಂತಾನೆ ಹೇಳ್ತಾರೆ. ಇಲ್ಲಿ ಕೊಲೆ ಮಾಡಿರುವುದನ್ನು ಸತ್ಯಪ್ರಿಯ ನೋಡಿ ನನಗೆ ಫೋನ್ ಮುಖಾಂತರ ತಿಳಿಸಿರುವಂತದ್ದು. 42 ಮಂಜುಳಾ ಅವ್ರದ್ದು ಸ್ಟೇಟ್ಮೆಂಟ್. 42
What is the medical evidence, counsel?
ಇದರಲ್ಲಿ ಫೈನಲ್ ರಿಪೋರ್ಟ್ awaited
evidence regarding committing rape on the victim.
ಇಲ್ಲ, ಅದವ್ರು ಹೇಳೋದಿಲ್ಲ ಏನ್ ಮಾಡಿದಾರೆ ಅಂತ. ಇವರು ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲೇ ಆ ಎವರ್ಮೆಂಟೇ ಇಲ್ಲ ನೋಡಿ, ಇದ್ರಲ್ಲಿ ಹೇಳಿರುವಂತದ್ದು ಸ್ವಾಮಿ.
ಸೆಕ್ಷನ್ 8 ಇನ್ವೋಕ್ ಮಾಡಿದ್ದಾರೆ, 6 ಇಲ್ಲ.
ಹೌದು
450 350 305
ಇದ್ರಲ್ಲಿ ಅವ್ರು ಹೇಳ್ತಾರೆ. ದಿನಾಂಕ 3/8 4th ಲೈನ್ ಇಂದ ಓದ್ತೇನೆ ಸ್ವಾಮಿ.
According to them, he committed the rape anta. What is the material for committing the rape? Medical examination ಮಾಡಿದಾರೆ ಅಂದ್ರೆ whether she was subjected to sexual act before committing the murder ಅಂತ. ಮತ್ತೆ ಇದು ಅವಳೆಂಬ ಸುಯಿಸೈಡ್ ಮಾಡ್ಕೊಂಡಿರ್ಬೋದು. ಏನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಯ್ತ್ರಿ, ಅದೆಲ್ಲ ಓರಲ್ ಸ್ಟೇಟ್ಮೆಂಟ್. ಯಾರ್ದಾರ ಒಬ್ಬರ ಮೇಲೆ ಬ್ರಿಡ್ಜ್ ಇದ್ದು ಮಗಳು ನೇಣು ಹಾಕೊಂಡಿದ್ರೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾಡಿಸ್ಬಿಟ್ಟು ಮಾಡ್ಬೋದಾ? ವಾಟ್ ಈಸ್ ದಿ ಪ್ರೈಮಾ ಫೇಸಿ ಮೆಟೀರಿಯಲ್? According to the complaint that they witnessed committing the rape and also hanging her after rape. What is the material? ಆಯ್ತ್ರಿ, ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಯ್ತು. ನಾನು ಕೇಳ್ತಾರ ಅಕಾರ್ಡಿಂಗ್ ಟು ಯು ಸಿ ಇಸ್ ಎನ್ ಐ ವಿಟ್ನೆಸ್. ಹೌದಾ? ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಪ್ರಕಾರ ಐ ವಿಟ್ನೆಸ್ ಅಲ್ಲೇನ್ರಿ? ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಅಪ್ಪ ಅಮ್ಮನಿಗೆ ತಿಳಿಸೋದು ಯಾರು? ಇವರೇನೆ ಅಲ್ವಾ? ಏನಂತ ತಿಳಿಸಿದಾರೆ? ರೇಪ್ ಮಾಡಿ ಮರ್ಡರ್ ಮಾಡ್ದ ಅಂತ. ಹೌದಲ್ಲ? ರೇಪ್ ಮಾಡಿದಕ್ಕೆ ಏನಿದೆ ಮೆಟೀರಿಯಲ್? ಏನೂ ಇಲ್ಲ. ಮತ್ತೆ ದಿ ಕೋರ್ಟ್ ಕ್ಯಾನ್ ಬಿಲೀವ್ ದಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ದಿ alleged eyewitnesses? Be practical. ಮಾಡಿ ಸಾಯಿಸಿದ್ರು ಅಂತ ಅಲ್ಲಿಗೆ ಇವರೇ ತಾನು ಹೇಳಿದವರು. ಮತ್ತೆ ರೇಪಿಗ್ ನೋ ಮೆಟೀರಿಯಲ್, ಅದು ಹ್ಯಾಂಗಿಂಗ್ ಅಲ್ಲ, ಅದು ಆಸ್ಫಿಕ್ಸಿಯಾ. ABC has committed suicide. ಇವನ್ ರೋಲ್ ಏನಿದೆ? ಮತ್ತೆ ಈಗ ವರ್ಷನ್ ಚೇಂಜ್. ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆಯಾ ವಿಟ್ನೆಸಸ್ ಏನಾರು? FSL ಏನ್ ಬರುತ್ತೆ ನಿಮ್ಗೆ? FSL ಅಲ್ಲಿ ಏನ್ ಬರುತ್ತೆ ಸಬ್ಸ್ಟಿಟ್ಯೂಟ್ ಮಾಡ್ಲಿಕ್ಕೆ? ಸೆಕ್ಷನ್ 8 ಆಯ್ತು. ಯಾವಾಗಿಂದ ನಾನು
ಕಸ್ಟಡಿಯಿಂದ ಸ್ವಾಮಿ? 12/8/2021 ಆಗಸ್ಟ್ 21 ಇಂದ.
ಹೋಗ್ಲಿ ಅವಳು ಪೋಸ್ಟ್ ಮಾರ್ಟಮ್ ಅಲ್ಲಿ ಏನಾದ್ರು ಇಂಜುರೀಸ್ ಇದೆಯಾ ಅವನೇನೋ ಅಟೆಂಪ್ಟ್ ಮಾಡಿದಾಗ?
There should be, my lord, the external injuries, my lord, over the body. FSL report await ಅಂತ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ, ಇದ್ರಲ್ಲಿ ಹಾಕ್ಲಿಲ್ಲ.
ಇದೆ ಎಕ್ಸ್ಟರ್ನಲ್ ಇಂಜುರೀಸ್ ಏನಾದ್ರು ಅಂದ್ರೆ ಪೋಸ್ಟ್ ಮಾರ್ಟಮ್ ಮಾಡಿದ್ರಲ್ಲ ಅವಾಗ ಏನಾದ್ರು ಇಲ್ವಾ? ಪೋಸ್ಟ್ ಮಾರ್ಟಮ್ ಇದೆಯಾ? ಅದ್ರಲ್ಲಿ ಇಂಜುರೀಸ್ ಇದೆಯಾ? ಆಯ್ತು, ಇವನು ಅಟೆಂಪ್ಟ್ ಮಾಡ್ದ ಅವಾಗ ಏನಾದ್ರು ಇಂಜುರೀಸ್ ಏನಾರು ಆಗಿದೆ ಅವಳಿಗೆ? ನೆಕ್ ಇಂಜುರಿ ಅದು ಮಾಡ ಈಗೇನು ಪೊಲೀಸ್ ಕೇಸ್ ಏನು ಅವಳೇನೆ ಹೆಂಗ್ ಮಾಡ್ಕೊಂಡು ಅಂತಾನ ಅಥವಾ ಇವನ್ ಹೆಂಗ್ ಮಾಡ್ದಂತ? ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಫ್ ಸೂಸೈಡ್ ಆಫ್ ಚೈಲ್ಡ್.
Okay. The actual fact is this, my lord. The ಮಂಜುಳಾ, my lord, ಅವರೇ ಬೈದಿರುವಂತದ್ದು ಅವರಿಗೆ ಇವನ್ ಜೊತೆ ಹೋಗಿ ಮಾತಾಡಿರೋದಕ್ಕೆ. ನಾನು ಅದನ್ನ ನನ್ನ ಬೇಲ್ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ ನಾನು ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೆ, ಪೇಜ್ ನಂಬರ್ 14 ಅಲ್ಲಿ ಸ್ವಾಮಿ, ಪೇಜ್ ನಂಬರ್ 14 ಆಫ್ ದಿ ಆರ್ಡರ್ ಆಫ್ ದಿ ಬೇಲ್. ನೋಡಿ, ಫೋರ್ತ್ ಲೈನ್, ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 3 ಅಲ್ಲಿ ಹೇಳಿದ್ದೇನೆ. ಸೊ as per the statement of the witnesses, when CW 2 to 6 were rushed inside the house, the victim girl was alive and the accused found running out of the house. Villagers gathered, victim girl frustrated and committed suicide is false. None of the witnesses knew the correct reason behind the suicide of the deceased. There was financial dispute between the parents of the deceased and the accused, and on the date of the incident, accused had been to ask for the payment of his hand loan, but the victim's parents were not in the house, and as such he had informed the girl to intimate her parents and went off. The deceased has not at all left any death note prior to the ಕಮಿಷನ್ ಆಫ್ ದಿ ಸುಸೈಡ್. ಸುಸೈಡ್ ಆಗಿರುವಾಗ ಇದ್ದಿದ್ದವ್ರು ಮಂಜುಳಾ ಅನ್ನೋರು ಒಬ್ರು ಮಾತ್ರ. ಅವ್ರು ನೋಡಿದ್ದೇನೆ, ನಾವೆಲ್ಲ ಊರವರೆಲ್ಲ ಬಂದಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ, ಬಟ್ ಅವರನ್ನು ಬಚಾವ್ ಮಾಡ್ಲಿಲ್ಲ ಅವರು. ಇವ್ರು ಹೋದ್ಮೇಲೆ ಆಗಿರೋದಂತಾನೆ ಹೇಳ್ತಾರೆ. ಬಟ್ ಇಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ, ನನ್ನ ಮುಂದೆನೆ ನೇಣು ಹಾಕೊಂಡ್ರು, ಅವನು ರೇಪ್ ಅಟೆಂಪ್ಟ್ ಮಾಡಿದ್ದಾರೆ ನನ್ನ ಮುಂದೆನೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಫರ್ದರ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅದಿಲ್ಲ. ಎಂಟೈರ್ ವರ್ಷನ್ ಇಸ್ ಚೇಂಜ್. ಇವರು ಹೋಗಿದ್ದಾರೆ, ಹ್ಯಾಂಡಲ್ ಮಾಡಿದ್ದಾರೆ.
The petitioner, counsel, and also the counsel appearing for the state. The factual matters of the case of the prosecution is that based on the complaint dated 3/8/2021 given by the father, an allegation is made that house taking the advantage of his minor daughter who is aged about 16 years alone in the house. This petitioner committed rape on her. She screamed. He took out the saree and committed the murder. Committed the murder, hanging her. The same is witnessed by
PW2
brother wife Srimati Manjula and her and his younger daughter who is aged about 12 years. And the same is informed over the phone, and immediately he rushed to the spot and came to know that his daughter is not alive. Based on the complaint, police at the first instance registered the case for the offense provision of 302, 376, 3, 450 of IPC and section 6 of POCSO Act. The matter is investigated, and while filing the charge sheet, deleted the offense under section 376 and 302. Only invoked the offense under section 450, 354, 305 of IPC and section 8 of POCSO Act 2012. The prosecution, the counsel appearing for the petitioner would submit that there was a dispute between the family of the deceased and also the petitioner regard to the financial transaction. When he went to demand money from the parents of the deceased, and parents were not there, he only gave an instructions to inform their parents, and he came out. And this petitioner is in custody from August 2021. Counsel also submits that earlier a false allegation is made that this petitioner had raped her, committed the murder, hanging when she screamed. The course of investigation, no such No, only invoke the offense under 305. That is abetment to commit suicide to child. And the very version of the prosecution is changed while filing the charge, and hence there is a doubt with regard to the very incident as well as the material collected by the prosecution, and hence this petitioner may be enlarged on bail. For contra, the counsel appearing to the state would submit that no doubt an allegation is made at the first instance that the victim was subjected to rape and was murdered. And during the course of investigation comes to light that this petitioner outraged the modesty of a child, and victim committed suicide, and this petitioner caused abetment to commit suicide, and hence offense under 305 and 8 of POCSO Act is invoked. And there are material against the petitioner hearing. The counsel also would submit that FSL report is awaited. FSL ಯಾವ್ದ್ರ ಬಗ್ಗೆ ಇದೆ? Having heard the petitioner, counsel and also counsel appearing to the state, and also looking at the factual aspects at the first instance, an allegation of rape as well as murder is alleged, and during the course of investigation only invoke the offense of 305 of IPC and section 8 of POCSO Act. And also on perusal of the PM report, no injuries are found except the injury in the neck. When such the actual aspect and cause of death is also on account of asphyxia. Asphyxia. When such material available on record, and also it is the case of the prosecution that the brother, wife, and also the younger daughter have witnessed the incident. But at the first instance, it is an allegation of rape and murder. But subsequently, no material are found. And when such being the case, whether they have witnessed the incident or not, and the same is also a matter of trial. And the contradictions in the case of the prosecution at the first instance and also to the investigation. And when such being the factual aspects, it is a fit case to exercise the discretion in favor of the petitioner. Custodial trial is not required. Taking into note of prima facie material collected by the prosecution, and hence enlarged on bail with certain conditions.
Much obliged.
49. ನಿಮ್ಮ ಹೆಸರೇನು? ಪ್ರದೀಪ್ NR. You also enrolled in 2011. 12 years. Argue ಮಾಡಿ. Memo of appearance sign ಮಾಡಿದಿರಲ್ಲ ಮಾಡಿ. ಸೀನಿಯರ್ ಹೆಸರು ಹೇಳ್ಕೊಂಡು ಇಲ್ಲಿ ಟೈಮ್ ಕೇಳಂಗಿಲ್ಲ. ಓದಿಲ್ಲ ಅಂದ್ರೆ ಐ ವಿಲ್ ಗಿವ್ ಯು ಟೈಮ್ ಅಪ್ ಟು 2:30. ಓದಿ ಮಧ್ಯಾಹ್ನ ಬನ್ನಿ, ಆಯ್ತಾ? ಓದ್ಕೊಂಡು ಬನ್ನಿ 2:30. AB ಸಿದ್ದರಾಮಯ್ಯ, HCGP ಏನೋ ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ಸ್ ಏನೋ ಕೇಳಿದ್ರಲ್ರಿ ಲಾಸ್ಟ್ ಟೈಮ್? ನೀವೇನೋ ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ಸ್ ಇರ್ಬೇಕು ನೋಡಿ. HCGP ಏನೋ ಟುಕ್ ಟೈಮ್ ಅಂತ ಬರ್ಕೊಂಡಿದ್ದೀನಿ. ಸೆಕ್ಯೂರ್ ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ಸ್ ಅಂತ ಏನು ಅಫೆನ್ಸ್ ಏನ್ರಿ? 363 ಅಂಡ್ ಅದೇ ಪೋಕ್ಸೋ ಇದೆ.
ಹೌದೌದು. ದೇ ಆರ್ ಹ್ಯಾವಿಂಗ್ ಲವ್ ಅಫೇರ್ಸ್ ವಿತ್ ದಿ
ಲವ್ ಅಫೇರ್ ಎಲ್ಲ ಆಯ್ತು ಬಿಡ್ರಿ. ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ಏನಿದೆ ಹೇಳ್ರಿ? ಏನ್ ಲವ್ ಅಫೇರ್?
ಮಾತ್ರ ಮೆಟೀರಿಯಲ್ ಇಲ್ಲ.
ಐಮನ್ ನಾಟ. ಆಮೇಲೆ ಈಗೇನು ಅಂತಿಮ ವರದಿ ಆಗಿದೆ?
ಹೌದು, ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ಡ್ ಅಂಡ್
164 ಸ್ಟೇಟ್ ಏನು? Hmm. 14 years. Third. Counsel. 164 statement and also medical evidence against the victim. Against the petitioner. Third, the petitioner counsel and also the counsel appearing for the state. The factual aspect of the case of the factual matters of the case of the prosecution is that the victim girl is who is aged about 14 years. Sexual act by this petitioner taking her to the house of his friend and kept her along with him for a period of 1 week, and thereafter he brought her back and left her at Davanagere. And subsequently, victim girl is also subjected to medical examination, and also her statement is recorded in 164. The counsel appearing for the petitioner submits that there was a love affair between the petitioner and also the victim girl. But she voluntarily went along with him. And medical evidence also not supports the case of the prosecution, and hence he may be enlarged on bail. Further, the counsel appearing for the state would submit that when the victim was subjected to medical examination, hymen was not intact. Medical evidence, doctor and ಹೇಳಿದಾರೆ. And also the victim in her evidence, in her statement before the learned magistrate under section 164(5) says that this petitioner, as against her will, subjected her for sexual act. Having taken note of the medical evidence that his hymen is not intact apart from 164 statement of victim girl, who is also aged about 14 years. There is a prima facie case against the petitioner herein. But hence it is not a fit case to exercise the powers under section 439 of CRPC to enlarge him on bail. The very contention of the petitioner counsel that he has been in custody and already charge sheet is filed and no custodial trial cannot be accepted for the reasons that the apex court also recently held that if child is subjected to sexual act and the same is an offense against the humanity, and also this court has to take note of the very object in bringing the special enactment, and the child below the age of 18 under section 2D of the POCSO Act cannot give any consent also, since the counsel contend that the victim herself eloped with the petitioner, and the same cannot be a ground. Siri Rajshekar.
Was appearing for the petitions counsel in this matter, my lords.
Yes, counsel. Yes.
Lords, this is the third in the series of the complaints filed in relation to the testamentary instruments executed by Lauzia Manohari. This Lauzia Manohari had executed about 5 wills, about 6 wills. Accused numbers 1 to 6 are the beneficiaries under the will. Accused number 8, Lords, he is a witness to the registration. Accused number 9, Lords, is an advocate who has practiced for 50 years. Mr. Leela Krishnan, and he is appointed as an executor under the will for distribution of the properties.
Executor.
Yes. And A11, Lords, he is a person who is a fee collector in the schools which was conducted by Lauzia Manohari.
What he did?
Fee collector. He is only an employee. Yes, fee collector, employee in one of the institutions of the deceased Lauzia Manohari.
Fee collector.
Yes.
Fee institution.
Now, yes. Lords, may I just request, there was one additional fact which I intended to bring to your lordship's notice. My colleague is before the court. This complaint has already been filed and is subject matter of an investigation in pursuant to PCR number 6620 of 2021, which your lordships will find at page number 1313 in the additional compilation which I have given.
31.
Yes, at page 1313. The relevant allegation, Lords, is at page 21. There is an allegation that these are all the criminal conspiracy, and there is a will which has been concocted, so on and so forth. And the FIR, Lords, is at page number 36.
Based on the private complaint, case is registered.
Based on private complaint, the first case is registered in Yeshwanthpur police station. That matter is pending investigation. We have been enlarged on bail in those matters.
First case. Now this is third case.
This is the third case for the same allegation.
Same allegation.
Very same allegation. Therefore, I wanted to draw your lordship's attention to page 21.
21 of
21 of the present compilation, which I have now handed over to your lordships. The accused number 1 to 5 are all the legal heirs of Lauzia Manohari along with others.
Whether the subject disputed will is the part of the civil dispute?
It is part of the civil dispute. Yes, my lords, kindly take, my lords, this very complainant has filed a civil suit in OS number 3611 of 2020. Seeking for a relief of...
This suit is pending?
This suit is pending without any interim orders. Lords, we are only seeking for enlargement on anticipatory bail, my lords. Because even otherwise, this is a matter which is already pending investigation in some other offense, not some other FIR. Now, this is an FIR registered in Vijayanagar police station. There is already an FIR which is already under investigation in Yeshwantpur police station. That is the FIR, my lords, which I have now produced before lordships at page 36. Very same allegation.
Who is appearing for other side? Nima. He is assisting. Right. How there can be two FIRs? One is already filed criminal complaint. Based on the criminal complaint, matter is referred and the FIR is registered. And now one more complaint in respect of the very same allegation of the. No. You give instructions to him. How there can be two FIRs in respect of the same allegation? Maybe different. Complainant may be different, but allegation is one and the same. Same alva. And already in respect of the earlier complaint is concerned, they have already got the bail. Whether ಈಗ ಒಂದ್ಸರಿ ಅಕ್ಕ ಇನ್ನೊಂದ್ಸರಿ ತಂಗಿ ಇನ್ನೊಬ್ರು ಇನ್ನೊಂದ್ಸರಿ ಅಂತ ಹೇಳಿ 25 ಕಂಪ್ಲೇಂಟ್ ಮಾಡಕ್ ಆಗ್ತದ? ಈ ಕಾಪೀಸ್ ಕೊಟ್ರೇನ್ರಿ ಕೌನ್ಸಿಲ್ ಯಾರು ಈಗ ಸಪ್ಲೈ ಮಾಡಿದವ್ರು ಕೊಟ್ಟಿದಾರ?
I have given the copies.
Why you have not supplied earlier?
This compilation was brought to my notice today morning immediately. Sorry, my lord.
Petitioner counsel filed additional documents today and HCGP 6 time. You verify if same facts, same incident, same allegation, ivella adre. First of all, registration of second FIR itself is bad in law, and also prosecuting a person by different complainants for the same facts. That is also a process. Heard in part. Next matter. Counsel HCGP 6 time to make submission with regard to the additional documents filed by the petitioner counsel. This matter. Guruvar. Punde iruttalla. Guruvar. 24th. Sharat Jain. Henry. ಒಂದ್ ನಿಮಿಷ ಯಾರು ಒಬ್ರು ಹೇಳಿ, ಒಬ್ರು ಕೇಳ್ತೀನಿ ಆಮೇಲೆ ನಿಮ್ಮನ್ನು ಕೇಳ್ತೀನಿ. ಈಗ ನೀವ್ ಹೇಳಿ, ನಾನು ಅವ್ರು ಕೇಳ್ತೀನಿ. ಹೇಳಿ ನಿಮ್ ಕೇಸ್ ಏನ್ ಹೇಳಿ. ಶರತ್ JM 438 ಪಿಟಿಷನ್ ಅಲ್ವಾ? 417 420 465 468 471 ಅಲಿಗೇಷನ್ ಮಾಡಿದಿರಿ. ಫೋರ್ಜರಿ ಎಲ್ಲ ಏನಿದೆ?
Case of prosecution, the petitioner was impersonated as a complainant. Executed a sale deed in favor of the 2 and 3. Accused number 2 and 3. As per the sale deed, the petitioner was issued 24 lakh rupees from the accused number 2 and 3. The sale deed, the narration disclosed that. ಆ ಚೆಕ್ಗಳಲ್ಲಿ ನಮ್ಮ ಹೆಸರು ಅಕೌಂಟ್ ಇಲ್ಲ ಸರ್, ಚೆಕ್ಗಳು ತೋರಿಸ್ತಾರೆ. ನನ್ನ ಚೆಕ್ ಐ ಬ್ರಾಟ್ ದ ನೋಟಿಸ್ ಆಫ್ ದಿಸ್ ಆನರಬಲ್ ಚೆಕ್ ನಂಬರ್ 000119.
ಲಾಸ್ಟ್ ಟೈಮ್ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ.
6 ಲಕ್ಷ ತೋರಿಸ್ತಾರೆ.
ಏನೋ ಪೇಮೆಂಟ್ ಬಗ್ಗೆ ಏನೋ ಮಾಡಿ.
ಲೆಟರ್ಸ್ ವಾಸ್ ಇಲ್ಲಿಟರೇಟ್ ಪರ್ಸನ್ ಇಲ್ಲ.
ಫಸ್ಟ್ ಟೈಮ್ ಇದು.
ಇಲ್ಲ ಸರ್,
ಇನ್ನೊಂದು ಆರ್ಡರ್ ಇರಬೇಕು. ಗವರ್ನಮೆಂಟ್ ಪ್ರೀಡರ್ ಅಪಿಯರಿಂಗ್ ಫಾರ್ ಸ್ಟೇಟ್ 6 ಟೈಮ್ ಅಂತ.
So, as per the check, check number 000119. As per the check.
ಒಂದೇ ನಿಮಿಷ wait. ಹಿಂದೆ ಇದೆ. ಪೇಮೆಂಟ್ ಏನಾಯ್ತು? ಚೆಕ್ ಅಮೌಂಟ್ ಏನಾಯ್ತು? ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಏನಾದ್ರು ಚೆಕ್ ಅಮೌಂಟ್ ಇದೆಯಾ?
ಚೆಕ್ ಅಮೌಂಟ್ ಹೇಳ್ತಾರೆ. ಇಲ್ಲಿ ನಮ್ದು ಅಲಿಗೇಷನ್ ಆಫ್ ದ ಕಂಪ್ಲೇಂಟ್ ಇಟ್ಸೆಲ್ಫ್ ಪೇಜ್ ನಂಬರ್ 8 ದಯಮಾಡಿ ಶಿವಕುಮಾರ್ ಶಿವಕುಮಾರ್ ಎಸ್ ಎಚ್.ವಿ. ದೀಕ್ಷಿತ್ ದಿನಾಂಕ 30/10/21 ಕ್ರಯಪತ್ರದಲ್ಲಿ ನನ್ನ ಹೆಸರಿನಲ್ಲಿರುವ ಮಾರಾಟಗಾರರ ವಿರುದ್ಧ ಸೂಕ್ತ ಕ್ರಮ. ಅವರು ಅಲಿಗೇಷನ್ ಮಾಡ್ತಾರೆ, ಅವರು ಹೇಳ್ತಾ ಇರೋದು ಡಿಫೆನ್ಸ್ ತಗೊಳ್ತಾ ಇರೋದು ಕಂಪ್ಲೇಂಟ್ ಗೆ ಅಬುಟ್ಟ ಸಂದಾಯ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಕಂಪ್ಲೇಂಟ್ ಎಲ್ಲ ಸಮಯ 2 and 3 ಅವರು ಯಾವ ರೀತಿ ದುಡ್ಡು ಇಸ್ಕೊಳ್ತಾರೆ ನಮಗೆ ಕೊಡದರೆ they are 2 and 3 created the sale deed.
I agree 2 and 3 are the purchasers. 2 and 3 are the purchasers. ಹೌದಾ? ಅವನು ಪರ್ಚೇಸ್ ಮಾಡ್ಬೇಕಾ ನಿಮಗೆ ದುಡ್ಡು ಕೊಡ್ಬೇಕಲ್ಲ? ಅದನ್ನೇ ಹೇಳ್ತಾ ಇರೋದು. ಏನ್ ಚೆಕ್ಸ್ ಇದೆಯಾ? ಸೇಲ್ ಡೀಡ್ ಕಾಪಿ ಇದೆಯಾ? ಎಲ್ಲಿದೆ ಸೇಲ್ ಡೀಡ್ ಕಾಪಿ? ಲಾಸ್ಟ್ ಟೈಮ್ ನನಗೆ ಕೇಳಿದ್ದೆ ನಾನು. ಇದೆಯಲ್ಲ ಇದ್ರಲ್ಲಿ ಏನಂತ ಹೇಳ್ತಾರೆ? ನೆನಪಿದೆ. seeks time to verify regarding payment made in favor of this petitioner through check ಅಂತ ಹೇಳಿದ್ದೆ. ಏನಾಯ್ತು ಈಗ? ಚೆಕ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಆಯ್ತ್ರಿ, ಚೆಕ್ಸ್ ಯಾರು ಆನರ್ ಮಾಡಿದಾರೆ? ಯಾರಿಗೆ ಆನರ್ ಆಗಿದೆ?
ಶಿವಕುಮಾರ್
ಶಿವಮ್ಮ is not the vendor. ಸೇಲ್ ಡೀಡ್ ಹಂಗೆ
ದಯಮಾಡಿ ಸಮಯ ಚೆಕ್ ಅಲ್ಲಿ ಸೇಲ್ ಡೀಡ್ ಪ್ರಕಾರ 6 ಲಕ್ಷ ತೋರಿಸ್ತಾರೆ. ಅಲ್ಲಿ ಚೆಕ್ ಅಲ್ಲಿ ಇರೋದು 50,000.
ಬರೀ 55,000. ಬಾಕಿ ಇದೆಲ್ಲ
ಬಾಕಿದಲ್ಲಿ ಯಾವ್ದು ಇಲ್ಲ ಸರ್.
ಕ್ಯಾಶ್ ಕೊಟ್ರಿ ಅಂತಾನ?
ಇಲ್ಲ ಸರ್, ಇದು ಚೆಕ್ ಮುಖಾಂತರ ತೋರಿಸಿರೋದು.
3 ಲಕ್ಷ.
ಹೌದು.
ಈ ಚೆಕ್ ಯಾರಿಗೆ ಆನರ್ ಆಗಿದೆ ರೀ? ಅದನ್ನೇ ನಾನು ಕೇಳಿದ್ದು. ಪೇಮೆಂಟ್ ಯಾರಿಗಾಗಿದೆ ಅಂತ.
Those two checks are not issued to me means complaint. It is not duly credited to my account. ನನಗೆ ಬಂದೇ ಇಲ್ಲ. It was issued.
ಸರಿ, ಅಕ್ಯೂಸ್ಡ್ ಈಗ 438 ಇದು.
Before this, they are relying on the sale deed. This 30/30/2021. The case of the complainant in page number 8 itself is very clear.
ಇವನ ಹೆಸರು ಪಾಪಣ್ಣನ? ಇವನ್ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಸಿಗ್ನೇಚರ್ ಇದೆಯಾ? ಫೋಟೋ ಯಾರ್ದಿದೆ?
ಫೋಟೋ ನಂದೇ ಸಮಯ ಮೆನ್ಷನ್ ಮಾಡಿಸ್ತೀನಿ ಅಂತ ಸಮಯ ಸ್ವಲ್ಪ ಆಲ್ಕೋಹಾಲ್ ಅಡಿಕ್ಟ್ ಪರ್ಸನ್
impersonation. Apart from impersonation, also you went to the sub-registrar office and executed the document of sale in favor of accused number 2 and 3. Though you are not the I think it requires the proof, not a case for 438.
ಪೇಮೆಂಟ್ ಅಂತ ಹೋಗಿಲ್ಲ. ಹಾಗಾಗಿ ಇಲ್ಲಿಟೆಡ್ ಪರ್ಸನ್
ಅಲ್ಲರೆ ನಿಮ್ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲೇ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲೇ you are present before the sub-registrar. You went to the sub-registrar office.
ಅವ್ರ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಸೈನ್ ಅಣ್ಣಯ್ಯ ಅಂತ ಈಗ ಬರೀತಾರೆ ಸರ್.
ಅದು ನೋಡೋಣ, ನಾವು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗಿ not a case for 438. ತೊಳಿ order the petitioner counsel and also the counsel appearing to the state.
ಹೌದು, ಇದು ನಮ್ಮ 2 is ಆಲ್ರೆಡಿ ಅವ್ರಲ್ಲಿ ಅದರಲ್ಲಿ ಫೈಂಡಿಂಗ್ ಏನು
ನಿಮ್ಗೆ ಯಾಕೆ ಕೊಡ್ಲಿಲ್ವಾ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
ಅವ್ರ ಕಂಟೆಂಟ್ಸ್ 24 ಲಕ್ಷ ಇಸ್ಕೊಂಡು ಇಬ್ಬರೇ ಚೀಟಿಂಗ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತ ಅವ್ರ ಕಂಟೆಂಟ್ಸ್ ಇದೆ ಸರ್. ರಿಮಾಡಿ ಸಮಯ
ಪೇಜ್ ನಂಬರ್ ಪ್ಯಾರಾ ನಂಬರ್ 5 ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ ನೋಡಿ. On verification of the sale deed, he has found that the accused number 1 Papanna, the present petitioner, sold the property belongs to the complainant in the name of the complainant as Annaya. So a specific case is made out against accused number 1 for having represented the complainant and sold the property in survey number 127 to the accused number 2 and 3. That's the reason only. Our only the beneficiaries ನೀವು ದುಡ್ಡು ತಗೊಂಡು ಬರ್ಕೊಟ್ಟಿದ್ದೀರಿ ಅಂತ ಕೊಟ್ಟಿಲ್ಲ ನಿಮ್ಗೆ.
ದುಡ್ಡು 1 ರೂಪಾಯಿ ಬಂದಿಲ್ಲ.
ಆಯ್ತು ನಾ
ದಯಮಾಡಿ ಸಮಯ
ಅಲ್ಲ ರೀ, ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಚೆಕ್ ತೋರಿಸಿದಾರಲ್ರಿ, ಬಟ್ ಚೆಕ್ ಪೇಮೆಂಟ್ ಆಗಿಲ್ಲಲ್ಲ. ಆಯ್ತ್ರಿ, ಅವ್ರ ಹೆಸರಲ್ಲಿ ಚೆಕ್ ಕೊಟ್ಟು ಈಗ ಚೆಕ್ ಏನಾಗಿದೆ ನೀವು ನೋಡಿದೀರಾ ಹೋಗ್ಲಿ? ಆಯ್ತ್ರಿ, ಈಗ ಸೇಲ್ ಡೀಡ್ ಏನು, ಈಗ ಸೇಲ್ ವ್ಯಾಲಿಡ್ ಸೇಲ್ ಕನ್ಸಿಡರೇಷನ್ ಪಾಸ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಈ ಸೇಲ್ ಡೀಡ್ ವ್ಯಾಲ್ಯೂನೇ ಇಲ್ಲ. ನಿಮ್ ಪ್ರಕಾರ ಸೇಲ್ ಡೀಡ್ ಪ್ರಕಾರ ಅವ್ರು ಕೊಟ್ರ ಸೇಲ್ ಡೀಡ್ ಪ್ರಕಾರ ಮೂರ್ ಪಾಪ ಅವನೇನೋ ಸ್ವಲ್ಪ ಕುಡಿದ್ ಗಿಡ್ದಿದ್ನ ಕರ್ಕೊಂಡು ಹೋಗಿ ಒತ್ಸಾರ ಬೆಟ್. ಮತ್ತೆ ಈ ಪ್ರೇಮಾ ಫೇಸಿ ಏನಂದ್ರೆ ಈ ಪೇಮೆಂಟ್ ಏನಾರು ಇದೆಯಾ, ಚೆಕ್ ಪೇಮೆಂಟ್ ಅವನ ಹೆಸರು ಕೊಟ್ಟಿಲ್ಲ. ಮತ್ತೆ ಆಯ್ತು, ನೀವು ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಮಾಡಿ ಕೊಡೋಣ ಬೇಲ್. ಮತ್ತೆ ಅವನ ಹೆಸರಲ್ಲಿ ನೀವು ಪೇಮೆಂಟ್ ಆಗಿದ್ರೆ ಪ್ರೇಮಾ ಫೇಸಿ ಕೇಸ್. ಇವ್ ನಾವು ದೇರ್ ಇಸ್ ನೋ ಪ್ರೇಮಾ ಫೇಸಿ ಕೇಸ್ ಅಟ್ ಆಲ್. ಏನ ಜನ ಮೋಸ ಮಾಡೋರು ಇರ್ತಾರೆ, ಕರ್ಕೊಂಡು ಹೋಗಿ ಒಂದ್ ಮಸಾಲೆ ದೋಸೆ ತಿನ್ಸಿ ಅವನ್ನ ಕರ್ಕೊಂಡು ಹೋಗಿ ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಆಫೀಸಿಗೆ ಕರ್ಕೊಂಡು ಹೋಗಿ ಏನ್ ಮತ್ತೆ ಹಿಂಗ್ ಮಾಡಿ. That is the reason only I asked you whether any payment is made in favor of this petitioner anta. But sale consideration ತೋರಿಸಿರೋದು ಕೂಡ through check ಮೂಲಕ. ಆ checks are not honored in favor of the petitioner. ಮತ್ತೆ ಏನಮ್ಮ ಹೋಗಿದಾನೆ ಹೇಳ್ಕೊಂಡು ಹೋಗೋರು ಅಥವಾ ಏನ್ ಮಾಡೋರು ಏನೋ ಮಾಡಿರ್ಬೋದು, ಇಲ್ಲ ಒಂದು ಕ್ವಾರ್ಟರ್ ಗಿಟ್ ಹಾಕ್ಸ್ಕೊಂಡು ಕರ್ಕೊಂಡು ಹೋಗಿರ್ಬೇಕು ನೋಡಿ ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಆಫೀಸ್.
So when that being the case,
ಸೇಲ್ ಇಸ್ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ಲಿರಿ. ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲಿ ಕನ್ಸಿಡರೇಷನ್ ಪಾಸ್ ಆಗಿಲ್ವಲ್ಲ. ಈ ಚೆಕ್ಸ್ ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ, ಬೇರೆಯವ್ರ ಹೆಸರಿಗೆ ಕೊಟ್ಟವ್ರೆ, ಇವ್ರ ಹೆಸರಿಗೆ ಕೊಟ್ಟು ಇಲ್ಲ. ಮತ್ ಹೌ ಈ ಕ್ಯಾನ್ ಮಗು ನಿಮ್ಗೇನ್ ಸಂಬಂಧ? ಆಯ್ತು ತೋಳ್. Heard the petitioner, counsel and also the counsel appearing for the state. The fact and matters of the case of the prosecution is that this petitioner by impersonation sold the property in favor of accused number 2 and 3. In the property belongs to the complainant, and based on the complaint, police have registered the case. Counsel appearing for the petitioner would submit that he is addicted to alcohol and he was taken to the sub registrar officer and he has not received any sale consideration, and also produce the copy of the sale deed before this court, wherein the sale consideration is paid through checks mentioning the check numbers, and those checks are also not honored in favor of the petitioner. Hence, petitioner has been cheated. The trial court already granted bail in favor of accused number 2 and 3. Hence, he may be enlarged on bail and he will assist the IO for investigation. For contra, the counsel appearing for the state would submit that this petitioner only went to the sub registrar office and the document of sale deed discloses that he was very much present in the sub registrar office, and photo contains the photo of this petitioner is depicted in the sale deed. Has to be proved and 138 section 438 cannot be invoked. Having heard
page number 7 of the petition, direct allegation,
complaint ಅಲ್ಲಿ
ತೆಗೆದಿರುವ ವ್ಯಕ್ತಿಯನ್ನು ನೋಡಿದಾಗ ನನಗೆ ಪ್ರಯತ್ನವನ್ನು ಕೊಟ್ಟ ಶ್ರೀಮತಿ ದೇವಿ ಎಂಬುದರ ಎರಡನೇ ಮಗನಾದ
ಹೆಸರೆಲ್ಲ ಇದೆ ರೀ, ಅವ್ರೇನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ. ಆಯ್ತು, ಏನಾಯ್ತು? Respective counsel and also on perusal material available on record, and also particularly looking into the document of sale deed. This petitioner is an illiterate. Illiterate, and the contention of the petitioner also that his illiteracy is misused, and no payment is made in favor of the petitioner in terms of the checks which details have been given in the sale deed. And this court also directed the HCGP to verify whether those checks are honored in favor of the present petitioner. And the counsel appearing for the state would submit that no such payments are made in favor of the petitioner herein. And having taken note of the said fact, made to the complainant, made to the complainant, and also this petitioner also, and also no payment is made in favor of ಇವನು ಇಂಪರ್ಸೋನೇಷನ್. ಅವ್ನು ಪಾಪಣ್ಣನ ಹೆಸರಿನಲ್ಲಿ ಇವನು ಬರ್ಕೊಟ್ಟವನೆ ಅಂತ ಇವನ್ಗೇನ ಪೇಮೆಂಟ್ ಆಗಿದೆ ಇಲ್ಲಲ್ಲ? ಈ ಚೆಕ್ ಗಳೇನಾರು ಇವನಿಗೆ ಪೇಮೆಂಟ್ ಆಗಿದೆ ಇಲ್ಲಲ್ಲ? ಹೊಂಟೋಗಿದೆ ಸರಿ, ದುಡ್ಡೇನಾರು ಕ್ರೆಡಿಟ್ ಆಗಿದೆಯಾ ಶಿವಮ್ಮನ ಹೆಸರಿಗಾರುವೆ? in favor of the complainant through the said checks, and also material is placed that this petitioner has received the amount by impersonation, stating that he is the original owner. When searching the factual aspects, when this petitioner is illiterate, the matter has to be probed. Regarding payment also, doubtful in favor of the complainant. When searching the factual aspects, it is a good case to exercise the powers under section 438 of CRPC with conditions. And this petitioner has to assist and cooperate the IO for investigation in the matter. 54. Viranna Tigde. Pass over. Ilva. 55. M. Krishnagoda. 354A, 305.
305 on section 8 and 12 of
Hill.
data incident of 9/2021.
Data
incident on 6/9/21.
6/9/21.
Complaint on 12/9/21.
Very nice.
Investigation completed, charge sheet filed, madam. 11th portion of the charge sheet in page number 32 of my petition.
52.
32 of my petition.
32 is column number 17.
ಪಟ್ಟಿ ಕಾಲಂ ನಂಬರ್ 12 ನಮೂದಿಸಿರುವ A1 ಆರೋಪಿ ಮತ್ತು ಮೃತ ಕುಮಾರಿ ತಂದೆ ಕೃಷ್ಣಪ್ಪ 17 ವರ್ಷ ವಿದ್ಯಾರ್ಥಿ ಮಾರ್ಸಂಡಳ್ಳಿ ನಂದಿನಿ ಯೋಗಿರವರು ಮಾರ್ಸಂಡಳ್ಳಿ ಊರಿನವರಾಗಿದ್ದು ದಿನಾಂಕ 6/9/21 ಬೆಳಗ್ಗೆ 5 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಕುಮಾರಿ ಸೌಮ್ಯ 1ನೇ ಘನ ತ್ವರಿತ ನ್ಯಾಯಾಲಯ ಬೆಂಗಳೂರು ಗ್ರಾಮಾಂತರ ಜಿಲ್ಲೆ ವ್ಯಾಪ್ತಿ ನಂದಗುಡಿ ಸರಹದ್ದು ಮಾರ್ಸಂಡಳ್ಳಿ ಗ್ರಾಮದ ಸಾಕ್ಷಿ 1 ರವರ ಮನೆ ಪಕ್ಕದ ನೀಲಗಿರಿ ತೋಪಿಗೆ ಬಹಿರ್ದೆಸೆಯಲು ಹೋಗಿದ್ದಾಗ A1 ಆರೋಪಿ ಗುರುತು ಸಿಗದಂತೆ ಮುಖಕ್ಕೆ ಮಫ್ಲರ್ ಕಟ್ಟಿಕೊಂಡು ಹಿಂದಿಂದ ಸೌಮ್ಯಳ ಕುತ್ತಿಗೆಗೆ ಕೈ ಹಾಕಿ ಮೈ ಕೈ ಬಿಟ್ಟು ಎಳೆದಾಡುವಾಗ ಸೌಮ್ಯ ಅಮ್ಮ ಎಂದು ತಿಳಿಸಿಕೊಂಡಾಗ ಕಿರ್ಚಿದ ಶಬ್ದ ಮನೆಯಲ್ಲಿದ್ದ ಸಾಕ್ಷಿ 8 ರವರು ಕೇಳಿಸಿಕೊಂಡು ಮನೆಯಿಂದ ಹೊರಬರುವ ಶಬ್ದವನ್ನು A1 ಕೇಳಿಸಿಕೊಂಡು ನೀಲಗಿರಿ ತೋಪಿಗೆ ಓಡುವಾಗ ಆತನ ಬಳಿ ಇದ್ದ ಮೊಬೈಲ್ ನಂಬರ್ ಮೊಬೈಲ್ ಕೆಳಗೆ ಬಿದ್ದು ಹೋಗಿರುತ್ತದೆ. ಯಾಕೆ ಮೈ ಕೈ ಬಿಟ್ಟು ಎಳೆದಾಡಿದ ವಿಚಾರವನ್ನು ಆರೋಪಿ ಊರಿನವರು ಹೇಳಿತು. ಈ ವಿಷಯ ತಿಳಿದ ಸಾಕ್ಷಿ 15 ರವರು ಸಾಕ್ಷಿ 1 ರವರಿಗೆ ಸಾಕ್ಷಿ 1 ಪಾದರಪಿಸಿದರು. ಊರಿನ ಸುಬ್ರಹ್ಮಣ್ಯ ಅವರು ಸೌಮ್ಯಳನ್ನು ಮೈಕೈ ಮುಟ್ಟಿ ಎಳೆದಾಡಿರುವುದು ಹೇಳಿಕೊಂಡು ತಿರುಗಾಡ್ತಾ ಇದ್ದಾನೆ ಎಂದು ತಿಳಿಸಿದರು. ಸದರಿ ವಿಚಾರವನ್ನ ಸಾಕ್ಷಿ 1 ರವರು ಕಂಪ್ಲೇಂಟ್ 9/9/21 ಬೆಳಿಗ್ಗೆ ಸೌಮ್ಯಳನ್ನು ಕುರಿತು ನಿನ್ನನ್ನು ಸುಬ್ಬು ಹಾಕಿದ್ರು, ಕುತ್ತಿಗೆಗೆ ಹಿಂದಿನಿಂದ ಕೈ ಮೈ ಹಾಕಿ ಎಳೆದಾಡಿರುವ ವಿಷಯ ನನಗೆ ಯಾಕೆ ಹೇಳಲಿಲ್ಲ, ಈಗ ನೋಡು ಊರಲ್ಲಿ ನಮ್ಮ ಮಾನ ಮರ್ಯಾದೆ ವಹಿಸು ಎಂದು
ಡೆತ್ ನೋಟ್ ಬರ್ದಿಟ್ಟಿದಳ. ಡೆತ್ ನೋಟ್ ಇದೆಯಾ?
ಅವ್ರ ತಂದೆ ಬಂದು ಕೂಗಾಡಿದ್ರಿಂದ ನನ್ನ ಸಾವಿಗೆ ಸುಮ್ಮನೆ ಕಾರಣ ಎಂದು ಡೆತ್ ನೋಟ್
ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಪಾರ್ಟ್ ಮಾಡಿದ್ರು, ಪಾರ್ಟ್ ಆಫ್ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ
ನಮ್ಗೆ ಕಾಪಿ
ಹಾಕಿದ್ದೀರಾ? ನಿಮಗೆ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಚಾರ್ಜ್ ಶೀಟ್ ಜೊತೆ ಇಲ್ವಾ?
ಚಾರ್ಜ್ ಶೀಟ್ ಕಾಪಿ ತಗೊಂಡು ಅದನ್ನ ಕೊಟ್ಟಿಲ್ಲ. ಅದೇ ಎಫ್ಎಸ್ಎಲ್ ರಿಪೋರ್ಟ್ ಹೋಗಿದೆ ಅಂತ
ಎಫ್ಎಸ್ಎಲ್ ಹೋಗ್ಲಿ, ಬಟ್ ಡೆತ್ ನೋಟ್ ಇದೆಯಾ? ವಾಟ್ಸ್ ಹಿ ಸೇಸ್? ಅದೇ ನೋಡಿ ಗೊತ್ತಾಗಿ ವಿಚಾರ ಕೂಗಿದ ತಕ್ಷಣ ಮನೆಯವರೆಲ್ಲ ಅಪ್ಪ ಮಗಳಿಗೆ ಬೈತಾನೆ, ನಿನ್ ಕಡೆಯಿಂದ ಮರ್ಯಾದೆ ಹೋಯ್ತು ಅಂತ. ಆಗ ಅವಳು ಡ್ಯೂ ಟು ದಟ್ ಹ್ಯುಮಿಲಿಯೇಷನ್ ಶಿ ಕಮಿಟೆಡ್ ಸುಯಿಸೈಡ್. ವೈಲ್ ಕಮಿಟಿಂಗ್ ಸುಯಿಸೈಡ್ ಆಲ್ಸೋ ಶಿ ಲೆಫ್ಟ್ ವಿತ್ ಡೆತ್ ನೋಟ್ wherein she has made an allegation against this petitioner that he outraged the modesty of a child ಅಂತ. ಹೌದಾ?
ಆ ಡೆತ್ ನೋಟ್ ಅಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ ಅಂತ ನನಗೆ ಗೊತ್ತಿಲ್ಲ, ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ. ಮತ್ತೆ ಆ ಮೊಬೈಲ್ ಕೂಡ
ಕೊಡ್ರಿ, ಒಂದು ಕಾಪಿ ಕೊಡ್ರಿ ಅವ್ರಿಗೆ. ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಆಗಿಂದ ಚಾರ್ಜ್ ಶೀಟ್ ಜೊತೆ ಹಾಕಿರ್ತಾರೆ. ಅಪ್ಲೈ ಮಾಡೋದು ಯಾಕೆ? ನಿಮ್ಗೊಂದು ಕಾಪಿ ಕೊಡ್ಬೇಕಲ್ಲ, ಯು ಆರ್ ಇನ್ ಕಸ್ಟಡಿ ಅಲ್ವಾ?
ಹಂಗಾಗಿ ಏನ್ ಬರ್ದಿದೆ ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ, ಅವ್ರು ಕೊಟ್ಟಿಲ್ಲ ಕಾಪಿ. ಆ ಮೊಬೈಲ್ ಅಲ್ಲಿ ಬಿದ್ದಿತ್ತಂದ್ರೆ ಅದು ನನ್ನ ಮೊಬೈಲ್ ಅಲ್ಲಿ
ಆಯ್ತಾ? ಮೊಬೈಲ್ ಅಲ್ಲಿ ಅದು ಹೇಳಿದಾರೆ, ಈಗ ಗೊತ್ತಾಯ್ತಲ್ಲ. ಒಳ್ಳೆ ನೀನು ಅವರು ಅಕ್ಯೂಸ್ಡ್ ಟ್ರೈ ಇದ್ ಮಾಡದ ನನಗೆ. ಆವಾಗ ನಾನು ಕಿರ್ಚ್ಕೊಂಡಾಗೆಲ್ಲ ಜನ ಬಂದು ನೋಡಿದ್ರು. ಆವಾಗ ಅಲ್ಲ ತಾಯಿ CW8 ವಾಸ್ ಇನ್ ದಿ ಹೌಸ್. ಮೊಬೈಲ್ ಬಿದ್ದೋಗಿದೆಯಲ್ಲ ಅದೇ ಅಂತಲ್ಲ ಮೊಬೈಲ್. ನೋಡ್ರಿ, ಏನೋ ಮೊಬೈಲ್ ಯಾರ ಹೆಸರಲ್ಲಿದ್ದಾರೆ? ಮೊಬೈಲ್ ಯಾರ ಹೆಸರಲ್ಲಿದೆ? ಬೇರೆಯವ್ರ ಹೆಸರಲ್ಲಿದೆ. ಅದನ್ನ ನೀವು ಯಾರು ಯೂಸ್ ಮಾಡ್ತಾ ಇದ್ರು ಕಂಡುಹಿಡಿದಿದ್ದೀರಾ? ಮುಖ ಮುಚ್ಕೊಂಡು ಅವಳು ಹೇಳಿದಾಳಲ್ರಿ ಮನೆಯಲ್ಲಿ. ಅವಳು ವಿಕ್ಟಿಮ್ ಸಾಯಕ್ಕಿಂತ ಮುಂಚೆ ಹೇಳಿದಾಳಲ್ಲ, ಅವಳೇ ಡೆತ್ ನೋಟ್ ಅಲ್ಲಿ ಬರ್ದವಳಲ್ಲ, ನೀವೇ ಅಂತ. ಏನು ಡೆತ್ ನೋಟ್ ಅಲ್ಲಿ ಅವಳೇ ಬರ್ದವಳಲ್ಲ ಏನು ಅಂತ? ಅಂದೇ ಕಿರ್ಚಾಡಿದ್ದಾಯ್ತ್ರಿ. ಡೆತ್ ನೋಟ್ ಅಲ್ಲಿ ಯಾರು ಅಂತ ಬರ್ದವಳಲ್ಲ ಅವಳು. ಈಗ ನೀವ್ ಹೆಂಗ್ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡ್ತೀರ ಅದನ್ನ? ಸಾಯಕ್ಕಿಂತ ಮುಂಚೆ ಅವಳೇ ಬರ್ದಿಟ್ಟು ಹೋಗೋಳೆ ನೀನೇ ಅಂತ.
ಯಾರು ಡೆತ್ ನೋಟ್ ಅವ್ರ ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಏನಂತ ಮ್ಯಾಟರ್ ಆಫ್ ಟ್ರಯಲ್
ಮ್ಯಾಟರ್ ಆಫ್ ಟ್ರಯಲ್
ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಅವ್ರದನ್ನ ಏನಂತ ಯಾರ ಮುಂದೆ ಹೇಳ್ಕೊಡ ಅವ್ರಿಗೆ ಏನು ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡಿಲ್ಲ ಆ ವಿಷಯನ 6 ದಿನಗಳ ನಂತರ ಅವ್ರ ತಂದೆ ಬಂದು ಬೈದಿದ್ರಿಂದ ಸತ್ತಿದ್ದಾಳೆ ಅಂತ ಅದು ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಅವ್ರಿಗೆ ಇರುವಂತ ಟ್ರಯಲ್.
ಆಯ್ತು, ರಿಪೋರ್ಟ್ ಬರ್ಲಿ ಬಿಡಿ. FSL ರಿಪೋರ್ಟ್ ಬಂದ್ಮೇಲೆ ನೋಡೋಣ. ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಎಕ್ಸ್ಪರ್ಟ್ ರಿಪೋರ್ಟ್ ಬಂದಾಗ ಇಂಥ ಚಿಕ್ಕ ವಯಸ್ಸಿಗೆ ಈ ಅಪವಾದ ಬಂದಿದ್ದಕ್ಕಾಗಿ ನಾನು ಆತ್ಮಹತ್ಯೆ ಮಾಡಿಕೊಳ್ಳುತ್ತಿದ್ದೇನೆ. ದಯವಿಟ್ಟು ಇವನಿಗೆ ತಕ್ಕ ಶಿಕ್ಷೆ ಆಗ್ಬೇಕು. ಯಾವ ತಂದೆ ತಾಯಿ ಈ ತರ ಆಗ್ಬಾರ್ದು. ಅವನಿಗೆ ನೇಣಿಗೆ ಹಾಕ್ಬೇಕು. ಅವನು ಈಚೆ ಬಂದರೆ ಇನ್ನು ಎಷ್ಟು ಜನ ಹೆಣ್ಣು ಮಕ್ಕಳ ಈಚೆ ಬಂದರೆ ಇಂಥ ದೂರು ನುಡುತ್ತಾನೋ ಅದಕ್ಕಾಗಿ ಅವನು ಯಾವುದೇ ಕಾರಣಕ್ಕೂ ಈಚೆ ಬರಬಾರ್ದು. ಸಾವಿನ ಇನ್ನು ಯಾವುದೇ ಹೆಣ್ಣು ಮಕ್ಕಳಿಗೆ ಬರೋದು ಅಂತ ಸೌಮ್ಯ ಅಂತ ಬರೆದು ನನ್ನ ತಂದೆ ತಾಯಿಗೆ ದುಃಖ ತಡೆಯಲು ದೇವರಲ್ಲಿ ಶಕ್ತಿ ಕೊಡು ಎಂದು ನಾನು ದೇವರಲ್ಲಿ ಕೇಳಿಕೊಳ್ಳುತ್ತಿದ್ದೇನೆ. ಆದರೆ ಇಂಥ ಯಾರಿಗೂ ತಂದೆ ತಾಯಿ ಸಿಗುವಷ್ಟು ಮಾಡಿಲ್ಲ. ಇದರಿಂದ ಒಂದು ಕೊತ್ತನ್ನು ಹಿಡಿದು ಎಳೆದಾಡಿ ಯತ್ನಿಸಿದ್ದ. ಹೋಗಿದಾಗ ಬಾಯಿ ಮುಚ್ಚಿ ಎಳೆದು ಇಲ್ಲ ಅಷ್ಟರಲ್ಲಿ ಅಮ್ಮ ಬಂದು ಓಡಿ ಹೋದ. ಫೋನ್ ಕೊಡುವ ಸಮಯದಲ್ಲಿ ಫೋನ್ ಬಿದ್ದಿತ್ತು. ಅನಂತರ ಫೋನ್ ತೆಗೆದುಕೊಂಡು ಆ ನಂಬರ್ಗೆ ಕರೆ ಮಾಡಿ ಫೋನ್ ತೆಗೆಯಲಿಲ್ಲ.
ಮಕ್ಕಳ ಕಟ್ಕೊಂಡಿದ್ದಾರೆ. ಗುರ್ಚಿಕ್ಕಿಲ್ಲ ಯಾರಿಗೂ ಯಾರು ಅಂತ ಹೆಂಗೆ ಗುರ್ಚಿಕ್ಕಿಲ್ಲ ಯಾರು ಬಂದು ಓಡುವುದು ಅಂತ
ನೀವೇ ಅಲ್ಲಿ ನಾನು ಹಿಂಗ್ ಹಿಡ್ದೆ ಎಳೆದಾಡ್ದೆ ಅಂತೆಲ್ಲ ಹೇಳ್ಕೊಂಡು ಊರಲ್ಲಿ ತಿರ್ಗಾಡಿದ್ರಂತೆ. ಆಮೇಲೆ ಅವಳಿಗೆ ಅವ್ರ ಅಪ್ಪನ್ ಗೊತ್ತಾಗಿ ಅವ್ರ ಅಪ್ಪ ಬಂದು ಹೇಳಿದಾಗ ಆಯ್ತು ಹ್ಯಾಂಡ್ ರೈಟಿಂಗ್ ಬರಲಿ ನೋಡೋಣ. Third, the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that when this court about the dictate the orders after hearing the arguments of the respective counsel at this juncture, petitioner counsel seeks permission to withdraw the petition with liberty to file fresh petition after receiving the FSL report. Handwriting of the victim. Permitted to withdraw with liberty. Vishwanatha A. Vishwanatha A. No representation last time. Pass over. 58. Pass over, right? 59. Yana call details keli the last time. 304B. 8183. ಏನ್ರಿ ಬಂತ? ಇನ್ನೊಂದು ಯಾವ್ದಿದೆ?
ಅದು 439 A4.
ಅದಾ 438 430 ಎರಡು ಇದೆ. ಏನಾಯ್ತು ಕೊಡು. 61 by whom? 61 ನೀವೇ ಇದ್ದೀರಿ. ಅಕ್ಯೂಸ್ ನಂಬರ್ ಎಷ್ಟು? A1
ಅವನು A4 ಸರ್. A1 ಗೆ ಏನಾಗಿದೆ?
A4
A4.
What is the relationship between A3 A2 3 to 4? A4 ಯಾರು?
A4 ಬಂದ್ಬಿಟ್ಟು this is
ಬಾಂಬ್ ಬ್ರದರ್ ಇಂದ ಮೈದ್ನ ಗಂಡನ್ ತಮ್ಮನ ಇವರಿಬ್ರು ತಂದೆ ತಾಯಿ ಅತ್ತೆ ಮಾವ ಅದೇನೆ ಗಂಡನ್ ತಂದೆ ತಾಯಿ. ಏನೋ ಬಿಫೋರ್ ಕಮಿಟಿಂಗ್ suicide she gave she made a phone call to the parents. ಹೌದಲ್ಲ? ಅದೇ ಪ್ಯಾರಾ ಪೇಜ್ 19 ಅಲ್ಲಿ ಪ್ಯಾರಾ 3 ಅಲ್ಲಿ ಹೇಳಿದಾಳೆ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಇದು ಅಲಿಗೇಷನ್ ಇದೆ. 25/12 ಏನೋ ಒಂದು ಬೆಳಿಗ್ಗೆ 9 ಗಂಟೆ ನನ್ನ ಹೆಂಡತಿ ನನ್ನ ಮಗಳು ಕರೆ ಮಾಡಿ ನನ್ನ ಮತ್ತೆ ಮಾವ ಅತ್ತೆ ಗಂಡ ಮಾವ ನನ್ನ ಮನೆಗೆ ಬಹಳ ಹಿಂಸೆ ನೀಡುತ್ತಿದ್ದಾರೆ ಎಂದು ಹೇಳಿದ್ದಾಳೆ. ಅದಾದ ನಂತರ ನನ್ನ ಬೀಗರು ಸುಮಾರು 11:30ಕ್ಕೆ ಕರೆ ಮಾಡಿ ಸತ್ತೋಗಿದ್ದಾಳೆ ಅಂತ, ನೇಣು ಹಾಕೊಂಡಿದ್ದಾಳೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ರಾಜಿ ಸಂಧಾನ ಮಾಡಿದ್ರ? ಅದು ಏನೋ ರಾಜಿ ಸಂಧಾನ ಆಗಿದೆ ಹಿಂದೆ, ಪ್ಯಾರಾ 2 ನಲ್ಲಿ ಇದೆ ನೋಡಿ. ಅದೇನು ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಇವ್ರು ಏನೋ ಪ್ರಾಪರ್ಟಿ ಡೀಟೇಲ್ಸ್ ಅನ್ನ ಕೊಟ್ಟರು, ಲೋನ್ ಏನೋ ತಗೊಂಡು ಇವರೇ ಲೋನ್ ತಗೊಂಡು ಪ್ರಾಪರ್ಟಿ ಪರ್ಚೇಸ್ ಮಾಡಿರೋದು, ಅದನ್ನ ಇವ್ರು ಪರ್ಚೇಸ್ ಮಾಡ್ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಆ ಅಲಿಗೇಷನ್ ಇತ್ತಲ್ಲ. ಮದುವೆ ಆಗಿದೆ ಅವಾಗ
2019 ಫೆಬ್ರವರಿ.
ಸತ್ತಿರೋದು
25/12/2021.
ಆಲ್ಮೋಸ್ಟ್ 2.5 years. ಏನ್ರಿ ಫೋನ್ ಕಾಲ್ ಒಂದ್ ಬಿಟ್ರೆ ಇವ್ರಿಬ್ರ ಮೇಲೆ ಏನಿದೆ? ಯಾರು ವಿಟ್ನೆಸ್? ಈಗ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗಿದೆಯಲ್ಲ, ಪಂಚಾಯತ್. ಹಾ ಅಲ್ಲ, ಈಗ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಹಾಕಿದಾರ ಇಲ್ಲ? ಹಾಕಿಲ್ವಾ ಇನ್ನು? ಅಂಡರ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್. ಅವ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾನ? ಅಂಜನಪ್ಪ ಏನ್ ಹೇಳ್ತಾನ ಅವನು? ಹಾ ಹೇಳಿ.
ಈ ವಿಚಾರವಾಗಿ ನಾನು ಮಧ್ಯಾಹ್ನ ತಂದೆ ಕುಮಾರ ಹಾಗೂ ನಮ್ಮ ಏರಿಯಾ ಇನ್ನಿಬ್ಬರಿಗೆ ಮಧ್ಯಾಹ್ನ ತಂಡ ಕುಮಾರ್ ಹತ್ಯೆ ಕುಮಾರ್ ಹಾಗೂ ಮೈದಿನ ಕಿರಣ್ ಕುಮಾರ್ ಅವರಿಗೆ ಪ್ರತಿ ಮಾತುಗಳಲ್ಲಿ ಹೇಳಿ ಮಧ್ಯಾಹ್ನ ಚೆನ್ನಾಗಿ ನೋಡಿಕೊಳ್ಳುವಂತೆ ನ್ಯಾಯ ಪಂಚಾಯತಿ ಹಾಕಿದ್ದಾರೆ. ಮಧ್ಯಾಹ್ನ ತಂದೆ ಕುಮಾರ ಅರುಣ್ ಕುಮಾರ್ ಅತ್ತೆ ಭಾಗ್ಯಲಕ್ಷ್ಮಿ ಮಾವ ನಂದಕುಮಾರ್ ಹಾಗೂ ಮೈದಿನ ಅರುಣ್ ಕುಮಾರ್ ಅವರೊಂದಿಗೆ ಸೇರಿ ವರದಕ್ಷಿಣೆ ಈ ಬಗ್ಗೆ ತನ್ನ ಮಗಳು ತನಗೆ ಹೇಳಿದಾಗ ತನ್ನ ಮಗಳ ಜೀವನ ಸುಖವಾಗಲಿ ಎಂದು ಹಣ ಸಹಾಯ, ಅನಂತರವೂ ಮತ್ತೆ ಮತ್ತೆ ವರದಕ್ಷಿಣೆ ತರುವಂತೆ ಕಿರುಕುಳ ನೀಡುತ್ತಿದ್ದ ಬಗ್ಗೆ ತನ್ನ ಮಗಳು ಹೇಳಿದಾಗ ನನ್ನ ಮಗಳು 25-58 ಆದರೂ ಸಹ ನನ್ನ ಮಗಳ ಗಂಡ ಅತ್ತೆ ಮಾವ 5 ಜನ ಸೇರಿ ಪದೇ ಪದೇ ದೈಹಿಕವಾಗಿ ಮಾನಸಿಕವಾಗಿ ಕಿರುಕುಳ ನೀಡಿ
ಆಯ್ತ್ರಿ. ಈ ಪ್ರಾಪರ್ಟಿಗೆ ಲೋನ್ ಪರ್ಚೇಸ್ ಮಾಡಕ್ಕೆ he only avoid the loan. This is a false allegation. Now the time of marriage they gave 180 grams of gold ornaments. From the date of marriage they gave an amount of rupees 12 lakhs till date. ಹೋಗಿ ದುಡ್ಡು ಕೊಟ್ಟಿದ್ಕೆ ಏನಾರು ಇದೆಯಾ? ಅರ್ಲಿಯರ್ ಏನಾರು 12 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ವಿ, ಆಮೇಲೆ ಮದುವೆ ಆದಾಗ ಇಲ್ಲಿವರೆಗೆ ಅಂತ ಏನು ಇಲ್ಲ. The daughter was looked after very well for a period of 1 year. Thereafter, these petitioners and also the husband subjected her for both mental and physical cruelty as well as demanded additional dowry. And also helped whenever they made the demand. It is also an allegation that in order to purchase the property, It is also alleged in the complaint that he had purchased the property in the joint name of his daughter and joint name joint name of his daughter and also the son-in-law, measuring 30 into 58. But in spite of that, they have continued the harassment. In this regard, Panchayat was also held. And after the Panchayat, they left the daughter in the matrimonial home. That on 25/12/21, before committing the suicide, she also called called them at 9:30, and within 2 hours they have received the information that his daughter committed suicide at around 11:30, and hence requested to take action against these petitioners and also against her husband. Based on the complaint, case has been registered for the offence resolution 304A, 304B. Only 304B ಅಲ್ಲ,
34.
and Red Section 34. Harassment ಏನು ಇಲ್ವಲ್ಲ, cruelty ಏನು ಇಲ್ಲ. Counsel appearing to the petitioner would submit that the very allegation made in the complaint that property is purchased by the complainant in the name of wife and daughter and son-in-law is false. And in support of his contention, he also produced the copy of sale deed as well as encumbrance certificate and also the document to show that he only availed the loan from the bank and made the payment. No help. The counsel also would submit that the other allegation that Panchayat was held is false. No harassment is made to the deceased before committing the suicide by the victim. And the petitioner number 1 and 2 in criminal petition number 336 of 2022 are the parents of the accused number 1 and accused number 4, who is the brother of the accused number 1 in criminal petition number 377 of 2022, and he has been arrested and he has been in custody from 26/12/2021. The counsel also would submit that no need of actual aspects. Attention. Petitioner contention. The counsel also would submit that no need of further custodial trial, further custodial interrogation in respect of the accused number 4. And petitioners, that is accused number 2 and 3, are ready to obey the conditions that may be imposed by this court, and they are ready to cooperate with the further investigation in the matter. Subcontra, the counsel appearing for the state would submit that the Panchayat statement is recorded by the IWOD and investigation is not yet completed, and specific allegation is made in the complaint against the in-laws also, and not a case for invoking 438 of CRPC. The counsel also would submit that before committing this research, he made phone call to the parents, and call details are also tallies with making the said phone call, and hence there is a prima facie case. Having heard the respective counsel and also taking into note of offense invoked under section 498A and only offense invoked under section 304B, that is because in a span of 2.5 years the victim has committed suicide, and no particulars is given with regard to payment of dowry as alleged in the complaint, and also the prima facie documents placed by the petitioners that the husband only availed the loan in order to purchase the site, since the complainant claims that he only bought the property, but documentary evidence discloses that the husband availed the loan. Having taken note of the allegations made in the complaint as well as the accused number 4, who is the brother-in-law, that is brother of accused number 1, was arrested in the month of December 2022, and taking into note of the consideration and also the call details of the victim prior to committing suicide, no custodial further investigation is required in respect of accused number 4 is concerned. The accused number 2 and 3 are the in-laws, and no specific allegations are made against them. except making general omnibus allegation, and hence it is a fit case to exercise the discretion under section 438 as well as under section 439 of CRPC in respect of sections number 2 to 4 with conditions. ಒಟ್ಟಿಗೆ 60 ಒಟ್ಟಿಗೆ ಹೇಳಿ 59 and 61 60 ದಿನೇಶ್ ಕುಮಾರ್ ರಾವ್ ಹೇಳಿ ಮೇಡಮ್. ಪ್ರೊಕ್ಲಮೇಶನ್ ಏನಿದೆ, ಏನು ಆಗಿದೆಯಾ? ಪಾಸ್ ಓವರ್ ಆಯ್ತು, ಪಾಸ್ ಓವರ್. 62 ವೆಂಕಟೇಶ್ ಸೋಮರೆಡ್ಡಿ. ಹಾ ಹಾ ಹೇಳಿ. ಹಾ 2 days ಆಯ್ತು. HCGP seeks 2 days time. This matter on 24th. 63 ಪ್ರದೀಪ್ ಕೇಸಿ. ಪ್ರದೀಪ್ ಕೇಸಿ ಇಲ್ವಾ? ಪಾಸ್ ಓವರ್. ಹೋಗ್ಸೋ ಇದೆ, ಅದೇನೆ ಪಾಸ್ ಓವರ್ ಮಾಡಿದೆ. ಯಾಕೆ ಫಸ್ಟ್ ಟೈಮ್ ಆರ್ಡ್ ಶೀಟ್ ನೋಡಿ ಮೇಡಮ್. ಫಸ್ಟ್ ಟೈಮ್ ಆಯ್ತು. HCGP 6 ಟೈಮ್ 3 days ಟೈಮ್ ಇರ್ಬೇಕಲ್ಲ, ನೀವು ಫಸ್ಟ್ ಟೈಮ್ ಅಂತೀರಿ. ಹಾಕಿ ನೋಡೋಣ 24th ಹಾಕಿ. Petitioner counsel is absent. HCGP 6 time. This matter on 24th. 64 Giri K. Victim 16 years 8 months. 4 and 6. Victim ಇಟ್ಕೊಂಡು ಏನ್ ಮಾಡೋದು ನಾವು? Victim ನೋಡ್ಕೊಂಡು ಆರ್ಡರ್ ಬರೆಯಕ್ಕೆ ನಾನು. Only court has to look into the material ಅಷ್ಟೇ. Why you are keeping the victim before the court? Engage ಮಾಡಿದಾರ ಅವರು ಅಡ್ವೊಕೇಟ್ ನ? ಮಾಡಿದಾರ? ಯಾರನ್ನ ಮಾಡಿದಾರ? ಮಾಡ್ತೀರಾ ನೀವು? ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದು ಅಂತಂದ್ರೆ ಪಾರ್ಟಿ ಮಾಡಿಲ್ದ ಹೋಗಿದ್ರು ಕೂಡ ನಿಮ್ಗೆ ಅವಕಾಶ ಇದೆ ಅಂತಾನೆ. ಇನ್ ವ್ಯೂ ಆಫ್ ದಿ ಅಮೆಂಡ್ಮೆಂಟ್. ಆಯ್ತು ಮೇಡಮ್, ಏನ್ ಮಾಡ್ತೀರಿ ನೀವು? ಅವ್ರಿಗೆ ಕೊಡ್ತೀರಾ ಅಥವಾ ನೀವೇ ಪರವಾಗಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತೀರಾ? ನೀವು ಎಂಗೇಜ್ ಮಾಡೋದಾರ ನಮ್ದೇನ್ ಅಭ್ಯಂತರ ಇಲ್ಲ. ಏನ್ ಮಾಡ್ತೀರಿ ಹೇಳಿ? ನಾವು ಬೇಲ್ ಆರ್ಡರ್ ಕೊಡಕ್ಕಿಂತ ಮುಂಚೆ ನಿಮ್ಗೆ ನೋಟಿಸ್ ಕೊಡ್ಬೇಕು. ಕೊಟ್ಟಿದೀವಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಪ್ರಕಾರ. ಬಿಕಾಸ್ ಬಿಲೋ ದಿ ಏಜ್ ಆಫ್ ಎಷ್ಟು 14 years 8 months ಎಷ್ಟು 16 16 years 8 months ಏನ್ರಿ? Why we ordered notice? ಇಲ್ಲ 16 hours ಮಾತ್ರ ಕೊಡ್ಬೇಕಲ್ಲ. ಆಯ್ತು, ಏನ್ ಮಾಡ್ತೀರಿ ಮೇಡಮ್ ನೀವು ಹೇಳಿ? ಮಾಡ್ತೀರಾ? ಮಾಡಿ, ಪರವಾಗಿಲ್ಲ. ವಕಾಲತ್ತಲ್ಲ, ಇದನ್ನ ಹಾಕಿದ್ರು ಸಾಕು. ಇವನ್ ನಿಮ್ಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ವಿ. ಯಾವಾಗ ಬೇಕು ಹೇಳಿ? ಎಷ್ಟು ದಿವಸ ಟೈಮ್ ಬೇಕು? ವಿಕ್ಟಿಮ್ ಅಪಿಯರ್ಡ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್ and also the counsel Srimati DK Kamala submits that victim is seeking legal assistance through her and hence seeks time and hence list this matter on
victim consent married and they were living together. The complaint is by the CDPO. Victim has not made any complaint, not their family members. It is the CDPO.
ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಕನ್ಸಿಡರ್ ಮಾಡೋಣ. ಈಗೇನ್ ನಾನೇನು ಮಾಡಕ್ಕಾಗಲ್ಲ. ಕನ್ಸೆಂಟ್ ಇಟ್ ನಾಟ್ ಎ ಕನ್ಸೆಂಟ್ ಅಟ್ ಆಲ್ ಅಂಡರ್ ಲಾ. ಮತ್ತೆ ಈಗ ಹೊರಗಡೆ ಬರುವಾಗ ಇಲ್ಲ ನಂದೇ ಮಗು ಎಲ್ಲ ಹೇಳ್ತಾನೆ, ಆಮೇಲೆ ಶುರು ಆಗ್ತದೆ ಎಲ್ಲ. ಆಯ್ತು, ಅದೇನ್ ಹೇಳ್ತೀರಾ ನೀವ್ ಹೇಳಿ ಮೇಡಮ್, ಕೇಳ್ತೀನಿ ನಾನು. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಡೇಟ್ ಕೊಡ್ರಿ. ಎಷ್ಟು ದಿವಸ ಬೇಕು ಮೇಡಮ್? ಈ ಮಂಡೆಗೆಲ್ಲ ಆಗೋದಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ 3 ದಿವಸ 3 days ಇಲ್ಲ, ಹಾಫ್ ಡೇ ಸಿಟ್ಟಿಂಗ್. ಬೇರೆ ದಿವಸ ಕೊಡಿ. 24th ಕೊಡಿ. 24th ಇನ್ನೊಂದಿದೆಯಾ? ವೆಂಕಟೇಶ್ ಸೋಮರೆಡ್ಡಿ. ಇದ್ರಲ್ಲಿ ನೀವೇ ಅಪೇರ್ ಆಗದ? ಎಷ್ಟು? ವಾಟ್ ಈಸ್ ಅವರ್ ಏಜ್? 10 years. ಅವಳನ್ನ ಮದುವೆನು ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟವ್ರ? 9, 10 ಏನೋ ಇನ್ನೂ ವರ್ಕ್ ಮಾಡ್ದಂಗಿದೆ. ಚೈಲ್ಡ್ ಮ್ಯಾರೇಜ್ ಆಕ್ಟ್ ಇಲ್ವಾ? 9, 10, 3 and 4. ಹೇಳಿ. 2 accused persons. ನೀವು ಇಬ್ರಿಗೂ ಹಾಕಿದ್ದೀರಾ? 1 and 2.
ಹೌದು.
ಹೇಳಿ. Victim is aged about 10 years.
10 years. Two and his wife.
Accused number?
And his wife accused number 3.
Accused number 3 nu idara?
Wife is
But 3 is not before this court.
granted bail.
3 granted bail anta. Aake ಏನು allegation?
ಇಲ್ಲ, allegation assisted.
Only assisted in.
Husband in the allegation is accused number 2 adopted the victim 10 years. Girl and her brother. And they were
Both na. Adopted victim girl as well as brother.
And they were staying in Mysore. At that stage, he was indulging in
Staying where they were staying?
Mysore, in their house.
In the house of this petitioner.
Number
1 and 2 yaro?
Number, there is allegation in the accused number 1 is when in the charge sheet accused number.
Yeah, 376 ಯಾರ ಮೇಲೆ ರೀ? Both. Ivrenu, what is the relationship between A1 and A2?
One is the relative of accused number 2.
Relative. You both are relatives.
Was taken by
Both are relatives who adopted?
Allah, adopted by accused number 2.
Accused number 2.
Okay, accused number 2. My lord, accused number 3 is the wife of accused number 1, 2. Accused number 3 is how this is Mudvili. Allegation is the accused number 3 had taken the victim to Mudvili. In our house, when nobody was there, accused number went there and also committed the act. Number 2 is concerned, the allegation is in the house. Lord, the first report is number 6.
Page number 46.
Statement recorded by the police.
ಪೊಲೀಸ್ನವ್ರದಾ? ಪೊಲೀಸ್ನವ್ರು ಬಿಟ್ಬಿಡಿ, ನಾನು ನೋಡೋದಿಲ್ಲ ಈ ಟೈಮಲ್ಲಿ. ನಾನು ನೋಡೋದೇ ಓನ್ಲಿ 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ಏನಾರು ಇದೆಯಾ? ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ಏನಾರು ಇದೆಯಾ? ಅರ್ಲಿಯರ್ ವಸ್ತು ನಾನು ನೋಡೋದಿಲ್ಲ, ಹೇಳಿದ್ನಲ್ಲ ಪೊಲೀಸ್ ರಿಪೋರ್ಟ್ ನಾನು ನೋಡೋದೇ ಇಲ್ಲ. ಈಗ ಏನಿದೆ? 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆಯಾ? ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ಏನಿದೆ ಹೇಳಿ.
Number 2, I don't find anything against the file. Charge sheet file.
ಏನ್ ಹೇಳ್ರಿ? ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ಏನ್ ಹೇಳಿ?
Medical evidence
that there is nothing to suggest that he avundadu akedu there is a sign of vaginal penetration.
I lift my lot because of 164 I am not able to explain.
Aaytu.
Other
164 I mean told
my lord the user is the 164 then my lord.
ಏನಪ್ಪ ಸಮಾಜ 10 ವರ್ಷದ ಮಕ್ಕಳನ್ನು ಬಿಡಲ್ಲ ಅಂದ್ರೆ
First report, irrigation is against number 2 only. It stated she left the house and went out and stating that father, the adoptive father is beating me, is troubling me to study Kannada. I did not study, therefore he said, Madilante, I will punish you. Then he went out of his house. And then she states, she's taken to women health center, etc. Then the allegation made is that he was indulging unnatural acts. Thereafterwards. So version of number 2 is that he was treating her for the reason beating her because he did not attend to her studies. And subsequent version is not true, his version. My God. This entire version appears to be because
A2 against
A2 ಮಾತ್ರ ಇದೆ, A1 ಮೇಲೆ ಏನೂ ಇಲ್ಲ.
ಫಸ್ಟ್ ರಿಪೋರ್ಟ್ 164
ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಕೂಡ A1 ಮಾತ್ರ ಇದೆ. FIR ಅಲ್ಲಿ ಕೂಡ irrigation A1 ಮೇಲೆ ಮಾತ್ರ. FIR and police statement recorded, everything is only A2.
A2 ये ಕಂಪ್ಲೇಂಟ್ ಯಾರು ಕೊಟ್ಟಿರೋದು?
By the
first by the
worker, page 11.
police ಇವ್ರದ
ಮಕ್ಕಳ ರಕ್ಷಣಾ
CDPO ಇರಬೇಕು, ಚೈಲ್ಡ್ ಪ್ರೊಟೆಕ್ಷನ್ ಆಫೀಸರ್. ಅವ್ರು ಫಸ್ಟ್ ಏನ್ ಹೇಳಿರ್ತಾಳೋ ಅದ್ರ ಮೇಲೆ ವಿಕ್ಟಿಮ್ ಕಮ್ಸ್ ಅಂಡ್ ಸೇಸ್ ಅಲ್ಲ ಇಬ್ರ ಮೇಲೂ.
And based on the detailed statement also, page number 46, in the recording in the hospital by women officers in Bhakti. There also irrigation is against it number 2 only.
Told. How did the petitioner counsel and also the counsel appearing for the state? The factual matters of the case of the prosecution is that these two accused persons who have been arraigned as accused number 1 and 2 subjected the victim girl who is aged about 10 years sexual act. And at the first instance, complaint is registered based on the complaint of the CDPO. And the victim girl is also subjected to medical examination, wherein the medical examination report is that hymen is not intact, and also she is subjected to sexual act. And there was a penetration. The victim girl is also examined before the learned magistrate under 164(5) of CRPC, wherein also the victim girl stated that both of them subjected her for sexual act. The counsel appearing to the petitioner would the police have investigated the matter and also filed the charge sheet for the offences punishable under section 376(2)(f) and 276(2)(I) and N. Also understand 9, 10, 3 and 3, 4. In bringing the special enactment in order to curb the sexual act against the children. Not a case for exercising the discretion. The discrepancy pointed out by the petitioner cannot be considered at this juncture, and it is a matter of trial. You know, of the discussions made, I pass the following order. Bail petition is rejected. 66 M. Krishna Gowda. ಹೇಳ್ರಿ ಏನಾಯ್ತು
ಇನ್ಮೇಲೆ ಏನಿದೆ ಅಲಿಗೇಷನ್ ನಂಬರ್ 1 to 12 ಅರೆಸ್ಟ್ ಮಾಡ್ತಾರೆ
1 to 12
ಅರೆಸ್ಟ್ ಮಾಡ್ತಾರೆ ಸರ್
1 to 12 ಅಂದ್ರೆ ಅದರಲ್ಲಿ 1 to 12 ಒಳಗೆ ನೀವು ಒಬ್ರು ಇದೀರಿ 9
10, 11, 12 are granted bail permission.
12?
10, 11, 12.
10 to 12 granted bail. ಈ ಕೋರ್ಟ್ ಅಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲ ಏನ್ ರೀಸನಿಂಗ್ ಏನು
ರೀಸನಿಂಗ್ ಏನಂದ್ರೆ ಇವ್ರಿಗೆಲ್ಲ ಬೇಲ್ ಆಗಿರೋದು
ನಾವೇ ಮಾಡ್ದಂಗಿದೆ. ಹೌದು, ಏನ್ ರೀಸನ್ ಏನು ಅಂತ
ಏನಂದ್ರೆ ಅವ್ರು 3 ಸಲ ಬೇಲ್ ಕೊಟ್ಟಿರೋದು 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ವಿಕ್ಟಿಮ್ ದ ಏಜ್ ಆಫ್ 19 ಇಯರ್ಸ್. ಆ ವಿಕ್ಟಿಮ್ ದ ಏಜ್ ಆಫ್ 19 ಇಯರ್ಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ 11 ಪೇಜ್ 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆ. 11 ಪೇಜ್ ಅಲ್ಲಿ ನನ್ನ ಹೆಸರು ಹೇಳಿಲ್ಲ. ಅದೇ ರೀತಿ 10, 11, 12 ಕೂಡ ಸ್ವಾಮಿ. 10, 11, 12 ಹೆಸರು 9 ಹೆಸರು ಹೇಳಿಲ್ಲ.
10 and 11 granted bail. ಹೌದಾ? ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ 74, 748 ಅಲ್ಲಿ ಅಕ್ಯೂಸ್ ನಂಬರ್ 12 ಇರ್ಬೋದು.
ಹೌದು, ಹೇಳಿದೆ ಸ್ವಾಮಿ.
12 ಸೇಮ್ ಸಿಮಿಲರಾ? ಏನು ಹೇಳಿಲ್ವಾ? ಬಟ್ ಅರ್ಲಿಯರ್ ರೀಸನ್ಸ್ ಅದೇ ಹೇಳಿರೋದಲ್ವಾ? ನೋ ಸ್ಪೆಸಿಫಿಕ್ ಅಲಿಗೇಷನ್ಸ್ ಮೇಡ್ ಅಗೇನ್ಸ್ಟ್ 164 ಸ್ಟೇಟ್ಮೆಂಟ್. ಬಟ್ ಏನ್ ಬೇರೆ ಏನು ಇವನ್ ಮೇಲೆ ಅಲಿಗೇಷನ್ ಸೇರಿದ್ರು ಅಂತ ಅಷ್ಟೇ. ಬಟ್ 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇಲ್ಲ. Only on that reason only this court granted bail in favor of accused number 10 to 12. Similar order, madam. Similar order. ಮತ್ತೆ ಬೇರೆ no changes. ಇಲ್ಲ ಇದೆ ಹಾಕಿದ್ದಾರೆ, ಅದರಲ್ಲಿ ಕಾಪೀಸ್ ಇದೆ, ಅವರೇ ಹಾಕಿದ್ದಾರೆ. GM ಶ್ರೀನಿವಾಸ ರೆಡ್ಡಿ. 439 ಹೇಳಿ. ಏಜ್ ಹೇಳಿ. ಏಜ್ 14 ಇಯರ್ಸ್. ಇಲ್ಲ, ಇವೆಲ್ಲ ನೋಡುವಾಗ ಇನ್ನೇನೋ ಡೆತ್ ಸೆಂಟೆನ್ಸ್ ಮಾಡ್ಬೇಕು ಇವಕ್ಕೆಲ್ಲ. ಇಲ್ಲಾಂದ್ರೆ ಕಂಟ್ರೋಲ್ ಮಾಡಕ್ ಆಗೋದಿಲ್ಲ. ಏನ್ರಿ 10 ವರ್ಷದ ಮಕ್ಳನ್ನು ಬಿಡಲ್ಲ, 6 ವರ್ಷದ ಮಕ್ಳನ್ನು ಬಿಡಲ್ಲ. ಅಲ್ಲ, ನಾ ಹೇಳಿದ್ದು ಇನ್ಮೇಲೆ ಚೈಲ್ಡ್ ಅಫೆನ್ಸಸ್ಗೆಲ್ಲ ಡೆತ್ ಸೆಂಟೆನ್ಸ್ ಮಾಡ್ಬೇಕು. ಆಗ್ಲೇ ಏನಾದ್ರು ಕಡಿಮೆ ಆಗುತ್ತೆ ಅನ್ನೋ ನೋಡ್ಬೇಕು. ಹಿಂದೆಲ್ಲ 16 ರಿಂದ 18 ಏನೋ ಕನ್ಸೆಂಟ್ ಅದು ಇದು ಅಂತಿದ್ರು. ಸ್ಪೆಷಲ್ ಎನಾಕ್ಟ್ಮೆಂಟ್ ತಂದ್ವಿ. ಸ್ಪೆಷಲ್ ಎನಾಕ್ಟ್ಮೆಂಟ್ ತಂದ್ಮೇಲೂ ಹಿಂಗೆ. ನಿಮ್ಮೇಲೆ ಏನ್ ಹೇಳಿ ಹೋಗಿ.
ಫೋನ್ ಮಾಡ್ತಾ ಇದ್ದ
ಲವ್ ಬಿಟ್ಬಿಡಿ, 14 ವರ್ಷ ಲವ್ ಏನು. ಆಮೇಲೆ ನೋ ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್. ನೋ ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ಅಂತಂದ್ರೆ ಎಲ್ಲಿದೆ ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್? ತೋರಿಸ್ತೀರಾ ಸ್ವಲ್ಪ? ಯಾಕೆಂದ್ರೆ ಸಬ್ಮಿಷನ್ ನಂಬಂಗಿಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ಐ ಶುಡ್ ಲುಕ್ ಇನ್ ಟು ದಿ. ಎಲ್ಲಿದೆ? ಎಲ್ಲ ಹಾಕಿದೆ ನೀವು? ಹಾಕೇ ಇಲ್ಲ, ಕೋರ್ಟ್ ಮುಂದೆ ಹಾಕೇ ಇಲ್ಲ ನೀವು. ಏನ್ರಿ ಹೇಳ್ರಿ, ನೀವೇ ಹೇಳ್ರಿ, ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ? ನೋ ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್. ಉಳಿದೇನೆ 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆ, ಅದ್ರಲ್ಲಿ ಏನ್ ಹೇಳ್ತಲ್ಲ?
ಫೋನ್ ಮಾಡ್ತಾ ಇದ್ದ.
ಮುನಿರಾಜ್ ಎಂಬವನು ಪರಿಚಯ ವರ್ಷಗಳಿಂದ ಇದೆ. ನಾನು ಅವನನ್ನು ತಿಳಿಸುತ್ತಿದ್ದ. ಅವನು ನನ್ನ ಮೇಲೆ ರೇಪ್ ಮಾಡಿಲ್ಲ. ನಾನು ಅವನಲ್ಲಿ ಮಾತನಾಡುತ್ತಿದ್ದೇನೆ. ಆ ವಿಷಯ ನಮ್ಮ ಮನೆಯಲ್ಲಿ ಗೊತ್ತಾಯ್ತು. ನಂತರ ನನ್ನ ಅಜ್ಜಿಯ ಮನೆಗೆ ಕಳುಹಿಸಿದರು. ಮುನಿರಾಜ್ ನನ್ನ ಜೊತೆ ಗೊತ್ತಿರಲಿಲ್ಲ, ಆದರೂ ಸಹ ಅವನ ವಿರುದ್ಧ ಸುಳ್ಳು ಪ್ರಕರಣ ದಾಖಲಿಸಿದ್ದಾರೆ. ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ಇದೆಯೋ ಇಲ್ಲ? ರೀಸೆಂಟ್ ರೀ ಅದು. ರೀಸೆಂಟ್ ಅಂತ ಹೌದಾ? ವರ್ಡ್ ಈಸ್ ಯೂಸ್ಡ್ ರೀಸೆಂಟ್ ಅಂತ. ಮತ್ತೆ ಅದು ಮಾತ್ರ ಅದನ್ನ ಹೇಳೋದಿಲ್ಲ ನೀವುಗಳು. ಅದಕ್ಕೆ ಹೇಳಿದ್ದು ನೋಡ್ಬೇಕು ಅಂತ. ಲಾಯರ್ ನಂಬಂಗಿಲ್ಲ ಅಂತ. ಓಲ್ಡ್ ಏನೋ ಇದೆ ನೋಡಿ, ಶೋಸ್ ಓಲ್ಡ್. ಕಾಲಮ್ ನಂಬರ್ ಮಾತ್ರ ಇಲ್ಲೇನ್ರಿ? ಅದೇ ನಾನು ನೋಡ್ತಾ ಇದ್ದೆ, ನನಗೂ ಸ್ವಲ್ಪ Hold. ಮೇಲ್ಗಡೆನ ಬರ್ದಿದ್ದಾರೆ ಹೈಮನ್ ಜೆರಾಕ್ಸ್ ಸರಿ ಇಲ್ವಲ್ರಿ ಹೈಮನ್ ಟೇರ್ ಅದು ಟೇರ್ ಪ್ರೆಸೆಂಟ್ ಆಯ್ತು 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅವಳೇನು ಹೇಳೋದಿಲ್ವಲ್ಲ ಇದೆಯಾ ಇಲ್ಲ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾಳೆ ಹೈಮನ್ ಮೇ ಬಿ ಟೋರ್ನ್ ಬಿಕಾಸ್ ಆಫ್ ಅದರ್ ರೀಸನ್ಸ್ ಆಲ್ಸೋ ಅಲ್ವಾ ನೋಡಿ heard the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that the victim girl who is aged about 14 years subjected to this petitioner. Based on the complaint, police have registered the case and the victim is also subjected to medical examination wherein the opinion of the doctor is that there was a wound tear in the hymen. Recent evidence of subjecting her for sexual act. The victim is also examined before the learned magistrate, wherein she has stated that she was not subjected to sexual act. Only both of them are loving each other, and he used to make phone call her, and when the same comes to note of the family members, she was shifted to her grandparents' house. The counsel appearing for the petitioner would submit that there is no any subjecting her for sexual act. Medical opinion is also that shows that no recent evidence of sexual act, and victim girl also not stated anything against the petitioner 164 statement, and hence may be enlarged on bail. The counsel appearing to the state would submit that victim girl is 14-year-old, and there is a medical evidence that hymen, there is a old hymen tear. And also the state counsel appearing to the state not disputes the fact that in 164 statement she has not narrated anything. Having heard the respective counsel and also taking into note of the victim girl is aged about 14 years and the very victim it made the statement before the learned magistrate under 164(5). When the same comes to notice of their parents, which was shifted to our grandparents' house, and specific statement is made that he was not subjected to any sexual act. No doubt there is a old hymen tear. The doctor has pointed that there is no any evidence of recent for sexual act. And when such being the material available on record, when the victim girl has not stated anything about subjecting her for sexual act, and the hymen will be torn for some other reason also, and not found any prima facie material against the petitioner. And when such being the case, it is a fit case to exercise the powers of 439 Allah, 439 of CRPC with conditions. ಮಧ್ಯಾಹ್ನ ಸಿಟ್ಟಿಂಗ್ ಇದೆಯಲ್ಲ, ಮಧ್ಯಾಹ್ನ ಕೂತ್ಕೊಳ್ಳಿ. ಮಧ್ಯಾಹ್ನ ಲಾಸ್ಟ್ ಟೈಮ್ ಆಲ್ ಡೀಟೇಲ್ಸ್ ಅನ್ನ ಕೇಳಿದ್ವಲ್ಲ ಯಾರು? ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ? ಆಯ್ತು ತಗೊಳ್ಳಿ. Petitioner counsel submits that police have filed the charge sheet and seeks time to place the charge sheet. When do you want? Yes, Friday.
May make a mention, Lord.
ಹೇಳ್ರಿ. ಒಂದ್ ನಿಮಿಷ ಇರಿ, ಅವ್ರದಿನ್ನು ಕಂಪ್ಲೀಟ್ ಮಾಡೋಣ ಇರಿ, ವೇಟ್
I'm sorry.
ದಿಸ್ ಫ್ರೈಡೆ ಯಾವಾಗಲೂ ಮೇಡಮ್? ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ 25th ಆಯ್ತು. ಯಾಕೆ ವೈ ವಾಂಟ್ 25th? ಯು ಡೋಂಟ್ ವಾಂಟ್ ದಿಸ್ ಬೆಂಚ್? ಯು ಡೋಂಟ್ ವಾಂಟ್ ದಿಸ್ ಬೆಂಚ್? 24th ಆಯ್ತು, 24th.
Serial number
ನೋಡ್ರಿ, ಕಾಲ್ ಡೀಟೇಲ್ಸ್ ತರಿಸಿದ್ರೇನ್ರಿ ನೀವು? ಲಾಸ್ಟ್ ಟೈಮ್ ನೀವು ಟೈಮ್ ತಗೊಂಡಂಗಿತ್ತು ಕಾಲ್ ಡೀಟೇಲ್ಸ್ ಬಗ್ಗೆ. ತರಿಸಿದೀರಾ? ಓಕೆ, ಹಾ ಹಾ ಆಯ್ತು. Now any other counsel is making submission that already charge sheet is filed, then it should contain the call details also. Right. 24th. Next. Remaining matters at 2:30. ಹೇಳಿ ಶ್ಯಾಮಸುಂದರ್, ಏನ್ ಹೇಳಿ?
ಸೀರಿಯಲ್ ನಂಬರ್ 91 ಮಲೋಡ್ ಬೆಳಗ್ಗೆ ಹೇಳಿದೆ, ಮಧ್ಯಾಹ್ನ ನನಗೆ
ಏನಾಗಿದೆ? 91 ಯಾವಾಗ ಬೇಕು ಹೇಳಿ?
ಎನಿ ಡೇ, ಮಂಡೇ ಹಾಕಿದ್ರು ತೊಂದರೆ ಇಲ್ಲ.
ಮಂಡೇಗಿಲ್ಲ, ಮಂಡೇ ಫಸ್ಟ್ 3 days ಆಗೋದಿಲ್ಲ. ಏನಾಯ್ತು? ಓನ್ಲಿ ಇದೆ ಅಷ್ಟೇ ಅಲ್ವಾ? ನಿಮಗೆ ಬೇರೆ ಯಾರು ಕೊಲೀಗ್ಸ್ ಇಲ್ವಾ? ನಿಮಗೆ ಬೇರೆ ಕೊಲೀಗ್ಸ್ ಇಲ್ವಾ? ನೀವು ಒಬ್ಬರೇನ ಇರೋದು ಆಫೀಸಲ್ಲಿ?
ಹೌದಲ್ಲ, ಈ
ಅಲೋ ದೆಮ್ ಟು ಆರ್ಗ್ಯೂ. ರಿಜೆಕ್ಷನ್ ಇದ್ರೆ ನೋಡೋಣ, ಆಮೇಲೆ ನೋಡ್ತೀನಿ. ಅಲೋ ಆಗೋದಿದ್ರೆ ಅವ್ರಿಗೆ ಅವಕಾಶ ಕೊಡೋಣ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಲಿ.
ಒಂದೇ ಒಂದು ಸಬ್ಮಿಷನ್ ಅಷ್ಟೇ, ಒಂದೇ ಒಂದು ಸಬ್ಮಿಷನ್. ಇನ್ ಫ್ಯಾಕ್ಟ್ ಮೈ ಲಾರ್ಡ್, ದಿಸ್ ಇಸ್ ಆಲ್ಸೋ ಆನ್ ಪ್ಯಾರಿಟಿ ಗ್ರೌಂಡ್. ಬೇರೆ ಮೈ ಲಾರ್ಡ್ಸ್ ಅಲೋನ್ ಮೈ ಲಾರ್ಡ್ ಹ್ಯಾವ್ ಎನ್ಲಾರ್ಜ್ಡ್ ಮೈ ಲಾರ್ಡ್ another accused my lord on bail, who is my lord, this accused my lord is even on a better footing.
Let you give instructions to your colleague, let them argue. If your presence required, then I will hear you also.
ಸಾಧ್ಯವಾದಷ್ಟು ನಾನೇ ಅಪಿಯರ್ ಆಗ್ತೀನಿ my lord, in case if I am not there, some of my colleagues.
ಅವ್ರಿಗೂ ಕೊಡ್ರಿ, ಅವಕಾಶ ಕೊಡ್ರಿ, ಯಂಗ್ಸ್ಟರ್ಸ್ ಗಳಿಲ್ಲಿ. ಎಲ್ಲ ಬರೀ ನೀವೇ ಮಾಡ್ತಾ ಇದ್ರ? allow them to open their mouth.
ಹೌದು,
ಆಯ್ತು. ಆಮೇಲೆ ನೀವೇ ಹೇಳಿ ನಿಮ್ ಕ್ಲೈಂಟ್ಗೆ, ನಾನೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದೆ ಅಂತ, ಪರವಾಗಿಲ್ಲ.
ಇಲ್ಲ ಆತರ ಇಲ್ಲ, ಹೇಳಕ್ಕಾಗತ್ತೆ.
Let them open their mouth. Yes, any submission? 41 ಏನಾಯ್ತು ಅದು? ಹಾ,
one contention that the petitioner has not approached the sessions court.
ಹಾ 439 ಬರ್ಬೋದಾ? ಈ ಕೋರ್ಟ್ಗೆ ಬರ್ಬೋದು. ಮತ್ತೆ both court having concurrent. ಅವರು ಅಲ್ಲಿಗೆ ಹೋಗಿ ಮತ್ತೊಂದ್ಸರಿ ಇಲ್ಲಿಗೆ ಬರೋದು ಬೇಡ ಅಂತ ಡೈರೆಕ್ಟ್ ಆಗಿ ಇಲ್ಲಿಗೆ ಬಂದಿದ್ದಾರೆ ಅಷ್ಟೇ. ದಟ್ಸ್ ಆಲ್. ಆಯ್ತು. 83. What do you want, madam? What do you want? No, last time also PT. Praise time. Earlier your counsel praise time. Last occasion also no time. But 6 ಗಂಟೆ ಆದ್ರೂ ಕೂತ್ಕೊಂಡು ಎಲ್ಲ ಹಿಯರ್ ಮಾಡ್ತೀನಿ. ಅಪ್ ಟು 105 ಇದೆ, ಪ್ಲಸ್ ಬೆಂಚ್ ಬೇರೆ ಇದೆ. ಕೂತ್ಕೊ ಬರ್ಲಿ ಅವರು. ನಾನು I will sit it up to 6:30. I will sit up to 6:30 to accommodate your senior. Get him. Or otherwise you argue. ನಮ್ಮ ಕೋರ್ಟಲ್ಲಿ ಏನು ಸೀನಿಯರ್ ಜೂನಿಯರ್ ಇಲ್ಲ. Only you have to present the case, that's all. ಸೀನಿಯರ್ ಬಂದ್ರು ಅದೇ ಆರ್ಡ್ರು, ಜೂನಿಯರ್ ಬಂದ್ರು ಅದೇ ಆರ್ಡ್ರು. Only you have to present the case, that's all. ಸರಿನಾ?
ಮುಂಜಾನೆ ನಂಗೆ ಏನ್ ಹೇಳಿದ್ರು ನೀವು ಏನು ಅದೇ ಡೆತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಆಗ್ಯದ ಅಂತ ಹೇಳಿನ್ರಿ ಮತ್ತೆ ಅವ್ರು ಈಗ ಲೆಟರ್ ಬರತ್ತು ಮತ್ತೆ
ಹಲೋ ಕೇಸರ್ಕರ್ ಸರ್ ಇದ್ದೀರಾ?
Two 00164 of 2022 criminal petition number. Hello, sir.
ಸರ್ ಲಿಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 18 ನೋಡಿ ಸರ್ ಒಂದು ಸ್ವಲ್ಪ.
Hello, sir. Hello. Hello. Hello.
हेलो हाँ कौन सा ये कहाँ से बात कर रहे हैं? हेलो यार परशुराम ತಪ್ಪದು ಬಂತು ಪ್ರಿಂಟ್ ಫೈಲ್ ಮಾಡಿ ಹೋಗ್ಬಿಡು ಚಾರ್ಜ್ ಮೇಲೆ ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ ಏನ್ ಹೇಳ್ತಾವ ದಿವಸನೇ ದವಾಖಾನೆಗೆ ಹೋಗಿ ಅಡ್ಮಿಟ್ ಆಗಿನಂತ ಸರ್ಕಾರ ದವಾಖಾನೆ.
Sir, kind attention, please.
Sir,
Dharwad and Kalburgi bench advocates idara.
ಕಲಬುರಗಿ ಬ್ರಾಂಚ್ ಸರ್ ನಮ್ದು.
ಧಾರವಾಡ ಲೆಕ್ಚರ್ ಇದ್ದಾರಾ?
ಇಲ್ಲ ಸರ್, ನಾ ಕಲಬುರಗಿ ಮಾತಾಡ್ತಾ ಇದ್ದೀನಿ.
ನಮ್ಮ ಹೆಸರು ಸರ್?
ನಂಬರ್ 2 ಹೌದು ಸರ್.
ಅವಿನಾಶ್ ಮಂಗಡಿ ಇದ್ದಾರಾ?
ಇಲ್ಲ ಸರ್.
ಇದೀವಿ ಸರ್, ಇದೀವಿ.
ಇದ್ದೀರಾ? ಶರಣ್ ಬಸಪ್ಪ ಕೆ 2:30. ಶರಣ್ ಬಸಪ್ಪ ಕೆ ಬಾಪ್ಶೆಟ್ಟಿ ಇದ್ದಾರಾ?
ಅವ್ರಿಗೆ ತಿಳಿಸಿದೀವ್ರಿ, ಬರ್ತಾರಂತೆ.
ಜಾಕಿರ್ ಹುಸೇನ್ ಉಸ್ತಾದ್? ಸರ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇರೋರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ಬಿಡಿ ಸರ್, 2:30 ಆಗುತ್ತದು.
ಸರ್ ನಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟು ಸರ್? ಅವಿನಾಶ್ ಸೀರಿಯಲ್ ನಂಬರ್
1.
ಸೀರಿಯಲ್ ನಂಬರ್ 1.
ಜಾಕಿರ್ ಉಸ್ತಾದ್ ಮತ್ತೆ ರೊಡ್ಡವೀರ ಶೆಟ್ಟಿ ಇವರು ಬರಕ್ ಹೇಳ್ಬಿಡಿ ಸರ್. ಧಾರವಾಡ ಬೆಂಚ್ ಇದಾರ ಯಾರಾದ್ರು? ಶ್ರೀನಂದ್ ಎ ಪಚ್ಚಾಪುರ ಇದ್ದಾರಾ? ಶ್ರೀನಂದ್ ಎ ಪಚ್ಚಾಪುರೆ. ವಿಶ್ವನಾಥ್ ಹೆಗ್ಡೆ, ಜೀವನ್ ನೀರಲ್ಗಿ.
Court officer. Court officer. Court officer. Court officer.
ಹೇಳಿ
ಸರ್ ಈಗ ಸಾಹೇಬರು 2:30ಕ್ಕೆ ಕೂತ್ಕೊಂತಾರ ಸರ್ ಅಥವಾ ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಮುಗಿಸ್ಕೊಂಡು ಕೂತ್ಕೊಂತಾರ ಸರ್?
ಸರ್ ಈಗಿರೋ ಇನ್ಫಾರ್ಮೇಶನ್ ಪ್ರಕಾರ 2:30 ಬರ್ತಾರೆ ಸರ್.
2:30 ಬರ್ತಾರ ಸರ್. ಅದೇ ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಇತ್ತಲ್ಲ ಹಂಗಾಗಿ ಕೇಳಿದ್ವಿ ಸಾಹೇಬ್ರದು.
ಬೇರೆ ಬೆಂಚಸ್ ಇರೋದ್ರಿಂದ ಮಧ್ಯದಲ್ಲಿ ಬರುತ್ತೆ ಇವರು. ಸೊ ಬಂದಾಗ ಹೋಗ್ಬಿಟ್ಟು ಮತ್ತೆ ರಿಸ್ಯೂಮ್ ಆಗ್ತಾರೆ.
ಹೌದು ಸರ್. ಈಗ 2:30ಗೆ ಕೂತ್ಕೊಂತಾರ ಸರ್ ಇಲ್ಲಿ? ಆಯ್ತು. ಥ್ಯಾಂಕ್ ಯು ಸರ್. ಥ್ಯಾಂಕ್ ಯು.
Court officer. Court officer. Court officer.
ಸರ್ ಹೇಳಿ.
ಸರ್ ನಾ ಕಲಬುರಗಿಯಿಂದ HCGP ಮಾತಾಡೋ ಸರ್ ಶರಣಬಸಪ್ಪ ಎಂ ಪಾಟೀಲ್ ಅಂತ.
ಸರ್ ಹೇಳಿ.
ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್?
ಕೇಳಿಸ್ತದೆ.
ಕಲಬುರಗಿಯಿಂದ ಶರಣಬಸಪ್ಪ ಎಂ ಪಾಟೀಲ್ ಅಂತ HCGP ಮಾತಾಡೋದು ಸರ್ ನಾನು.
ಯಾವ ಮ್ಯಾಟರ್ ಅಪೇರ್ ಆಗ್ತೀರಾ ಸರ್?
ಎಲ್ಲ ಮ್ಯಾಟ್ರು ಫಸ್ಟ್ ಟೈಮ್ಸ್ ಮತ್ತೆ ಆರ್ಡರ್ಸ್ ಎಲ್ಲ ಕಲಬುರಗಿ ಬೆಂಚ್ ಇಂದ ಎಲ್ಲ ಮ್ಯಾಟ್ರ್ ಅಪೇರ್ ಆಗ್ತಾ ಇದ್ದೀನಿ ಸರ್.
ಸರಿ ಸರ್, ಓಕೆ.
ಸರ್ ಅದು 2:30ಗೆ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ ಸರ್ ಅಥವಾ ಲೇಟ್ ಆಗುತ್ತೆ ಸರ್?
2:30.
2:30 ಸರ್. ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ಶರಣಬಸಪ್ಪ ಎಂ ಪಾಟೀಲ?
ಹೌದು ಸರ್, ಹೌದು.
ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ ಸರ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 30 ಪಾಸ್ ಓವರ್ ಆಗಿದೆಯಲ್ಲ ಸರ್ ಅದು?
ಬೆಂಗಳೂರು ಬೆಂಚ್ದಾ?
ಹಾ, ಬೆಂಗಳೂರು.
ಹೌದು. ಇಲ್ಲ,
ಇವಾಗ NOC ಕೊಟ್ಟಿದ್ದಾರೆ.
24/2 24/2
ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರಾ? ಸರಿ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್. ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ.
ಸರ್ ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ ನಮ್ದು ಕಲಬುರಗಿ ಬೆಂಚ್ ಅಲ್ಲಿ 4-5 ಅಲ್ಲಿ ಏನು ಅಬ್ಜೆಕ್ಷನ್ ಇದೆಯಲ್ಲ ಸರ್, ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಲಾಂಗ್ ವಿತ್ ಅಫಿಡೇವಿಟ್ ಅಂತ ಇದೆಯಲ್ಲ ಸರ್, ಅದಕ್ಕೇನು ಅಫಿಡೇವಿಟ್ ಆಗ್ತಾರೆ ಸರ್?
ಅಲ್ಲ ಸರ್, ಅಫಿಡೇವಿಟ್ ಫೈಲ್ ಮಾಡಿರೋದ ಮೇಲೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ.
ಇಲ್ಲ, ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಷ್ಟೇ ಹಾಕಿರೋದು ಸರ್. ಅದಕ್ಕೆ ಅಫಿಡೇವಿಟ್ ಬರೋದಲ್ಲ ಸರ್ ಕ್ರಿಮಿನಲ್ ಸೆಕ್ಷನ್ ಅಲ್ಲಿ.
ಅಲ್ಲ ಅದೇನು ಅಫಿಡೇವಿಟ್ ಹಾಕ್ಬಿಡ್ತೀನಿ, ಅದು ಸಬ್ಮಿಟ್ ಮಾಡಿ ಸರ್.
ಸರಿ.
ಕೊಡಿ ಫಸ್ಟ್ ಫಾರ್ವರ್ಡ್ ಕರೀರಿ. ಕಲಬುರ್ಗಿನೇ ಇರ್ಬೇಕಲ್ಲ. Dharwad bench.
Dharwad bench.
ಕಲಬುರ್ಗಿಯನ್ನೇ ಕರೀರಿ ಫಸ್ಟ್. ಯಾರಿದಾರ ಅವ್ರು ಕರೀರಿ.
Lord.
ಶ್ರೀನಾಥ್ ಪಚಾಪುರ ಬಂದ್ರಲ್ರಿ? ಹಾ ಅವಿನಾಶ್ ಇಲ್ಲ ಯಾವ್ದೋ ಅವಿನಾಶ್ ಅಂಗಡಿ.
My lord, it is insofar as Gulbarga's matters. Kalburgi's matters.
ಹಾ ಹೇಳಿ.
Lord, it's a successive bail, my lord.
ಹಾ ಹೇಳಿ. ಫಸ್ಟ್ ಟೈಮ್?
Yes, my lord. First time, my lord. My lord, at the time of dismissing the petition, my lord, your lordship has.
First time ಎಲ್ಲಿ HCGP ಇದಾರ ನಿಮ್ಮ ಕಲಬುರ್ಗಿ ಬೆಂಚ್ ನವರು?
Yes, my lord. He is present before the court.
My lord, I am appearing for respondent state, my lords.
ಹಾ ಹೇಳ್ರಿ.
My lords, may be permitted to file statement of objections, my lord, by next week, my lord.
HCGP is directed to take notice and file objections if any. Is this matter on next Friday ಗೆ ಕೊಡಿ. Sitting ಇರ್ತಾರೆ next Friday.
Please.
25th. BM Kenikeri.
I am first time matter, my lord. The IO
HCGP
has
is
filed.
directed to take notice and file objections if any. 25th. ಶರಣ ಬಸಪ್ಪ ಕೆ ಬಾಬಶೆಟ್ಟಿ ಸೇಮ್ ಆರ್ಡರ್. ಇಲ್ಲ ಇಬ್ರು ಇಲ್ವಾ? ಇದಾರ. ಶರಣ ಬಸಪ್ಪ ಶರಣ ಬಸಪ್ಪ ಇಲ್ವಾ? HCGP is directed to take notice and file objections if any.
Yes, my lord.
Serial number 4, 25th, same date, madam.
Yes, my lord.
Zakir Hussain Ustad.
Yes, my lord.
Raised on statement of objection, that is affidavit not forthcoming anta. Yaar objection?
My lords, I have filed statement of objections, my lord, but in that I have not filed any affidavit, my lords. For that they have raised objection, my lord, for statement of objections. Because my lords, in criminal side, my lords, usually will never file, my lords, because they have raised objection, my lord.
Objection.
Yes, my lord.
What is the
my
case?
lord, ready, my lord. Yes, my lord.
Yes, counsel.
My lord.
Argue. What is
My
the
lord.
ground?
My lord,
Where is the
previous
earlier
bail
order, rejection order? Where is the earlier rejection order?
previously it was rejected with the liberty to file the bail application after the charge sheet.
The petition and approach the trial court after filing of charge sheet.
Charge sheet, my lord.
Filed the charge sheet now?
Yeah, charge sheet is filed, my lord.
Only head of the charge sheet matra hakidri. Where is the other enclosures? Head of the charge sheet matra. Where is the other enclosures? Statement of witnesses ಏನು ಇಲ್ವಲ್ಲ?
Okay. My lord, CW 6 and 7 are the two eyewitnesses. And injured is the brother of complainant. And as per the allegation in the complainant has stated that
petitioner is accused number, sole accused.
One, accused number 1. No, in all 4 accused have been charged sheeted. He is accused number 1. And allegation against him is that he assaulted with the knife on the back. On the back.
How long he was in the hospital?
For 14 days, my lord.
14 days.
14 days. Thereafter, he was discharged.
Nature of injuries?
Serious, grievous in nature, my lord.
Grievous in nature.
Grievous in nature.
Stabbed with knife.
My only submission is injury is on the back, which is non-vital part of the body, my lord. And the offense is 307 of IPC. My lord, it is not exclusively punishable with imprisonment of life or death, exclusively. And even any stringent conditions may be imposed, my lord, like daily attendance to the concerned police station till the conclusion of trial. And since 6 months he is in judicial custody, my lord.
Yes, HCGP.
My lords, in this case, my lord, he has involved in some other cases also, my lord. Looking into the nature of injury also, my lord, it's grievous in nature, my lords.
Previous, he stabbed on the back, alva.
Yes, my lords. Yes, my lords. On the back, it was.
How many injuries? How many injuries? Only
Yes,
one
my
injury? Or?
No, my lord.
Two
On the
injuries,
back,
my lord. 2
1
injuries.
centimeter and right loin 3 to 5 centimeters stippled hematoma in spinal muscles at level of D9, 10, 11. What type of treatment given to him?
He was given treatment in for 40 days.
Medical records ಇದೆಯೇನ್ರಿ ಸರ್ಜರಿ ಮಾಡಿದಾರ ಏನಾಗಿದೆ?
ಇಲ್ಲ ಸರ್ಜರಿ ಆಗಿಲ್ಲ ಸರ್.
No, my lord. No surgery.
No surgery.
No, my lord.
ಏನ್ರಿ HCP?
No, my lord. No surgery, my lord. Only he was hospitalized, my lord.
Anyhow, he is out of danger, alva?
Yes, my lord. But he is involved in several cases, my lord. Other cases.
Several cases ಅಂದ್ರೆ ಏನು ನೀವು ಡೀಟೇಲ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ ಎಷ್ಟು ಕೇಸ್ ಅಲ್ಲಿ ಇದಾನೆ ಹೇಳಿ?
4 cases, my lord. Mentioned in statement of objections, my lord.
4 cases. ಏನ್ ನೇಚರ್ ಆಫ್ ಕೇಸಸ್ ಏನು?
Offense. Yes, my lord. Offenses are
324 and 504, my lord.
324
and 504, my lord.
All.
I have submitted all the FIRs before the trial court. Before the lower court.
Heard the petitioner counsel and also the counsel appearing for the state. This court earlier given liberty to approach the court after filing of the charge sheet. And now the petitioner is before this court. The offences alleged against the petitioner is section 323 and 307 reduced to 34 of IPC. The factual aspect of the case is that this petitioner inflicted the injury on the back of the victim. As a result, the victim had sustained previous injuries and he took the treatment for a period of 14 days. The counsel appearing for the petitioner would submit that this petitioner is in custody from last 6 months. There was no any intention to take away the life and the same has to be tested in trial. Investigation has already been completed and no need of custodial trial. The counsel also would submit that the injured is out of danger. He may be enlarged on bail. For contra, the counsel appearing for the state would submit that it caused serious injuries, stabbed on the back of the victim. And apart from that, there were 4 cases against this petitioner and he is an habitual offender. The counsel appearing for the state also given the details in paragraph number 5 regarding other cases are registered against this petitioner. Having heard the respective counsel and also on perusal of material available on record, there are grievous injuries. The victim also took the treatment for a period of 14 days and no surgery is conducted and now he is out of danger. The contention of the state that there were 4 cases against him and also on perusal of the crime details given in paragraph number 5. All the offences are punishable under section. The offences invoked against him are 323, 324, 504 and 506. Also under section 153A. And having considered this step act into consideration. Merely because 4 cases are registered against him is not a ground to reject the bail petition and court has to look into the specific allegation made in the case on hand and also look into the gravity of the offense and seriousness of allegations made in the complaint. Already investigation is completed and this petitioner is in custody from last 6 months and hence it is a fit case to exercise the discretion in favor of the petitioner with conditions. Next, 5.
Obliged, madam. Obliged.
Kota Veera Shetty. ಇಲ್ಲ ಇದಾರಾ? ಎಸ್ ಕೌನ್ಸಿಲ್ ಹೇಳಿ. 6AB 323 504 45L. ಅರ್ಲಿಯರ್ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ? ಈಗ ಹಾಕಿದ್ದೀರಾ? 130 138. What was the reason? The report of the government hospital, Hunnabad, the victim was subjected to genital examination. History also given that she was subject to rape on 26/2/21. And immediately within 2 days, she was subjected to medical examination on 28/2/21. And on examination of external genitalia, the medical report discloses that there was a swelling and also hymen was ruptured and there was a bleeding in the vagina. Take a note of this. Prima facie material petitioner is, since there is a prima facie case against him, the contention that petitioner was arrested on 21 is not a ground for rape. What is the change circumstances now? Innocent adella bitbidi ಈಗ ನೀವು successive bail petition ಹೇಳಿ. This court already given finding that there is a prima facie case anta. Victim subjected to sexual act on 26th and 28th she was examined and medical report confirms that used for sexual act anta. Again, what is the change circumstances now? Real grandfather?
Grandmother of the petitioner was seriously injured due to the arrest of the petitioner. Petitioner is love and affection of the
ಅರೆಸ್ಟ್ ಮಾಡಿದಕ್ಕೆ ಅವ್ರಿಗೆ ಹುಷಾರಿಲ್ಲ ಅಂತ ಹೇಳಿ ಬೇಲ್ ಕೊಡ್ಬೇಕಾ? ಎನಿ ಅದರ್ ಗ್ರೌಂಡ್ ಚೇಂಜ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸಸ್ ಏನ್ ಹೇಳಿ ಕೌನ್ಸಿಲ್? This order was passed on 23rd day of December 2021. 1.5 month ಅಲ್ಲಿ ಮತ್ತೆ ಬಂದಿದ್ದೀರಿ. What is the change circumstances? ಹೇಳಿ ಏನ್ ಹೇಳ್ತಾರೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ನವರು? ಮಕ್ಕಳ ಮೇಲೆಲ್ಲ ರೇಪ್ ಆದವ್ರಿಗೂ ಕೇಸ್ ಕೊಡಿ ಅಂತ ಬರ್ದವ್ರ? ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ರ ನೋಡೋಣ. ನಾವು ಏನ್ ಬರ್ದಿದಾರ? ಏನಿದೆ ಜಡ್ಜ್ಮೆಂಟ್ ಇದಾ 1978 ಏನದ್ರಲ್ಲಿ? What is the ratio? What is the ratio, counsel? Refusing bail does not bar fresh application on later occasion, giving more details, further development and different consideration. ಅದನ್ನೇ ನಾನು ಕೇಳ್ತಾ ಇದ್ದೀನಿ. What is the change circumstances ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. I am not on the point that there is a bar. You can file any number of bail petitions, but you have to make out a case for the change. Student. ಅದೆಲ್ಲ ಕನ್ಸಿಡರೇಷನ್ ಆಗಿದೆ ರೀ, ಮೊದಲೆಲ್ಲ ಕನ್ಸಿಡರೇಷನ್ ಆಗಿದೆ. ತೊಳಿ heard the petitioner counsel and also the counsel appearing for the ಆಯ್ತು. Counsel appearing for the state. This petition is successive bail petition and this court already rejected the bail petition with order dated 23rd day of December 2021, wherein in paragraph number 6 comes to the conclusion that the rape was committed on 26/2/21 and within 2 days she was subjected to medical examination and found that hymen was ruptured and there was a swelling and there was a bleeding in the vagina. Note of the prima facie material rejected the bail petition. Now petitioner before this court in a successive bail petition and counsel contends that the grandmother in view of this petitioner is in custody, not feeling well. ಏನು ಏನಾಗಿದೆ? Hence, this petitioner may be enlarged on bail. The counsel also submits that the petitioner is a student, but he is aged about 20 years and he may be enlarged on bail. Those considerations cannot be considered in a successive bail petition when this court has already formed an opinion that there is a prima facie case against the petitioner hearing. The grandmother is not having good health is not a reason for enlarging the petitioner on bail, and also on the other ground that the petitioner is a student also cannot be a ground to enlarge the petitioner on the petitioner, since the offense against a child who is below the age of 18 as defined under Section 2D of POCSO Act, and the offense against the child is against the humanity, and court has to take note of the very object in bringing the special enactment to curb the offences against the child. You have the discussions. I do not find any. I pass the, and I do not find any change circumstances to entertain the successive bail petition. If you have the discussion made up, I pass the following order. Bail petition is rejected. Madam.
One submission, my lords.
ಹೇಳ್ರಿ.
Notice has been served on the complainant, my lords, in this case, my lord.
ಯಾವ ಇದ್ರಲ್ಲ?
Yes, my lord.
Order sheet ಬರ್ಕೋಬೇಡಿ. HCCP submits that notice already been served against the complainant ಅಂತ order sheet ಅಲ್ಲಿ ಬರೀರಿ. Yes, ಧಾರವಾಡ ಬೆಂಚ್. ಶ್ರೀನಂದ ಪಚ್ಚಾಪುರ ಹೇಳ್ರಿ.
Please, my lords.
Yes, counsel lady.
Last occasion, my lords, your lordship had directed us, my lords, to verify as to whether after the disposal, whether when the court becomes functus officio, whether a court can settle the dispute. Not in respect of that, yes. Not we have produced some two judgments of one is from apex court, my lords, where not we can the court can settle the matter, not if both the parties are. Therefore, we filed this application for recalling and not.
Who is appearing for other side? Neerlagi idara.
Not the other side, not Mr. Vishwanath Hegde, my lords, he was here. Vishwanath Hegde is here, my lords. He was here, but I'm sorry, my lords. We both were here itself, my lords.
He was here. Whether now he is here? Neerlagi. Vishwanath Hegde.
ಅಲ್ಲ ಏನ ಬೇಕಾದ್ರೆ ನೋಡ್ರಿ ದವಾಖಾನೆ ಪಾಪ ಏನು
ದವಾಖಾನೆ ಹೇಳ್ತಾರ ನೋಡ್ರಿ. ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಏನೋ ದವಾಖಾನೆ ಹೇಳ್ತಾ ಇದಾರೆ ನೋಡಿ. ಯಾರು
ಬೇರೆದವರು
ಇಲ್ವಾ? ಅವರು ವಿಶ್ವನಾಥ್ ಇಲ್ವಾ? ಯು ಕೀಪ್ ಇನ್ ಪ್ರೆಸೆಂಟ್. ವಿಶ್ವನಾಥ್ ಇದ್ದಾರಾ? ವಿಶ್ವನಾಥ್ ಏನ್ರಿ ನೀವು? ಇಬ್ರು ಒಂದೇ ಆಫೀಸ್ ಅಲ್ಲಿ ಇದಾರೆ, ಒಟ್ಟಿಗೆ ಇದ್ದೀರಿ. ಹೇಳಿ ಏನ್ ಸೆಟ್ಲ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ? ಏನಾಯ್ತು ಹೇಳಿ.
ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್.
ಏನ್ ಹೇಳ್ರಿ ಟರ್ಮ್ಸ್ ಆಫ್ ಸೆಟ್ಲ್ಮೆಂಟ್?
We have agreed notes for 15 lakhs notes. 5 lakhs is already been deposited, and 10 lakhs notes DD notes. In fact, last occasion it was ready notes. That DD was only for a period of 3 months notes. Immediately notes we'll hand over the DD notes whenever your lordship would direct us notes.
Allah, where is the judgment? After the disposal of the matter, again court can.
Yes, ma'am.
Enter the compromise, compounding of offences. Kelidare judgment.
But the your lordship court please to dismiss the petition, lords.
KR online 2021 SC 807 ಕೊಟ್ಟಿದ್ರಿ. Where is that ratio? Even after the disposal of the matter on merits, court can again consider it ಅಂತ. ನಾನು ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದೆ ನೀವು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೋಗ್ಬೇಕು, ಅಲ್ಲೇ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೋಬೇಕು ಅಂತ. ಬಿಕಾಸ್ ದಿಸ್ ಕೋರ್ಟ್ ಬಿಕಮ್ ಆಫ್ಟರ್ ದಿ ಪಾಸಿಂಗ್ ಆಫ್ ದಿ ಆರ್ಡರ್.
ಪ್ಲೀಸ್
ಅಲ್ಲಿ ಹೋಗ್ಬೇಕಷ್ಟೇ. ನಾವು ಇಲ್ಲೇನು ಡಿಸ್ಪೋಸ್ ಮ್ಯಾಟರ್ ಹೆಂಗ್ ಎಂಟರ್ಟೈನ್ ಮಾಡಕ ನಿಮ್ ಕಾಂಪೌಂಡಿಂಗ್ ಆಫ್ ಅಫೆನ್ಸಸ್.
This AR online
ಅಂತ
ರಾಮ್ಗೋಪಾಲ್ ವರ್ಸಸ್ ಸ್ಟೇಟ್ ಆಫ್ ಮಧ್ಯಪ್ರದೇಶ್. ಒಂದು ಸೈಡ್
ಅದೇ ನಾನು ನೋಡ್ತಾ ಇದ್ದೀನಿ ಎಲ್ಲಿದೆ ಅಂತ, ಅದಕ್ಕೆ ಕೇಳಿದೆ ಯಾವ ಪೇಜು ಪ್ಯಾರಾದಲ್ಲಿ ಇದೆ ಅಂತ ಕೇಳಿದೆ.
Yes, ma'am. I'm sorry, ma'am.
After the disposal of the case, again court can compound the offense ಅನ್ನೋದಕ್ಕೆ ಎಲ್ಲಿದೆ ಅಂತ ಕೇಳಿದೆ. ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಒಂದು ಡೇಟ್ ಕೊಟ್ಟಿರ್ತೀನಿ, ನೋಡ್ಕೊಂಡು ಹೇಳಿ. ನಾನು ನೋಡಿದೆ, I have read the judgment. I have not found any such ratio.
Yes.
This matter on 18th. We'll see on 18th.
Please, ma'am.
18th.
Please, ma'am.
18th ಅಲ್ಲ, next Friday. 25th.
Next 25th. Please.
25th. Please come back.
ಮೇಡಮ್, ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್, ಇದು ರೆಗ್ಯುಲರ್ ಲಿಸ್ಟ್ ಎಷ್ಟಾಯ್ತು ಮೇಡಮ್? ಅದು ಸೀರಿಯಲ್ ನಂಬರ್ 68 ವರೆಗೆ ಆಗಿದೆ. 68 ವರೆಗೆ ಆಗಿದ್ದಾರೆ. ಸೊ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೀರಲ್ವಾ? ಹಲೋ ಮೇಡಮ್, ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. ಓಕೆ.
ಇದು ಇವಾಗ ತಗೊಳ್ಳೋದು ಮುಗಿತಾ? ಇಲ್ಲ ಇಲ್ಲ ಈಗ ಕುಂತವ.
230. ಏನು ಅವ್ರೇನೋ ಹೇಳ್ತೀನಿ ಕರೆಕ್ಟ್. Yes, counsel, make it short.
For the petitioner.
Cancellation of bail.
They had employed these tender to supply milk from the milk collection sector to the bulk pooling centers, which are there to store and do there. Because the say of the company that in the lorries, the milk got adulterated. Most recently, the complaint is there was a hidden chamber and there was a water store which led to dilution of the milk, and hence they had
their main contention is that the lorry which was used is not permitted to transport it, and also there was a separate compartment in the said vehicle without the permission. The very same vehicle was used.
And if you watch it, see the FIR, ಬೇರೆ ವೆಹಿಕಲ್ ಬಳಸ್ತಾ ಇದ್ದಾರೆ. It is found at running page 11, 721. And the vehicles which they complain not contain hidden chambers, but serial number 192.
In respect of the said vehicle, whether there was a permission?
These were permitted vehicles. These were permitted.
Hidden compartment was made in the lorry. Whether that lorry was permitted?
That was not evaluated with the and thereafter this was allowed to make.
Counsel, my question is very clear. When the vehicle is having separate compartment and you use that vehicle, whether that vehicle was permitted to transport it? You are not answering to my whether permission is given or not. Yes or no, you say.
We had that was produced before the authority.
I am not in respect of producing this concern. Whether permission is given to the particular vehicle, where is that permission? That's what I am asking. That's why first he answered the case. Where is that answer? Where is that permission? Their case is main case is that you have used the vehicle which is not permitted, and also the vehicle which was used is having the separate compartment for water and also the milk, and using the same for adulteration. That is their case. That's why I am asking where is that permission anta.
Hidden chamber marks is found as per the say of the custody in 264 and 64. Not 71.
Yes.
They say it was not given in the intent. But however, they were running it. The say of the accused says, I had tendered a letter. This was tendered. However, in this, the say of the prosecution.
You have tendered a letter for change of vehicle. Whether that is permitted, that is my question. Where is that order permitting to use that vehicle? That is the crux of the matter.
First para is read in
Sought permission for 3 days and no permission is given. That's what it says. No. You have sought for a change of vehicle for 3 days, but no such permission is given. That's what the contents of the letter complaint.
The allegation before the lordship says vehicle number 2634 and 6212 contain hidden chambers. And contain hidden chambers. Here, the say of the prosecution.
Now the counsel, it is for cancellation of bail. Only we have to see only 2 grounds for cancellation of bail. First ground is whether the trial court, while granting the relief, exercising the discretion, consider the material or not. Any perverse or capricious order is passed while exercising the discretion. The other aspect is another aspect for cancellation of bail if any violation of condition. But now not on the second part, only on the first part. Only you have to make submission with regard to the first part is concerned. You have to substantiate the order passed by the trial court. Now their case is that perverse order is passed, not consider the material and record while exercising the discretion. Dolatram judgment. Right, next. ಮತ್ತೆ ಹೇಳಿ ಆಯ್ತು ಹೇಳಿ
Because in the second matter which you are dealing, for the same the other matters which is challenged to 63. This relax is the reason order where every material has been taken upon. And judge comes to the conclusion at best it is a contractual dispute. Where in the
You are reading para number 11 or 11 of the judgment of the trial court? Or?
Yes.
Now you have placed available at page 4.
Yes.
Para 11.
Yes.
Para 11 is starts from the allegation made against the petitioners are that they violated the terms of the contract by illegally. Now you have placed material before the court along with citation.
Yes, sir.
Which paragraph you are relying? Page number 9. Counsel is
Illegally transporting belonging to a private vehicle first financial customer. The contention of they are not involved in illegal supply of milk belonging to a private milk tank. They are transporting the milk using the attached milk tank as per the terms of the contract. The manufacturer to cancel the contract with the also as stated earlier, the petitioner was already granted and anticipated bail, CMS number 614, for offences punishable under 272, 416 and 420. Even accused number 1 has been granted anticipated bail, 4390.
Those are the reasons given.
And it is ultimately what could be made out from their says is a purely contractual dispute where materials were placed before the learned reality. And but after considering it, an order has been passed. An order has been passed. To the effect that the petitioners were entitled to anticipate their bail. Because additional sections were incorporated. This is the final order which has not been challenged by the other side. Passed by the learned district judge. Which not is now the second order of marks after incorporation of the additional sections. Hence, that is not able to challenge before the lordship.
Yes.
Even as it is, but the lordship is still verifying scheme of things. Now, here is a detailed order. And even the trial judge at observe the fact that it is not that they are trying to threaten the witnesses or destroy you. That is the grounds not which are increased. And one more thing, there are offences alleged as premeditation. Here, I would have to say one thing. If someone is making an allegation of the Prevention of Premeditation Act, this Premeditation Act is self-contained code by itself. When I say self-contained code, Section 10 and 11 of the Arbitration Act postulates procedures to be employed by the investigating agency. How a sample has to be collected by the inspector. Because there are analysts approved by the central laboratory, and not it has to be sent to the such analysts. Report has to be obtained about
That is all matter of merits.
Yes,
Not at this stage.
There is a form of these are essential commodities. They come out to be a very serious. When there is such seriousness alleged against the provisions of section 10 and 11 mandate that they have to send it for an investigation. Any sample which has been taken in lots of men to show the dilution. I would submit.
Now, only point is whether it is a case for exercising the powers under 438. That's all. That's all. Only you have to restrict the argument for that. That's all.
That ratio of your lordship have weighted point. I don't have to read that. And subsequently, Supreme Court also made a distinction.
Both are different at stake. Granting and cancellation is different at stake. Yes. Settled law also.
Yes, your lordship have referred back in the recent judgment, 2021. Also. Now, that's keeping active there. That's the aspects of the in judicial review of the order of bail. That's generally the good is bail. Unless not, the gravity of the offense is so shocking.
Conscience of the court.
Now, here is a case where we are before the lordship's back. There has been an malice of the union to displace us from the parliament. We are before the Red Court challenging the cancellation of tenders. It's purely contractual in nature. And when it comes to arbitration, just pointed out, there is no ounce of material before the court or the agency.
Counsel, this court is not on with regard to the cancellation of contract or whether it is contract or not. Now only the question. Even though you were not there on that day, I have given permission to argue. Now you have argued. That's all? Yes. Or the respondent resolved. Yes. Yes.
There is also one more thing what I have to bring it close to. When I say milk is collected and delivered, after the milk is collected from the procedure which is employed by cane or process, the collection agent drops in the milk into the lorry. Plus, they take a dip test, density. After taking the density test, the lorry is sealed with a crimp seal. And there is a seal notch which can be only opened at the center notch where it is delivered. In the sense notch, if the seal is opened, that the ladder inside the material inside it will not be accepted by the milk collection system. And every time after the goods are delivered before the center notch, the lorry is this seal is opened by the authority. They take a sample test. After the sample
density is in order, that is, it matches with the density of the connection area. Thereafter, the unloading. After the unloading, one more test which goes in, where the density is again checked. If it matches not, thereafter these bodies are sent to weight bridge. When they check the laden weight, they compare the laden weight of the vehicle with the laden weight tender given in tender. Your Lordship, I had to give this reply because your Lordship asked whether it was permitted. The case is not, there is the excess weight inside. In case there is an excess weight, the tender weight and this excess weight do not match on every base kit. Every trip. In fact, I have done probably umpteen number of trips right from day one. That material is also not there before the court. I'm just trying to prove. Prima facie, no amount of material is there. Not that the water was mixed and the milk was stored in the baby compartment as alleged. Every time there was a weight which was paid factor which was taken. Those circumstances probably the level time the district court analyzing the order now, just taking note of the considerations which were tendered before it. And now for us, the investigation is completed. The investigation is completed. It is not the case of the state also that they need me for custodial interrogation. I have cooperated. Under these circumstances, the cancellation will not survive. Really because not there is a vendetta between me and my employer. So that means that I don't do other things were released on the are with me not. Their release
not challenged before this court. Now only we are restricting only with regard to these petitions. That's all.
All the allegation is conspiracy. All these got together.
Yes, counsel. Yes. Pasha. Roshat Pasha. A3. Petitioner counsel of them. Pass over Madi Raman will come back. Serial number 70.
My lords, I prepare for the petition in this case, my lords.
Yes, counsel.
My lords, the offense, the crime.
420. Yes. What are the grounds?
My lords, the petitioner was the CEO of the Primary Agriculture Cooperative Society, my lords. He has been alleged to have misappropriated funds of rupees 40 lakhs, my lords.
Hello? Only adjusted an amount of rupees 10 lakhs and all different amount. Response. Your main contention that it was done in long back and now it was in 2013, 15.
Please, my lords.
Now only case is registered.
Yes, my lord.
Long gap anta. Next.
Even in the audit reports, it's not been reflected, my lords. 2012, every year there is an audit report that has been conducted. Audit has been conducted. And now only after the complaints of some public, they have initiated the proceedings, my lords. Only against the CEO and the accountants. Then board of directors are not been included in the inquiry also, my lords. 64 inquiry.
When he was arrested? When he was arrested?
23/12/2021, my lords. Arrested on 23/12, my lords.
Now where he is working? Retired?
He's been dismissed from the service, my lords. He's been dismissed from the service, my lords.
Oh, dismissed from the service after coming to know about all this misappropriation.
Yes, my lords.
Have you made any payment subsequently? After the adjustment benefit?
No, my lords, nothing. Payments have not been made, my lords.
Then what are the grounds now?
My lords, if he's enlarged and bail, my lords, he will be making payments, my lords. Because he's in custody, he's not able to pay.
Custody, because he is in custody, he misappropriated the amount of rupees 45 lakhs. During your tenure as CEO.
Please, my lords.
That's all? That's all. Statute Agila. Heard the petition of counsel and also the counsel appearing for the state. The factual maximum of the case of the prosecution is that when the inquiry was conducted about the misappropriation of the amount, the society for the period from 2012-13 to 14-15 and from 15-16 to 2018-19, an amount of rupees 43,88,175 during the tenure of this petitioner misappropriated. But hence, based on the complaint, case is registered and matter is under investigation. The counsel appearing for the petitioner would submit that the allegation pertaining to for the period from 2012-13 to 2018-19. There is no any charging the complaint. And an amount of rupees around 10 lakhs is adjusted out of his retirement benefit. And this petitioner is in custody from 23/12/2021. No need of custodial trial. And hence, it may be enlarged and bail. For contrary, the counsel appearing for the state would submit that it is not in dispute that an amount of rupees around 10 lakhs is adjusted out of his retirement benefit, and still he has to pay the amount of rupees 33 lakhs and odd. And the total misappropriation during his tenure as a CEO is to the extent of 43 lakhs and odd. And being the CEO of the society, he committed the offense of misappropriation of the fund, and hence it requires custodial further investigation. Having taken note of the, having heard the respective counsel and also on perusal of material available on record, particularly for the period from 2013 to 2018, during the period of this petitioner as CEO, the amount of rupees 43 lakh and odd was misappropriated, and the same comes to light only after conducting the audit. And this petitioner is also removed from the service for its misconduct. And when such being the factual aspects, and when the matter is under investigation, unless the investigation is completed, is not a fit case to exercise the discretion to release him on bail. The counsel also would contend that it affects his right and liberty. And when the misappropriation is done to the extent of more than 40 lakhs, and apex court also in the judgment in Supreme Bhiwandi Wada Manor Infrastructure Private Limited versus State of Maharashtra and another, that court has to take note of the seriousness of offences alleged against them, and particularly when the fraud is committed and also the misappropriation of the huge fund, when the officer is in charge of the affairs of the society, has indulged in committing the offense of misappropriation, the discretion cannot be exercised, and hence I do not find any ground to exercise the discretion in time stage to enlarge him on bail. In view of the discussion, I pass the Kalangwada. Bail petition is rejected.
Minutes, I appear for the petitioner, please.
Yes, counsel, lady.
Minutes, 439 application, please, minutes. The
Counsel,
petitioner is A1, please, minutes.
A1, age of the victim.
Minutes, 17 years, my lord, according to the complaint.
17 years. Medical evidence.
Medical evidence is negative, my lord. My lords would find
negative.
How the Swami? I have produced it. Page,
is that medical evidence?
Page 49 minutes. 49, where the victim was examined.
49. Examination. It is not in prescribed format.
But the FSL report, but they have collected all the report, and the
this is in respect of the accused, right?
Please, brother.
The accused reference porta. I am asking the victim medical evidence.
One moment.
Good.
Page number 43 minutes.
3. Genital examination, no injuries. Around genital also.
No injuries were found, and around the genital, labia major intact. Pubic hairs intact.
For the FSL report.
FSL report, my lord, I have produced
super statement entry.
Page 155 minutes.
Can hymen ruptured? Hymen?
ಇಲ್ಲ ರಪ್ಚರ್ ಅಂತಿಲ್ಲ, ಹೇಮನ್ ರೊಗೇರೋ ಅಂತಿದೆ.
1 centimeter, not 10 centimeter. 1 centimeter width. ಒಳ್ಳೆ ಇದೆ ರೀ, ಸಿಕ್ಕಾಪಟ್ಟೆ ನೋಡಿ. Where is 164 statement of the victim?
It is not part of the charge sheet.
ಹೋಗ್ತಾ ಇದ್ದಾಗ ನಾನು ಕೇಳೋದು 3 ಕ್ವಶನ್. ಒಂದು ವಿಕ್ಟಿಮ್ ಏಜ್, ಸೆಕೆಂಡ್ ಒನ್ ಇಸ್ ಮೆಡಿಕಲ್ ಎಕ್ಸಾಮಿನೇಷನ್ ರಿಪೋರ್ಟ್, 164 ಸ್ಟೇಟ್ಮೆಂಟ್. These are the prima facie material to exercise the discretion. ಓದಿದಾರು ಓದಿ, ಇಲ್ಲ ನಾನೇ ಕೊಡಿ, ನಾನೇ ಬೇಗ ಸ್ಪೀಡ್ ಆಗಿ ಓದ್ಕೊಂಡ್ಬಿಡ್ತೀನಿ ಕೊಡಿ.
Page 56 is the melody FSL.
FSL.
ಹೌದು ಸ್ವಾಮಿ.
FSL ಅಲ್ಲಿ ಏನ್ ಇರ್ತದ್ರಿ, ಎಲ್ಲ ಬಟ್ಟೆ ಗಿಟ್ಟೆ ಎಲ್ಲ ಯಾವ್ದು
ಇಲ್ಲ
ಆಕ್ಚುಯಲ್ ಆಕ್ಟಿಗೆ ಒಳಪಟ್ಟಿದ್ದೆ ಒಂದ್ ದಿವಸ, ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡೋದೇ 2 ತಿಂಗಳು 3 ತಿಂಗಳ ಮೇಲೆ, ಅದ್ರಲ್ಲೇನ್ FSL ಅಲ್ಲಿ ರಿಪೋರ್ಟ್ ಬರುತ್ತೆ. ಓನ್ಲಿ ವಾಟ್ ಸಿ ಇದೆಯಲ್ಲ. She makes allegation in 164 statement.
But her statement is also have produced at page number 26. They according to 26
statement.
The victim statement.
Where victim made the statement?
They page number 26.
Before the police, before the police.
ಹೌದು
ಪೊಲೀಸ್ ಅಲ್ಲ, ನಾನು ಐ ಆಮ್ ರೆಫರಿಂಗ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಮೇಡ್ ಬಿಫೋರ್ ದಿ ಲರ್ನೆಡ್ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್. ಪೊಲೀಸ್ನವ್ರದೆಲ್ಲ ನೋಡಕ್ಕಲ್ಲ ಈಗ.
According to her, my lord, they were together for nearly 27 days together. And she is a major. And my lord, this is not the my lord.
This major. On what basis you are claiming that she is a?
ಅಲ್ಲ 17 ವರ್ಷ ಸ್ವಾಮಿ ಆಯ್ತು ಸುಪ್ರೀಂ ಕೋರ್ಟ್.
17 ವರ್ಷ ಮೇಜರ್ ಆಗ್ತಲ್ಲ.
ಅಲ್ಲ ಸುಪ್ರೀಂ ಕೋರ್ಟ್.
That's why even IPC is also amended. Consent. It was amended in 2018 also, made it as 18 also.
ಅಲ್ಲ ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ಇಲ್ಲ.
According to POCSO 18, now IPC is also amended.
Please.
What the petitioner counsel and also the counsel for the state. The factual matters of the case of the prosecution is that this petitioner subjected the victim, who is aged about 17 years, for sexual act as against her wish continuously. And he took her, stating that he would marry her, but subjected her for sexual act.
One submission, my lord.
Really?
So even one more case was registered against him in earlier. My lord would find it at charge sheet, page number 25, second part of it. My lord, ಸೆಕೆಂಡ್ ಪಾರ್ಟ್ ಅಲ್ಲದೆ ಅದೇ ಆರೋಪಿತರು ಈ ಹಿಂದೆ 26/5/2019 ಬಾಲಕಿ ನಾಗವೇಣಿಯನ್ನು ಮದುವೆ ಮಾಡಿಕೊಳ್ಳಬೇಕೆಂಬ ಉದ್ದೇಶದಿಂದ ಕರೆದುಕೊಂಡು ಹೋಗಿ Malad, there, Malad, a case was registered in 63/20, which is a subject matter of subject SC20, SC30. Malad.
How many cases is that?
Malad, same, Malad, for the same incident. Malad, may submit, Malad. Malad, in that case, Malad, he was.
He charge sheet to e case ಸಂಬಂಧಪಟ್ಟಿದ್ದು ಅಲ್ವೇನ್ರಿ? Available at page 5.
ಹೌದು ಈ ಕೇಸಿಗೆ ಹಳೆ ಒಂದು ಕೇಸ್ ನಲ್ಲಿ Malad,
ಹಳೆ ಕೇಸ್ ರೆಫರೆನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇನೆ.
ಹೌದು ಅದರಲ್ಲಿ he was released on bail. He has not violated any of the conditions. Thereafter, in order to see that Malad, he should be put in Malad, one more case has been registered. Even the medical evidence Malad on record would show it's a negative the case of prosecution. In this case.
Madam?
Of the case of the prosecution, this petition subjected the victim who is aged about 17 years for sexual act as against.
And continued the repeated act of sexual act. It is also the case of the prosecution that one more case is registered against him. in connection with the incident dated 26/5/2019. And a marriage was performed with the said victim along with this petitioner. So the counsel appearing for the petitioner would submit that false case has been registered against this petitioner, and the victim is aged about 17 years. And the victim and as well as the petitioner have fallen in love with each other from last 3 years. The allegation that this petitioner subjected her for sexual act is not supported by any evidence. Hence, this petitioner is entitled for bail. For contra, the counsel appearing to the state would submit that victim is aged about 17 years, and medical examination supports the case of the prosecution. And apart from that, victim girl also stated before the learned magistrate that this petitioner subjected her for sexual act repeatedly, and there is a prima facie material against the petitioner. Having heard the respective counsel and also the counsel appearing to the state and also looking into the factual aspects, the victim is aged about 17 years and the same is not in dispute. And the petitioner counsel also not disputes the same, but now contend that now she has attained the majority. The court has to look into the date of subjecting her for sex, not the present age. And, having considered the material on record, particularly the evidence, hymen ruptured with 1 centimeter width, and also the 164 statement of the victim before the learned magistrate categorically stated that this petitioner subjected her for sexual act continuously. Having considered the material available on record, case of the victim as well as the medical report and also the 164 statement, there is a prima facie case against the petitioner, and completion of the investigation is not a ground to large human grade heinous offense sexual act against the child who is below the age of 18 as defined under Section 2D of the POCSO Act. That this petition in custody. The rate of arrest is also not a ground when an heinous offense against the child is committed. No reasons. Rejected. Sebastian. A2 406 420 case.
Husband booked a flat. Mr. Sudhakar Gupta, 2009. He made a payment of 35.26 lakhs.
How much?
35 lakhs 26,000.
35 lakhs is
checks. One check for 25 lakhs plus in favor of Sudhakar, and another check for 10 lakhs in favor of Narsim.
Narsiman is the second petitioner hearing.
Petitioner is only the financier of the developer. So when the flats are sold, some part of the state consideration is transferred to the state. The petitioner filed anticipated petition before the Sessions Court. Sessions Court rejected on the ground earlier petition. The property your lordship will get in page 22. This number 9029 of 2021 was dismissed. All new grounds are made up. Given petition 9029 was not filed by the petitioner, it was filed by accused number 1. That order I have produced at page 25. And later on, accused number 1 has approached this court with given petition number 8635 of 21, and he has been granted anticipatory bail by this court. Wherein he has admitted having received the payment in this court and said that he has no objection to executing the same. The balance is not of that order. Therefore, my respectful submission to your lordship is The learned session judge has not considered the petition on merits as far as the petition is concerned. The main accused, who is the developer, who has signed the agreement, has been granted bail by this court. The petitioner who has received the part payment at the instance of the developer, who has received the finance made by him.
Where is that order? Granted its bail in favor of accused number 1. Memo jothe ilwal.
Subsequently,
Here, in respect of the same crime or different crime?
same crime. Accused number 1.
A1.
A1.
What is the reasoning?
Hello?
Reasoning.
Sir, I have asked them your lordship.
Reasoning. Kodi avರಿಗೆ report ಕೊಡಿ madam. Under text.
Case of the prosecution, the complainant Gita Reddy has filed a complaint, etc. Para 4. The learned counsel of the petitioner submits that the petition is ready to execute the sale deed by receiving the balance. The complainant has paid 25 lakhs to this petitioner and 10 lakhs to accused number 2, where she is ready to receive the entire sale consideration. The petition is ready to execute the sale. Submission is recorded. The petition granted by development. He is the developer who has executed the agreement of sale. He has to execute the sale.
What is your role?
My role, I had financed the developer. As and when you are selling the flats, a part of the sale consideration must be paid to me.
Paid to you.
Paid to me. So this flat is paid to me at the instance of the developer by the purchaser. Husband of the petitioner in 2009.
Counsel, what is it? Becker.
Petitioner released that he has not disputed the check and the amount was credited to the account of the petitioner. Now the account was reached.
Any sale agreement between A1 and the complainant? Hoda? And already bail also granted in favor of accused number 1. For the petitioner counsel and also the counsel appealing to the state. The prosecution that the complainant filed a complaint 21 alleging that her husband late Pattabi Raman purchased a flat at Banshankari second stage. From this petitioner number 1 for the total consideration of rupees 35.26 lakhs by way of check. After receiving the payment, the first accused did not come forward to execute the sale deed. And this petitioner is also arraigned as accused number 2 since he has received the part of the amount, that is 10,04,000. The counsel appearing to the petitioner submits that there was an agreement between the first accused and the complainant husband. And this petitioner only financed the amount in the developer, that is number 1. Repayment of the same only, he has received the amount of rupees 10,04,000. And this court already granted bail in favor of accused number 1 in criminal petition number 8636 of 2021. According to the counsel appearing for the state submits that part payment was made in favor of this petitioner. No sale deed is executed and the said payment was made in 2000. Irrigation made in the letter. So arraigned this petitioner as accused number 2 since he has 4,000. Not in dispute that there was an agreement between the accused number 1 and the complainant husband. Already granted bail in favor of accused number 1. And then suspending the factual aspects of the case. It is a fit case to exercise the powers of 438 of CR with the conditions directing the petitioner to assist the IO for assist and cooperate to IO for further investigation in the matter. A5A3 392.
Okay, in the year 2015, an affair came to the
2015.
13/2015. Against unknown person. That is by North Police. And in the year 2018, registered another affair
Another FIR or only separate FIR?
Separate FIR.
In respect of the same?
Different offense.
Different offense.
That is 15 for 2018.
Yes.
That is also for 394. Now in the year 2020-21, on 1/11/2021, the accused number 1 and 2 were apprehended in the road traffic, and they were under suspicious conduct and interrogated, and then they disclosed the commission of offences.
Offense in the year 2015.
No, initially they disclosed the 2018 59 crime number of
18.
Karnataka police.
Aito.
In the confession statement, those
mentioned the name of this petitioner.
Stated that they sold their jewelry to this petitioner.
What happened? First FIR.
First FIR
registered in 2015.
That was G report.
C report.
C report. Sorry.
C report. Not found on. Next.
Then again the 59 also C report.
In respect of recent 2020.
2021 was they are apprehended and reopened the case.
All other 2 cases are reopened.
And in the 59
only based on the voluntary statement of A1 and A2.
Yes.
This petitioner is accused number 3 and 5.
3 and 5. In 59, the Karnataka police are interrogated. In the year 2021, they reopened that case. And confession, they stated that they sold the jewelry to me. And
you are the receiver.
Receiver.
A5 or A3?
A5 is the receiver.
Receiver. A3?
A3 from the specific allegation was not there in the requisition. Saying that they, on the basis of that statement, I was arrested. In the crime number 59, they are arrested. And recoveries are made. So in the remand application, they stated that this crime number, that is 2015 crime number is concerned also, they recovered. I was arrested and I was still released on bail. And in the requisition also, the remand application, they stated I was involved in this case. They are not caught me under that.
According to you, only based on the court statement, these 2 petitioners have been arraigned. One as receiver and no allegation against A3. That's what.
Now,
no recovery at in respect of the earlier incident of 2015. Any recovery?
They recovered at crime number 59.
59. That is in 2018. Including earlier.
Then now, Lord, I was released on bail. As per the
in 53. 59.
And I was in custody for 10 days.
Yadralli 59 alla idralla? 59 alli.
Now they filed a requisition to seek body warrant of
I think body warrant kottidara illa?
Kottidare 1 and 2 case. I have an apprehension that the requisition, they mentioned the crime number of against me also in the requisition. That is in the 59.
That's why there is an apprehension. Madlin C report agiddu idu reopen agidiya? Ee claim alli agide. Reopen agide. Charge sheet also filed. 139 of 15. In crime number 59 also, these petitioners have been arraigned as an accused.
I was released on bail.
In crime number 59. That is also recovery by A1, not by this accused. A4 ilvalri court munde A5 and A3 irodu. Present condition alli eno idu 139 139 alli ಎಷ್ಟು accused number? He is the receiver. One of the item it was robbed in 2015. He has received. Through other accused, it was recovered anta. Recovered from whom? ಆಯ್ತು, ಅವಾಗ ಅವ್ನ ಅರೆಸ್ಟ್ ಮಾಡಿಲ್ವಾ? 438 ಪಿಟಿಷನ್ ಇದು. ಓನ್ಲಿ ಥ್ರೂ ಫ್ರಮ್ ದಿ ಹೌಸ್.
That was recovered at my instance. I read that remand application. At my instance, they have recovered 3 items and so it in the.
That is in pertaining to the crime number 59. Re. ಈ 139 ಅಂತಲ್ಲ.
Let's say that the 2015 offense ಗೆ recovery ಮಾಡ್ತಾ ಇದ್ದೀನಿ ತೋರಿಸ್ತಾ ಇದ್ದಾರೆ.
ತೋರಿಸಿ.
I read. Page number 23.
23. 23. ಹೇಳಿ.
In second para. ಪ್ರಕರಣ ದಸ್ತಗಿರಿ ಮಾಡಿದಾಗ ಅಪಾದಿತ ಇಸ್ಲಾಂ ಎಂಬರ ಮಾಹಿತಿ ಖುಷಿ ಹೇಳಿಕೆಯನ್ನು ಪಡೆದು ತಾನು ಸಬ್ಬಾನ್ ಮತ್ತು ಮೊಹಮ್ಮದ್ ತೌಸೀಫ್ ಆಚಿಯರು ಅಬ್ದುಲ್ ಸಿನಾನ್ ಇವರು ಸ್ವಯಂಪ್ರೇರಿತದಲ್ಲಿ ಮಾರ್ಚ್ ತಿಂಗಳಲ್ಲಿ ತಕ್ಕಂತ ಸ್ವಯಂಪ್ರೇರಿತರಿಂದ ಹೇಳಿದ ಕಡಿಮಣಿಯನ್ನು
2018 ಕೆಲಸ ಮಾಡಿಕೊಂಡಿರುವ ಮುಜಾಹಿದ್ ರಹಮಾನ್ ಎಂಬಾತನಿಗೆ ಮಾರಾಟ ಮಾಡಿರುವುದಾಗಿ ಮತ್ತು ಇಲ್ಲಿ 2015 ಏಪ್ರಿಲ್ ತಿಂಗಳ 2ನೇ ವಾರದ ಟಿಟಿ ರೋಡ್ ಎಂಬಲ್ಲಿ ಮಹಿಳೆಯಿಂದ ಹಿಡಿದುಕೊಂಡು ಚಿನ್ನದ ಕರಿಮಣಿ ಸರ 2000 ನವೆಂಬರ್ ತಿಂಗಳ ಕೊನೆಯ ವಾರದ 1 ದಿನ ಕಾವೂರಿನ ಮಾಲೆವಾರ್ ಎಂಬಲ್ಲಿ ಕೊಂಕಣಿ. ಏನ್ ಇವರೆಲ್ಲ ಬಹಳ ಬಿಚ್ಚಲು ದಿನ ಬಿಟ್ರೆ ಕದಿಯೋದೇ ಕೆಲಸ. ಗುತ್ತಿಗೆಯಿಂದ ಎಳೆದ ಚಿನ್ನ ಸರವನ್ನು ಮಲ್ಲೂರಿನ ಫಸಲ್ ಎಂಬ ಬಂಜಾರ ಮಾರಾಟ ಮಾಡಿ ತನ್ನ ಜೊತೆ ಬಂದರೆ
ಮಾರಾಟ ಮಾಡಿ 2015 ಇನ್ಸಿಡೆಂಟ್
ಆಯ್ತು.
ಎಂಬಾತನಿಗೆ ಮಾರಾಟ ಮಾಡಿ ತಂಡ ಬಂದರೆ ಸದರಿಯ ತೋರಿಸುವುದಾಗಿ ಅದರಂತೆ
ಆಯ್ತು. ಅವ್ನ ಮನೆ ಕರ್ಕೊಂಡು ಹೋದಾಗ ಯಾರಿದ್ರು?
ಫ್ರಮ್ ದ ಕೀ ನಂಬರ್ ದಿಸ್ ಪಿಟಿಷನರ್.
ದಿಸ್ ಪಿಟಿಷನರ್. ಆ ಪಿಟಿಷನರ್ ಇದ್ನ ಅವಾಗ ಇದ್ರೆ ಮತ್ತೆ ಅವ್ನ ಅರೆಸ್ಟ್ ಮಾಡಿಲ್ವಾ?
ಅರೆಸ್ಟ್ ಮಾಡಿದಾರೆ 59 ಅಲ್ಲಿ.
59 ಅಲ್ಲಿ ಆಯ್ತ್ರಿ. ಇದಕ್ಕೂ 59 ಮಾಡುವಾಗ ನೀವ್ ಹೇಳೋದು 15 ಮಾಡಿದಾರೆ ರಿಕವರಿ.
39 ಮಾಡಿದ್ದಾರೆ. They say that in the April 2nd there incident 2015 incident also they recovered. ಪತಿ ಎಂಬಾತನ್ನು ತೋರಿಸಿಕೊಟ್ಟ ಮೇರೆಗೆ ಸದರಿ ಅವರ ಸಹಾಯದಿಂದ ವಿಚಾರಿಸಲಾಗಿ ಮೊಹಮ್ಮದ್ ಅಲಿಯಾಸ್ ಪತಿ ಅವರು ತಪ್ಪನ್ನು ಒಪ್ಪಿಕೊಂಡು ಸದರಿ ನಂತರ ವಾಹನದಿಂದ ಇಳಿದು ಅಪಾಯ ಪತ್ರಿಕೆ ಹೇಳಿದಂತೆ ವಾಹನ ಇಲ್ಲದಲ್ಲಿ ಮಲ್ಲೂರು ಮುಂದೆ ಹೋಗಿ ಬದ್ರನಾಗಿರುವಾಗ ವಾಹನ ಮುಂದೆ ತಿರುಗಿ ಅಪಾದಿತನ್ನು ಮನೆಯಲ್ಲಿ ನಿಲ್ಲಿಸುವಂತ ಹೇಳಿ ವಾಹನದಿಂದ
ಅಕಾರ್ಡಿಂಗ್ ಟು ಇನ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 23 ನಲ್ಲಿ ಇನ್ಕ್ಲೂಡಿಂಗ್ ಬೋತ್ 2015 and 2018 ಎರಡು ಸೇರಿಸಿ ಕರ್ಕೊಂಡು ಹೋಗಿ ಅಲ್ಲಿ ಮನೆಯಲ್ಲಿ ರಿಕವರಿ ಆಗಿದೆ ಅಂತ. ಬಟ್ ನಾಟ್ ಅಪ್ರೆಂಡೆಡ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ದಿಸ್ ಕೇಸ್. ಆವಾಗಲೇ ನೀವು ಮಾಡ್ಕೋಬೇಕಿತ್ತಲ್ಲ ಅವನ್ನ.
ಅವರಿಗೆ ಗೊತ್ತಿತ್ತು
59 ಅಲ್ಲಿ ನೀವೇ ಮಾಜರ್ ಮಾಡ್ರಿ, ನಿಮ್ ಪೊಲೀಸೇ ಮಾಜರ್ ಮಾಡಿರೋದಲ್ಲ. ಆಯ್ತು. ಈಗ 59 ಬೇಲ್ ಆಗಿದ್ಯಾ? ಈಗ ಮೊನ್ನೆ ರೀಸೆಂಟ್ ಆದ್ರಲ್ಲಿ ಇನ್ನೊಂದು ಯಾವ್ದೋ 2021 ಅಂದ್ರಲ್ಲಿ
21 ಅಲ್ಲಿ ನನ್ನ
ಎರಡೇ ಕೇಸಾ? 139 59 ತೋಳಿ ಮೇಡಮ್. 4 ಕೇಸಸ್. ಇನ್ಯಾವ್ದು? A2 ಬ್ಯಾಡ್ರಿ. ನಾವು A5 and A3 ಇರಿದ್ವಿ. ಇವ್ರ ಮೇಲೆ ಎರಡೇ ಕೇಸ್ ಅಲ್ವಾ? ನೀವ್ ಹೇಳೋದು ಒಂದೊಂದ್ ಕೇಸಲ್ಲಿ ಒಂದೊಂದ್ ಆಗಿದ್ದಾರೆ ಅಂತ. ನಂಬರ್ ಅಕ್ಯೂಸ್ ನಂಬರ್ ಒಂದ್ರಲ್ಲಿ 4 ಒಂದ್ರಲ್ಲಿ 5 ಆ ರೀತಿ. ಇಲ್ರಿ, ಇಲ್ಲಿ ಹಾಕಿರೋದು ಓನ್ಲಿ A5 and A3 ಅಂತ ಹಾಕಿದಾರೆ. ನೋಡ್ರಿ A5 A3 ಅಂತ ಹಾಕಿದ್ದಾರೆ ಪಿಟಿಷನ್ ಅಲ್ಲಿ. ಚಾರ್ಜ್ ಶೀಟ್ ಇದೆಯಾ? ನೀವು ಬೇಸ್ಡ್ ಆನ್ FIR ಮಾಡಿದಿರಿ? ಅನ್ನಂಬರ್ಡ್ ಇದೆ 19. 19 ಅಲ್ಲಿ ಹೇಳಿ ಕ್ರೈಮ್ ಇದು ಯಾವ್ದು ಕ್ರೈಮ್ ಸಂಬಂಧಪಟ್ಟಂತ. 59 ಬೇಡ ನಮ್ಗೆ. ನಮಗೆ ಬೇಕಾದ್ರೆ 139. ಆಯ್ತು. 139 ಅಲ್ಲಿ ಎಷ್ಟು ಅಕ್ಯೂಸ್ ನಂಬರ್? 139 ಅಲ್ಲಿ 4. ನೀವು 5 ಅಂತ ತೋರಿಸಿದೀರಿ, ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇದೀನಿ. 4 ತೋಳಿ. ಹಾಗಾದ್ರೆ 4 and ಇವರು 4 and 2 2 and 4 ತೋಳಿ. Petition heard the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that the complainant one Shalini Bhatt had lodged the complaint stating that on 13/4/25 when her TV cable was not working, and to inform the same at about 7:45 she left the house and reached near Mahaprana temple and spoke to one Ganesh, and while returning to the house with a lady who was working. While standing in the road and speaking to her at that particular time, 3 unknown persons unknown people in a black color motorbike came from Tirumaleshwara temple side, and person who was sitting in the middle stopped the bike and asked the complainant way to reach place called Kudroli. At that particular instance, another person who was sitting at the back side of the bike suddenly put his hand to the neck of the complainant and snatched the chain weighing 13 pounds, which worth about rupees 4,80,000, and escaped from the spot. Based on the complaint, police have registered the case in crime number 139 of 2015 for the offence punishment 392, Red 34. The police also registered the case in respect of crime number 59 of 2018 in respect of Yadod 59 Vajpayee police station. And recoveries are made. At that time, the accused 1 and 2 also revealed the involvement of this petitioner. And recovery is made in 15. And one of the item which was ಅಲ್ಲಿ ಯಾವಾಗ ಒಂದೇ ಅಲ್ಲ ಮೊದಲು ಕತ್ಕೊಂಡು ಹೋಗಿರೋದು, ನೀವು 4 ಐಟಮ್ ಅಂತೀರಿ 2015 ಅಲ್ಲಿ. The item which was robbed in 2015 also recovered.
Three items are recovered.
And now the police investigated the matter and filed a charge sheet against these two petitioners, arraying them as accused number 2 and 4. The case of the prosecution is that accused number 4 is the receiver of the item which was robbed. And A2 no allegation. And he is also the part of robbing the gold ornaments. The counsel appearing for the petitioner would submit that only based on the voluntary statement of accused number 1 and 2 in respect of crime number 59 of 2018. This petitioner has been arraigned as an accused number 4. First petitioner arraigned as accused number 4, alleging that he is the receiver. And accused number 2 is also the part of in ಅವನ ಮೂಲಕ ಏನಿಲ್ಲ, ರೆಕವರಿ ಇಲ್ಲ. ಆಯ್ತು. And these two petitioners are also arraigned as accused in crime number 59 of 15. And now the police are making hectic efforts to apprehend this petitioner, and hence there is an apprehension of arrest. For contra, the counsel appearing for the state would submit that these two petitioners are also the habitual offenders, and recovery is made at the instance of accused number 4. One of the item which was robbed in 2015. And if anticipated bail is granted, there are chances of committing of similar offences. Having heard the respective counsel and also perusal of material, the incident was taken place on 13/1/2000, and the HCGP also submits that investigation is completed and charge sheet is filed. They have taken note of the year of the incident of the year 2015, and subsequently this petitioner also number 59 of 2018 material on record, particularly article, and also against A2 is that he was part of committing the offense. Take into consideration of the other cases are registered against this petitioner. It is a fit case to exercise the powers under section 438 of CRPC, and this court can impose the condition if petitioners have committed future liberties given to the state to seek for cancellation of bail. Anil Kumar, 406.
My lord, I am appearing for the petitioner in this case, my lord. Last occasion, my lord, government advocate has took time to verify whether he was involved in antecedent.
ಯಾಕೆ ಸಿಐಡಿ ನಲ್ಲಿದೆ ಈಗ? ಎಷ್ಟು ದಿವಸ ಮತ್ತೆ ನೀವು ಕೊಡೋದು? ಮಂಡ್ಯಕ್ಕೆ ಬುಧವಾರ ಮಂಡ್ಯಕ್ಕೆ ಆಗುತ್ತಾ? ನೋಡಿ, HCGP seeks time regarding criminal antecedents. This matter on Monday ಜಾಸ್ತಿ ಇದೆಯಾ?
23rd,
24th?
My lord, 24th I got some inconvenience. It may be on Monday or Tuesday. My lord.
Monday ಎಲ್ಲ ಜಾಸ್ತಿ ಇದ್ದಾರೆ, ರೀಚ್ ಆಗೋದು ಡೌಟ್ ಆಗ್ತದೆ.
Tuesday, my lord.
ಅದೊಂದು ಚಾನ್ಸ್ ಕೊಟ್ಟಿರ್ತೀವಿ ತಗೊಂಡಿ. ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ ಹೇಳಿ ಮೇಡಮ್. ಟ್ಯೂಸ್ಡೇ ಹಾಕ್ತೀರಿ ನೋಡು. 22nd. Sebastian ಹೇಳ್ರಿ 376 420.
Now the complaint is at page 15.
ಹೌದು. Crime is registered. Apprehension of arrest ಬಂದಿರೋದಾ?
The complaint is lodged before the Commissioner of Police. That is forwarded through the DCP, AC.
Complaint registered against whom?
Complaint is lodged before the Commissioner of Police.
Commissioner against whom? Against whom? Present petition against present petitioner. Yes.
And the police have recorded the statement of the complainant as well as the petitioner.
Complainant as well as the petitioner.
And he was made to sign an undertaking that he will marry her within a period of 30 days. That undertaking and statement recording was on 7/1. That period expired. They have produced all those documents, not the complaint which is before the Commissioner of Police, and the statements recorded by the police. They are given certified copies by the police, and also the statements of the complainant and the victim. Plus this agreement which is said to have been executed by one and
whether your client has given an undertaking to marry her?
No, in that he was made to sign.
Made to
undertake. In the police station. Otherwise, the threat was made that he and his family members would be arrested. He was forced to sign it. That period of 30 months is 30 days is also over. The learner said, both the prosecution do not dispute these documents. The complaint, my lord, she says that for the past 3 years, they have become friends and they have been moving around place to place. And according to her, they had stayed in various hotel rooms and they had sex. Finally, they decided to get married to each other. This was informed to both the family members. And later on, there was some.
You have to go to the contents of the complaint now.
Yes, madam. Page 15.
15.
I am Charu Khera. I was loving one guy who was working in the same company. Both of us liked each other and fell in love. The guy's name is mother's name, father's name, etc. We were loving each other for the last 3 years, and we decided to marry. His mother and her family members were informed. We had been to trips and stayed in hotel rooms as well as in Chennai, Pondicherry, Chikmagalur and Jammu. We got to know that he was dating with multiple girls. We decided to get married, which had come to the stage of fully. And his parents supporting him and his broken brothers also. He is now saying that he is not ready to marry me. I was just one. Her statement.
The case is not registered.
My lord.
No, case is not registered. Petitioner is also called and his statement is recorded.
Petitioner is also called, his statement is recorded, and her statement is also recorded. They don't say that they will not register the case because of this so-called agreement, my lord. It was taken on 7th, on the date of the statements. There it is said that within 30 days he will marry. That 30 days got expired. Even before that, he approached the sessions court. The learner session judge, I will read only the operative.
No, counsel, why I have to read this? I'm not sitting as appellate court. You make out the case for granting relief. That's all.
The complaint is there. Complaint is not closed.
No need to read the order of the trial court. I am not sitting as an appellate.
I understand.
You make out your case for granting bail. That's all.
Submission, Your Lordship, is the complaint governments and her statement, which is recorded by the police, which they do not dispute, shows that she has made such allegation against me and requested the police to register the case against me. And that is seldom because of the so-called undertaking given on the same day of the execution of the sick, and that 30 days has expired on 7/2. Any moment, except saying that they have not registered the case, they don't say that this complaint is closed. For them to wait for that launch a second.
What is the progress?
In fact, the IO has told me, informed us that she is putting pressure to register the case.
Now you are getting information from IO also.
They have given us all these papers. We enquired. We enquired. Whether the case is now registered.
Class 2.
31 class 2.
ಎರಡನೇ ಪಾರ್ಟಿಯವರು ನಾವು ಒಂದು ವೇಳೆ ಒಂದು ತಿಂಗಳ ಒಳಗಾಗಿ ಮೊದಲನೇ ಪಾರ್ಟಿಯವರಾದ ಸಾರ್ವಜನಿಕ ಮಾಡಿಕೊಳ್ಳದೆ ಇದ್ದ ಪಕ್ಷದಲ್ಲಿ ಎರಡನೇ ಪಾರ್ಟಿಯಾದ ನಮ್ಮಗಳ ಮೇಲೆ ಸೂಕ್ತ ರೀತಿಯ ಕಾನೂನು ಕ್ರಮ ಜರುಗಿಸಲು ನಿಮಗೆ ಸಂಪೂರ್ಣ ಅಧಿಕಾರವಿರುತ್ತದೆ ಎಂದು ಒಪ್ಪಿರುತ್ತೇವೆ. This is the application given by the police. This is only the apprehension. But as of now, as per the information given by the police, there is no FIR.
Good. Heard the petitioner, counsel, and also the counsel affair to the state. The factual matters of the case of the prosecution is that the complainant has given the complaint on 5/1/2022 before the police, stating that this petitioner and the complainant both are fell in love from last 3 years, and they had been to different places and stayed in hotel rooms in Chennai, Pondicherry, Chikmagaluru, Jammu, and now she comes to know that he is dating with other multiple girls, and his parents are also supporting him. Now he is not ready to marry her, and hence requested to take action against him. Police, in pursuance of this complaint, secured the complainant as well as the petitioner herein. And before the police also, there was an agreement between them that they are going to marry within a period of 30 days, within 30 days. And now 30 days have already been expired. No case has been registered after the negotiation between the complainant and also the petitioner herein. The counsel appearing to the petitioner would submit that even though statement of petitioner and also the complainant was recorded, and the said agreement was entered into under coercion before the police, and now making hectic efforts to apprehend the petitioner. Hence, there is a of arrest of this petitioner in view of the serious allegation made against the petitioner herein. The counsel also would submit that the complaint doesn't constitute the offense under Section 376, and all of them and both of them went together to different places and had sex with consent and stayed in different hotels and different places. In view of the apprehension, the petitioner is entitled for bail. The counsel appearing to the state would submit that both petitioner as well as the victim are secured, and this petitioner has given an assurance that he would marry her within 30 days. Now he has not married her, but even though no case has been registered against the petitioner herein, there is no any apprehension of arrest. Having heard the petitioner, counsel, and also the counsel appearing to the state and looking into the contents of the complaint, wherein specific government is made with regard to both of them went to different places and stayed in different hotel and had sex, and also he had, and both of them have decided to marry but it is not an allegation that on the guise of marry her or with the said promise. The petitioner subjected her for sexual act. Both of them voluntarily went to different places and had sex, and also the victim girl is aged about age 25 years, and petitioner 31 years, and both of them working in the same office. And the complainant is also having the consequence of subjecting her for sexual act along with him. And when she, along with the petitioner, went to different places and different places and stayed with him, she is aware of the consequence also. And when suspecting the factual aspects of the case, it is a fit case to exercise the powers and support of CRPC to grant bail with conditions. ಎಲ್ಲ ಮಾಡ್ಕೊಂಡ್ಬಂದು ಇಲ್ಲಿ ಬಂದ್ಬಿಡೋದು ಕೋರ್ಟಿಗೆ. ಕನೆಕ್ಟೆಡ್ ಎರಡು ಇದೆ. 420, 504, 506. ಅಪ್ಲೈನ್ ಸರ್. ಸಬ್ಜೆಕ್ಷನ್ ಫಾರ್ ಸೆಕೆಂಡ್ ಟೈಮ್. ಯಾವ್ದು ಸೆಕೆಂಡ್ ಮ್ಯಾಟರ್? ಯಾರು? ಕೆಂಪೇಗೌಡ ಯಾರ್ರಿ? ನೀವಾ? ಏನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡಿಲ್ಲ? ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಏನು? Just 832 na. Innal message second page. Order. Second page of the order. 1, 2, 3. 625. 466 ಇದೆ. Second page ಇಲ್ಲ. ಮತ್ತೆ ಸೆಕೆಂಡ್ ಪೇಜ್ ಇಲ್ಲ ಅಂತಂದ್ರೆ ಮತ್ತೆ ಫ್ರೆಶ್ ಆರ್ಡರ್ ತಗೊಂಡಿದ್ರಾ? ಕೊಡಿ ನೋಡಿ. ಇನ್ನೊಂದು ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಯಾರು? ಹೇಳಿ ಅಕ್ಯೂಸ್ ನಂಬರ್ ಫಸ್ಟ್ ಒನ್ ಅಲ್ಲಿ A2 ನಾ? ಇವನು A1 ನಾ? 2438. ಹೇಳಿ, ವಾಟ್ ಈಸ್ ದಿ ಅಲಿಗೇಷನ್? 420 ಅಫೆನ್ಸ್ 420. 504, 506 ಬಿಟ್ಬಿಡಿ. 420 ಮಾತ್ರ ಹೇಳಿ ಏನು? ದುಡ್ಡು ಇಸ್ಕೊಂಡು 4 ಲಕ್ಷ ಏನು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ. ಯಾರು ಕೊಟ್ಟಿಲ್ಲ, ಏನು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ. ಪೇಮೆಂಟ್ಸ್ ಯಾವ ರೀತಿ? ಚೆಕ್ ಮೂಲಕ. Who has received the amount of ₹4 lakhs? A2. How A1 is connected to this?
A1 is came to the contact with the complainant. He is a retired soldier. Therefore, he was assured
he made him to make the payment of ₹4 lakhs in favor of accused number 2. ಹೌದಾ? ಯಾರು ದುಡ್ಡು ರಿಸೀವ್ ಮಾಡಿದ್ರ? A2 ನಾ? ಕೊಟ್ರ ದುಡ್ಡು ವಾಪಸ್ಸು? ಮತ್ತೆ ಕೊಡ್ಬೇಕಲ್ಲ. ಪೇಮೆಂಟ್ ಕ್ಯಾಶ್ ಮೂಲಕ, ಚೆಕ್ ಮೂಲಕ ಆಗಿದೆಯಾ? ಇಲ್ಲ. ಮತ್ತೆ ನಿಮ್ಮವನಿಗೆ ಯಾಕೆ ಬೇಲ್ ಕೊಡ್ಬೇಕು? ದುಡ್ಡು ತಗೊಂಡು 4 ಲಕ್ಷ ಮಜಾ ಮಾಡ್ಕೊಂಡು ಇದ್ದವನಿಗೆ ಯಾಕೆ ಬೇಲ್ ಕೊಡ್ಬೇಕು? ಅದು 438. ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಳ್ಳಿ, ಆಮೇಲೆ ಬನ್ನಿ. ಮತ್ತೆ ಅಲ್ಲ ರೀ, 4 ಲಕ್ಷ ಅವನೇನು ಪಾಪ ಯಾರೋ ಎಕ್ಸ್ ಆರ್ಮಿ ಮ್ಯಾನ್. ಅವನ ಹತ್ರ 4 ಲಕ್ಷ ಇಸ್ಕೊಬಿಟ್ಟು ಕಾರ್ ಕೊಡ್ತೀನಿ, ದುಡ್ಡು ಕೊಡ್ದಲ್ಲ ಈ ಕಡೆ. ಅಕ್ಯೂಸ್ ಎಕ್ಸ್ ಆರ್ಮಿ ಮನ್ನ. ಇವನೇನ್ ದೇಶಕ್ಕಾಯ್ತು ನನಗೆ ಗೊತ್ತಾ ಏನು? ದುಡ್ಡು ಕೊಡಿ, ಆಮೇಲೆ ಕನ್ಸಲ್ಟ್ ಮಾಡೋಣ. A1 at your instance only amount of ₹4 lakhs paid ಅಂತ. ಅದೇ ರೀ, at your instance. Two received the amount ರೀ. ಅದೇ A1 ಸರ್ವಿಸ್ ಮ್ಯಾನ್. At the instance of A1 only, he parted the amount of ₹4 lakh. ನೋಡಿ, ಒಂದು ವಾರ ಟೈಮ್ ಕೊಡ್ತೀನಿ, ಏನ್ ಮಾಡ್ತೀರಿ ನೋಡಿ, ಮಾಡ್ಕೊ ಬನ್ನಿ. ನಾನು ಇಲ್ಲಿ ಕೂತ್ಕೊಂಡು ಸೀಲ್ ಹಾಕಕ್ ಕೂತಿಲ್ಲ ಕಳ್ಳರುಗಳಿಗೆಲ್ಲ, ಮೋಸಗಾರರಿಗೆಲ್ಲ. ಆಯ್ತಾ? ಯು ಮೇಕ್ ದಿ ಪೇಮೆಂಟ್, ಐ ವಿಲ್ ಕನ್ಸಿಡರ್ ಇಟ್ ಯುವರ್ ಪಿಟಿಷನ್. ಅಟ್ಲೀಸ್ಟ್ ಹಂಗಾರ ದುಡ್ಡಾರ್ ಬರ್ಲಿ. ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ ದುಡ್ಡು ಕೊಟ್ಟು ಬನ್ನಿ, ಇಬ್ಬರಿಗೂ ಕೊಡೋಣ ಬೇಲ್. ಏನ್ರಿ ಚೆಕ್ ಮೂಲಕ ದುಡ್ಡು ಇಸ್ಕೊಂಡಿದ್ದೀರಿ, ದುಡ್ಡು ಕಾರು ಕೊಡಲ್ಲ, ಈ ಕಡೆ ದುಡ್ಡು ಕೊಡಲ್ಲ ಏನ್? ನೆಕ್ಸ್ಟ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ, ಅದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಮೆಮೋ ಹಾಕ್ಬಿಟ್ಟು ಕೊಡಿ. ಅದು ತಗೊಳ್ಳಿ, ಎರಡನೇ ಮ್ಯಾಟರ್ ತಗೊಳ್ಳಿ. Petitioner counsel is directed to comply with office objection within 2 days. List both the matters on 25th. 77 Sayyid Mujakir Ahmad. ಹೇಳ್ರಿ.
Next under section 67B of the information. Allegation my lords there. Sir, to have watched a photo on 27/2020 in 11:45 and 21:07 now. 11:45 12:30. This is of report forward by the voters. CPC police constable has so much registered this around 24/11 after 1.5 years of allegations. The allegations is that regularly
ಏನು ಅಪ್ಲೋಡ್ ಮಾಡಿದ್ದೀರಾ?
ಅಪ್ಲೋಡ್ ಅಲ್ಲ,
ಸೈಬರ್ ದೂರನೇನು ಆರೋಪಿಯಾದ ಸೋನ್ಸೋರ ಮಕ್ಕಳ ವಿರುದ್ಧ ಲೈಂಗಿಕ ಅಪರಾಧ ತಡೆಗಟ್ಟು ನಿಟ್ಟಿನ ಪ್ರತ್ಯೇಕವಾದ ಸಪರೇಟ್ ಸೆಲ್ ಇದೆ. ಆ ಸೆಲ್ ಅಲ್ಲಿ ಕಮ್ಸ್ ಟು ನೋ ಅಬೌಟ್ ದಟ್ 27/2 11 ಗಂಟೆ ಸಂಧ್ಯಾದಿಂದ 21 ಬೆಳಗಿನ ಜಾವ 3 ಗಂಟೆಯವರೆಗೆ ಮಕ್ಕಳ ಅಶ್ಲೀಲತೆ ಭಾವಚಿತ್ರ ಇದರೊಂದಿಗೆ ಲಗತ್ತಿಸಿಕೊಂಡಿರುವ ಆರೋಪಿಯ IP ವಿಳಾಸ, ನಿಂದ IP ವಿಳಾಸ ಕಂಡು ಬಂದಿದ್ದು. ಸಿಡಿಯಲ್ಲಿರುವ ಮಾಹಿತಿಯನ್ನು ದೃಢಪಡಿಸಿದ ಆರೋಪಿಯ ವಿಳಾಸವು ಸೋನ್ಸೋ. ಬೇರೆ ಏನಾರು ಇದೆಯಾ? ಇದೊಂದೇನಾ? ಬೇರೆ ಏನಾರು ಇದೆಯಾ? ಇನ್ವಾಲ್ವ್ ಆಗಿದ್ದಾನ? ಇಲ್ಲ. ಕೌನ್ಸಿಲ್ ಅಫೇರಿಂಗ್ ಫಾರ್ ದಿ ಸ್ಟೇಟ್. The factual matters of the case of the prosecution is that through the IP number of this petitioner, this petitioner has indulged in indecent pictures of the children at 27/2020 at 11:45 in between 11:45 and 21/7/2020 00:30 hours. Based on the said information, case is registered and matter is under investigation. The counsel appearing for the petitioner would submit that this petitioner has not indulged in any such acts and false case is registered and no person has given complaint and so motor complaint is registered. For count of the counsel appearing for the state would submit that the cell which noticed the same based on the information, case has been registered and matter is under investigation. Having considered the factual aspects of the case and allegations made against it. What is it? Onenre on kelsa?
Now working in a pawn broker shop. His father Sunday jote pawn broker shop ide.
Madam, have got the respective counsel and also perusing the factual aspects of the case and also taking into note of the allegation made against the petitioner. And the case is also registered by the slow motor by the concerned cell. And there is no any other criminal antecedents against this petitioner. Hence, it is a fit case to exercise the powers before the date of service. 78 Mohammed Pasha. FIR stage. Charge sheet ಆಗಿದೆಯಾ? ಹಾಕಿದಿರಾ? ಯಾವಾಗ ಹಾಕಿದಿರಿ ನೀವು ಕೋರ್ಟ್ ಮುಂದೆ? ಈಗ ಕೊಡ್ತಾ ಇದ್ದೀರಾ? petitioner counsel files memo along with charge sheet materials. Matter on next Friday. Date ಕೊಡಿ. 25th. ತಗೊಳ್ಳಿ. ಮೆಮೊ along with ಹಾಕಿದಾರಾ? ತಗೊಳ್ಳಿ. ಅವ್ರಿಗೆ ಕಾಪೀಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ನಿಮ್ಮ ಹತ್ರ ಇದೆಯೇನ್ರಿ ಚಾರ್ಜ್ ಶೀಟ್ ಮೆಟೀರಿಯಲ್ ಎಲ್ಲ? ಆಯ್ತು. ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 22. ನೆಕ್ಸ್ಟ್ 79 ಪ್ರದೀಪ್ CS.
appearing for the petition, my lord.
Next time ಏನು ಫೈಲ್ ಕಂಪ್ಲೇಂಟ್ ಅನ್ನ ಲಾಸ್ಟ್ ಟೈಮ್ ತಗೊಂಡಿದ್ರಿ?
Please, my lord. I have filed a memo along with the complaint, my lord. For the date petition, my lord. The date of FIR is on 5/4/2020. The offence punishable on 408 and 420. My lord. The petitioner is working in the complaint office, my lord, company as an accountant, my lord, from the past 4 years. And was misappropriate a fund of rupees 12,50,000. This is the allegation made by the complainant, my lord.
Now the police are frequently searching the house of the petitioner to arrest.
What is the complaint now? This is regarding.
My lord, the complaint is, I have filed a memo, my lord. That is the
complaint against whom?
Against Dhanalakshmi, my lord.
Against the present
Please,
petition.
I have filed another complaint in the petition, my lord. That was a complaint given with the petitioner against the complainant, my lord.
That was dated. That was dated.
Dated 33/2021, my lord.
33/21.
Please, my lord.
Present complaint.
Present complaint 5/4/2021, my lord.
Hmm. 33.
Please, my lord.
This is subsequent to the complaint.
Lord, I have filed a complaint on 33/2021, my lord. Later, the complaint.
33 on no complaint.
Lord, I have filed along with the petition page.
Oh, Rashmi Alme. No, nim complaint ne first hakidira.
Please, my lord, my colleague has.
Annexure B.
How do, my lord? That's the complaint made by the petitioner.
The complaint is dated 6/4.
Please, my lord.
Told. Here is the.
30/3/2021 only prepared the complaint, not inside.
ಈ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟೇ ಇಲ್ವಾ?
Page number 11.
ಎಲ್ರಿ ಈ ಕಂಪ್ಲೇಂಟ್ ಪೊಲೀಸ್ ಕೊಟ್ಟಿದ್ದೀರಾ ನೀವು?
Please, my lord, they have given to the police of Micro Layout Police Station, Thana Adhikari.
Where is the acknowledgement? Thana Adhikari ಇದೆ ರೀ, acknowledgement ಇಲ್ಲಿದೆ for having given the complaint. It appears that you have prepared this complaint and now annexed it.
No, my lord.
No, where is the acknowledgement?
Produce, my lord. The client has not.
Acknowledgement for having given a complaint.
Petition has not given the acknowledgement to me, my lord. I will collect that.
ನೀವು FIR ಜೊತೆಗೆ ಆ ಕಂಪ್ಲೇಂಟ್ ಕಾಪಿನ ಇಟ್ಟಿದ್ದೀರಿ?
ಹೌದು, my lord.
Complaint copy. Where is the acknowledgement for having given complaint on 33/21 to police?
Please, my lord, verify that, my lord. Actually, the petitioner has.
What happened? What happened about this complaint?
Nothing process, my lord. The police have called the both of them and they have settled that.
ನಿಮ್ಮ ಹತ್ರ acknowledgement ಇದೆಯಾ? 33 ಕೊಟ್ಟಿರೋದಕ್ಕೆ ಕಂಪ್ಲೇಂಟ್.
ಅದು ರೂಪಕ್ಕೆ, my lord, ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಿದ್ರು petitioner.
ಕೊಡಿ ನೋಡಿ, then we will consider it. ಮತ್ತೆ ಆಗಿಲ್ಲ. ಸಿಗ್ನೇಚರ್ ಇಲ್ಲಿ ಮೋಸ್ಟ್ಲಿ ಅದೇ ಕಾಪಿ ಇಟ್ಟಿರ್ತಾರೆ.
Through account is transfer the customer.
What is the allegation against this petitioner? Both husband and wife.
No, my lord. Against the
wife was working. Her allegation in her complaint that the both of them were subjected to assault anta. This allegation, you know. How much amount? 12,50,000. Amount transferred in favor of whom? They yaar kadinda yaar? From the customer. From the customer, she has received the amount to her account. Houda? 12,50,000. Towards 70 transactions between 2018 to 21 for about 3 years. ಏನ್ರಿ ಆಮೇಲೆ ನೀವೇ ಒಂದು ಕಂಪ್ಲೇಂಟ್ ತಯಾರು ಮಾಡ್ಕೊ ಬಂದಿದ್ರಿ? ಈಗ ಆನ್ ರೆಕಾರ್ಡ್ 12,50,000 ಟ್ರಾನ್ಸ್ಫರ್ ಟು ದಿ ಅಕೌಂಟ್ ಆಫ್ ನಿಮ್ಗೆ ಹೆಂಗ್ ಬಂತು 12,50,000? ಯು ಬಿಂಗ್ ಎನ್ ಅಫಿಷಿಯಲ್ ಇನ್ ದಿ ಕಂಪನಿ.
They have made allegation against me, my lord.
ಸ್ಮೈಲ್ ಕೊಡ್ಬೇಡ್ರಿ, ರೀಸನ್ ಕೊಡಿ.
My lord, our allegation ಹೇಳ್ತಿರೋದು ನಾವು ಕಸ್ಟಮರ್ ಕಡೆಯಿಂದ ಕಲೆಕ್ಟ್
not a case for granting bail counsel.
Apprehension.
And also why you involved in creating this document?
Well, I am not involved, my lord. The petitioner maybe has filed a complaint, my lord, to the Michael Layout Police Station.
There is the acknowledgement. You produce the acknowledgement, then I will consider it.
Produce, my lord.
It takes time to place the acknowledgement for having given the complaint on 33/21/2021 against the complainant herein. Is this matter on
24, my lord.
24th? 80 Praveen C. Praveen C. Last time no representation. Ready. Barlila and I'm dismiss Marnella. 81. Shashidara TP. Shashidara, last time price time. Charge sheet. Pass over ಮಾಡಿ. Srinivas M. ಏನು interim bail? ಏನಾಗಿದೆ? ಡಿಸ್ಚಾರ್ಜ್ ಆಗಿದಾರಾ?
ಆಗಿದ್ದಾರೆ.
ಏನ್ ನೇಚರ್ ಆಫ್ ಇಂಜುರೀಸ್ ಏನು?
27/11/2021.
ಎಷ್ಟು ದಿವಸ ಇದ್ದಾರೆ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಹೇಳಿ?
27/11/2021 ಅಡ್ಮಿಟ್ ಆಗಿತ್ತು. 2/12/2021 ಡಿಸ್ಚಾರ್ಜ್. Course of treatment in hospital ಅಲ್ಲಿ no intra or immediate post operative
ಮೇಡಮ್ ಕೊಡಿ
and
ಏನಾಯ್ತು ನೇಚರ್ ಆಫ್ ಇಂಜುರೀಸ್ ಏನ್ರಿ ಹೇಳಿ ಮೇಡಮ್ ಒಂದು ಸರ್ಟಿಫಿಕೇಟ್ ಏನೋ ಡಿಸ್ಚಾರ್ಜ್ ಸಮರಿ ಕೊಡಿ.
ಎಲ್ಲರಿಗೂ ಬೇಲ್ ಆಗಿದೆ.
ನೇಚರ್ ಆಫ್ ಇಂಜುರೀಸ್ ಏನ್ರಿ ಹೇಳ್ರಿ?
I am the lady, age about 64 years. I am filed a civil suit. ನಮ್ಮ ಅಣ್ಣನ ಮೇಲೆ ಹಾಕಿರೋದು ಕೇಸು. ಸಿವಿಲ್ ಸೂಟ್ ನಡೀತಾ ಇದೆ.
ಸಿವಿಲ್ ರಾಜ್ಯ ಹೊಡೆದಾಡ್ಕೊಂಡು ಯಾರಿಗೆ ಏನ್ ಮಾಡಿದ್ರಿ ಹೇಳಿ?
ಅಲ್ಲ ಈಗ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಇವರು ನಮ್ಮನ್ನ ಕಾಂಪ್ರಮೈಸ್ ಕರೋದಕ್ಕೆ ಇದೆಲ್ಲ ನಮ್ಗೆ 2 ಸೂಟ್ ಇದೆ. ಆ ಸೂಟ್ಗೆ A1 A2 A3 ಅಂತ ಬೇರೆ ಇದ್ದಾರೆ.
ನೇಚರ್ ಬೈಂಡಿಂಗ್ ಫ್ರಾಕ್ಚರ್ ಆಫ್ ಲೆಫ್ಟ್ ಜೈಗೋಮ್ಯಾಟಿಕ್ ಆರ್ಚ್. ಬೇರೆ ಯಾರು ಬೇಲ್ ಆಗಿದೆ? ರೆಗ್ಯುಲರ್ ಬೇಲ ಆಂಟಿಸಿಪೇಟರಿ ಬೇಲ?
A1 and A2.
63 ವರ್ಷ ಏಜ್. ಇವ್ರ ಎಷ್ಟನವ್ರು ಅಕ್ಯೂಸ್ ನಂಬರ್? A4 ಬೇಲ್ ಯಾರಿಗಾಗಿದೆ ರೀ? ಬೇಲ್ ಯಾರಿಗಾಗಿದೆ? ಒಂದ್ಸರಿ 4 ಅಂತೀರಿ, ಒಂದ್ಸರಿ ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇದೀವಿ.
A3 A5 A1
A1 A3 A5 ಆಗಿದೆ. A2 ಆಗಿಲ್ಲ ಅಷ್ಟೇ. Totally heard the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that on 26/11/2021, when the complainant questioned the encroachment of the property, this petitioner along with other assailants with an intention to take away the life assaulted. ಯಾರ್ಯಾರು ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ? CW only ಒಬ್ಬರೇನ injured? Assaulted 4 persons who have sustained the injuries simple in nature or grievous in nature? Sustained 4 injuries by injuries. 4 persons have sustained injuries. Out of that, one injured has sustained grievous injury and he took the treatment for a period of 8 days. The counsel appearing for the petitioner would submit that charge sheet agila. The matter is under investigation. The counsel appearing for the petitioner would submit that this petitioner is aged about 64 years and there were 2 civil suits between the parties, only with an intention to offer settlement. A private complaint, separate false complaint is filed against the petitioner hearing. The counsel also would submit that except this petitioner or all other accused persons are enlarged on bail. The injured witness also discharged from the hospital and produced the discharge summary, which discloses that he was admitted to hospital on 27/11/21 and discharged on 2/12/2021. And the injured suffered fracture of left zygomatic arch. The counsel appearing for the state would submit that out of the 4 injured persons, 1 had sustained grievous injuries and he was in the hospital for a period of 8 days. Having heard the respective counsel and also perusal of material available on record, the injured had sustained fracture of left zygomatic arch and the injury is also not on the vital part. And apart from that, injured is out of danger and other accused persons have already been enlarged on bail. And this petitioner is also a lady and aged about 64 years and hence allowed petition with conditions. Prasanna Kumar P. Yes, madam. No, 445, madam. Coordinate bench, no, 445. Hi, petitioner counsel seeks time with this matter on 25 ಆಗುತ್ತಾ ಜಾಸ್ತಿ ಆಗ್ತಾ ಇದೆಯಾ ಇಲ್ಲ ಹಾಕ್ಬೋಣ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂದ್ಬಿಡೋಣ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂದ್ರೆ ಮತ್ತೆ ಆಗೋದಿಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಇದೆಯಾ ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್ ಮೂರ್ತಿ 84 327 354 506 504 427 ಏನ್ರಿ ಹಾ ಒಂದೇ ನಿಮಿಷ ಅವ್ನು ಕೇಳ್ತೀನಿ ಅವ್ನು ಕೇಳೋದಿದ್ರೆ ಮಾಡೋಣ ಇಲ್ಲ ಏನ್ರಿ ಎಲ್ಲ ಅಫೆನ್ಸ್ ಎಲ್ಲ 327 354 ಇವೇ ಇದಾವೆ ನೀವ್ ಎಷ್ಟನವರು ನಾಟ್ ಅಟ್ ಆಲ್ ಇನ್ ದ ಸ್ಪಾಟ್ ಸಿವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಆಯ್ತು heard the petitioner counsel and also the counsel appearing to the state. The factual matters of the case of the prosecution is that on 25/12/21, this petitioner and the other accused persons have trespassed it by laundry offense. Oh, these are trespassed and demolished the shed and also caused a life threat and abused in a filthy language and outraged the modesty of a woman. Based on the complaint, police are registered the case and matter is under investigation. Also, the petitioner would submit that there is a civil dispute between the parties and this petitioner was not present at the time of the alleged incident, not committed any offences as alleged in the complaint. This petitioner is ready to obey the conditions that were imposed and also ready to cooperate with the investigation. For contrary, the counsel appearing for the state would submit that this petitioner along with other accused passed the hand and caused the life threat and also outraged the modesty of a woman. Hence, there is a prima facie case. Having heard the respective counsel and also on perusal of material available on record, it discloses that there is a dispute in respect of the property site number bearing number 246, Kata number 536 of 536/60/1/246. Incident was taken place. Having considered the gravity of the offense and allegations made in the complaint, it is a fit case to exercise the powers under section 438 of CRPC with conditions. 86 Latif B. A6. 420 ಏನ್ ಇದು ಫೋರ್ಜರಿ ಇದೆಲ್ಲ ಏನು 465 460
done by the issue number 2 and 3.
2 and 3 ಏನ್ ಮಾಡಿದ್ರು 2 and 3
Running the factory by creating a
fake deed ಈನಾ ತುಪ್ಪ fake ತುಪ್ಪ ನಿಮ್ಮ ಮೇಲೆ ಏನು ಅಲಿಗೇಷನ್
is I am purchasing that ghee.
ಅಲ್ಲ ಸರಿ ರೀ ಅದಕ್ಕೇನು ಫೋರ್ಜರಿ ಏನ್ ಬರ್ತದೆ 468 468 470
has created some the fake plastic covers,
fake documents, fake bills,
and bundles of that.
ಆಯ್ತು ನಿಮ್ಮವ್ರ A6 ನಿಮ್ಮವ್ರ ಮೇಲೆ ಏನು ಅಲಿಗೇಷನ್
I purchased the ghee from the accused number 2 and 3 on the confession and implicated. Now the
confession
of the accused number 2 and 3 have been implicated me as accused number 6. Now accused number 6 1 4 5 8 9 9 are enlarged on bail.
ಆಯ್ತು ನಿಮ್ಮೋನ್ ಮೇಲೆ ಏನು ಹೇಳಿ ಫಸ್ಟ್ ಅಲಿಗೇಷನ್ you have purchased the ghee then
sold to the retailer, sir.
You have purchased and sold the same to the general public,
not to the shop.
ಶಾಪಿಗೆ ಕೊಟ್ರಾ
Accused number 7.
accused number 7 ಗೆ
That is the allegation.
ಅವನೇನ್ ಶಾಪ್ ಅಲ್ಲಿ ಅವ್ನು ಸೇಲ್ ಮಾಡ್ತಾ ಇದ್ನ
Yes,
you are purchasing the same from other accused who prepared the adulterated ghee and then
and that was I purchased and
in turn you supplied it to the accused number 7. ಏನು ಎಷ್ಟು ಇದು ವ್ಯವಹಾರ
but there is no recovery from me.
ಏನು ರಿಕವರಿ ಇಲ್ವಾ ಓನ್ಲಿ ಆನ್
confession
ಸ್ಟೇಟ್ಮೆಂಟ್ ರಿಕವರಿ ಇದೆಯೇನ್ರಿ ಒಂದ್ ಕಡೆಯಿಂದ
entire transaction in the year of 2015
ಹಾ
started.
ಹಾ
Trade in the name of the
ಆಯ್ತು ಹಾ
but then some other dealers came with Nandini parlor. Again, another person is the created going to the double. 1 kg ತಗೊಳ್ಳೋದು ಅದರಲ್ಲಿ
ಮೇಕಿಂಗ್ ದಿ ಸೇಮ್ ಆಸ್ 3
repack ಮಾಡಿ ಮತ್ತೆ ಇವರಿಗೆ ಕೊಟ್ಟು ಇವರಿಗೆ ಸಪ್ಲೈ.
ಹಾ ಮೂಲಕ ಆಯ್ತು. ಇವನ್ ಕಡೆಯಿಂದ ಏನಾದ್ರು ರಿಕವರಿ ಇಲ್ಲ
ಅವ್ರಿಗೆ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಆಗಿದೆ ಸರ್, ನೋ ರಿಕವರಿ.
ಬಟ್ ಏನಾದ್ರು ಹೋಗ್ಲಿ ಇವನ್ ಕಡೆ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಆದ ಬಗ್ಗೆ ಏನೋ ದುಡ್ಡು ಏನಾದ್ರು ಇದೆಯಾ?
ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಹಿಸ್ಟ್ರಿ
ಹಾ ಅದೇನಿದೆ ಏನು ತೋರಿಸಿ. ಹಾ ಥ್ರೂ ಅಕೌಂಟ್ ಪೇಮೆಂಟ್. ಹಾ ಅದೇ ಹೌ ಮಚ್ ಹಿ ಹ್ಯಾಸ್ ರಿಸೀವ್ಡ್?
But that admittedly I was a wholesale dealer. I purchased the DL. I am also a dealer from the Milk Federation. The allegation is that in time I am selling to the, I am also purchasing from this person. That does mean that entire items are purchased from the only.
ನೀವು ಯಾವಾಗ ಅರೆಸ್ಟ್ ಆಗಿದ್ದ ಅವಾಗ?
I was in custody from 28/12/2021.
28/12. ಏನ್ ಮಾನಿಟರಿ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಎಷ್ಟಾಗಿದೆ? ಇವನ ಅಕೌಂಟಿಗೆ ದುಡ್ಡು ಎಷ್ಟು ಬಂದಿದೆ? ವೆನ್ ಹಿ ಸೆಲ್ಸ್ ದಿ ಸೇಮ್ fake ghee in favor of accused number 7.
ಮತ್ತೆ ಇವರು ಡುಪ್ಲಿಕೇಟ್ ಮಾಡೋರಿಗೆ ಇವ್ರು ಕೊಟ್ಟು ಅವರಿಂದ ಒಂದು ಡಬಲ್ ಮಾಡ್ತೀವಿ ಸಪ್ಲೈ ಆಗಿ.
ಅಲ್ಲ ಇವರೇ ಇಂಟೆಲಿಜೆಂಟ್
ಮಿಡ್ಲ್ಮ್ಯಾನ್ ಎಂಟೈರ್ ತಗೊಳ್ಳೋದು, ಇದನ್ನ ಡುಪ್ಲಿಕೇಟ್ ಮಾಡೋರಿಗೆ ಕೊಡೋದು, ಇವರೇ ಸ್ವಲ್ಪ ತಗೊಂಡು ಆಮೇಲೆ ಅದನ್ನ ಒಂದು ಡಬಲ್ ಪ್ಯಾಕ್ ಮಾಡಿ 1 kg 2 kg ಮಾಡಿ ಮತ್ತೆ
ಅಡಲ್ಟ್ ಮಾಡಿ ಫೇಕ್ ಇದನ್ನು ಹಾಕಿ ಆಮೇಲೆ ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇರೋದು ಫೈನಾನ್ಷಿಯಲ್ ಎಷ್ಟು ಟ್ರಾನ್ಸಾಕ್ಷನ್? ಫೈನಾನ್ಷಿಯಲ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಎಷ್ಟು? ಬಟ್ ನೋ ಸಚ್ ಫೇಕ್ ಘೀ ಇಸ್ ರಿಕವರ್ಡ್ ಫ್ರಮ್ ಹಿಸ್ ಇನ್ಸ್ಟೆನ್ಸ್, ಹೌದಾ? ಬಟ್ ಈ ಇಂಟೆಲಿಜೆನ್ಸ್ ಇನ್ ಸಚ್ ಆಕ್ಟ್ ಅಂತ ತೋರ್ಸಕ್ಕೆ ಏನಾದ್ರು ಫೈಮಾ ಫಿಸಿ ಏನಿದೆ? ಎಷ್ಟ್ರಿ ಅದು ಅಮೌಂಟ್ ಹೇಳಿ ಅಟ್ಲೀಸ್ಟ್ ನಿಮಗೆ ಗೊತ್ತಿಲ್ಲ ಈಗ ಎಷ್ಟಿದೆ ಅಂತ? ತರ್ಸ್ಕೊಳ್ಳಿ ನೋಡೋಣ. ಇಮಿಡಿಯೇಟ್ ಮಿಲ್ಕ್ ಫೆಡರೇಷನ್ ಇಂದ ಪರ್ಚೇಸ್ ಮಾಡಿ ಆಮೇಲೆ ಏನ್ ಮಾಡಿದ್ರು?
Not I sold to the retailers. And there is an allegation that I was also purchased from this issue number 2 and 3. They are manipulating the red.
ಅದೇ ರೀ 2 and 3 ಇಂದ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ಕೆ ಏನಾರು ಇದೆಯಾ ನೀವು? ಅದರ್ ದನ್ ದಿ
that to on the confession note. There is no specific allegation.
ಆಯ್ತು, ಅದಕ್ಕೆ ನಾವು ಏನು ಫೈನಾನ್ಷಿಯಲ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಗೊತ್ತಾಗುತ್ತಲ್ಲ ಏನು?
Financial transaction, I am a wholesale dealer. I have a membership in this.
A7 ನೀವು ಸೇಲ್ ಮಾಡಿದಿರಿ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ ಅವರು. A2 ಕಲೆಕ್ಟ್ ಮಾಡಿ. HCCP seeks time to get the details regarding monetary transaction in view of the fake ghee sold. Discuss this matter on 25th.
D.
86 sir. Harish Kumar D. 420 504 506. Harish Kumar absent. Told. This matter.
Present.
ಹೇಳ್ರಿ ಕಾರ್ಡ್ ಬಂದಿಲ್ಲ. ಫಸ್ಟ್ ಟೈಮ್
Second time, madam.
ಸೆಕೆಂಡ್ ಟೈಮ್ ಅಂದ್ರೆ ಫಸ್ಟ್ ಟೈಮ್ ನೋಟಿಸ್ ಆಗಿತ್ತು ಅವ್ರಿಗೆ.
Yes, ma'am. Yes, my lord. It was listed on.
ಬಂದಿದೆಯಾ? ಮತ್ತೆ ಯಾರು ಗೆಟ್ ದಿ ರೆಕಾರ್ಡ್ಸ್ ಅಂತ ಎಷ್ಟು ಸರಿ ತಗೋಬೇಕ್ರಿ? ಒಂದು 420 ಅಫೆನ್ಸ್ ಇದೆ. ಹೌ ಮೆನಿ ಟೈಮ್ಸ್ ಮ್ಯಾಟರ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಲಿಸ್ಟೆಡ್?
My lord,
only ಏನು ಅಲಿಗೇಷನ್ ಫ್ರಾಡ್ ಏನು 420 ಇದೆ? ಅದರ್ ದನ್ ದೋಸ್ ಟು
the fact is the complainant and the accused number 1 are working in the same institution, Venkatraju Institution of Polytechnic College, my lord. Accused number 1, the petitioner number 1 is the principal and the complainant is the helper working over there. So in the year 2 helper, lab technician helper, my lord. In the year 2013, the government make a resolution that all private college should be given a government aided recognition
for aiding.
For that reason, in entire Bangalore, the many colleges have been.
ಹುದ್ದೆಗಳಿಗೆ ಸುಮಾರು 80 ರಿಂದ 90 ಜನ ಭರ್ತಿ ಮಾಡಿಕೊಳ್ಳಲು ಸೀಟ್ ಒಂದಕ್ಕೆ ಇಂತಿಷ್ಟು ಹಣವನ್ನು ತೆಗೆದುಕೊಂಡು ಒಂದು ಹುದ್ದೆಗೆ 2-3 ಜನ ಅಭ್ಯರ್ಥಿಗಳನ್ನು ಹಣವನ್ನು ಪಡೆದಿರುತ್ತಾರೆ. ಇದನ್ನು ಫಿರ್ಯಾದಾರ ಪ್ರಶ್ನಿಸಿದಾಗ ನಮ್ಮ ಕಾಲೇಜು ಸರ್ಕಾರದ ಅನುದಾನಕ್ಕೆ ಹಣವನ್ನು ನಂಬಳವಾಗಿ ನೀಡಿ ಫಿರ್ಯಾದಾರನ್ನು ಸಂಸ್ಥೆಯಲ್ಲಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದವರು ನಂಬಿಸಿರುತ್ತಾರೆ. ಈ ರೀತಿಯಾಗಿ ಮೋಸ ಮಾಡುತ್ತಿರುವುದನ್ನು ಇವನ್ ಕಡೆಯಿಂದ ಏನಾರಾಗಿದೆ ಏನ್ರಿ ಮೋಸ? ಇವನಿಗೆ ಏನಾರು ಆಗಿದೆಯಾ ಕಂಪ್ಲೇನೆಂಟ್ ಗೆ?
ಸ್ವಾಮಿ
ಜನರಲ್ ಅಲಿಗೇಷನ್ ಮಾಡ್ತಾನೆ
ಕಂಪ್ಲೇನೆಂಟ್ ಹೇಳೋದು ಇವ್ರು ಹೇಳೋದು 2,66,000. 2,60,60,000 ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ. ಮೈ ಲಾರ್ಡ್ಶಿಪ್ ಮೈ ಕೈಂಡ್ಲಿ ಸಿ ಪೇಜ್ ನಂಬರ್ 18 ಸೆಕೆಂಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಸ್ವಾಮಿ. ಈ ವಿಚಾರವಾಗಿ ವೆಂಕಟರಾಜು ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಆಫ್ ಟೆಕ್ನಾಲಜಿ ಚೇರ್ಮನ್ ರವರಾದ ರಮೇಶ್ ರಾಜು ಅವರಿಗೆ ಭೇಟಿ ಮಾಡಿ ಕಾಲೇಜ್ ಪ್ರಾಂಶುಪಾಲರ್ ಚಂದ್ರಿಕಾ ತಿಲಕ್ ರಾಜ್ ಹಾಗೂ ಹಣವನ್ನು ಪಡೆದ ಬಗ್ಗೆ ಹೇಳಿ ಚೇರ್ಮನ್ ರವರಾದ ರಮೇಶ್ ರಾಜು, ನಾವು SVIT ಸಂಸ್ಥೆ ಸರ್ಕಾರ ಅನುದಾನ ಸೇರಲು ಪ್ರಯತ್ನಿಸಿದ್ದು ನಿಜ, ಆದರೆ ಅದು ಸದ್ಯಕ್ಕೆ ಆಗದ ಮಾತು. ಅದಲ್ಲದೆ ನಿಮ್ಮಿಂದ ಆಕೆ ಎಷ್ಟು ಹಣ ಪಡೆದಿದ್ದಾರೆ ಎಂಬ ಮಾಹಿತಿ ನನಗಿಲ್ಲ. ಆದರೆ ಆಕೆ ನನ್ನ ಸಂಸ್ಥೆಯಿಂದ ನಿಮ್ಮಿಂದ ಪಡೆದು ನೀಡಿರುವ ಹಣ ಯಾರಿಂದ ಎಷ್ಟು ಪಟ್ಟಿ ನೀಡಿದ್ದಾರೆ ಅದರಂತೆ ನಾವು ಸಂಸ್ಥೆಗೆ ನೀವು ನೀಡಿರುವ ಹಣವನ್ನು ನಾವು ನಿಶ್ಚಿತವಾಗಿ ಹಿಂತಿರುಗಿಸುತ್ತೇವೆ. ಅದ ನಂತರ ನಿಮ್ಮ ಉಳಿದ ಹಣವನ್ನು ನಮಗೆ ನಮ್ಮ ಸಂಸ್ಥೆಯಿಂದ ನಿಮಗೆ ಯಾವ ವ್ಯವಹಾರಿಕ ಸಂಬಂಧವೂ ಇರುವುದಿಲ್ಲ. ನಂತರ ನೀವುಂಟು ಪ್ರಿನ್ಸಿಪಲ್ ಚಂದ್ರಿಕಾ ತಿಲಕ್ ರಾಜ್ ಉಂಟು ಎಂದು ಕಡ್ಡಿ ತುಂಡು ಹೇಳಿದ್ದಲ್ಲದೆ ಕಳೆದ ವರ್ಷದಿಂದ ಈವರೆಗೂ 2-3 ಕಂತುಗಳಲ್ಲಿ ತಮ್ಮ ಪಟ್ಟಿ ಹಿಡಿದು ಕೆಲವರಿಗೆ ಅಲ್ಪ ಹಣವನ್ನು ನೀಡಿರ್ತಾರೆ. ಇನ್ ದಿಸ್ ಕೇಸ್ ಮೈ ಲಾರ್ಡ್,
ನೀವ್ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ರಿ
ಸ್ವಾಮಿ? ಈವನ್ ಐ ಆಮ್
ಕಂಪ್ಲೇಂಟ್ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ರು ಅಂತ ನೀವು ರಿಸೀವ್ ಮಾಡಿದ ಕಂಪ್ಲೇಂಟ್ ಕಡೆಯಿಂದ?
ನಾವು ರಿಸೀವ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. ಚೇರ್ಮನ್ ಅಕ್ಯೂಸ್ ನಂಬರ್ 2 he is the chairman ಸ್ವಾಮಿ. wherein she was also principal and she herself has also paid 3 lakhs for
ಆಯ್ತು ನೋಡಿ, you get the details. ಆಯ್ತು ನೋಡಿ, HCP 6 2 days time to get the records. This matter on 24th. ಏನ್ರಿ ರಾಜು? 302 201 143 ಹೇಳಿ ರಾಜು ಅಂದ್ರೆ ನೀವ? ವಕಾಲತ್ ಇದೆಯಾ? ಏನ್ ಮಾಡಿದೀರಾ? ಆಯ್ತು ಹೇಳಿ. 8226 202 201 143
5 ಇಲ್ಲ ಸ್ವಾಮಿ.
8226 ಅಲ್ವಾ?
5 ಇಲ್ಲ,
5 ಇಲ್ವಾ?
234
16 ಆಯ್ತು. ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗಿ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ? Go to column number 17. Available at page
41.
Page 41.
So 6 to 7 months prior to the date of incident, my lord, since the deceased committed theft of a mango in the garden of number 1. This is my lord, after 6 months, that is on 19th October 2021. The accused number 1 went near the shop, condiment shop of this is 20 years the condiment shop of accused number 1 where he made Galata statement, which does still you assaulted me. On the same day, my lord, along with the other accused, that is accused number 2 to 6.
ಆರೋಪಿ 2, 3, 4, 5 ಅವರನ್ನು ಜೊತೆಯಲ್ಲಿ ಕರೆದುಕೊಂಡು ಮಹೇಶನ ಹುಡುಕಿಕೊಂಡು ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ವ್ಯಾಪ್ತಿ ಹೊನ್ನವಳ್ಳಿ ಗ್ರಾಮದ ಸೋನ್ಸೋ ರಸ್ತೆಯಲ್ಲಿ ಮಹೇಶನ ಬಳಿ ಹೋಗಿ ಮಹೇಶ ಆರೋಪಿ ಸಂಖ್ಯೆಯವರಿಗೆ ಹಲ್ಲೆ ಮಾಡಲು ಹೋದಾಗ ರಾಕೇಶ್ ತಂದಿದ್ದ ಚಾಕುವಿನಿಂದ ಮಹೇಶನ ಹೊಟ್ಟೆಗೆ 1 ಬಾರಿ ತಿವಿದು ಪ್ರಯತ್ನ ಮಾಡಿದ್ದು. ಆ ಸಮಯದಲ್ಲಿ ಕೂಡ ಚಾಕುವಿನಿಂದ ರೋಸಿ 1 ರವರಿಗೆ ತಿಳಿಯಲು ಪ್ರಯತ್ನಿಸಿದಾಗ ಆರೋಪಿ ಸಂಖ್ಯೆ 1 ಬಲಕೈಗೆ ರಕ್ತವಾಗಿತ್ತು. ತೀವ್ರವಾಗಿ ಗಾಯಗೊಂಡ ಮಹೇಶ್ ಆರೋಪಿ 1, 2, 3, 4, 5 ಮತ್ತು 6 ರವರಿಂದ ಪ್ರಾಣ ಉಳಿಸಿಕೊಳ್ಳಲು ತಪ್ಪಿಸಿಕೊಂಡು ಓಡಿ ಹೋಗಿ ಪಕ್ಕದಲ್ಲಿ ದಿನೇಶ್ ಅವರಿಗೆ ಸೇರಿದ ಮಾವಿನ ತೋಟಕ್ಕೆ ಓಡಿ ಹೋಗಿದ್ದು. ತೀವ್ರವಾಗಿ ಗಾಯಗೊಂಡಿದ್ದ ಮಹೇಶ್ ಅಲ್ಲಿಯೇ ಸತ್ತು ಹೋಗಿರ್ತಾನೆ ಅಂತ ತನಿಖೆಯನ್ನು ದೃಢಪಟ್ಟಿರುತ್ತದೆ.
ಚೇಸ್ ಮಾಡಿದ್ರು ಅಷ್ಟೇ, ಇವರು ಅಸಾಲ್ಟ್ ಮಾಡಲಿಲ್ಲ.
ಅಸಾಲ್ಟ್ ಮಾಡಿದವನು ಯಾರು? ಓನ್ಲಿ A1.
Informant is not a eyewitness to the incident. Mother of the deceased. After 10 days of the incident, my lord, CW 2 and 3, Rajesh and Suresh have been examined as
all of them were together ಅಷ್ಟೇನೆ.
ಹೌದು ಅಷ್ಟೇ.
ಜೊತೆಯಲ್ಲಿ ಕರೆದುಕೊಂಡು ಮಹೇಶ್ನನ್ನು ಹುಡುಕಿಕೊಂಡು ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಹೋಗಿ ಮಹೇಶ್ನ ಬಳಿ ಹೋಗಿ ಗಲಾಟೆ ಮಾಡಿದ್ದು. ಆ ಸಮಯದಲ್ಲಿ ಮಹೇಶ ಹಲ್ಲೆ ಮಾಡಲು ಹೋದಾಗ ರಾಕೇಶ್ ತಂದಿದ್ದ ಕೊಲೆ. ರಾಕೇಶ್ ಯಾರು?
Rakesh is accused number 1. He is not before the
accused number 1. All were there together ಅಂತ.
Members of the
ಅಷ್ಟೇನೆ. No vote act, nothing. Only he took along with them. ನೋಡಿ ಯಾವಾಗಿಂದ?
24th October 2020.
24th October. Heard the petitioner, counsel and also the council of the state. The factual matters of the case of the prosecution is that 1910-2021, in view of the previous incident of assault, the accused number 1 having the motive, and in furtherance of the said motive and intention to take away the life of the victim, he went along with these petitioners, this petitioner and also the accused number 5. And accused number 1 quarreled with the victim and assaulted with knife on his abdomen. And when again he tried to inflict more injuries, he ran away from the spot to mango plantation and he passed away. The counsel appearing for the petitioner would submit that the allegation made in the charge sheet against these petitioners, all of them were there together with the accused number 1, and accused number 1 only took all of them, but no any overt act allegation against them, except they were along with the accused while accused number 1 while stabbing the victim. No other material and also nothing is collected. Nothing is collected against these petitioners. The counsel appearing for the state also would submit that these petitioners were there along with the accused number 1. No overt act allegation against the petitioner's hearing. Having heard the respective counsel and also perusal of material available on record, due to the previous ill will, the accused number 1 and also the victim, an incident was taken place. And also, case of the prosecution is that accused number 1 took along with them, but no allegation that these petitioners also went along with the accused number with any other weapons, but only allegation that they were there together, accused number 1, and no overt act allegation against these petitioners. When such the factual in of CRPC and in investigation already been completed, need of custodian travel, considering the material by the IO against these petitioners. These petitioners are also in custody from October, and hence enlarged on bail conditions. 88 Basavaraju TA. 307 ಏನಿದೆ 307 ಗೆ ಏನಿಲ್ವಾ ಇಂಜುರೀಸ್ ಏನಾರು ಇದೆಯಾ ಏನ್ ಇಂಜುರಿ ಸಿಂಪಲ್ ಪ್ರೀವಿಯಸ್ ಸಿಂಪಲ್ ಇನ್ ನೇಚರ್ ನೋಡಿ ಪ್ರೆಷನ್ ಆಫ್ ಕೌನ್ಸಿಲ್ ಅಂಡ್ ಆಲ್ಸೋ ದಿ ಪಿಸಿಆರ್ ಬೇರೆ ಪಿಸಿಆರ್ ರೆಫರ್ ಆಗಿತ್ತು ನೋಡಿ ದಿ ಪ್ರೆಷನ್ ಆಫ್ ಕೌನ್ಸಿಲ್ ಅಂಡ್ ಆಲ್ಸೋ ದಿ ಕೌನ್ಸಿಲ್ ಅಪೇರಿಂಗ್ ಫಾರ್ ಸ್ಟೇಟ್. The factual matters of the case of the prosecution is that the complainant filed a private complaint in PCR number 238 of 2021, and based on the complaint, and the London magistrate has referred the matter under 156(3). 156(3) tanne. FIR is registered, and matter is under investigation. So report hakidare enayitu pending, and matter is under pending for investigation. Counsel appearing for the petitioner would submit that a false allegation is made that they have trespassed and assaulted. When there was a civil dispute between the parties, and offences which have been invoked against the petitioner is also not punishable with death or imprisonment for life. The counsel also would submit that the alleged nature of injuries are also simple in nature, only with an intention to implicate. Offence under 307 is invoked, and no ingredients of offence under 307 attracts against the petitioner's hearing. For the counsel appearing for the state also not disputes the fact that two persons and also perusal of material available on record, the case is FIR is registered based on the private complaint when the matter is referred under 156(3). When such practical aspects of the case, it is a good case to exercise the powers under 438 of CRPC. Next 89 Rahmatullah Kotwal. Yes, madam.
2, which is for robbery. Accused number 1 is concerned in this case. As far as the petitioner is concerned, section 411, dishonesty receiving stolen property. Is right. Your Honor, I draw your kind attention to para number 5 of the petition. The petitioner herein is the ex-director of Attica Gold Company. Said company is engaged in directly purchasing these articles from its customers and retrieving pledged ornaments of its customers from other financiers. The company exercises all the care and caution.
Case registered against the unknown persons.
Complaint is against unknown persons.
At the first instance. What at the first instance?
Yes, Your Honor. And
Then what is the basis for arraying him as an accused?
because the petitioner was the director of the company in 2015. The petitioner resigned in 2015. On the first day of 2016, his resignation was accepted. But solely because he was the ex-director, the only statement pertaining to the company from the accused number 1 is that he sold the gold article to the Attica Gold Company. Now, Your Honor, the petitioner is not at all concerned with the day-to-day affairs of the company. But is being arrayed wrongly as the accused number 4. In the remand application, the IU sought for case number 45. And he evaluated him as accused number 4. He has no involvement, he has no connection with the company.
Recovery and
stolen property received the company. But,
company received. At that time, this petitioner was a director.
at the time of
Company received on Thorsek ಏನಿದೆ ದಾಖಲೆ ಏನಾದ್ರು ಇದೆಯಾ?
accused is voluntary statement is there. But at the time of the investigation officer go to the same company, but the petitioner not applies the police investigation.
ಅದಕ್ಕೆ ಅವನ್ನೇ ಅಕ್ಯೂಸ್ ಮಾಡ್ಬಿಟ್ರಾ? then he is the receiver.
Receiver.
As director.
So many stolen properties receiver.
ಎಷ್ಟು ರಿಸೀವ್ ಮಾಡಿದಾನೆ ಆ ರೀತಿ?
Sir, your report is more than 30 cases is a receiver. One case is Dengeri police station, crime number 399/21. 392 cases pending.
Your Honor, kindly see page number 59.
392 ಹೆಂಗೆ ಇನ್ವೋಕ್ ಆಗುತ್ತೆ? 411 ಇದೆ. Only 411. Receiver, but he has not obliged when the
Kindly, Your Honor, see page number 59.
59. What is that, madam?
Current 3 directors. The offense took place in 21. The petitioner resigned from the company in 2015, which was accepted on first day of 2016.
2016 itself.
Not concerned with the company since 2016. All the cases that have been arraigned, in all the cases I have approached this honorable court, I have got all the matters stayed. So far as investigation is concerned to me.
Sorry, madam, third. Heard the petitioner counsel and also the counsel appearing for the state. The factual matters of the case. Again, on the anticipatory bail, how many pages you have drafted? 18 pages.
No, they are accusing again and again. So I'm happy to this honorable court. I've already made a representation.
How much you have charged each page? How much you have charged each page? ಯಾರು ನಿಮ್ ಸೀನಿಯರ್ ಯಾರು? ಆಯ್ತು ಬಿಡಿ, ಯಾರು heard the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that on 39/20/21 around 6:47 p.m. the complainant was proceeding in front of the house. An unknown person came from backside and snatched the gold chain weighing 50 grams, which is worth of rupees 2,50,000. Based on the complaint, police have registered the case. And allegation against this petitioner is that he is the receiver of the gold which was robbed. Appearing, the petitioner would submit that this petitioner was not working as director of the company and he had resigned in the year 2016 itself. And the incident is taken place. Incident took place on 39/20/21. And as on the date of the incident, he was not in charge of the affairs of the said receiver's company. Hence, he may be enlarged on bail. Per contra, the Council of Appeal for the Statehood submits that when the police went to the petitioner, and petitioner also not obliged the police regarding receipt of the articles which were subject matter of the robbery. And there are several cases against the petitioner. Having heard the respective counsel and also on perusal of material, the allegation against the other accused invoking section 392 and only offense invoked against the petitioner is 411. And also the contention of the petitioner counsel that the petitioner already tendered resignation in 2015 itself, and the same was accepted in 2016 itself and not in the affairs of any. Explaining the factual aspects of the case and also taking into note of the gravity of the offense and allegations made in the complaint as well as the offense invoked under section 411. It is a bit case to exercise the powers of 438 of CRPC conditions. Henry HCP and last time and a wound certificate and admitted on
13/12/2021 ಅಂತ ಹೇಳ್ತಾರೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್
13/12/21 discharge ಆಗಿರೋದು ಯಾವಾಗ
not furnished any documents for this course
regarding discharge
admittedly Chandan page number 19 annexure B Chandan himself is the employee of KRH hospital KRH according to him he himself admitted
Chandan. What is the name of the petitioner is Naveen Kumar and another
according to the case of facts of the case on 10th at about 6 p.m. they went to take for drinks.
Drinks ಕುಡಿಯಕ್ಕೆ
around 10 p.m.
ಡಾಬಾಕ್ ಹೋದ್ರು
ಅಲ್ಲೇನ್ ಹೇಳ್ತಾರೆ ಅವರು
ನವೀನ್ ವೆಂಟ್ ಟು ಅಟೆಂಡ್ ವಾಶ್
ಆಚೆ ಕಡೆ ಹೋದ್ರು ನವೀನ್ ಹೋದಾಗ ಏನ್ ಇನ್ಸಿಡೆಂಟ್ ಆಯ್ತು ಅಂತ ಗೊತ್ತಿಲ್ಲ ಗಲಾಟೆ ನಡೆದಿತ್ತು ಹಟ್ ನಂಬರ್ 6 ನಲ್ಲಿ 6 ಜನ ಇದ್ರು ಅಂತ ಅಲಿಗೇಷನ್ ಹಟ್ ನಂಬರ್ 6 ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ based on the remand application lordship may kindly turn to page 37
ಹಟ್ನಲ್ಲಿದ್ದ ಪೈಕಿ ಒಬ್ಬ ಮಿಲಿಟರಿ ಟ್ರೀಟ್ಮೆಂಟ್ ಸಾಯಿಸುವ ಉದ್ದೇಶದಿಂದ ನವೀನ್ ಕುಮಾರ್ ಅವರಿಗೆ ಹೊಟ್ಟೆಗೆ ಎದೆಗೆ ಕೈಗೆ ಹಾಗೂ ಇತರ ಕಡೆ ಹಿಡಿದು ಕೊಲೆ ಮಾಡಲು ಪ್ರಯತ್ನಿಸಿದ್ದು 3 ಜನ ನನ್ನನ್ನು ಮತ್ತು ಶಿವಕುಮಾರ್ ನನ್ನ ಡಾಬಾದ ಗೇಟ್ ಕಡೆ ತಳ್ಳಿಕೊಂಡು ಬರುತ್ತಿದ್ದು ನನ್ನ ಶಿವಕುಮಾರ್ ಕಲ್ಲು ಬೀಸಿದ್ದು ಕಲ್ಲು ನನ್ನ ಕಾರಿಗೆ ತಗಲಿ ನಾನು ಯಾವುದೇ ಗಾಯವಾಗಿರ್ಲಿಲ್ಲ. ನಂತರ ಎಲ್ಲರೂ ಡಾಬಾದಿಂದ ಹೊರಗೆ ಬಂದು ಅವರು ಬಂದಿದ್ದ ವಾಹನಗಳಿಗೆ ಕುಣಿಗಲ್ಗೆ ಹೋದರು. ತಕ್ಷಣ ನಾನು ಶಿವಕುಮಾರ್ ಇಬ್ಬರು ನವೀನ್ ನನ್ನು ಕಾರಿನಲ್ಲಿ ಕೂರಿಸಿಕೊಂಡು ನೆಲಮಂಗಲ ಆಸ್ಪತ್ರೆಗೆ ಹೋದೆವು.
2 p.m. ಅವರ 1 p.m. ಗೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ತಾರೆ. ಇಲ್ಲಿ ಪೇಜ್ 37 ಇಲ್ಲ. ಬೇಸ್ಡ್ ಆನ್ ದ ರಿಮೈಂಡ್ ಆಫ್ FIR ಲಾಡ್ಜ್ ಅಗೇನ್ಸ್ಟ್ ಅನ್ನೋನ್ ಪರ್ಸನ್.
ಅಂದ್ರೆ ಇಲ್ಲಿ ನವೀನ್ ಅಂದ್ರೆ ಇಂಜೂರ್ಡ್ ಇದ್ದಂಗೆ ಇದಾನೆ.
ನವೀನ್ ಇಂಜೂರ್ಡ್
ಅವನೇ ಪಿಟಿಷನರ್
ಅಲ್ಲ ಇವನ್ ಬೇರೆ
ಡಿಫರೆಂಟ್ ನವೀನ್.
ನವೀನ್ ಇದರಲ್ಲಿ ಪೇಜ್ 37 ಇಲ್ಲಿ A4 60 ಸ್ಟಾಲಿನ್ ಅವರು ರಿಮೈಂಡ್ ಅಪ್ಲಿಕೇಶನ್ ಫ್ರಮ್ ಬಾಟಮ್ 5th ಲೈನ್
ಪೇಜ್ ನಂಬರ್ 37
ಆ ಸಮಯದಲ್ಲಿ
ಮಾರ್ಕ್ ಮಾಡಿದ್ವಿ.
ಅಲ್ಲಿ ಪ್ರಮೋದ ತನ್ನ ಬಳಿ ಇದ್ದ ಚಾಕುವಿನಿಂದ ಆ ವ್ಯಕ್ತಿ ಎದೆ ಮತ್ತು ಹೊಟ್ಟೆಗೆ ತಿವಿದನು ಅಂತ ಹೇಳಿ. ಇವನ್ ಸ್ಟಾಲಿನ್ ಅನದರ್ ಪ್ರವೀಣ್ A3 he also stated that Pramod has stabbed. Pramod is A1. Here A3 and A4 have been arrested. I am A5 and A6.
ನಿಮ್ದು 438
ನಾನು A5 and A6 and I am basically a contractor. I am not at all present on that day. ಅದರಲ್ಲಿ ಏನಾಗುತ್ತೆ falsely implicated and no allegation against me.
ಏನ್ರಿ ಇಂಜೂರ್ಡ್ ಸ್ಟೇಟಸ್ ಏನ್ರಿ? ಸ್ಟ್ಯಾಬ್ ಮಾಡಿದ್ದಾರೆ. Injuries to chest and arm. Abdomen ಇದೆಯಾ? How long he was in the ನಿಮಗಿಲ್ವಾ? ನಿಮ್ಗೆ ಸಿಕ್ಕಿಲ್ವಾ? ಏಕೆ? ಕೊಡಿ ಉಂಡ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡಿ ನೋಡ. ನೇಚರ್ ಆಫ್ ಇಂಜುರೀಸ್ ವಿಲ್ ಸಿ.
ಹಾಗೆ ಇನ್ನೊಂದು ಹೇಳಿದೆ ಸರ್ 37 ಪೇಜ್ ಅಲ್ಲಿ ಡಾಕ್ಟರ್ ಹೇಳ್ತಾರೆ ಪೇಜ್ 37
ಏನ್ ಹೇಳ್ತಾರೆ ಡಾಕ್ಟರ್ ಏನ್ ಹೇಳ್ತಾರೆ?
ವೈದ್ಯಾಧಿಕಾರ ಡಾಕ್ಟರ್ ಶ್ರೀನಿವಾಸ್ ಅವರು ನವೀನ್ ಕುಮಾರ್ ಕೇವರ್ ಅವರು ಹೇಳಿಕೆ ನೀಡಲು ಶಕ್ತರಾಗಿದ್ದಾರೆ ಎಂದು ತಿಳಿಸಿದ್ದರಿಂದ ಡಾಕ್ಟರ್ ಹೇಳಿದ್ದಾರೆ
ಮಲ್ಟಿಪಲ್ ಸ್ಟ್ಯಾಬ್ ಓವರ್
ಹೌದು ಹಾಸ್ಪಿಟಲ್ ಅದು
ಯಾರ್ದು
ಕೇರ್ ಏಷ್ಯಾ ಹಾಸ್ಪಿಟಲ್ ಚಂದನ್ ಅನ್ನೋದು ಇಸ್ ಮ್ಯಾನೇಜರ್
ಕೇರ್ ಏಷ್ಯಾ ಹಾಸ್ಪಿಟಲ್
ಇವನೇ ಎಂಪ್ಲಾಯಿ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ ನೋಡಿ ಚಂದನ್ ಕೇರ್ ಏಷ್ಯಾ
3, 4 and 6 are grievous injuries
ಅಂತ ಹೇಳ್ತಾರೆ ಅವ್ರದೇ ಹಾಸ್ಪಿಟಲ್ ಅವರೇ ಮ್ಯಾನೇಜರ್
ಏನಾದ್ರು ಎನಿ ವೋಟ್ ಆಕ್ಟ್ ಅಲಿಗೇಷನ್ ಇಲ್ಲ ತೋಡ್
ಅವ್ರ ಮೇಲೆ ಮಾತ್ರ
A1 ಮೇಲೆ
ಮಾತ್ರ
heard the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that the incident was taken place on 12/12/21. Not 12/12 ರಾತ್ರಿ ಆಗಿರೋದಾ ಎಷ್ಟು ಗಂಟೆಯಲ್ಲಿ 1 ಗಂಟೆನೇನೋ ಬಂತಲ್ಲ ನೋಡಿದ್ರು ಎಲ್ಲ ಇನ್ಸಿಡೆಂಟ್ ಅಟ್ ವಾಟ್ ಟೈಮ್
ಅಲ್ಲ ಇನ್ಸಿಡೆಂಟ್ at 10 PM page 19
ಏನಾಯ್ತು ಮೇಡಮ್
Incident was taking place on 12/12/21.
ಮೇಡಮ್ 10 PM and the same was took place near the L6 hut with an intention to take away the life stabbed with knife on the abdomen of Naveen Kumar. Also he has sustained injury to chest and hands. What is the motive for any earlier event?
ಇಲ್ಲ ಊಟ ಮಾಡಕ್ ಹೋದಾಗ ಅವನ ಒಬ್ಬ ಯಾರೋ
ಏನಾಯ್ತು ಮೇಡಮ್
With the intention to take over the left, stabbed with knife on the abdomen of Naveen Kumar and sustained injuries to chest and hands.
Chest and hands. As a result, he has sustained injury, and based on the complaint, police have registered the case and the matter is under investigation. The counsel appearing for the petitioner would submit that specific vote act allegation is against accused number 1, and these two petitioners are accused number 5 and 6. No other vote act allegation against these petitioners. And also, there was no any motive. Petitioners. Hence, then, for count of the counsel appearing for the state would submit that the injured had sustained 6 injuries, and out of that 5 injuries are previous in nature. And injured was admitted to hospital on 13/12/21. No records on whether he was discharged from the hospital or not. And, the injured is also employee of the very same hospital in which he took the treatment. Having heard the petitioner counsel and also the counsel appearing for the state and also looking into the factual aspects of the case, the specific allegation is made against accused number who inflicted the injury with knife. No specific vote act allegation against these two petitioners. When such being the factual aspects, when there is no any vote act, it is a fit case to exercise the powers and before the date of CRPC with conditions. 1 Sham Sundar. ಯಾರು ಇದ್ದೀರಾ? ಹೇಳಿ ನೀವೇ ಇದ್ದೀರಾ?
ನಾನೇ ಇದೆ. Similarly situated, my lord, my colleague is there, my lord, in criminal 9671.
Similarly.
ಹೌದು ಅವನಿಗಿಂತ ಕಡಿಮೆ ಇವನ.
Same crime or different crime?
Same crime, my lord, different accused. ಅದೇ ಒಂದೇ ಕೇಸ್ ನಲ್ಲೇ ಇವನ ಹತ್ರ ಇರೋ ರಿಕವರಿ ಅವನಿಗಿಂತ ಈಗ ಆಲ್ರೆಡಿ ಬೇಲ್ ಸಿಕ್ಕಿರೋನಿಗಿಂತನೂ ಕಡಿಮೆ ರಿಕವರಿ.
ಏನ್ ರಿಕವರಿ ಹೇಳಿ, ಎಷ್ಟು ಹೇಳ್ಬೇಡಿ ಫಸ್ಟ್.
ಇವನ ಹತ್ರ ಪೇಜ್ ನಂಬರ್ 46, my lord. 40 ಇವನ ಹತ್ರ
ಹೈಡ್ರೋ ಗಾಂಜಾ
ಇವನ ಹತ್ರ ರಿಕವರ್ ಮಾಡಿರೋದು ಬರೀ 28 ಗ್ರಾಮ್ ಅಷ್ಟೇ.
ಬೇಲ್ ಕೊಟ್ಟವನ ಹತ್ರ ಎಷ್ಟಿತ್ತು?
ಬೇಲ್ ಕೊಟ್ಟವನ ಹತ್ರ 1250 grams. 1250 grams.
14 grams of hydro ganja. 1250 grams of ganja.
ಇವನ ಹತ್ರ ಬರೀ 28 grams of hydro ganja ಅಷ್ಟೇ. ಪೇಜ್ ನಂಬರ್ 46 ನಲ್ಲಿ ಇದೆ ರಿಕವರಿ.
ಅರ್ಲಿಯರ್ ಆರ್ಡರ್ ನಾನು ನೋಡ್ತಾ ಇದ್ದೀನಿ, ಅದ್ರಲ್ಲಿ 14 grams of hydro ganja ಇದೆ. ಹೌದಾ? ನಿಮ್ ಕಡೆ 28 ಗ್ರಾಮ್. ನಾವು
28 gram. That is also, my lord, small quantity.
Intermediate quantity.
Rather small quantity, my lord. 28 grams of ganja is small.
Not ganja re, hydro ganja.
ಅದು in fact last time ತಾವು ಇದೇ ಕ್ವಶನ್ ಕೇಳಿದ್ರೆ ಅದು ಹೈಡ್ರೋ it doesn't, it is not something different. Ganja one.
already grant ಮಾಡಿದೀವಲ್ಲ ಯಾರಿಗೂ ತೋಳ್ ಸೇಮ್ ಆರ್ಡರ್ ತೊಗೊಳ್ಳಿ ಮೇಡಮ್, ಓನ್ಲಿ ರಿಕವರಿ 28 grams ಒಂದು ಚೇಂಜ್ ಮಾಡ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ. ಅದರ್ ದೆನ್ ಎನಿ ಗಾಂಜಾ ಇಸ್ ಸೀಸ್?
ಇಲ್ಲ ಇಲ್ಲ ಮೇಲಡ್, ಇವನ ಹತ್ರ ಏನು ಇಲ್ಲ.
ಹೈಡ್ರೋ ಗಾಂಜಾ
ಅಷ್ಟೇ ಇವನ ಹತ್ರ.
allowed with conditions, allowed with conditions.
Great, great.
You are not allowed your junior to make submission.
I am extremely sorry.
Is added as exception number 2 to 4, my lord. Litigation in this petition is only to the extent that this petition accompanied the A1. A1 taking the victim girl.
Kidnap 366A ಇದೆ.
A1 and victim are fell in love. He herself is called the A1 to take her. The petitioner marriage was performed with other than
What is her age? 16 years 2 months ಎಷ್ಟು?
16 years 5 months 90 days.
ಅಪಹರಣ ಮಾಡಿರೋ ವಿರುದ್ಧ ಪ್ರಮುಖವಾಗಿ ದೂರು. ನೇಮ್ ಹೆಸರು ಹೇಳ್ಬಿಟ್ಟಿದ್ದಾರೆ ಯಾರ್ಯಾರು? ಕಸ್ಟಡಿ only 366. Heard the petitioner, counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that these petitioners along with accused number 1 kidnapped the minor girl. ಮ್ಯಾರೇಜ್ ಇದೆಯಾ ಅಥವಾ ಏನಿಲ್ಲ? ಬರೀ ಪರ್ಫಾರ್ಮ್ ಮ್ಯಾರೇಜ್ ಅಫೆನ್ಸ್ ಇದೆಯಾ? ಬರೀ ಕರ್ಕೋಗಿರೋದು ಅಲ್ಲ, ಅದೇನೆ ಅಲ್ಲ. ಆಮೇಲೆ ಏನಾಯ್ತು? ಮದುವೆ ಮಾಡಿದ್ರ? ಏನಾಯ್ತು? ಅಲ್ರಿ, ಕರ್ಕೊಂಡೋಗಿ ಕಿಡ್ನಾಪ್ ಮಾಡ್ಕೊಂಡೋಗಿ ಏನ್ ಮಾಡಿರ್ರಿ? ಆಮೇಲೆ ವಾಟ್ ಈಸ್ ದೇರ್ ರೋಲ್ ಅಲಾಂಗ್ ವಿತ್ 366A? ಬೇರೆ ಎನಿ ಅದರ್ ರೋಲ್? ಮದುವೆ ಮಾಡಿದ್ರಾ ಅಥವಾ ಏನ್ ಮಾಡಿದ್ರು? ಮದುವೆ ಆಗಿಲ್ವಾ? ಬಟ್ ಫೆಲಿಸಿಟೇಟೆಡ್ ಟು ಆವಾಗ ಇವ್ರು ಇದ್ರ ಅಂತ ನನ್ ಪ್ರಶ್ನೆ. ಇವ್ರು ಬರೀ ಕರ್ಕೊಂಡೋಗಿ ಅವನ ಜೊತೆ ಕಳಿಸ್ಕೊಟ್ರ ಅಥವಾ ಏನ್? ಅದನ್ನ ಹೇಳಿ. ಇಲ್ಲೇ ಓನ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಕರ್ಕೊಂಡು ಹೋದ ಬಗ್ಗೆ ಇದೆ ಕಂಪ್ಲೇಂಟ್. ಆಮೇಲೆ ದೆನ್ ವಾಟ್ ದೇ ಡಿಡ್ ಆಫ್ಟರ್ವರ್ಡ್ಸ್? ಇವ್ರಿಗೆ ಯಾವ 366A ಬಿಟ್ರೆ ಬೇರೆ ಏನೋ ಅಪ್ಲೈ ಆಗೋದಿಲ್ವಾ? ಏನ್ರಿ ಪ್ರಾಸಿಕ್ಯೂಷನ್? ಅಪಹರಣ ಮಾಡಿದ ಆರೋಪಿಗಳನ್ನು ಪತ್ತೆ ಮಾಡಿ ಕಾನೂನು ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ಕೋರಿಕೊಳ್ಳುತ್ತೇವೆ. Heard the petitioner, counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that minor girl who is aged about 16.5 years was kidnapped, and these petitioners are also the part of in kidnapping the minor girl. And other offences are invoked against the accused number 1. The counsel appearing for the petitioner submit that only allegation against these petitioners that they took the victim girl. They kidnapped the victim girl. No such other allegations is made. Only allegation against other accused that he subjected her for sexual act, even though knowing fully well that he is a minor. For count of the counsel appearing for the state would submit that except the allegation of kidnapping the minor girl, no other allegation is made against these petitioners that they have committed any other offences. Having heard the respective counsel and also perusal of material available on record, except the allegation and invoking of offences in 360A against these petitioners, no other offences attracts. That is 376(2) or section 4 and 6 of POCSO Act. When suspending the factual aspects of the case, and these petitioners are in custody, and hence they are enlarged on bail and no need of custodial further investigation in the matter. 3 Samir SN Henry 420 ಏನ್ ಅಲಿಗೇಷನ್ ಏನು? ಹೋಂಡಾ ಆಕ್ಟಿವಾದಲ್ಲಿ ಒಂದು
ಅಂದ್ರೆ ನಿಮ್ಗೆ ಯಾವ್ದೋ ಒಂದು ಸ್ಕೀಮ್ ಅಲ್ಲಿ ನಿಮ್ಮ ಹಸ್ಬೆಂಡ್ ಮೆಂಬರ್ ಆಗಿದ್ರು,
ಸ್ಕೀಮ್ ಮೆಂಬರ್
ಆಗಿದ್ರು, ತೀರ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ ನಿಮ್ಮನ್ನ ಹೊಡ್ಕೊಂಡ್ ಬಂದ್ವಿ. ಹೊಡ್ಕೊಂಡು ಬಂದು ಸಿಕ್ಕಾಪಟ್ಟೆ ಇದ್ರಲ್ಲಿ ಆಫರ್ ಇದೆ, ಅದ್ರೊಳಗೆ ಏನೇನಿದೆ ಅಂದ್ರೆ ನಿಮ್ಮನ್ನು ಈ ಸ್ಕೀಮ್ ನಲ್ಲಿ 2 ಶಿಪ್ ಅಲ್ಲಿ ಕಂಪ್ಲೀಟ್ ಅಲ್ಲಿ 6 ಲೈನ್ ಪೈಕಿ ಮಟ್ಟದಲ್ಲಿ 2 ಶಿಪ್ ಕಾರ್, ಒಂದು ಇನ್ನೋವಾ ಕ್ರಿಸ್ಟಾ, 2 ಬುಲೆಟ್ ಮೋಟರ್ ಸೈಕಲ್, 2 ಹೊಂಡಾ ಆಕ್ಟಿವಾ, 500 ಗ್ರಾಮ್ ಚಿನ್ನ, ಒಡವೆ, ಬೆಳ್ಳಿ,
ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿ ಯಾರಿಗೂ ಹೇಳ್ಬೇಡಿ ಅಂತ ದಟ್ ಈಸ್ ದ ಅಶೂರೆನ್ಸ್. ಆಮೇಲೆ ಏನ್ ಮಾಡಿರಲ್ಲ ಇಂಡ್ಯೂಸ್ ಮಾಡಿ ಏನ್ ಮಾಡಿದ್ರು?
ನಾವು ಅವರಿಗೆ 3.5 ಲಕ್ಷದ ಸಾಮಾನು ಕೊಟ್ಟಿದ್ವಿ ಅಂತ.
3.5 ಲಕ್ಷ ಸಾಮಾನ
3,35,000 ರೂಪಾಯಿ ಸಾಮಾನು ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದೀವಿ.
ಯಾರು ಕೊಟ್ಟಿದ್ದು?
ನಾವು ಕೊಟ್ಟಿದ್ದು ಅಂತ ಹೇಳ್ತಾರೆ.
ನೀವು ಕೊಟ್ಟಿದ್ದು?
ನಾವು
ದುಡ್ಡು ತಗೊಂಡಿದ್ದು 13,75,600.
ಇಲ್ಲ ನಾವು ಥಿಂಗ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ, ಏನು ಕೊಟ್ಟಿಲ್ಲ. ಅಲ್ಲ ಪೇಮೆಂಟ್ ಮಾಡಿದಕ್ಕೆ ಯಾವ ಇದು ನೋ ಡಾಕ್ಯುಮೆಂಟ್ ಪೇಮೆಂಟ್.
Allegation against you that you have received an amount of rupees ಎಷ್ಟು ನಂಬಿಸಿ ಸುಮಾರು 3 ಲಕ್ಷ
13 ಲಕ್ಷ
13,75,600.
ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ಲ.
ಏನ್ ಪೇಮೆಂಟ್ ಮಾಡಿದ್ಕಾ? ಆಯ್ತು. ಆಮೇಲೆ
ಆಮೇಲೆ ಯಾವಾಗ ಎಷ್ಟೆಷ್ಟು ಪೇಮೆಂಟ್ ಮಾಡಿದ್ರು ಅದು ಇಲ್ಲ. ಆಮೇಲೆ ಇದು ಒಂದು ಇನೋವಾ ಕ್ರಿಸ್ಟಾ, ಒಂದು ಇನೋವಾ ಕ್ರಿಸ್ಟಾಕ್ಕೆ ಅದು 30 lakhs ಆಗುತ್ತೆ. ಆಮೇಲೆ 2 ಶಿಫ್ಟ್
ಇಷ್ಟೆಲ್ಲ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರು.
ನಾವು ಅಷ್ಟೆಲ್ಲ ಕೊಡ್ತೀವಿ ಅಂತ ಇಲ್ಲ. ಅಲ್ಲ ನಾವು ಆ ತರ ಬಿಸ್ನೆಸ್ ಮಾಡಿಲ್ಲ.
ಆಯ್ತು. ಏನ್ರಿ ಏನಿದೆ ರೀತಿ ಮೆಟೀರಿಯಲ್? 13,75,000 is received. Is there any material for having made the payment of rupees 13 lakh? ಸರಿ ರೀ, ಈಗ ಕೊಡುವಾಗ ಏನ್ ಕೊಟ್ಟಿದ್ದಾರೆ? ಕ್ಯಾಶ್ ಕೊಟ್ಟಿದಾರ ಏನು?
ಕ್ಯಾಶ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಒಂದು ಸೈಟ್ ಇಸ್ ಆಲ್ಸೋ ಸೋಲ್ಡ್ ಸೇಮ್ ಸ್ಕೀಮ್. ಇದು ಕರ್ನಾಟಕಕ್ಕೋಸ್ಕರ ಇಸ್ ಆಲ್ಸೋ ಒಂದು ಸೈಟ್.
He has sold the site ಅಂತನಾ? Oh, not only the complainant, several persons.
Complaint from others.
No, let the matter be probed.
ಏನಿಲ್ಲ ಇಲ್ಲ ಅಲ್ಲ ಇವರು ಅಲ್ಲ ಶೀಟ್ ಫ್ಲವರ್ ರೋಡ್ ಅಲ್ಲಿ ಫ್ಲವರ್ ಸೇಲ್ ಮಾಡೋರು. ಅವ್ರದ್ದು 13 ಲಕ್ಷ ಬರ್ಬೇಕು, ಎಲ್ಲಿ ಬರುತ್ತೆ? ರೋಡ್ ಅಲ್ಲಿ ಫ್ಲವರ್ ಸೇಲ್ ಮಾಡ್ತಾರೆ. ನಾನು ಮೇಲ್ಕೊಂಡ ವಿಳಾಸದಲ್ಲಿ
ಬೇರೆ ಏನೋ ಕ್ರಿಮಿನಲ್ ಆಂಟಿಸಿಡೆಂಟ್ಸ್ ಇದೆ ಅವ್ರ ಮೇಲೆ?
ಇಲ್ಲ ಇಲ್ಲ ಏನಿಲ್ಲ.
ವೆರಿಫೈ ಮಾಡಿಸಿದ್ರಾ? ಬೇರೆ ಯಾವ್ದಾದ್ರು ಕೇಸ್ ಇದೆಯಾ?
ಅಲ್ಲ ಇಲ್ಲ.
ಯಾರು ಹೇಳೋದು? ಹೌದಾ?
ಅಲ್ಲ ಸೈಟ್ ಮಾಡಿ ಹೇಳಿದ್ವಿ. ಅಟ್ಲೀಸ್ಟ್ ಇಷ್ಟು ದಿನ ಆಯ್ತು, ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಬರ್ಬೇಕು.
ಆಯ್ತು, ಒಂದು ವಾರ ಟೈಮ್ ಕೊಡ್ತೀನಿ. ಅವ್ರು ನೋಡಿದ್ವಿ ಹೇಳಿ ಮಾಡಿ. HCGP to get the details regarding criminal antecedents and also with regard to the allegation that the complainant has sold the site and given the amount in favor of the petitioner, and hence list this matter on 25th. 94 Hemanta B ಏನ್ರಿ 306 ಏನ್ ಅಲಿಗೇಷನ್ ಏನು?
This is the accused number 1 are love affair between the accused number 1 and this is my one Sakam.
1 and the victim, love affair.
The mother is the complaint. 15ನೇ ತಾರೀಕು accused number 2 ಫಿರ್ಯಾದಿದಾರರಿಗೆ ಕರೆ ಮಾಡ್ಬಿಟ್ಟು ಬೇರೆ ಜೊತೆ ಮಗಳನ್ನ ಮದುವೆ ಮಾಡ್ತಾ ಇದೀವಿ, ಒಂದೇ ಆರೋಪಿಗೆ ನೀವು ಕೊಡ್ಬೇಕು, ಇವನು ಸುಸೈಡ್ ಅಟೆಂಪ್ಟ್ ಮಾಡಿದಾನೆ, ಬಸವೇಶ್ವರನಗರ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಬನ್ನಿ, ಬಂದು ನೀವು ಬೇರೆಯವ್ರಿಗೆ ಫೋನ್ ಕಾಲ್ ಟು ಕಂಪ್ಲೇಂಟ್
ಏನು ಬಣೇಶ್ವರ ಅಟಾಣಿಗೆ ಬನ್ನಿ ಅಂತ ಕರ್ಕೊಂಡು ಬನ್ನಿ ಅಂತ. ಅದಕ್ಕೆ ತಮ್ಮ ಅಳಿಯನ್ ಸಾಕಷ್ಟು ಉಳಿದಿದ್ದಾರೆ, ಸ್ವಲ್ಪ ಬೇಕು ಅಂತ ಹೇಳಿದ್ದರು. ಯಾರೋ ಅಪರಿಚಿತ ವ್ಯಕ್ತಿ ಫೋನ್ ಮಾಡಿದ ವಿಷಯ ನಾವು ತಿಳಿಸಿ ನೀವು ಕೂಡಲೇ ಊರಿಗೆ ಬಂದ್ಬಿಡು, ಮಾತನಾಡಿ ಈ ಸಮಸ್ಯೆಯನ್ನು ಬಗೆಹರಿಸಲು ಸಾಕುಮಾರ್ ಅವರು ತಿಳಿಸಿದರು. ನಮ್ಮ 3ನೇ ಮಗಳಾದ ವರಲಕ್ಷ್ಮಿ ಅವರು ಗಂಡ ಪ್ರಜ್ವಲ್ ಅವರು ಸಾಕಷ್ಟು ನಮ್ಮ ಮಗು ಕಟ್ಟಿಕೊಂಡು ಬಂದು ತಿಳಿಸಿದ್ದೇನೆ, ಏನು ಹಾಕಿಕೊಂಡು ಮೃತಪಟ್ಟಿರುತ್ತಾರೆ.
ನಂಬರ್ 1 ಮತ್ತೆ ವಿಕ್ಟಿಮ್ ಇಬ್ರು ಒಟ್ಟಿಗೆ ಮೆಟ್ರೋದಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಾ ಇರ್ತಾರೆ. ಸುಮಾರು 3 ವರ್ಷದಿಂದ ಪ್ರೀತಿ ಮಾಡ್ತಾ ಇದ್ರು.
ಏನ್ರಿ ವಾಟ್ ಇಸ್ ದಿ
ಮನೇಲಿ ಗೊತ್ತಾದ್ಮೇಲೆ ಊರಿಗೆ
ಪ್ರಾಕ್ಸಿಮಿಟಿ ಟು ಕಾಸ್ ಆಫ್ ಡೆತ್. ಡೆತ್ ನೋಟ್ ಇದೆಯಾ? ಏನು ವಾಟ್ ಇಸ್ ದಟ್ ಡೆತ್ ನೋಟ್? ಏನ್ ಹೇಳ್ತಾರೆ ಅದರಲ್ಲಿ? ಅದು ನನ್ನ ಒಂದು ಪೇಜ್ ಇದ್ದಂಗಿದೆ.
ಫಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಮಾತ್ರ ಸಿಗ್ನೇಚರ್ ಇದೆ 4 ಲೈನಿಗೆ, ಉಳಿದಿದ್ದು ಫಸ್ಟ್ ಪೇಜ್ ರೂಲ್ಡ್, ಸೆಕೆಂಡ್ ಪೇಜ್ ಅನ್ರೋಲ್ಡ್ ಇದೆ. ಮೇಲ್ ಫಸ್ಟ್ ಪ್ಯಾರದಲ್ಲಿ ಮಾತ್ರ ಸಿಗ್ನೇಚರ್ ಮಾಡಿ ಸೀಲ್ ಹಾಕಿದ್ದಾರೆ. ಕೆಳಗಡೆ
ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ ಗೊತ್ತಾಗದೆ ಈ ನಿರ್ಧಾರ ತೆಗೆದುಕೊಂಡಿದ್ದು.
ಮನೆ ಬಂದು ಮಾತಾಡೋಣ ಅಂತ ಕರೆದಿದ್ದಾರೆ.
ಇವನ್ ಮೇಲೆ ಏನಿದೆ?
ನೋ ಅಲಿಗೇಷನ್. ಇಷ್ಟಪಡ್ತಾ ಇದ್ದ, ಮನೆಗೆ ಹೋಗಿ ನಮ್ ಭಾವದಿರ ಹತ್ರ ಮಾತಾಡು ಅಂತ ಹೇಳ್ದೆ ಅಂತ ಹೇಳಿ.
ನಾನು ಆ ಹುಡುಗನ ಇಷ್ಟಪಡ್ಲೇ ಇಲ್ಲ.
ಇಷ್ಟಪಡ್ತಾ
ಎಷ್ಟೊಂದು ಇಷ್ಟಪಡೋದು ಎಲ್ಲ ಸಿಗ್ತಾರೆ. ಯಾರನ್ನು ಮದುವೆ ಆಗೋದಕ್ಕಿಂತ ನನಗೆ ಗೊತ್ತಿರೋ ನನಗೆ ಕಾಲ್ ಮಾಡಿ ಕೊಡ್ತಾವನೆ.
16/12/21
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆಯಾ? ಆಗಿಲ್ಲ.
ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ. ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡಿದ್ದು ಆಲ್ರೆಡಿ 2 months ಆಗಿದೆ.
But the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that the mother of the victim had lodged the complaint. Police stating that this petitioner stating that the victim was working in Yashwantpura Metro Shopping Mall. She did not go to duty and hence she was removed from the said job. When they were searching for boy to perform the marriage, and she has expressed that this petitioner who was working in the very same metro forcing her to marry her, but she is not having any interest. But he was regularly making phone call and giving torture to her. And the victim went to Bangalore stayed in the sister's house. At the time 15/12/21, she comes to know that this petitioner made an attempt to suicide. The case was registered in Basveshwar Nagar. And called the complainant to come along with the victim. And hence the victim extreme step in committing suicide to overcome from the torture meted out to her by this petitioner. Based on the complaint, police registered the case and investigating the matter and invoked the offence punishment section 306 of IPC. The counsel appearing for the petitioner who submits that this petitioner is in custody from December 16/12/2021. There is no any proximity to cause of death and the offence section 306 not attracts looking into the contents of the complaint. And no need of further custodial investigation. For contrary, the counsel appearing for the state would submit that the victim before committing the suicide she has left the death note wherein specific allegation is made that even though she is not having any interest about this petitioner, he is giving torture by making phone calls. Hence, she committed suicide. Having heard the respective counsel and also on perusal of material, specific allegation is made against this petitioner by the mother of the victim and also the complainant stated that this petitioner made an attempt to commit suicide, and in this regard, a call was made from the Basaveshwara police station. And asked to come to police station. And when such incident has taken place, the victim took the extreme step of committing suicide. And in the death note also specifically stated that this petitioner making phone call to her. And when the death note is left before committing the suicide, further investigation is required. For further investigation, the presence of the petitioner is required. And unless investigation is completed, it is not a case for enlargement bail. Bail petition is rejected. However, liberty is given to the petitioner to court after filing up 95. Huh?
5 months. 164 statement in page number 26.
What she says 164 statement. What she says 164 le. Huh. Page number 30. Not intact provision victim is used to enact like to the turf section. What is her age? So, the petitioner counsel and also the counsel appeal for the state. The factual matters of the case of the prosecution is that this petitioner subjected the minor girl who is aged about 15 years for sexual act. Police have registered the case. This charge sheet custody.
About 21 years.
And this petitioner took her to Tamil Nadu.
ಇಲ್ಲ ಅವರೇ ಹೋಗಿರೋದು.
ಆಕೆನೇ ಹೋಗಿರೋದಾ?
ತಮಿಳುನಾಡು ಇವ್ರಿಗೆ ಹುಡ್ಕೊಂಡು ಹೋಗಿರೋದು.
ಪೊಲೀಸ್ ಕೇಸ್ ಬೇರೆ ಏನೋ ಹೇಳಿದ್ರು ಪೊಲೀಸ್
ಮಿಸ್ಸಿಂಗ್ ಕಂಪ್ಲೇಂಟ್ ಅದು. ಬೇರೆ ಹೇಳ್ತಾರೆ ಅವನು ಅಲ್ಲಿದ್ದ ನಾನು ಇಲ್ಲಿಂದ ಮಾಡ್ಕೊಂಡು ಬಸ್ ಹುಡ್ಕೊಂಡು ಹೋದೆ.
The factual matter of the case is that the petitioner subjected the minor girl age of 15 years for sexual act, and the police have registered the case and filed the charge sheet. And this petitioner took her to Tamil Nadu.
And also invoked the offence punishment was 366 of IPC and section 4 and 6 of POCSO Act and also section 9, 10. Counsel appearing to the petitioner would suggest that the victim herself went to Tamil Nadu. This petitioner is in custody from last 4 months.
5 months.
5 months. I 4 5 months. And also no material is collected against this petitioner and he has been implicated in the case in subjecting her for sexual act. No need of custodial trial since the investigation has been completed. For counter, the counsel appearing for the state would submit that victim is aged about 15 years, and also in 164 statements, he categorically stated that this petitioner subjected her for sexual. Examination report is very clear that hymen is not intact, and also the doctor has opined that she was used to sexual act, and there is a prima facie case. Having heard the respective counsel and also on perusal of material, the age of the victim girl is 15 is not in dispute, and the fact that the victim girl herself made the statement before the learned magistrate that this petitioner subjected her for sexual act. The medical records also discloses that her hymen is not intact, and also she was subjected to sexual act. The other contention of the petitioner counsel that petitioner, the victim herself went to Tamil Nadu. It clearly shows that her fell in love. Considering the age of the victim, also doesn't arise. Then the medical evidence also against the petitioner, it is not a case to 439 of CRPC. The other contention that this petitioner is in custody from last 5 months is also not a ground when an heinous offense of sexual act made against the child. 96 Latif. Ilva, petitioner counsel is absent. Is this matter week after next? 97 Shashank Nagendran. Yes, counsel. What is the allegation in 420?
Page 17, para 4, if I may read, my lord. ಶೇಕಡ 25% ಅಂತೆ ಹಣ ಕೊಟ್ಟರು, ಉಳಿಕೆ ಹಣವನ್ನು ಉಳಿದುಕೊಳ್ತಿದ್ರು. ಉಳಿಕೆ ಹಣದ ಆಧಾರವಾಗಿ ನಮಗೆ 7 ಖಾಲಿ ಚೆಕ್ ಅನ್ನು ನೀಡಿರುತ್ತಾರೆ. ಹೀಗೆಯೇ ನಾವುಗಳು ಸುಮಾರು 5 ತಿಂಗಳ ಕಾಲ ವ್ಯವಹಾರ ಮಾಡಿರುತ್ತೀವಿ. ಈ ವ್ಯವಹಾರದಲ್ಲಿ ಫಯಾಜ್ ಅಹಮದ್ ರವರು ಒಂದು the people who he owes money to totally amounting to a sum of 86 lakhs. The allegation against me is that I have purchased ginger from farmers to the tune of 86 lakhs and not paid them. My lord, I'm obviously they demonstrate saying 7 khali check galannu kottidini as on page 17 in the complaint. During the course of investigation, my lord, at page 31, Amanatu Panchaname conducted by the police, they clearly say 4 items are recovered, my lord, from the complainant and his aides.
From the complainant or from the accused?
From the complainant, my lord. I have given them 7 khali checks. The complainant, when
you have given khali.
Now khali check kottidini. Namdu actually with the complainant, the petitioner number 1 had rented out a ginger washing machine. Now shunti vyapara madala, shunti toliyod vyapara martidi. The recovery shows from the complainant, HDFC Bank check bearing number so and so, 2.5 lakhshakya with date, with person's name, with amount. All 4 checks show the same, my lords. In the complaint, they say khali check kottidini, 4 check recovery agatte, which they say hesru bardidivi, date bardide, amount bardide. The witnesses to the Samanat Panchaname are people named in the complaint itself. They are not independent witnesses, my lord. On page number 17, at person number 4, Narsimha, and person number 6, Srinivas, who I am allegedly due to pay 5 lakhs and 8 lakhs. These are the witnesses to the Mahajan. My lord, demonstrably the police is acting in a high-handed manner where, in fact, the entirety of the complaint does not even show any inducement from my part to bring about the ingredients of the offense of cheating. However, they go ahead and lodge the FIR for 420. They even implicate my son, who is today 19 years old, as of the commission of the offense would have been a minor. I now stand before this court seeking bail for him as a petitioner. Petitioner number 3 is a minor even as on date. He is 15 years old. He has been released to the custody of his mother upon affidavit by the juvenile justice court. My lord, these allegations, if any, I do not even know the other people. I know the complainant. Petitioner number 1 and the complainant, there is an agreement in place. I will concede that in fact is reflected in the complaint itself at page 17, where they say ನಾನು ಮೇಲಿನ ವಿಳಾಸದಲ್ಲಿ ಇದು ವ್ಯವಸಾಯ ಮತ್ತು ಶುಂಠಿ ವ್ಯಾಪಾರ ಮಾಡಿಕೊಂಡು ಜೀವನ ಮಾಡಿಕೊಂಡಿರ್ತೇನೆ. Hasan Taurana, so pension the address where in the later part he says, ಶ್ರೀ ಫಯಾಜ್ ಅಹಮದ್ ರವರಿಗೆ ಒಂದು ತಿಂಗಳಿಗೆ 1,75,000 ರೂಪಾಯಿಗಳಂತೆ ಬಾಡಿಗೆ ಮಾತನಾಡಿ ಕರಾರು ಪತ್ರವನ್ನು ಬರೆದುಕೊಟ್ಟಿರುವುದು, ನಾನು ಅದರಿಂದ ಮುಂಗಡವಾಗಿ 3 ಲಕ್ಷ ಹಣವನ್ನು ಪಡೆದುಕೊಂಡಿರುತ್ತೇನೆ. My lord, there is such an agreement. I will concede to that. There is an agreement between the petitioner number 1 and the de facto complainant. ನಾವು ಶುಂಠಿ ತೊಳೆಯೋದು ವ್ಯಾಪಾರ ಮಾಡ್ತೀವಿ. Subsequently he said ನಾವು ಶುಂಠಿನೇ ಕೊಂಡ್ಕೊಂಡ್ಬಿಟ್ಟು 86 ಲಕ್ಷ ಕೊಡ್ಬೇಕು ಇವರಿಗೆ ಅಂತ. View of this agreement, I have given him 7 checks for security. That also I will concede. Subsequently ದುರುಪಯೋಗ ಮಾಡ್ಬಿಟ್ಟು ಬೇರೆ ಬೇರೆ ಅವರ ಹೆಸರು ಬರ್ದ್ಬಿಟ್ಟು ಅವರೇ ಖಾಲಿ ಚೆಕ್ ಅಂತ ಹೇಳ್ತಾರೆ, ಅಮಾನತ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಅವರೇ ಕೊಡ್ಬೇಕಾದ್ರೆ ಹೆಸರು ಬರ್ದ್ಬಿಟ್ಟು ಡೇಟ್ ಕೊಟ್ಬಿಟ್ಟು ಅಮೌಂಟ್ ಬರ್ಬಿಟ್ಟು ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ. My lord, I am completely innocent of these offenses. Me and my son who is now implicated in this matter falsely. I am ready and willing to abide by any conditions that may be imposed. I am ready and willing to surrender. I pray that this honorable court please enlarge me on anticipated bail in the event of my arrest.
Yes, counsel.
Regarding that shunti cultivation and cleaning of that cultivation, there was nothing. To that extent, now as of now, the contents of the complaint reveals that 86 lakhs was due from the petition. Prima facie, there is material and that too, the check was being issued, that was not being denied. And so far as the allegation is concerned against the petition, they are not paying and they are absconding and they are evading the pay. Considering the huge amount of the due amount, number submission to this honorable court.
Heard the petitioner counsel and also the counsel appearing to the state. The factual matters of the case of the prosecution is that this petitioner entered into an agreement with this under first petitioner or second petitioner? First petitioner entered into an agreement with the complainant. In connection with letting the ginger washing machine for a rent of rupees 1,75,000 per month, and he has also received an amount of rupees 3 lakhs as advance. It is also an allegation that both the petitioners are also doing ginger business. And ginger also sold to them by different farmers. And while purchasing the same, they used to give only 25% of the amount. Remaining amount to be paid subsequently. And checks are also issued. And in this, the transaction was taken place for a period of 5 months. The petitioners are due for an amount of rupees 10 lakhs to complainant, an amount of rupees 26 lakhs to one Chandrasekhar, 15 lakhs to BT Srinivas, 5 lakhs to Lakshmi Narasimha, 0.5 lakhs to Sukendra, and an amount of rupees 8 lakhs to Srinivas, 5 lakhs to Swami Goda, 14 lakhs to Chandrasekhar Rao. In all, an amount of rupees 86 lakhs payable to all of them. When they went and inquired, comes to know that the petitioners have vacated the house without any information and hence cheated petitioner.
Not the allegation, my lord.
That is the
Come to my house.
FIR. FIR ಇರೋದು ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಏನು
ಕಂಪ್ಲೇಂಟ್ ಇರೋದು ಅವರೇ ಹೇಳ್ತಾರೆ, ನಮ್ಮ ಮನೆಗೆ ಬಂದಿದ್ದಾರೆ, ಸಿಕ್ಕಿದ್ದಾರೆ, ಭೇಟಿ ಮಾಡ್ಬಿಟ್ಟು ನಾನು ಮಾತಾಡಿದ್ದೀನಿ,
ಮನೆ ಬಿಟ್ಟು ಹೋಗಿದ್ದಾರೆ, ಬೀಗ ಹಾಕೊಂಡು ಹೋಗಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಜಿಂಜರ್ ವಾಷಿಂಗ್ ಮಷಿನ್
ಇಂದಿನಂತೆ ವಾಷಿಂಗ್ ಮೆಷಿನ್ ನ ಬಳಿ ಬಂದಾಗ ಬೀಗ ಹಾಕಿರುವುದು ಕಂಡು ಬಂದಾಗ ನಾವುಗಳೆಲ್ಲರೂ ಗಾಬರಿಕೊಂಡು ಫಯಾಜ್ ಅಹಮದ್ ರವರ ವಿಳಾಸಕ್ಕೆ ಹೋಗಿ ವಿಚಾರಿಸಲಾಗಿ ಸದಾ ಅವರು ಮತ್ತೆ ಅವಾಗ ಒಂದು ಟೈಮ್ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿ ಆಮೇಲೆ ಖಾಲಿ ಮಾಡ್ಕೊಂಡು ಹೋಗಿದ್ದೀರಿ ಅಂತ. ಮೋಸ ಮಾಡೋ ಉದ್ದೇಶದಿಂದ ಮೋಸ ಮಾಡಿರ್ತಾರೆ. ಅದರಿಂದ ಸೂರ್ಯಗಳ ಮೇಲೆ ಏನಾಯ್ತು ಮೇಡಮ್?
When they went and inquired, comes to know that the petitioners are vacated.
When they went and inquired, they were not there near the washing machine, ginger washing machine. On inquiry, they promised that they would pay the amount within 1 week. Till date, they have not made the payment of rupees 86 lakhs, and hence complaint is registered. The counsel appearing for the petitioner would submit that these petitioners are falsely implicated in the case and they are not doing any ginger business, but only doing washing of the ginger. And also admits that there was an agreement and also issuance of check, but not indulge in committing the cheating for an amount of rupees 86 lakhs. And hence, petitioner may be enlarged on bail. Per contra, the counsel appearing for the state would submit that the allegation is very specific that in payable to the complainant and other farmers and not paid the said amount, and when they have purchased the ginger, only paid the amount of 25% and remaining amount was not paid, and when they have trust also they promised to pay the amount but not paid the amount. Having heard the respective counsel and also on perusal of material available on record, and this court, while exercising the powers under section 438 of CRPC to look into the contents of the complaint. Perusal of the contents of the complaint, it is specific that the complainant and the petitioners have cheated an amount of rupees 86 lakhs, and those checks were paid given, and the same are also not honored. The counsel also brought to the notice of this court that merger was done regarding seizure of checks also, and not disputing the issuance of checks also, and also not disputing the entering into an agreement with the complaint. When judging the factual aspects, prima facie appears to be involving of in cheating, and hence it is not a fit case to exercise the powers under 438 of CRPC to enlarge the petitioner on bail. 98 Siddeshwara. ಏನ್ರಿ ಏನಾದ್ರು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದೆಯಾ? ಇಂಜುರಿ ಓನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಏನು? ಸಿಂಪಲ್ ಇನ್ ನೇಚರ್. ಎಷ್ಟು ಜನ ಇಂಜೂರ್ಡ್ ಎಷ್ಟು ಜನ ರೀ? ಒಬ್ರೇನಾ? ಇಂಜುರೀಸ್ ಆರ್ ಸಿಂಪಲ್ ಇನ್ ನೇಚರ್. ಆಯ್ತು.
ಸಿಂಪಲ್ ಇಂಜುರೀಸ್ ಅಂತ ಫಸ್ಟ್
ಸ್ಕ್ಯಾನ್ ಆಫ್ ಹೆಡ್ ಶೋಸ್ ನೋ ಎವಿಡೆನ್ಸ್ ಆಫ್ ಕ್ರೇನಿಯಲ್ ಬೋನ್ ಫ್ರಾಕ್ಚರ್. Inside wound measuring 6 inches into tenderness and muscle deep. How long he was in the hospital?
Hospital ಅಲ್ಲಿ
8-12
11-12
within 2 days.
ಆಮೇಲೆ ಇವರು
ಏನಾರು ಹೇಳೋದಿದೆಯೇನ್ರಿ? ಇಲ್ಲ. How the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution is that on 7/12/21 at 11 AM the complainant was discharging the duty in court premises, heard the immediately went and found 2 persons were hurting each other. When tried to pacify the Galata, and assailant was also taken to
ಇವ್ರ ಸಿಸ್ಟರ್ ಒಂದು ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ತಾರೆ ಸರ್. ಅವರಿಗೆ ಕೈಗೆ ಈ ಮಂಜುನಾಥ್ ಈ himself not stabbed the petitioner's elder sisters.
ಕೇಸ್ ಅಂಡ್ ಕೌಂಟರ್ ಕೇಸ್ ಎರಡು ಇದೆ.
ಎರಡು ಇದೆ. ಅನಂತರಿ H1 ಅದರಲ್ಲಿ ಇದೆ. In page number 44 ಅಲ್ಲಿ
as a result the complainant sustained injury or
both
sustained injury in the incident the complainant had sustained injuries. The counsel appearing that the complainant sister also the petitioner sister also sustained injury, and the injury sustained by the complainant is also simple in nature and not any grievous injuries, and only took the treatment within treatment as inpatient for 2 days. On the next day, injured was discharged. Under the council appeal to the state would submit that the complainant has sustained injury and not dispute the nature of injury as simple injuries. Having considered the nature of injuries and also allegation complaint and also the circumstances under which incident is taken place, injured is also out of danger and hence and also injured was in only 2 days in the hospital as inpatient and hence 2 days ಇದ್ದಂಗಿದೆ 7 and 8 ಅಂತ ಇದೆ.
7, 11 ಇಲ್ಲ 11 12 ಈ ಕಡೆ ಇನ್ನೊಂದು ಆರೈಕೆ ಹಾಸ್ಪಿಟಲ್
7, 12, 21 ಅಂತ ಮತ್ತೊಂದು ಆಸ್ಪತ್ರೆ
ಇನ್ನೊಂದಿದೆ ಅದು ಆರೈಕೆ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ 7, 12 ಆರೈಕೆ ಹಾಸ್ಪಿಟಲ್ 7, 12
in total 4 days in different 2 hospitals ಅಂತ
4 days.
Hmm. 99 Ramesh CN. A1 120B 420 465 468. Here the allegation entry.
Main allegation against the A2 minor who got the bail. Allegation is the page number 17 complaint. Further, I told that this is a A2 minor to help on home loan to complete the sale contract with many.
57 ಲಕ್ಷ ರೂಗಳನ್ನು ಮಾತನಾಡಿ ಆರೋಪಿ ಜಗದೀಶ್ ಬ್ಯಾಂಕ್ ನಲ್ಲಿ ಗೃಹ ಸಾಲ ಕೊಡಿಸುವುದಾಗಿ ಫಿರ್ಯಾದಿಗೆ ಕೆಲವು ದಾಖಲೆಗಳಿಗೆ ಸಹಿ ಪಡೆದುಕೊಂಡಿದೆ. ಮೊನ್ನೆ ಹೇರ್ ಮಾಡಿದ್ವಲ್ಲ, ಏನಕ್ಕೆ ಅರ್ಜೆಂಟ್ ಆಯ್ತು ಇದು?
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅನ್ನ ತರ್ತೀನಿ ಅಂತ
ಸಾಲ ಮಂಜೂರಿ ಮಾಡಿಸಿಕೊಂಡು ಮೋಸ ಮಾಡಿರ್ತಾರೆ. 18
sanctioned with their loan amount, sale property in the name of the company. Then again, through Axis Bank loan is also 17 October 2017. Sale property in the name of
7th October.
7th October in the name of the
different dates. 27th ಎರಡು loan transaction for same amount from different the account opened and so and so. Next to Axis Bank ಅಲ್ಲಿ 7th 11,98,961. Next Corporation Bank.
same property.
In total
It's also RTGS amount transferred to present petitioner. 13,95,000. Loan amount 29,25,000 is also.
ಫ್ಲಾಟ್ ಕೊಡಿಸ್ತೀನಿ ಅಂತ ಹೇಳಿ, ಲೋನ್ ಕೊಡಿಸ್ತೀನಿ ಅಂತ ಹೇಳಿ ದುಡ್ಡು ಸಾಲ ಮಂಜೂರು ಮಾಡಿಸಿರ್ತಾರೆ. ಸದರಿ ಮಂಜೂರಾದ ಹಣದಲ್ಲಿ ಒಂದು 13,95,000 RTGS ಮೂಲಕ ಆರೋಪಿ ಬಸವರಾಜ್ ಔಟ್ ಆಫ್ 29 lakhs ಅಲ್ಲಿ ಇದುವರೆಗೆ ಫ್ಲಾಟ್
ಕೊಟ್ಟಿಲ್ಲ ಅಷ್ಟೇ. ನಮ್ಮ ಮೇಲೆ ರೆಸ್ಟ್ ಆಫ್ ದಿ ಅಲಿಗೇಷನ್ ಅಗೇನ್ಸ್ಟ್ A2
ಅಮೌಂಟ್ ರಿಸೀವ್ ಮಾಡಿದ್ರೆ ಇಲ್ಲ ನೀವು?
ಅಮೌಂಟ್ ರಿಸೀವ್ ಮಾಡಿದ್ರೆ ಇಟ್ಸ್ ಅಂಡರ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡೋದು.
ಎಷ್ಟು ರಿಸೀವ್ ಮಾಡಿದ್ರೆ ಹೇಳಿ ನೀವು? 13,95,000. ಮತ್ತೆ
29,25,000 is also received.
ಯಾವಾಗ ರಿಸೀವ್ ಮಾಡಿದ್ರು? ಯಾವ ಇಯರ್ ಅದು? 17. ಮತ್ತೆ ಇದುವರೆಗೆ ಯಾಕೆ?
Agreement construction. Corona we could not complete. It's the only allegation against. Not given flat.
ದುಡ್ಡು ಕೊಟ್ಟು ರೀಫಂಡ್ ಮಾಡ್ಬಿಡಿ ಅವ್ರ ದುಡ್ಡು ಅಷ್ಟು. If you are not able to give flat
ಇದ್ರಲ್ಲಿ ಒಂದಲ್ಲಿ ಪೇಮೆಂಟ್ ಈಜಿಯಾಗಿ ಕೊಟ್ಬಿಡ್ತಾರೆ. ಇದರಲ್ಲಿ ಲೋನ್ ಅವರೇನ ಅಮೌಂಟ್ ಈಜಿಯಾಗಿ ಕೊಟ್ಬಿಡ್ತಾರೆ. ಅದರ್ 3 ಲೋನ್ ಇಸ್ ಬಾರವ.
ಅವರು ಇವರ ಹೆಸರಲ್ಲೇ ಇವರೇ ಲೋನ್ ತಗೊಂಡಿರೋದಲ್ಲ.
ಡಿಫರೆಂಟ್ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ
ಸೇಮ್ ಪ್ರಾಪರ್ಟಿ. ಆ ದುಡ್ಡು ಇವರೇ ತಗೊಂಡವ್ರ? ಯಾರು? A1 A2 ಆ ತರ ಚೀಟಿಂಗ್ ಇದು.
After the receiving of the bank note, my knowledge
comes to know about this the transaction.
Well, recently after filing this case, the charge sheet is filed. All allegation whatever is learned.
I think charge sheet material ಇದೆಯಾ?
ಇದೆ.
ಕೊಡಿ ಮತ್ತೆ ಅದನ್ನು ಕೊಡಿ. ನೋಡಿ.
Charge sheet is filed again.
ಆಯ್ತು, ಈಗ ಕೊಡ್ತಾ ಇದ್ದೀರಾ ಅದು ಚಾರ್ಜ್ ಶೀಟ್ ಮೆಟೀರಿಯಲ್?
ಲಾಸ್ಟ್ ಟೈಮ್ ಕೊಡ್ತಾ ಇದ್ದೆ, ಅವ್ರು ಬೇರೆ ತರ್ತೀನಿ ಅಂತ.
ನಮ್ಮ ಕೋರ್ಟಿಗೆ ಹಾಕಿಲ್ಲ ನೀವು?
ಇಲ್ಲ, ಆಗ್ಲಿಲ್ಲ.
Petitioner counsel has filed the memo along with charge sheet materials. And hence list this matter on 24th. ಆಯ್ತು, 6 ಗಂಟೆ ಆಗೋಯ್ತು. ಸಾಕು ಜಾಸ್ತಿ ಆಯ್ತು. ನಾಳೆ ನಾಡಿದ್ದು ರಜಾ ಅಂತ ಮತ್ತೆ ನಮ್ಗೆ ಬೇರೆ ಕೆಲಸ ಇರ್ತದೆ. ಹೇಳಿ. ಯಾವ್ದಾದ್ರು ಅಷ್ಟೇ, ಈಗ ಟೈಮ್ ಇಲ್ಲ. ಐ ಆಮ್ ಆಲ್ಸೋ ಎಕ್ಸಾಸ್ಟೆಡ್. 100 ನೋಡಿ, 100 ಯಾವಾಗ ಬೇಕು ಹೇಳಿ. ಏನ್ ಮೇಡಮ್? 22 ಜಾಸ್ತಿ ಇದೆಯಾ? ಹಾಫ್ ಡೇ ರೀ ಅದು. 23 ದಿವಸ ಹಾಫ್ ಡೇ ಇದೆ, ಬಾಕಿ 2 ದಿವಸ ಮಾತ್ರ ಫುಲ್ ಡೇ ಇರ್ತದೆ. ಅದಕ್ಕೆ 22 ಹಾಕಿರಿ ನೋಡೋಣ. ಡ್ಯೂ ಟು ಪಾಸಿಟಿವ್ ಆಫ್ ಟೈಮ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 22 ರೀಚ್ ಆದ್ರೆ ಮಾಡ್ತೀನಿ. 101 ಏನ್ರಿ? 101 ಯಾವತ್ ಬೇಕು? 101 24th ಆಗ್ಬೋದಾ? 24th ಡ್ಯೂ ಟು ಪಾಸಿಟಿವ್ ಆಫ್ ಟೈಮ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 24th. ನೆಕ್ಸ್ಟ್ 102 AV ರಾಮಕೃಷ್ಣ. ಯಾವಾಗ? ಏನಿದೆ? 24th ನೋಡೋಣ. ನೆಕ್ಸ್ಟ್ 103
I am appearing not on behalf of the petitioner counsel.
21
But any short date not 439.
24th
24th no?
24th ಮೂರ್ತಿ ಕೆ ಮಂಗಳವಾರ ಡೌಟ್ ರೀ ಅದು ರೀಚ್ ಆಗೋದು. 24th ಅದೇ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕೊಡ್ತೀನಿ. 24th ಕೊಡ್ತೀನಿ. ನಾನು 3 days ಇಂಟರ್ವ್ಯೂಸ್ ಇದೆ, ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ, ಆಮೇಲೆ ನೋಡೋಣ. 105 ರವೀಂದ್ರ ಪ್ರಸಾದ್ ಇದು ಆಯ್ತಲ್ಲ, ಆಗಿದೆಯಲ್ಲ. ಫಸ್ಟ್ ಇಲ್ಲಿ ಬನ್ನಿ. ನಿಶಾಂತ್ ಏನಾಯ್ತು? ಏನಾಯ್ತು ಮೇಡಮ್? ವಾಟ್ ಹ್ಯಾಪನ್? ಆಯ್ತು ಆಯ್ತು. ನೀವು ಯಾವಾಗ ಕಳ್ಸಿದ್ರಿ? ಸ್ವಲ್ಪ ಒಪಿನಿಯನ್ ಸ್ಯಾಂಕ್ಷನ್. ಹಾ that is only in respect of IAS officer. ಇನ್ನೊಂದು the council appearing for the state would submit that already sanction is given in respect of 1, 2, 3, 4, 7 and accused number 11 and going to and ಮತ್ತೆ ಇನ್ನೊಬ್ರಿಗೆ ಯಾರಿಗೋ ಯಾವಾಗಲೂ ಕೊಡ್ತಿದ್ರಲ್ಲ. and sanction will be given within another 2 days in respect of accused number 10. The accused number ಯಾರು? IAS officer. accused number 8 is the retired IAS officer. ರಿಟೈರ್ ಆದ್ಮೇಲೆ ಮತ್ತೆ ಹಾಕ್ಬೇಕು ಸ್ಯಾಂಕ್ಷನ್. ಈಗ ರೀಸೆಂಟ್ ಆಯ್ತು. ಸರಿ ಸರಿ. ಏನಾಯ್ತು ಮೇಡಮ್?
Case number 8 is the
Case number 8 is retired from the service and competent authority has to give sanction and the same is in process. ಅಷ್ಟೇ. ಅದೊಂದೇನಾ? ಶಂಕರ್ ಅವ್ರು ರಿಟೈರ್ ಆಗಿದಾರ? and hence it takes ಎಷ್ಟು ಸಾಕ್ತದೆ? ACB ಯಾರು ಅಪಿಯರ್ ಆಗೋದಾರ?
I appear for the ACB.
ಏನ್ರಿ ನಿಮ್ಗೆ ಎಷ್ಟು ದಿವಸ ಬೇಕ್ರಿ ಸ್ಯಾಂಕ್ಷನ್ ತಗೊಳಕ್ಕೆ? ಅಲ್ಲಿ ಏನೋ ನಿಮಗೆ ರಿಟರ್ನ್ ಮಾಡಿ ಏನೋ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಡ್ಬೇಕು. ಟ್ರಾನ್ಸ್ಲೇಟೆಡ್ ಅಂಡ್ ಥ್ರೂ ಸ್ಟೇಟ್ ಗೌರ್ಮೆಂಟ್ ಇಟ್ ವಿಲ್. ಏನ್ರಿ ನೀವು ಟ್ರಾನ್ಸ್ಲೇಟ್ ಮಾಡಕ್ಕೆ ಎಷ್ಟು ದಿವಸ ಬೇಕು? ಯಾವಾಗ ಕೊಡ್ತೀವಿ?
I'll make a translation and send it as soon as possible. Maybe about 20 days at least.
ಈಗ ಎಷ್ಟು ದಿವಸ ಡೇಟ್ ಕೊಡ್ಲಿ? 15 20 ದಿವಸ ಕೊಡ್ಲಾ? ಒಟ್ಟಿಗೆ ಎಷ್ಟು ದಿವಸ ಕೊಡ್ಬೇಕು?
Lord may grant me a month's time.
And the same is under ತಗೊಳ್ಳಿ. and ಏನಾಯ್ತು ಮೇಡಮ್? ಸೇಮ್ is in process ಅಷ್ಟೇ. and it you are going to process it. ಏನಾಯ್ತು ಮೇಡಮ್?
And the competent authority has to give sanction. The same is in process.
Same is in process and it takes some time since they have to get the permission sanction the DOPT and hence list is ಯಾರು? who is he has to pursue the matter. ಏನ್ ಬೇಕ್ರಿ ಸರ್ಕಾರ? ನೀವು ಎಷ್ಟು ಸರಿ ನಿಮ್ಗೆ ಕೊಡೋದು ಟೈಮ್ ಕೊಡೋದು? 17 ಪರ್ಮಿಷನ್ಗೆ 6 ತಿಂಗಳು ಆಮೇಲೆ ಈಗ 19 ಪರ್ಮಿಷನ್ ಇನ್ನೊಂದು 6 ತಿಂಗಳು ಆಯ್ತು ನೋಡಿ 1 ಮಂತ್ ಕೊಡಿ. Is this matter on March? First of March. Again, ಆಮೇಲೆ vacation ಬರುತ್ತೆ. 21st of March. 21st of March.
Very well. Great.
ಯಾವ್ದು ಮೇಡಮ್ ನಂಬರ್ 26 ಮೆಮೋ ಸಿಕ್ತು ಅಲ್ಲ ಹಾಕೋಬಿಡಿ. The council also the CCGP also submitted a copy of the sanction order. AG ಗಲ್ವಾ ಅಡಿಷನಲ್ ಗವರ್ನಮೆಂಟ್ ಏನು ಗವರ್ನಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ AGA files memo along with order and the same is taken on record on this matter on 21st of next job madam 27 part ready ಇದು ಅರ್ಜುನ್ ಬೆಳಗ್ಗೆ ಏನ ಪಾಸ್ ಅವರಂದ್ರಲ್ಲ ನೀವೇನ ಯಾರು ಇರ್ಲಿಲ್ಲ ನೀವಿರ್ಲಿಲ್ಲ ಅಂತ ಯಾರಿರ್ಲಿಲ್ಲ ನೀವಿರ್ಲಿಲ್ಲ ಅಂತ ನೀವಿರ್ಲಿಲ್ಲ ಅಂತ ಆಯ್ತು ನೋಡಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇರ್ಲಿಲ್ಲಲ್ಲ ಬೆಳಗ್ಗೆಲ್ಲ ಇದ್ರು ನೀವಿರ್ಲಿಲ್ಲ ಅಂತ ಪಾಸ್ ಓವರ್ ಆಗಿತ್ತು ಆಯ್ತು ದಿಸ್ ನಾನು ಕ್ವಾರ್ಟರ್ಡ್ ಮ್ಯಾಟ್ರ್ ಯಾವಾಗ 22nd ಹಾಕಿತ್ತು 31 ತಿಗಡಿ ವೀರಣ್ಣ ಬರ್ಲಿಲ್ಲ next week ಆಯ್ತು ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್ next time this matter on 24th 25th ಎರಡು ಡೇಟ್ ಬೇಡ ಬೇರೆ ರೋಸ್ಟರ್ ಬೆಂಚ್ ಆದಾಗ ಬೇಕು ಆಯ್ತು 23rd ಇಫ್ ದಟ್ ಇಸ್ ದಿ 23rd ಆಯ್ತು 23rd ಹಾಕೊಳ್ಳಿ ಮೇಡಮ್ ನಾಮದ್ ಇವ್ರು ಬರೋದೇ ಇಲ್ಲ ಬನ್ರಿ ಬೆಳಗ್ಗೆಲ್ಲ ಇರ್ಲಿಲ್ವಾ ಡಿಸ್ಮಿಸ್ ಅಲ್ಲ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ ತಗೊಂಡಿ ಮೇಡಮ್ ಏನ್ ಮಾಡಿದ್ವಿ ಇಲ್ಲ ಮೋಸ್ಟ್ಲಿ ಫಸ್ಟ್ ಇದು ಒಂದು ಅಪರ್ಚುನಿಟಿ ಕೊಟ್ಟಿರ್ಬೇಕು ಡಿಸ್ಮಿಸ್ ಫಾರ್ ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಬಟ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಡಿಸ್ಮಿಸ್ ಅಂತ ಅಂದಾಗ ಕೊನೆಗೆ ಬಂದ್ರು ಅವರು ಅಲ್ವಾ ಅಂತ ಕೊಟ್ವಿ ತೋಳಿ ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಇವತ್ತು ದಿಸ್ ಮ್ಯಾಟರ್ ಇಸ್ ಲಿಸ್ಟೆಡ್ ಫಾರ್ ತೋಳಿ ದಿಸ್ ಮ್ಯಾಟರ್ ಇಸ್ ಕಾಲ್ಡ್ ಟ್ವೈಸ್ ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ and earlier also this court made it clear on 15/2/22 that petition will be dismissed for non prosecution. On that day the council when the matter is called for second time appeared but no representation today and hence petition is dismissed for non prosecution. Next 34 Jagadish H entry ಇದು cancellation of 34 ಸಾರಿ 34 ಬೆಳಗ್ಗೆ ಏನಾಯ್ತು ಮ್ಯಾಟ್ರಸ್ ಯಾಕೆ ಪಾಸ್ ಓವರ್ ಆಯ್ತಲ್ಲ ಆಯ್ತು ತೋಳಿ ಡ್ಯೂ ಟು ಪಾಸಿಟಿವ್ ಆಫ್ ಟೈಮ್ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ಸ್ ಆನ್ 24th 24th ಆಯ್ತು 24th ಎರಡು ಅದೇ ಸೇಮ್ ಮೇಡಮ್ ಒಂದೇ ಸೇಮ್ ಕನೆಕ್ಟೆಡ್ ಅದು 38 ಹನುಮಂತರಾಯ CH ಹೇಳ್ರಿ ಏನು 36 ಇದೆ ಒಂದ್ ಸೆಕೆಂಡ್ 36 ಚಂದ್ರಕುಮಾರೇಗೌಡ ಬರೋದಿಲ್ಲ ತಗೊಳ್ಳಿ this matter is listed several time and no representation and this court made it clear on 10/2/22 that if counsel doesn't appear matter will be dismissed. Today also matter is called twice no representation dismissed for non prosecution. 38 ಹೇಳಿ counsel ಹೇಳಿ 21st ಆಗೋದಿಲ್ಲ ನೆಕ್ಸ್ಟ್ ಮಂಡೇ 3 ದಿವಸ ಆಗೋದಿಲ್ಲ 24th ತಗೊಳ್ಳಿ 2-3 ಆಗೋದಿಲ್ಲ 21st 22nd 23rd ಹಾಫ್ ಡೇ ಸಿಟ್ಟಿಂಗ್ ಅದಕ್ಕೋಸ್ಕರ 24th second of March ಕೊಡಿ the petitioner counsel seeks time to list this and time the petitioner counsel seeks time for 2nd of March and hence this matter on 2nd of March. 39 ಜಗದೀಶ್ H ಏನ್ರಿ ಇದು ಕ್ಯಾನ್ಸಲೇಷನ್ ಆಫ್ ಬೇಲ್ 24th ನೋಡಿ 43 ನಾ ಹರೀಶ್ ಕುಮಾರ್ ಇದೇನೋ ನಂಬರ್ ಬರ್ಕೊಂಡಿದ್ದೇನಲ್ಲ 8768 of 22 ಅಂತ ಬೇರೆನದು ಇವ್ರು ಇರ್ಲಿಲ್ವಾ ಯಾರು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಾಪಿ ಟು HB ತೋಳಿ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 25th ಆಯ್ತು 49 ಹೇಳಿ ಕೌನ್ಸಿಲ್. ಹಾ ಹೇಳಿ. ಹುಷಾರಿಲ್ವಾ? 49 proxy counsel 6 time on behalf of the petitioner counsel on the ground of ill health. This matter on madam ಯಾವ 25 to 54 53 ಆಯ್ತಾ? 54 ತಿಗಡಿ ವೀರಣ್ಣ ಅದ? ತಗೊಳ್ಳಿ ಕೊಡಿ. ಯಾವಾಗ ಅದೇನ್ರಿ? ಯಾವಾಗ? ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆಯ್ತು. ದಿಸ್ ಮ್ಯಾಟರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಡೇಟ್ ಬೇಡವಾ? ಸ್ಪೆಸಿಫಿಕ್ ಡೇಟ್ ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್ ಕೊಡಿ ಅವ್ರಿಗೆ. ನಮ್ ಬೆಂಚ್ ಬೇಡ ಅದಕ್ಕೆ. ಅದಕ್ಕೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅನ್ನೋದು. ಅಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂದ್ರೆ ಬರೋದಿಲ್ಲ, ಅದು ಗೊತ್ತವ್ರಿಗೆ. ಅಲ್ಲಿ ಹೋಗಿ ಮಾಡ್ತಾರೆ, ಮ್ಯಾನೇಜ್ ಮಾಡ್ತಾರೆ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರ್ದಂಗ್ ಮಾಡ್ತಾರೆ. 56 ಏನಾರು ಅನ್ಫಾರ್ಚುನೇಟ್ಲಿ ಏನಾರು ಮತ್ ನಾವೇ ಕಂಟಿನ್ಯೂ ಆದ್ರೆ ಆಯ್ತು. ಲೈಟರ್ ವೇ ಎಷ್ಟು? 56 ವಿಶ್ವನಾಥ. ಲಾಸ್ಟ್ ಟೈಮ್ ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ತಗೊಳ್ಳಿ. This no representation in the previous occasion also, and this court given one more opportunity, and today also no representation, and hence list this matter on 25th. If counsel doesn't appear, matter will be dismissed for non-prosecution. 58 ಮಂಡ್ಯಾಗ ಇಲ್ರಿ, 3 ದಿವಸ ಕಷ್ಟ. ತಗೊಳ್ಳಿ. this matter on 24th ನೋಡೋಣ. due to paucity of time 25th ಹಾಕಿ. 60 ಪ್ರೊಕ್ಲಮೇಶನ್ ಏನೋ ಹೇಳಿದ್ವಲ್ಲ, ಏನಾಯ್ತು ಪ್ರೊಕ್ಲಮೇಶನ್? ದಿನೇಶ್ ಆಗಿದೆಯಾ? ಅವ್ರು ಅದರ್ ಸೈಡ್ ಅನ್ನ ಹೇಳ್ತೀವಿ ಇದ್ರಲ್ಲ, ಕೇಳ್ಬಿಟ್ಟು ಪಾಸ್ ಓವರ್ ಮಾಡಿ. ಆಯ್ತು, ಇನ್ನು ಮಂಡ್ಯಾಗ ಹಾಕಿರ್ ನೋಡಿ. ಸುಮ್ಮನೆ ನಮ್ಮ ಅಬ್ಸೆನ್ಸ್ ನಾನು 6:15 ಡಿಸ್ಮಿಸ್ ಮಾಡಿದೆ ಅಂತ ಮಾಡಿ. ಮ್ಯಾಟರ್ ಆನ್ 22nd 23rd ಮೇಡಮ್ 22nd 22nd ಡ್ಯೂ ಟು ಪಾಸಿಟಿವ್ ಆಫ್ ಟೈಮ್. 69 ಔಷಧ ಪಾಸ್. ಯಾರು ಬರೋದೇ ಇಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್. ಆಯ್ತು. ದಿಸ್ ಮ್ಯಾಟರ್ ಕಾಲ್ಡ್ ಟ್ವೈಸ್, ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್. ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 25th. 80 ಪ್ರವೀಣ್. ಇದು ಅಷ್ಟೇ, ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಇನ್ ದ ಅರ್ಲಿ ಅಕೇಶನ್, ಅಂಡ್ ಟುಡೇ ಆಲ್ಸೋ ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ when the matter called twice. However, in the ends of justice, one more opportunity is given. If counsel doesn't appear, matter will be dismissed for non-prosecution on 25th. 81 ಶಶಿಧರ TP. ಚಾರ್ಜ್ ಶೀಟ್ ಇದು ಅಷ್ಟೇ. ಮ್ಯಾಟರ್ ನ ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್ ಟುಕ್ ಟೈಮ್ ಟು ಫೈಲ್ ಚಾರ್ಜ್ ಶೀಟ್ ಮೆಟೀರಿಯಲ್, ಬಟ್ ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಟುಡೇ, and hence if counsel doesn't appear, matter will be dismissed for non-prosecution on 25 to. ಮುಗಿತಾ?